ಏನ್ ಮಾಡಿಫಿಕೇಶನ್ ಆಫ್ ಆರ್ಡರ್ ಏನು? ಆಯ್ತು, ಬೀಯಿಂಗ್ ಸ್ಪೋಕನ್ ಮಾಡಕ್ ಬರಲ್ಲ, ನೀವು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ಅಂತ ಹೇಳಿದ್ವಲ್ಲ. ಆಯ್ತ್ರಿ, ಈಗ ನೀವು ಹಾಕಿದಿರ ಅಪ್ಲಿಕೇಶನ್ ನಿನ್ನೆ. ಏನ ಫಾರ್ ಬೀಯಿಂಗ್ ಸ್ಪೋಕನ್ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ ಅಂತ ಹೇಳಿದೆ. ನೆಕ್ಸ್ಟ್ ನೆನ್ನೆ ಮೆಮೊ ಕೊಟ್ಟಿದ್ದೀರಾ ನೀವು ಪೋಸ್ಟಿಂಗಿಗೆ? ಯಾಕೆ ಮೇಡಮ್ ಪೋಸ್ಟ್ ಮಾಡಿಲ್ಲ? ನೆನ್ನೆ ಡೇಟ್ ಕೊಟ್ಟಿದೀವಲ್ಲ, ಡೇಟ್ ಕೊಟ್ಟ ಮೇಲೆ ಯಾಕೆ ಪೋಸ್ಟ್ ಮಾಡಿಲ್ಲ? ತೊಗೊಳ್ಳಿ ಮೆಮೊ ತೊಗೊಳ್ಳಿ. 2:30. ಆಯ್ತು. ಯಾರು ಇವ್ರಿಗೆ ಅಪನೆಂಟ್ ಕೌನ್ಸಿಲ್ ಹೇಳಿದಿರಾ? R3 counsel seeks time. Appellant counsel also says no objection. List this matter. ಎಷ್ಟು ದಿವಸ ಬೇಕು? 1 week. List this matter on 12/11. Interim order granted earlier is extended till next date of hearing. 50? You are appearing for whom? Intimate ಮಾಡಿದ್ರೆ ಸಂಗಮೇಶ್ RB ಅವರಿಗೆ? ಮಾಡಿಲ್ಲ. ಇಂಟಿಮೇಟ್ ಮಾಡಿ ಆಮೇಲೆ ನೋಡಿ.
$66, my lord. I informed other side, my lord. His junior took the phone and also his colleague took the phone.
You are appearing for whom?
One case respondent again, one case petitioner again. 3 cases are there, my lord.
3 ಇದೆಯಾ? ಈಗ ಯಾರಿಗೆ ಇವ್ರು ನೀವೇ
ಚಂದ್ರಚೂಡ್
ಹೇಳಿದಿರಾ?
ಹೇಳಿದೆ. ಅವ್ರ ಇನ್ಫಾರ್ಮೇಶನ್ ಕೊಡ್ತೇನೆ ಅಂತ ಹೇಳಿದ್ರೆ ಅಲ್ಲಿಗೂ ಮತ್ತೆ ಇನ್ಫಾರ್ಮೇಶನ್ ಕೊಡಲಿಲ್ಲ, ಫೋನ್ ತೋರ್ತಾ ಇಲ್ಲ.
Yes madam, they are seeking time.
Yes my lord, they have informed us, my lord. Yes my lord, they have informed us, my lord.
Respondent and counsel seeks time and also submits that he has already intimated the appellants in 2 appeals and hence list this matter on 13/11.
Grateful.
2000 ಯಾವ year ಇದು? 6 ಯಾವಾಗಿದೆ? ಇವತ್ತಿದೆಯಾ? ಯಾವ್ದು ಸೀರಿಯಲ್ ನಂಬರ್ ಹೇಳ್ಬೇಕು ನೀವು. ಪೇಜ್ ವೈಸ್ ಕರ್ಸಿದೀವಿ. ಪೇಜ್ ವೈಸ್ ಕರೆಸ್ತಾ ಕೇಳ್ಬೇಕ್ರಿ. ಏನ್ 44? ಕ್ವಾರ್ಟರ್ ಟೈಮ್ ಕೇಳ್ತಾ ಇದೀರಿ? ಅದು ಏನಕ್ಕೆ ಅಂತ ಕೇಳ್ತಾ ಇದೀನಿ. ಆ ರೀಸನ್ ಅಲ್ಲೇ ಲಾಸ್ಟ್ ಟೈಮ್ ಡೇಟ್ ತಗೊಂಡಿರೋದು, ಹೌದಾ? ಆ ರೀಸನ್ಗೆ ಡೇಟ್ ತಗೊಂಡಿರೋದು. ಬೋತ್ ವಿಲ್ ಲುಕ್ ಇನ್ ಟು ದಿ ಅದರ್ ಸೈಡ್ ಮಾಡಿದೀರಾ? Appellant counsel seeks time and counsel also submits that he has already intimated counsel for respondent. List this matter on 13/11. In 8790. ಅವೆಲ್ಲ ಮಧ್ಯಾಹ್ನ 2:30 matters.
I am for the appellant in this case, my lord. I seek for 2 weeks time to comply on this objection.
Trial court valuation slip to be produced and value to be stated in at appeal. First time, appellant say counsel seeks 2 weeks time, and hence 2 weeks time granted as sought.
According to the appellant, my lord, I see 2 weeks time, my lord, to comply with it.
Appellant counsel seeks 2 weeks time, and 2 weeks time granted as sought.
My lord, in serial number 3, my lord.
Hmm.
Kindly pass over, my lord. I'll file a memo for withdrawal, my lord.
Pass over. Right.
Please, my lord.
My lord, in this case, my lord, I have produced the certified copy of grant certificate.
Yesterday office objections ಹೇಳಿ.
My lord, complaint, my lord, complaint ಆಗಿದೆ.
Complaint ಮಾಡಿ ಮತ್ತೆ
Copy
ಬರುತ್ತೆ.
copy ಹಾಕಿದ್ದೀವಿ.
ಇನ್ನು ಎಷ್ಟಿದೆ ಮೇಡಮ್?
Not again to be filed under Interim.
ಅದು certified copy ಹಾಕಿದ್ದೀವಿ.
Legible in a error raised in legible copy of the document of page number 6061 to be furnished to verify the right document. And then a complete right copy of document at page number 63 to be furnished.
ಕೊಡಿ ನೋಡೋಣ ಅದೇನು ಪೇಜ್ ನಂಬರ್ 60, 61, 63. ಏನ್ರಿ ಇದು ಹೆಂಗ್ ಓದದ್ರಿ?
My lord, ಅದು endorsement.
ಆಗ್ಲಿ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಅಲ್ಲಿ ಯು ಆರ್ ರಿಲೈಯಿಂಗ್ ಅಪಾನ್ ದಟ್ ಡಾಕ್ಯುಮೆಂಟ್ ಹೌದಾ? ಹೇಗ್ ಓದೋದು?
Certified ಮಾಡಿದ್ದಾರೆ.
ಹಾ?
Certified
ಟೈಪ್ಡ್ ಕಾಪಿ ಹಾಕಿದೀರಾ?
Typed copy ಹಾಕಿದ್ದೀವಿ.
ಅದ್ರದ್ದೇನ ಇದು?
ಹೌದು.
ಇನ್ನೇನ್ ಅಬ್ಜೆಕ್ಷನ್ ಮೇಡಮ್ ಟೈಪ್ಡ್ ಕಾಪಿ ಹಾಕಿದ್ಮೇಲೆ? ಸಿಕ್ಸ್ಟಿ 61 ಎಲಿಜಿಬಲ್ ಇಲ್ಲ ಟೈಪ್ಡ್ ಕಾಪಿ ಹಾಕಿದ್ದಾರೆ ಮತ್ತೇನ್ ಬೇಕು? 62
Legible copy of the documents of page number 6061 to be furnished
ಆಯ್ತು.
to verify the right copy of 62, 63.
ಓ ಇದನ್ನ ವೆರಿಫೈ ಮಾಡಕ್ಕೆ ಇದು ಲೆಜಿಬಲ್ ಹಾಕಿ ಅಂತ. ಲೆಜಿಬಲ್ ಇದ್ರೆ ಅವ್ರ ಹಾಕಿ ಟೈಪ್ಡ್ ಕಾಪಿ ಹಾಕ್ತಾರೆ. ಹಾ ಏನ್ ಮಾಡೋದು ಇರೋದನ್ನ ಏನಾದ್ರು ಮಾಡ್ತಾರ ಅವ್ರು ಅದರ್ ಸೈಡ್ ಇದ್ರೆ ಅಬ್ಜೆಕ್ಟ್ ಮಾಡಿ. ಆಯ್ತು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇಸ್ ಓವರ್ ಪೋಸ್ಟ್ ದಿ ಮ್ಯಾಟರ್ ಫಾರ್ ಅಡ್ಮಿಷನ್. ಅರ್ಜೆನ್ಸಿ ಇದೆಯಾ ಏನು?
ಹೌದು.
ಆಯ್ತು ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲೇ ಕೊಡಿ ಯಾವ್ದಾರು ಡೇಟ್ 7/11. ಮೇಂಟೈನಬಿಲಿಟಿ.
1 week time.
ಹಾ?
14 March says 1 week time.
ಅಲ್ಲ ರೀ 2022 ಮೇಂಟೈನಬಿಲಿಟಿ ಮೇಲೆ ಇನ್ನೆಂತ ರೀ 1 ವೀಕ್?
People
ಹಾ.
UK is that ಯಾವ್ದೋ ಒಂದು ಪೇಪರ್ ಕೇಳ್ಬೇಕು ಅದಕ್ಕೆ ಒಂದು.
ಮೇಂಟೈನಬಿಲಿಟಿ ಅಲ್ವಾ? ಓ ಸಾರಿ 1 second. ನಂದೇ ಡಬಲ್ ಡೇಟ್ ಬಂದಿದೆ. 2000 ಮ್ಯಾಟರ್ ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ಅಪ್ಲಿಕೇಶನ್ ಫಾರ್ ಸಬ್ಸ್ಟಿಟ್ಯೂಟೆಡ್ ಸರ್ವಿಸ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ಪ್ರಪೋಸ್ಡ್ R3.
UK ಪೇಪರ್ ಯಾವ್ದು?
ಯುಕೆನಲ್ಲಿ ಇಲ್ಲಿ ಎಲ್ಲಾರು ಇರಲಿ 12/6 ಅಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿರೋದು ಆಗ್ಲೇ ಅಬೇಟ್ ಆಯ್ತು ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ?
UK ಇದ್ದಾರೆ.
ಅಲ್ಲಿ ಯುಕೆಲಿ ಇರ್ಲಿ ಬಿಡಿ ಅವ್ರು ಅಲ್ಲೇ ಇರ್ಲಿ.
ಅದು ಪೇಪರ್ ಅಂತ
ತಗೊಳ್ಳಿ. In spite of order was passed on 12/6/24 for filing of substituted service in respect of proposed R3, steps are not taken. Proposed R3 ಅಂದ್ರೆ impleading application ಮೇಡಮ್? ಹಾ
2 ಸಲ ಕವರ್ ರಿಟರ್ನ್ ಆಗಿದೆ ಸುಮ್ಮನೆ ಸರ ಏನು ಬರಲಿಲ್ಲ ಅದಕ್ಕೆ ಪೇಪರ್
ಕೈ ಹಾಕಿದ್ದಾರೆ ಅವ್ರಿಗೆ ಸರ್ವಿಸ್ ಆಗಿಲ್ಲ.
ಸರ ಹೆಂಗೆ ಬ್ಲಾಂಕೆ ಬಂದಿದೆ ಏನು ಬಂದಿಲ್ಲ. ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ತಗೋತಾ ಇದ್ವಿ ಅದು ಪೇಪರ್ ಯಾವ್ದು ಕೇಳ್ಬಿಟ್ಟು 1 week time.
1 week time is granted to do the needful failing which IA 4 of 2018 to implead the proposed respond number 3 shall stand rejected ಅಂತ ಮಾಡಿದ್ದಾರೆ. 1 week time ಅಲ್ಲ ಅದು ಯಾವಾಗ 26/2/24 ಹಾ. ಆಮೇಲೆ ಏನಾಯ್ತು? ನೋಟಿಸ್ ಹೋಯ್ತಾ? ಅನ್ರೆಪ್ರೆಸೆಂಟೆಡ್
ಇಯರ್ ಮೇಲೆ ಹೋಗಿದೆ ಸರ ಏನು ಬಂದಿಲ್ಲ ಬ್ಲಾಂಕ್ ಬಂದಿದೆ.
ಸಬ್ಸ್ಟಿಟ್ಯೂಟೆಡ್ ಸರ್ವಿಸ್ ಅಂತ ನೀವೇ ಕೇಳಿದಿರಿ.
ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ತಗೊಂಡಿದ್ದೀವಿ ಪೇಪರ್ ಯಾವ್ದೊಂದು ಕೇಳ್ಬಿಟ್ಟು 1 week.
ನೋಡಿ ದ ಅಪಲೆಂಟ್ ಕೌನ್ಸಿಲ್ ಅಗೇನ್ 6 time. And finally, 1 week time granted. List this matter on. 1 week ಆದ್ಮೇಲೆ ಕೊಡಿ ಮೇಡಮ್. 1 week ಆದ್ರೆ 7/11 ಹೆಂಗಾಗ್ತದೆ ಮೇಡಮ್? ಮುಂದಿನ ಇದ ಆಯ್ತು 7/11.
This case, appearing for appellant to lordship.
Actually,
as per the order of the Supreme Court, we have served the notice to the council appearing for respondent.
ಕೌನ್ಸಿಲ್ ಬರಲಿಲ್ಲ ಅವರು.
Please, my lord.
ಈಗ ಇವ್ರಿಗೆ ನೋಟಿಸ್ ಆರ್ಡರ್ ಮಾಡಿದಿರಿ.
Please, my lord, we have taken, my lord, steps to the address given by the plaintiff in the suit properties.
Third time.
Please, my lord. ಹೋಗಿದೆ ಬಂದಿಲ್ಲ ಅವರು ಅದಕ್ಕೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ FTP ಪ್ರೊಸೀಡಿಂಗ್ ಪೆಂಡಿಂಗ್ ಇದೆ. ಅದರಲ್ಲಿ ಸರ್ವಿಸ್ ಮಾಡಿ FTP ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅಲ್ಲಿ ಡ್ರಾ ಫೈನಲ್ ಡಿಗ್ರಿ ಅಂತ ಹೇಳಿದ್ರೆ IFR ಸ್ಟೇಗ್ ಆಲ್ರೆಡಿ ಫೈಲ್ಡ್ ಅಪ್ಲಿಕೇಶನ್
ಸರ್ವ್ ಮಾಡೋದಕ್ಕೆ ಹಾಕಿದಾರ?
ಹಾಕಿದ್ದೀನಿ ಸ್ವಾಮಿ ಅಪ್ಲಾಯ್ಮೆಂಟ್ಸ್ ಎಲ್ಲ.
ಈಗ ಕೋರ್ಟ್ ಇಂದ ನೋಟಿಸ್ ಹೋಗಿದ್ದು ಏನಾಯ್ತು? ನೋ ಸಚ್ ಪರ್ಸನ್.
Lordship, kindly see lordship.
Acknowledgement for having served the copy of the appeal memo and applications on the council represent the respondent in FDP 117 of. Told. The council appearing for the appellant would submit that notice was taken against the council on record before the trial court on behalf of the respondents in the FDP number 117 of 23. And in spite of the same council did not appear before this court, and this court also issued notice against the respondents. The address mentioned is also the same address which was mentioned in the plight,
Please.
but returned with a Shara no such address. And pressing for FDP proceedings before the trial court. Howda?
Please, my lord.
And in spite of service of notice, respondent did not choose to appear before the court, and hence the further proceedings in the FDP number 117 of 2023 is stayed till next start of hearing. Issue fresh notice against the respondents if correct address is furnished to the respondents within
Please.
1 week. Ascertain ಮಾಡಿ 1 week
Please.
ಅಲ್ಲಿ steps ತಗೊಳ್ಳಿ.
2 weeks ಅದು ಈಗ
2
ಟೈಮ್
weeks ಯಾಕೆ ascertain ಮಾಡಕ್ಕೆ?
ಇದು ಅಪ್ಲೈ ಬರ್ತದೆ 2 weeks.
ಎಂಟ್ರಿ ಮಾಡ್ರ್ ಕೊಟ್ಟವಲ್ಲ?
ಅಲ್ಲ
ಮತ್ತೆ
2 weeks.
ಎಂಟ್ರಿ ಮಾಡಿದ್ಮೇಲೆ you must be diligent.
ಅಲ್ಲ ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ 2 weeks kindly. ಅಲ್ಲ ಹಬ್ಬ ಎಲ್ಲ ಆಲ್ರೆಡಿ ಬರ್ತಾ ಇದೆ ಅದಕ್ಕೆ.
ಆಯ್ತು 2 weeks time granted. List this matter on 14/11.
ಮಚ್ಚೋಗಿ
ಅಲ್ಲ ಸ್ಟೆಪ್ಸ್ ತಗೊಳಕ್ಕೆ ನೀವು 2 ವಾರ ಆದ್ರೆ ನೋಟಿಸ್ ಹೋಗಿ ಬರೋದೇ ಯಾವಾಗ?
ನಾನು ಮಾಡಿದ್ದೀನಿ ಸ್ವಾಮಿ ಅವ್ರು ಕ್ಲೈಂಟ್ ಅಲ್ಲಿ ಅಡ್ರೆಸ್ ಕೊಟ್ಟಿರೋದು ಕ್ಲೈಂಟ್ ಅಡ್ರೆಸ್ಗೆ ಕೊಟ್ಟಿದ್ದೆ.
ಕ್ಲೈಂಟ್ ಅಡ್ರೆಸ್ ಹೋಗಿ ನೋ ಸಚ್ ಅಡ್ರೆಸ್
ಅದಕ್ಕೆ ಸ್ವಾಮಿ ಅಸರ್ಟೈನ್ ಮಾಡಿಬಿಟ್ಟೆ.
ರಿಟರ್ನಬಲ್ ಬೈ ನವೆಂಬರ್ ಎಂಡಲ್ಲಿ ಕೊಡಿ. ಅಷ್ಟೊಳಗೆ ಹೋಗಿ ಬರಲ್ಲ ಮೇಡಮ್, ಇವ್ರು ಡೇಟ್ ತಗೊಳ್ಳೋದೇ 14ಕ್ಕೆ. 2 weeks ಅಂತಂದ್ರೆ 2 week ಯಾಕ್ರಿ? 4, 5, 6, 7 ವರ್ಕಿಂಗ್ ಡೇ ಇದೆಯಲ್ಲ, 8 ವಿತಿನ್ 1 week ತಗೊಳ್ಳಿ. 1, 2, 3 ಮತ್ತೇನಿದೆ? 29/11.
ಪ್ಲೀಸ್ ಒಬ್ಲೇಜ್
Chandrasekhara Reddy ME. Steps to be taken in respect of LRs of deceased R1A.
Already on record, man.
ಯಾರು?
Number B2E.
1A died. Who are all the other LRs? ಯಾರು ಅಂತ ಹೇಳ್ರಿ?
Phone number B2E, man. One B2.
1 B2E ನಾ?
Yes, madam. I'm filing the memo.
ಮೆಮೋ ಆಗ್ತಾ ಇದೀರಾ? ಕೊಡಿ. Appellant counsel files memo stating that R1, B2E are the LRs of R1A, correct? And hence no need to take steps, and hence memo is allowed. Appellant counsel is permitted to amend the cast title and file amended cast title in terms of the memo. Next connected aleno?
Same.
Same ಅದು ಕಾಮನ್ ಆರ್ಡರ್. ಕಾಮನ್
Order maybe. Interim order.
ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇದೆಯಾ? ಎಂಟ್ರಿ ಮಾಡೋ ಗ್ರಾಂಟೆಡ್ ಅರ್ಲಿಯರ್ ಇಸ್ ಎಕ್ಸ್ಟೆಂಡೆಡ್ ಟಿಲ್ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್. ಯಾವ್ದ್ರಲ್ಲಿ ಇದೆ ಅದ್ರಲ್ಲಿ ಮಾತ್ರ ಮಾಡಿ. ಅದ್ರಲ್ಲೇ ಮಾಡಿ. ಮತ್ ಇನ್ನೊಂದೇನೋ 7.2 ನಲ್ಲೂ ಏನೋ ಇದೆಯೇನ್ರಿ? ಅದನ್ನು ಈಗ ಇದೆಲ್ಲ ಮೂರುನು ಸೇಮ್. ಮತ್ತೇನು ಇದು ಮೆಮೋ ಡೇಟೆಡ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಮೆಮೋ ಅಷ್ಟೇನಾ? ಎಲ್ಲ ಬರೀ ಮೆಮೋನೇ. ಎಷ್ಟು ಮೆಮೋ ಇದಾವ್ರಿ ಅದು? ಆಯ್ತು ನೆಕ್ಸ್ಟ್. Dismissal of appeal for non-compliance of office objection,
Paid the-
non-payment of cost.
Paid the cost to them.
Huh?
Paid the cost today.
ಬರೀ ಕಾಸ್ಟ್ ಮಾಡಕ್ ಕಟ್ಟಕ್ಕಲ್ಲ ಮಾತ್ರ ಇಟ್ಟಿರೋದು, ಡಿಸ್ಮಿಸಲ್ ಇಟ್ಟಿರೋದು ಇಫ್ ನಾನ್ ಕಂಪ್ಲೈಡ್ ಅಂತ. ಏನಾಯ್ತು, ಕಂಪ್ಲೈ ಮಾಡಿದ್ರೆ ಇಲ್ಲ? ಕಂಪ್ಲೈ ಮಾಡಿದಿರಾ?
I will comply it, I have to file an application.
ಪಾಸ್ ಓವರ್.
Application should be filed.
ನಿಮ್ ಕಾಸ್ಟ್ಗೋಸ್ಕರ ಅರ್ಜೆಂಟ್ ಮಾಡಿಲ್ರಿ, ಡಿಸ್ಮಿಸಲ್ ಇಟ್ಟಿರೋದು ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ ಗೆ. ಕಾಸ್ಟ್ ಕಟ್ ಬಂದಿದೀನಿ ಅಂದ್ರೆ
Party has
ವೈ ಯು ನಾಟ್ ಕಂಪ್ಲೈಡ್ ಇಟ್?
IA to be filed.
ಏನ್ ಮಾಡಕ್ಕಲ್ಲ, ಡಿಸ್ಮಿಸ್ ಮಾಡೋಣ ಬಿಡಿ, ಮಧ್ಯಾಹ್ನದವರೆಗೂ ಟೈಮ್ ಕೊಟ್ಟಿರ್ತೀನಿ, ಏನ್ ಮಾಡ್ತೀರಾ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ನೆಕ್ಸ್ಟ್ ಹೇಳ್ರಿ ಇದ್ರಲ್ಲಿ.
ಇದರಲ್ಲಿ ಅದು 6,80,000 ರೂಪಾಯಿ ಎನ್ಹಾನ್ಸ್ ಮಾಡಿದ್ದಾರೆ.
ಹಾ.
It is under challenge.
ಹ್ಮ್.
Now, my lords, the office raises an objection, my lords, as per section 20.
Hmm.
The Karnataka Civil Courts Act, it should go to the Sessions Court. But an appeal will lie there on the office has raised an objection.
ಹೌದು.
yesterday. So, my lords,
ಅಲ್ಲೇ ಬರುತ್ತೆ.
ಅಲ್ಲೇ ಹೋಗ್ಬೇಕು.
ನೀವ್ ಇನ್ಯಾಕೆ 22ರಿಂದ ಇಲ್ಲೇ ಇಟ್ಕೋ ಕೂತಿದ್ದೀರಿ?
ಅವ್ರು ರೈಸ್ ಮಾಡ್ಲಿಲ್ಲ, ನಾನು ಅವಾಗ ಅಬ್ಸರ್ವ್.
ಏನ್ ರೈಸ್ ಮಾಡಿಲ್ಲ?
The objection, my lord, that I left.
ಅಬ್ಜೆಕ್ಷನ್ ರೈಸ್ ಲಾಂಗ್ ಬ್ಯಾಕ್.
ಇಲ್ಲ, only the yesterday it was raised.
ನೋಡ್ರಿ,
It was not raised long back, my lords, only it is yesterday. it was-
22ರಿಂದ 24ವರೆಗೂ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ರೈಸ್ ಮಾಡಿರ್ಲಿಲ್ವಾ?
ಇದು ಈ ವಿಚಾರ ರೈಸ್ ಮಾಡಲಿಲ್ಲ. They were directing me, please, my lord, to get the petition copy which I secured.
Hmm.
I was not the, my lords, I was not a party before the reference court. My lords, the state was a party. State subsequently informed us, please, my lords, to file this appeal. We rushed before the honorable court. Thereafter, my lords, when the office raised an objection.
ವ್ಯಾಲ್ಯೂ ಆಫ್ ದಿ ಅಪೀಲ್ ಅಂತ ಅವಾಗ ತೋರ್ಸಿರ್ಲಿಲ್ಲ ಅಂತ, ಈ ಕಂಪ್ಲೈ ಮಾಡಿದ್ಮೇಲೆ ರೈಸ್ ಮಾಡಿದ್ದಾರೆ. ಆಯ್ತು. ದ ಅಪಲೆಂಟ್ ಕೌನ್ಸಿಲ್ ಇಸ್ ಪರ್ಮಿಟೆಡ್ ಟು ಫೈಲ್ ಅಪೀಲ್ ಬಿಫೋರ್ ದಿ
The original
Concerned-
documents may be.
ಕನ್ಸರ್ನ್ ಕೋರ್ಟ್. ಒರಿಜಿನಲ್ ಏನು?
ಅದೇ
ಒರಿಜಿನಲ್ ಏನ್ ಹಾಕಿರ್ತೀರಿ? ಬರೀ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಹಾಕಿರ್ತೀರಿ.
certified copy, please.
And the registry is directed to return the certified copy of the judgment passed by the reference court.
Reference court.
Reference court.
Execution file ಮಾಡಿದ್ದಾರೆ. ನಾನು
By
2 weeks time.
by furnishing the Xerox copy
Xerox.
on the file.
2 weeks time, lords, till such time not a precipitate in the execution court. Attach
2022ರಿಂದ ಏನು
ಅಲ್ಲ,
ಮಾಡಿದ್ರೆ
attach ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ, ಇಲ್ಲ.
No, no, no.
No, ಅದು I put a
You
date
go
of
to,
it, just-
you go to the very same court, that's all.
I will move it now.
When the appeal itself is not maintainable, passing of any such order doesn't arise counsel.
My only
You go to
lords,
the
observe,
court
lords,
ಅಷ್ಟೇ.
2 weeks ಅಲ್ಲಿ ನಾನು ಫೈಲ್ ಮಾಡ್ತೀನಿ.
ನೀವು ಹೋಗಿ ಫೈಲ್ ಮಾಡಿ, ನಾವೇನು ಬೇಡ ಅಂತ ಹೇಳ್ತಿಲ್ವಲ್ಲ.
ಅಲ್ಲ, ಅದು ಅವ್ರು ಅಟ್ಯಾಚ್ಮೆಂಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ಏನ್ ಮಾಡ್ಬೇಕು? ಅಪೀಲ್ ನಾಟ್ ಮೇಂಟೈನಬಲ್. How can
Ah,
court can
that-
pass an interim order counsel? ಹಾ,
ಅಲ್ಲ, one
ಹಾ.
little, my lords may observe this. my lords.
ಸರಿ ರೀ, ಅಪೀಲ್ ನಾಟ್ ಮೇಂಟೈನಬಲ್ ಇಲ್ದಾಗ ಹೆಂಗ್ರಿ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡೋದು?
The things I'm not, I'll maybe.
No, no such order. I am not sitting here to please the advocates.
No, I'm sorry, please, my lords, just that.
ಲೀಗಲ್ ಆಗಿ ಏನಿದೆ ಮಾಡೋಣ, ಅದ್ ಬಿಟ್ಬಿಟ್ಟು ಎಂತ ಇದು ನಿಮ್ದು? ಇಂಟ್ರಿ ಮಾಡ್ರ ಮೇಂಟೈನ್ ಇಲ್ಲ ಅಪೀಲ್, ಇಂಟ್ರಿ ಮಾಡ್ರ ಕೊಡಿ ಅಂದ್ರೆ ಹೆಂಗ್ರಿ?
ಅದು
ಹಾ.
ಆಫೀಸ್ did not raise that objection at
counsel.
that point of time.
ನಾನೇನ್ ಮಾಡಕ್ಕಲ್ಲ, 22ರಿಂದ 24 ಸುಮ್ನೆ ಇದ್ಬಿಟ್ಟು ಈಗ ಅಲ್ಲಿವರೆಗೆ ಆರ್ಡರ್ ಕೊಡಿ ಅಂದ್ರೆ
Probate.
ಡಿಸ್ಪೋಸ್ಡ್ ಪರ್ಮಿಟೆಡ್ ಟು ಏನು ಮೇಂಟೈನಬಿಲಿಟಿ ಏನಿದೆ, ಮೇಂಟೈನ್ ಆಫ್ ದಿ ಅಪೀಲ್ ಅಗೇನ್ಸ್ಟ್ ಪರ್ಮಿಟೆಡ್ ಟು ಫೈಲ್ ದಿ ಸೇಮ್ ಬಿಫೋರ್ ದಿ, ಆ ಪರ್ಮಿಷನ್ ಅಂದ್ರೆ ಅದೇ, ದಟ್ ಇಟ್ ಸೆಲ್ಫ್ ಇಸ್ ಡಿಸ್ಪೋಸಲ್.
Limitation aspect, my lords may observe one observation, lord, that I was.
ಆಯ್ತು, ಲಿಮಿಟೇಷನ್ ಬಗ್ಗೆ ನೋಡೋಣ. ಇನ್ ವ್ಯೂ ಆಫ್ ದಿ ಫೈಲಿಂಗ್ ಆಫ್ ಅಪೀಲ್ ಬಿಫೋರ್ ದಿಸ್ ಕೋರ್ಟ್, appeal in 2022, the trial court can consider the grounds for delay in filing the appeal, the pendency of this appeal.
10, 11, 12, 13. my lord.
Dismissal of appeal in view of
But
compliance of office
it's connected
objection
matter,
as
Lord.
per court order. ಹೇಳಿ.
Connected matter, your lordship has proceeded to 11, yesterday. All connected.
ಇವತ್ತಿರೋದು ಈ ಕೇಸ್ ಇರೋ ಡಿಸ್ಮಿಸಲ್ ಗೆ ಏನ್ ಹೇಳಿ, ಕಂಪ್ಲೈ ಮಾಡಿದ್ರ ಇಲ್ಲ?
ಮಾಡಿದ್ದೇನೆ ಸ್ವಾಮಿ.
ಯಾವಾಗ?
I was supposed to pay cost, I paid the cost,
Huh?
subsequently I complied.
ಹಾ. ಈಗ ಹೊಸದಾಗಿ
11 ಗೆ
ಕಟ್ಟಿದೀರಾ, ದುಡ್ಡು ಕಟ್ಟಿದೀರಾ? 135 ಕೋರ್ಟ್ ಫೀ ಡೆಬಿಟ್,
ಎಲ್ಲ
ಕೋರ್ಟ್
ಕೊಟ್ಟಿದ್ದೇನೆ.
ಫೀನಾ ಪಿ ಎಫ್?
ಕೋರ್ಟ್ ಫೀ ಕಟ್ಟಿದ್ದಾನೆ.
ಕೋರ್ಟ್ ಫೀನೇ. ಹಾ,
Extra one.
ಕೋರ್ಟ್ ಫೀ ಕಟ್ಟಿದ್ದಾನೆ, I paid cost also.
Sorry, the office has raised additional objections after compliance and hence another 10 days time is granted. List this matter along with, ಏನು ಬೇರೆ ಇನ್ನೊಂದಿದೆಯಾ?
ನಿನ್ನೆ ಬಂದಿತ್ತು.
List this matter
11.
on 11/11. In the meanwhile, council is directed to comply with the office objections.
12, 13 is also the same. Lord.
ಏನ್
11, 12.
12-13? ಅದ್ರಲ್ಲೂ ಹೊಸ objections raise ಮಾಡಿದಾರಾ?
ಹೌದು.
ಅದೇ ನಾವು ಡೆಫಿಸಿಟ್ ಕೋರ್ಟ್ ಫೀ 135 ಕೊಡ್ಬೇಕು ಅಂತೇನೋ ಇದೆಯಲ್ಲ.
ಅದು ಕೊಟ್ಟಿದ್ದೇನೆ, ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದೇನೆ ಸ್ವಾಮಿ.
ಕೊಟ್ಟಿದ್ರೆ ಮತ್ತೆ ಯಾಕೆ ಹಾಕ್ತಾರ್ರಿ? ರಸೀಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಬೇಕು.
Receipt office ಅಲ್ಲಿ ಇದೆ. I paid the process, I'm very sure about it. I'm making.
11 ನಿಮ್ದೇನಾ? 11 ನಿಮ್ದಲ್ಲ ಇದೆ?
11, 12, 13 are mine.
11 also.
Yes.
10, 11, 12, 13. Receipt ಹಾಕಿಲ್ಲ. The council submits that he has paid the deficit.
I'll pay the, I'll,
135 and hence directed to produce the receipt for having paid the same. And if any other of his subjections comply, in the meantime, list this matter on 11/11. Next matter lo adene, 12 allo adene, 13 allo adene. Ella 13 allo adene, 135 illa. 135,
ಎಲ್ಲ
13 allo ಇದೆಯಾ? ಆಯ್ತು, ಸೇಮ್ ಮಾಡು. All 4 matters same order. Permission to post this appeal before division bench since value, I post the matter before the division bench.
Cost ಕಟ್ಟಿದೀನಿ. Cost ಕಟ್ಟಿದೀನಿ.
ಕಾಸ್ಟ್ ಕಟ್ಟಿದಿರಿ, ಕಂಪ್ಲೈನ್ಸ್ ಮಾಡಿದಿರಾ? ಎಂಟು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಯಾವ್ದು ಕಂಪ್ಲೈ ಮಾಡಿಲ್ಲ, ಪಾಸ್ ಓವರ್ ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಡಿಸ್ಮಿಸಲ್ ಮಧ್ಯಾಹ್ನ. ಬರೀ ನಿಮ್ ಕಾಸ್ಟ್ ಕಟ್ಟಕ್ ಮಾತ್ರ ಕೇಸ್ ಇಟ್ಟಿರಲ್ರಿ, ಕಾಸ್ಟ್ ಅಂಡ್ ಕಂಪ್ಲೈನ್ಸ್ ಅಂತ ಇರುತ್ತೆ, ನೋಡ್ಬೇಕು ಅದನ್ನ. ಕಾಸ್ಟ್ ಕಟ್ಟಿದೀನಿ ಅಂದ್ರೆ ಏನೋ ಚಾರಿಟಿಗೆ ದುಡ್ಡು ಕಟ್ಟಿದೀನಿ ನಂಗೆ ಮಾಡ್ತೀರಿ ಎಲ್ಲ ಲಾಯರ್ಸ್. ಕಾಸ್ಟ್ ಕಟ್ಟಿದೀನಿ ಕಂಪ್ಲೈನ್ಸ್ ಯಾಕೆ ಮಾಡಲ್ಲ? ನೆಕ್ಸ್ಟ್
16 for the appellant.
submission with regard to non-filing of IA per additional
IA
document.
With respect to IA, objection 1, I am filing the IA, my lord. Objection number 2, my lord, lordship may peruse, my lord, it has to be overruled. I have shown in the cost title, my lord, the name of the appellant, my lord. In the trial court, it is not completely shown. So I have shown in the cost title itself wrongly shown anta. Adike verifying affidavit ಹಾಕಿದ್ವಿ ಕೆರಡೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ.
Note below, the cost title is accepted.
Please.
Regarding office objection number 2. The council submits that going to file application in terms
Today
of
only I will file.
the office objection number 1.
Please.
ಯಾವಾಗ?
ಇವತ್ತು ಈಗಲೇ.
ಆಯ್ತು.
Interim order has to be extended. Interim order has to
Interim order granted earlier is extended. The matter extended in state of hearing. List this matter on ಯಾವ್ದಾರ ಒಂದು ಡೇಟ್ ಕೊಡಿ ಮೇಡಮ್. ಇವತ್ತು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲೇ ಕೊಡಿ 7/11.
oblige.
Memo for withdrawal of appeal filed by advocate for appellant. Appellant counsel has filed memo seeking permission of this court to withdraw the appeal on the ground that the same doesn't survive for consideration, since the matter is settled out of court amicably between the parties. In terms of the memo, permitted to withdraw. Panajakshi, non-taking of hand summons in respect of.
My lord, we have served on the lower court, trial court advocates as per the order. The summons has served on the respondent. They have not engaged any advocate.
Hand summons ಸರ್ವಾಯ್ತಾ?
He is appearing.
1, 2, 3 ಎಲ್ಲಾರ್ಗುನಾ? ವಕಾಲತ್ ಆಫೀಸಲ್ಲಿ ಫೈಲ್ ಮಾಡಿ. ದ ಕೌನ್ಸಿಲ್ ಶ್ರೀನಿವಾಸ್ N undertakes to file wakalat for respond number 1 to 3. If wakalat is filed in the registry, show the name of the counsel in the cause list.
May I make some submission?
List this matter.
No, may I make my submission? The appellants are the sisters of first respondent's brother. There is a partition suit going on in Somarpet.
ಆಯ್ತು ಕೌನ್ಸಿಲ್.
My submission is.
ಡಿಲೇ ಇದೆ, ಎಲ್ಲ ಒಟ್ಟಿಗೆ ಹಿಯರ್ ಮಾಡೋಣ, ಡೇಟ್ ಕೊಡ್ತೀನಿ.
My submission is, if it is referred to mediator.
Mediation ಹೋಗ್ಬೇಕಾ?
Mediation.
ಏನ್ರಿ? ಆಯ್ತು, ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಷ್ಟೊಳಗೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ತಗೊಳ್ಳಿ.
On fourth, my lord.
ಆಯ್ತು, 4th ಮಂಡೇನೇ ರೀ.
Monday.
ಅವ್ರಿನ್ನು ವಕಾಲತ್ ಹಾಕ್ಬೇಕು, ಪುಟಪ್ ಆಗ್ಬೇಕು.
Fifth release.
ಆಯ್ತು, 5/11.
Obligation.
Counsel submission with regard to office objection, typed and legible copy of page number 102. ಯಾರು ಬರ್ಲಿಲ್ವಾ ಕೌನ್ಸಿಲ್? And also for maintainability is kept open ಅಂತಿದೆ. ಏನ್ ಸಬ್ಮಿಷನ್?
Right copy and legible copy of page number 3.
ಕೊಡಿ. ಏನಂತ ಕೊಟ್ಟಿದ್ದಾರೆ?
Pages are online copies and not required or relayed by the appellant.
The counsel submission is accepted that not going to rely upon the documents which have been objected and hence counsel submission is accepted. Post the matter for admission on ಅದು ಇದೆಯಲ್ಲ ಅದು kept open ಅಂತಿದೆ ನೋಡಿ 1411. Office objection raised on A number 3/24 for vacating stay. ಯಾರು ಹಾಕಿರೋದು vacating
I have
stay?
filed an application.
ಇದಿದೆ ನೋಡಿ office objection.
The office of respondent has already filed the wakalat. Separate wakalat by GPA holder is not necessary, your lordship.
It is not, there is an office objection and moreover, I have to file my objections also to the.
Objections ಹಾಕಿರಂತೆ first office objections ಏನ್ ನೋಡ್ರಿ ಮೇಡಮ್. GPA holder
ಹಾಕಿಲ್ಲ. ಇದು ತೋರಿಸಿದ್ದಾರೆ.
ವಕಾಲತ್ ಹಾಕಿದ ಇಲ್ಲ ಅವ್ರ ಪ್ರಕಾರ ಈಗ ಒರಿಜಿನಲ್ ರೆಸ್ಪಾಂಡೆಂಟೇ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ.
Wakalat is already there.
ಯಾರದು?
Padmavati, by Srimati Padmavati, in my favor, there is a wakalat, your lordship. Affidavit has been sworn by a GPA holder, her son, your lordship. So separate wakalat by son is not
GPA holder
necessary.
for R1 ವಕಾಲತ್ ಟು ಬಿ ಫೈಲ್ಡ್ ಅಂತಿದೆ. R1 ಗೀಗ ಒರಿಜಿನಲ್ ರೆಸ್ಪಾಂಡೆಂಟೇ ಫೈಲ್ ಮಾಡಿದಾರ ವಕಾಲತ್ತು.
Wakalat.
ಹೌದಾ?
IA is filed by GPA holder.
IA is filed by GPA holder.
Nothing wrong in that, your lordship.
Wakalat is not shown like that. That is the office objection.
ಮತ್ ಹಾಕ್ಬೇಕಲ್ಲ.
I will file it.
Maybe the GPA holder, original respondent number 1 has filed the wakalat.
Wakalat.
But GPA holder who had filed IA number 1 for vacating. ಅವ್ರಿಗೆ ವಕಾಲತ್ತೆ ಇಲ್ಲ, ಪವರ್ ಆಫ್ ಅಟಾರ್ನಿ ಇಲ್ಲ, ಮತ್ತೆ
Power of attorney is annexed, your lordship.
ಏನಿದೆ GPA holder for R1 ವಕಾಲತ್ ಟು ಬಿ ಫೈಲ್ಡ್ ಅಂತಿದೆ. ಪವರ್ ಆಫ್ ಅಟಾರ್ನಿ ಇದೆ, ವಕಾಲತ್ ಇಲ್ಲ. ಮತ್ತೆ ಹೆಂಗೆ ಅಫಿಡವಿಟ್ ಸ್ವೇರ್
I
ಮಾಡಿದ್ರು?
will file it, your lordship. I will not enter in.
ಏನ್ ಮಾಡ್ತೀರಿ ನೋಡಿ.
Now
counsel
steps.
counsel for respondent seeks time to file wakalat of GPA holder for R1 who had filed the application for vacating the stay. Illen non-compliance of office objection raised on PF to furnish foreign
Yes,
cover and acknowledgement to declaration form to issue notice to R4 ಅಂತಿದೆ.
in 2 weeks I'll file the Australia ಕಳ್ಸ್ಬೇಕಂತೆ. ಆಸ್ಟ್ರೇಲಿಯಾದು process fee ಎಷ್ಟು ಎತ್ತ ಅಂತ ತಿಳ್ಕೊಂಡು ಒಂದು steps ತಗೊಳಕ್ಕೆ ಒಂದು 2 weeks time. Process will be paid next week. Issue by 2 weeks ಅಂತ.
My humble submission is respondent 4 is respondent 3 is ex parte in the court below also, your lordship.
ಆಯ್ತು.
Her presence is
2 and
not.
3 ಆಲ್ರೆಡಿ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ ವಕಾಲತ್ ಯಾರು ಕೌನ್ಸಿಲ್ ಇದ್ದಾರೆ.
Yes.
ಆಲ್ರೆಡಿ ಇದ್ದಾರೆ. 4 ಮಾತ್ರ.
4 is, she is ex parte in the court below, your lordship.
ಎಕ್ಸ್ಪರ್ಟ್ ಏನ ನೋಡ್ರಿ. ಇಂಟ್ರಿ ಮಾಡ್ರಿ ಇದೆಯಾ ಇದ್ರಲ್ಲಿ?
Interim order is there of injunction.
ಎಕ್ಸ್ಪರ್ಟ್ ಇದ್ರೆ ಯು ಫೈಲ್ ಎ ಮೆಮೋ.
I'll verify because we are not, it's not the plaintiff.
The counsel for the respondent would submit that R4 was placed ex parte and no need to take any steps against R4. And hence counsel for the appellant would submit that he will go verify and file appropriate memo before the court. And hence list this matter on file level.
Maybe
Interim
taken
order
up
granted,
week
interim order
after.
granted earlier is extended.
Fifth bala matters iliste 7th or 8th.
ಆಯ್ತು 7/11.
Interim order maybe.
Interim order extended. Next.
Clarification.
ಯಾವ್ದ್ರಲ್ಲಿ?
Matter serial number 9, my lord.
ಹಾ.
The court fee may be directed to be transmitted to the court below, please, by the registry. I have made a full deposit.
ಕೋರ್ಟ್ ಫೀ ಕೊಟ್ಟಿದಾರ?
ಹೌದು, full ಕಟ್ಟಿದ್ದೀನಿ.
ಆಫೀಸ್ನವರು ಪರ್ಮಿಟೆಡ್ ಟು ಮಾಡಿದಾಗ ಏನ್ ಮಾಡ್ತಾರೆ? ಫೈಲ್ ಸೇಮ್ ಬಿಫೋರ್ ದಿ ಅಂತ. Registry is also directed to transmit the court fee to the concerned court. ಅಂದ್ರೆ ನೀವಿನ್ನ ಎಲ್ಲಿ ಬರುತ್ತೆ ಅಪೀಲ್ ಅನ್ನೋದೇ
And I'll
ಗೊತ್ತಿಲ್ಲ.
file a memo
ಹಾ.
before the registrar.
To the concerned court. If counsel for appellant files memo with details. ಯಾವ್ದ್ರಲ್ಲಿ? Absolute stay ಇದ್ರೆ extension ಏನ್ ಬೇಕಾಗಿಲ್ಲ.
But in this matter, appellant number 1 died, madam. He died on 8th August 24. Therefore, 1 week accommodation to file LR application.
Steps to be taken in respect of 23/9/94 order ಆಗಿರೋದು.
He died on 8th of August 24, madam. They have sent me copies.
ಆಯ್ತು. The appellant counsel again seeks time to bring the LRs of appellant number 1 on record.
1 week time.
And hence 1 week time granted as sought.
Interim order mechanism.
Interim order granted earlier is extended till next date of hearing.
Allotted date.
Well, date may be fixed.
Non taking hand summons by order dated 24/9/24.
Earlier matter,
Huh?
date may be fixed, earlier matter.
One week date ಕೊಡ್ಲಿಲ್ವಾ? 7/11.
Lordships, may kindly
Non taking
permit
hand
us to
summons.
serve-
Huh?
serve on the trial court advocate as well, madam.
Hand summons ಇದ್ರೆ hand summons ಯಾರಿಗೆ ಆರ್ಡರ್ ಮಾಡಿರೋದು ಮೇಡಮ್?
And summons, ಏನಾಗಿದೆ ಅಂದ್ರೆ problem one submission, my lord. In the trial court had also issued hand summons, my lord. And the appellant along with my colleague had gone to serve the respondent.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಬೇಡ ಇಲ್ಲಿದ್ ಹೇಳಿ.
ಅಲ್ಲಿ ಸರ್ವ್ ಮಾಡಕ್ ಹೋದಾಗ ಅವರು ಡೀಟೇಲ್.
ಅಲ್ಲಿದ್ ಬಿಡ್ರಿ ಇಲ್ಲಿದ್ ಹೇಳ್ರಿ ಇಲ್ಲಿ ಆರ್ಡರ್ ಮಾಡಿ ಇಲ್ಲಿ ಆರ್ಡರ್ ಮಾಡಿದಾಗ ಏನಾಯ್ತು ತಗೊಂಡೋದ್ರೆ?
ಮಾಡ್ಕೊಂಡ್ರು ಅದಕ್ಕೆ ಸಮನ್ಸು ರಿಸೀವ್ ಮಾಡ್ಕೊಳ್ತಾ ಇಲ್ಲ ಅವರು. So that is why I'm thinking.
ಇಲ್ಲಿರೋದ್ ನಾನ್ ಟೇಕಿಂಗ್ ಆಫ್ ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಮೇಡಮ್. ನೀವು ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ತಗೊಂಡೇ ಇಲ್ಲ.
Once, I'll take it, my lords, and even permit me to serve on the trial court advocate.
ಆಯ್ತು ಪಿ ಎಫ್ ಏನಿದೆ ಕೊಡ್ರಿ ನೋಡ್ರಿ ಏನಾಗಿದೆ. ಏನ್ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಏನಾದ್ರು ಇದೆಯಾ?
No, my lords.
ಇಲ್ಲ ಆಯ್ತು. ನೋಟಿಸ್ ಹೋಗಿದ್ದು ವಾಪಸ್ ಬಂದಿದೆ R125 ಫಾರ್ ಫಸ್ಟ್ ಟೈಮ್ ಅಂತ ಏನಾಯ್ತು? ಪಿ ಎಫ್ ಎ ಕೊಟ್ಟಿಲ್ವಾ?
No, my lord.
ಪಿ ಎಫ್ ಎ ಕೊಟ್ಟಿಲ್ಲ.
One submission,
ಹ್ಯಾಂಡ್
my
ಸಮನ್ಸ್ ತಗೊಂಡಿಲ್ಲ.
lord. One submission, my lord. ನಾವ್ ಸರ್ವ್ ಮಾಡಕ್ ಹೋದಾಗ ಅವರು ಡೀಟೇಲ್
ಹೇಗ್ರಿ ಮಾಡ್ತೀರಿ ಆರ್ಡರ್ ಇಲ್ದಲೇನೆ ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಆರ್ಡರ್ ಮಾಡಿದ್ರೆ ನೀವು ತಗೊಂಡೇ ಇಲ್ಲ.
lodge the complaint against them, my lords. The issue is going on, my lords.
You are not answering to my question, madam.
Collect it. my
This
lord.
court has passed an order, issue hand summons, you have not taken,
Collect
and
it.
also you have not paid the PF. No notice was issued.
I will
How can
collect-
they refuse it?
Today itself, I'll collect it, my lords, and kindly permit us to serve on the trial court advocate as well.
ಕೆಲವು ಕೇಸಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಡ್ವೊಕೇಟ್ ಸರ್ವ್ ಮಾಡಿದ್ರು ಅವ್ರು ತಗೊಂಡ್ರು ಬರೋದಿಲ್ಲ. ಆವಾಗ ಅದಕ್ಕೇನೆ ನೋಟಿಸ್ ಆರ್ಡರ್ ಮಾಡ್ತೇವೆ. ಈಗ ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿದೆ, ಯು ಪೇ PF.
I'll take.
ತೊಗೊಳ್ಳಿ. In spite of order to take hand summons and the same is not taken and counsel submits not going to take the hand summons forthwith. And also permitted to serve the copy of this appeal memo on the counsel who appear before the trial court. Apart from that, pay PF and if PF paid, issue notice to respond number 125. ಎಲ್ಲ ಮಾಡಿದೀನಿ ನೋಡಿ. Steps to be taken in respect of respondent since unserved cover returned as unclaimed for first time. ನೋಡಿ ಏನಾಗಿದೆ?
ಕ್ಲೇಮ್ಡ್ ಅಂತ ಬಂದಿದೆ.
ನಾಟ್ ಕ್ಲೈಮ್ಡ್ ಅಲ್ಲಿ ಇಂಟಿಮೇಷನ್ ಡೆಲಿವರಿ ಆಗಿದ್ರೆ ಆಗುತ್ತೆ, ಇದ್ದವ್ರಿಲ್ಲ. ನೋಡೋಣ.
He is aware of proceedings. And arbitration section 9.
ಡೋರ್ ಲಾಕ್ ಆದ್ರೆ ಇಂಟಿಮೇಷನ್ ಇಲ್ಲ, ನೋ ಪ್ರಾಪರ್ ಸರ್ವಿಸ್. ತಗೊಳ್ಳಿ. The counsel for the appellant is directed to take press steps against the respondent. If we have paid, issue notice. List this matter on 25/11. Maintainability of the appeal against the order passed before this court.
My lord, the suit property is valued at 15 lakhs, my lords, and the plaintiff share is been valued at 5,46,000, my lord. Therefore, it is not maintainable, my lord. So therefore, I may be permitted to withdraw. Yeah.
The counsel is permitted to withdraw in terms of the memo filed by the appellant. ಅಷ್ಟೇ. Vijay Kumar.
Appeal for the appellant.
Copy on the appeal memo on counsel who appears before the respondent before the trial court by order.
Third, and I filed a memo to that effect that I.
ಯಾರು ಬಂದಿದಾರಲ್ಲ ಹಾಕಿದೀರಾ? ಕೌನ್ಸಿಲ್ ಶ್ರೀ ರಮೇಶ್ ಚಂದ್ರ. ಕೌನ್ಸಿಲ್ ಶ್ರೀ ರಮೇಶ್ ಚಂದ್ರ submits that he has filed ವಕಾಲತ್ for respondents ಎಲ್ಲರಿಗೂನಾ? ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1 and 2. ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ? ಇಬ್ರೇ ಇರೋದಾ? 1 and 2. ಏನ್ ಇನ್ನೊಂದ್ ಏನ್ ಹೇಳಿದ್ರಿ?
6723 of 2020.
Arising out of the same order, another.
Same order.
Same order.
Both counsel submits that another MFA 6723 of 24 is also arising out of the same order. And hence registry is directed to put up the same and also show the name of the counsel Ramesh Chandra in lieu of filing of wakalat in the cause list. List this matter. ಯಾವಾಗ ಬೇಕು? List this matters on 12/11. 7th ಅಲ್ಲ ಸಿಕ್ಕಾಬಿಟ್ಟಿದ್ದಾರೆ. ಜಾಸ್ತಿ ಇದೆ 7th ಅಲ್ಲ. 7th 8th ಇರೋದೇ 4 ದಿವಸ, ಎಲ್ಲ ದಿವಸ ಇದೆ. ಕೊಡಿ ನೋಡೋಣ, ರೀಚ್ ಆಗ್ಲಿಲ್ಲ ಅಂತ ಮತ್ತೆ ಅವರ ಡೇಟ್ ತಗೊಂಡು ಹೋಗ್ತಾರೆ. 8/11.
So far as respondent
is to R2, R3, R4 and R5.
Lord, so far as R3 and 4 are concerned, they were set ex parte before the trial court. R2, my lords.
ಈಗ ಏನ್ ಮಾಡ್ತೀರಿ? ಮೆಮೋ ಹಾಕ್ತೀರಾ?
Memo ಹಾಕ್ತೀರಿ.
ಕೊಡಿ. The appellant counsel files memo to dispense the notice against ಯಾರು R3, 4,
R 2, 3 and 4.
2, 3 and 4 since they were placed ex parte
Three-
before the
my
trial
lords,
court.
3 and 4 was placed ex parte. R2 has not filed written statement.
And only a memo for parents.
Written statement ಹಾಕ್ಲಿ ಹಾಕ್ತಾವಲ್ಲಿ ಅದು ಪ್ರಶ್ನೆ ಬರಲ್ಲ. ಆಯ್ತು, only the 3 and 4 and dispensed against the notice against. ಅಲ್ಲ ಬಟ್ ಇದೇನು ಟೆಂಪರರಿ ಇಂಜಂಕ್ಷನ್ಸ್ ಅಲ್ವಾ? ಅವ್ರ ಮೇಲೆ ನೀವು ರಿಲೀಫ್ ಕೇಳಿದ್ರಾ ಇಲ್ಲ?
Idu suit itself was dismissed as saying no territorial jurisdiction.
ಹಾ,
Other mele
ಬಟ್ ಅವ್ರು ಅಪಿಯರ್ ಆಗಿದಾರಲ್ಲ, ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಲ್ಲ.
R2 and 5.
3 and 4 ಡಿಸ್ಪೆನ್ಸ್ಡ್ ಆಯ್ತು. What about
I'll take steps.
R2 and 5 ಗೆ
I'll take steps.
ತಗೊಳ್ಳಿ. The appellant counsel seeks 1 week time to take steps against R2 and R5 and if PF paid issue notice against R2 and R5. ಹೇಳ್ರಿ ನಿಮ್ದೇನು?
My lord, I have filed my objections to the IA number 2,
Hmm.
wherein an interim order was passed on the last date of hearing during my absence, my lord.
Hmm.
In my objections, I have highlighted certain substantial points
Hmm.
which warrant this interim order should not be extended, my lord.
Hmm.
My lord, may kindly permit me 5 minutes of audience, I would.
ನೀವು ಆಲ್ರೆಡಿ ಹಾಕಿದ್ರಲ್ಲ ಅಬ್ಜೆಕ್ಷನ್ಸ್.
ಹಾಕಿದ್ದೀನಿ, my lord, it should not be extended ಅಂತ, my lord.
ನಿಮ್ಮ ಅಬ್ಜೆನ್ಸ್ ಅಲ್ಲಿ ಆಗಿದೆ ಅಂತಂದ್ರೆ ವೆದರ್ ಯು ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ಕೇವಿಯಟ್.
My lord, I was on Probate.
ಮತ್ತೆ
On that day, there was some medical emergency, my lord. It is a fault on.
ಕೇವಿಯಟ್ ಇತ್ತು, ನೀವು ಇರ್ಲಿಲ್ಲ, ಹೌದಾ? ಏನು ಮಾಡಕ್ಕಲ್ಲ, ಬರ್ಲಿ.
My lord, once.
Interim order may be extended.
ಟೇಕ್ ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್ against R2 to R5.
R2 and R5.
Ah.
My lord, one.
Interim order may be extended.
Interim order granted earlier is extended till next date of hearing.
My lord, one small submission. My lord, the lower court has passed a reasoned order holding that.
Right, anyhow, this court already passed an order. This court has to consider your objections and pass an order. Presence of others also necessary.
My lord,
Ah.
I have been the only contestant.
Emergent
party, my
notice,
lord.
this matter on 15/11. One week time ಇಲ್ಲ ರೀ, PF ಇವತ್ತೇ ಕೊಡಿ.
Please.
Interim order ತಗೊಂಡಿದ್ದೀರಿ.
ಇವತ್ತೇ
You pay PF today itself.
My
Today
lord,
itself
can
I'll-
you- On the first week of November, my lord.
ಅವ್ರಿಗೆ ಸರ್ವ್ ಆಗ್ಬೇಕ್ರಿ ಅವರಿಗೆ ಅದರ್ R2 and R5 ಗೆ.
This application, this preliminary issue was contested only by me, my lord.
Hmm.
I am the only affected and aggrieved party who has been contesting this matter. my lord.
Oh, application was filed by you only.
I was the one who filed the application.
It was a
for treating it as a
Preliminary issue. Preliminary issue was framed.
Preliminary issue
Preliminary issue was framed by the honorable court.
in view of the contention raised by.
By him. By-
ಹೌದಾ?
ಹೌದು.
Then R2 and R5 ಯಾಕೆ necessary?
R
It is an intersay between the appellant and also the person who objected before the trial court. ಅಲ್ವಾ? ಬೇಕಾಗಿಲ್ಲ. ಆಯ್ತು ಮೇಡಮ್.
ಯಾಕಂದ್ರೆ R2 ಅಂತೂ ಅವ್ರು ಬಂದೇ ಇಲ್ಲ ಕೋರ್ಟಿಗೆ.
ಏನು? 2, 3, 4 ಕೊಟ್ಟಿಲ್ಲ ಮೇಡಮ್, ಓನ್ಲಿ 3 and 4 ಡಿಸ್ಪೆನ್ಸ್ ಮಾಡಿದೆ ಬಿಕಾಸ್ ದೇ ವರ್ ಪ್ಲೇಸ್ಡ್ ಎಕ್ಸ್ ಪಾರ್ಟಿ ಅಂತ. ಆಯ್ತಾ? ತಗೊಳ್ಳಿ, ತಲೆ ಕೆಡ್ಸ್ಕೊಬೇಡಿ, ಸುಮ್ನಿರಿ. The counsel for the respondent also submits that this MFA is arised out of the ground urged by the respondent that no territorial jurisdiction.
Please.
And hence R2 and R5 also not necessary since they have not raised any such objection. And having taken note of the submission of the respondent counsel, when the dispute is intersay between the appellant and also the respondent number 1, there is a force in the contention of the counsel for the respondent. And hence issuance of notice to R2 and R5 doesn't arise. The counsel for the respondent also submits that he has already filed a detailed objection statement and matter may be taken up and hence list this matter on 7/11.
Great.
Jurisdiction.
For admission ಅಂತ ಹಾಕಿ. Admission along with ಈ vacating ಹಾಕಿದೀರಾ?
Objections file ಮಾಡಿದ್ದೀನಿ ಸ್ವಾಮಿ.
Objections ಹೆಂಗ್ರಿ ಮಾಡ್ತೀರಾ? Already.
My lord, it is not an ex parte order for me to file under 39(4) to show that there is a change in circumstance.
ನಾನ್ ಕೇಳ್ತಾ ಇರೋದು ಈ court ಅಲ್ಲಿ already when order has been passed.
I'll file, my lord, I'll file.
To file application.
I'll file it.
Vacating.
Interim order may be extended.
Interim order granted earlier is extended till next date of hearing. ಹೇಳಿ. ಉಮಾಶಂಕರ್ ಹೇಳ್ರಿ ಏನು? Issue notice to R2, R3, R4,
I undertake to
R5 and
appear
R8.
One submission. I undertake to appear for respondent number 8, my lordship.
Respondent number
8.
8. Counsel Sri
Amshit Hegde HS, my lordship.
Amshit Hegde
HS.
undertakes to file wakalat for R8.
R8.
And if wakalat is filed, show the name of the counsel in the cause list. ಆಯ್ತಾ? What about others?
ಇದು ಎಲ್ರಿಗೂ ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಸರ್ವ್ ಮಾಡಿದೀವಿ. ಆಲ್ ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಹ್ಯಾಸ್ ಬೀನ್ ಸರ್ವ್ಡ್.
ಅವರಿಗೆ ಸರ್ವ್ ಆಗಿದೆಯಾ?
ಹೌದು.
ಅವರಿಗೆ ಸರ್ವಿಸ್ ಆದ್ರೆ ಮತ್ತೆ ಯಾಕೆ?
ಕೋರ್ಟ್ ಒಂದು ನೋಟಿಸ್ ಹೋಗ್ಲಿ ಅಂದ್ರಿ ಲಾಸ್ಟ್ ಟೈಮ್ ಬರ್ಲಿಲ್ಲ ಅವ್ರು.
ಸರಿ ರೀ, ನೀವು ಲಾಯರ್ ಹೆಸರು ಮಾಡಿದಿರಾ
ಪಾರ್ಟಿಗೆ
ಪಾರ್ಟಿಸ್ಗೆ ಮಾಡಿದ್ರೆ ಮತ್ತೆ ಹಾಕ್ಬೇಕು. ಹಾ ಇಲ್ಲ ಮೇಡಮ್, ಸ್ಟೆಪ್ಸ್ ಇರೋದು R2, R3, R5. ಈಗ ಯಾರು
ನಾವು R3, R4 and R5 represented by
R3 ಏನಂತ ಬಂದಿದೆ? ಔಟ್ ಆಫ್ ಸ್ಟೇಷನ್ ಅಂತ ಆಯ್ತು. ಹಾ ಬಟ್ ಅವ್ರೇನೋ ಅಕ್ಲಾನ್ಮೆಂಟ್ ಹಾಕಿದೀನಿ, ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಸರ್ವ್ ಮಾಡಿದೀವಿ ಅಂತಾರಲ್ಲ, ಎಲ್ಲಿದೆ ನೋಡಿ?
ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದೀವಿ.
ಕೊಟ್ಟಿದ್ದೀರಾ?
ಕೋರ್ಟಿಗೆ ಲಾಸ್ಟ್ ಟೈಮ್ ಆರ್ಡರ್ ಶೀಟ್ ಲಾಸ್ಟ್ ಟೈಮ್ ಕಳಿಸಿದ ಆರ್ಡರ್ ಶೀಟ್ ಲಾಸ್ಟ್ ಟೈಮ್ ಆರ್ಡರ್ ಶೀಟ್.
ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಸರ್ವ್ ಮಾಡಿದ್ಮೇಲೆ ಮತ್ತೇನ್ರಿ ಸಿಗ್ನೇಚರ್ಸ್ ಇದೆಯಾ?
ಇದೆ ಇದೆ
ಮತ್ತೆ
ಅದು ಕೊಟ್ಟಿದ್ದೀವಿ.
personally served as notice to respond number R1 to served as ordered by this court on 8/10/24 and council also submit that respond number 8 is also served through postal service. ಈಗ acknowledgement ಆಯ್ತು. The council submit that this court has permitted to take out notice and they have served the same personally on 8/10/24 and none appears before this court in spite of service and also submit that notice sent to respond number 8. ಮತ್ತೆ ಅದೇ reputation. This court has issued emergency notice. In spite of service of note, respondent did not choose to appear either in person. Hence, it is appropriate to stay any constructions by changing the nature of the scheduled property till the next date of hearing as sought. ಅಂತಿದೆ. ಮತ್ತೆ ಆರ್ಡರ್ ಇದೆ ಮಾಡಿದ್ವಿ, ಕನ್ಸ್ಟ್ರಕ್ಟ್ ಸ್ಟೇ ಮಾಡಿದೀವಿ.
ಅಲ್ಲ ನೋಟಿಸ್ ಅವ್ರಿಗೆ ಹೋಗ್ಬೇಕು ಅಂತ ಸೆಕೆಂಡ್ ಟೈಮ್ ಅಂತ ಬಂದಿದೆ. ಸೆಕೆಂಡ್ ಟೈಮ್
ನೋಟಿಸ್ ಅಂತ ಬಂದಿರೋದೇ ತಪ್ಪು. ಸರ್ವಿಸ್ ಆದ್ಮೇಲೆ ಮತ್ತೇನಿದೆ ತೊಗೊಳ್ಳಿ. The office has committed an error in posting the matter for furnishing the PF. Since the appellants have served the notice against all the respondents personally as ordered by this court and hence question of taking once again steps against other respondents doesn't arise. ಇಲ್ಲೇನೋ ಇಲ್ಲ ಸರ್ವಿಸ್ ಆಗಿದೆ, ಏನೋ ಮಾಡಿದ್ದೇನೋ ವಾಪಸ್ ಬಂದಿದೆ ಅಂತೇನೋ ನೀವೇನೋ ನೋಟ್ ಹಾಕಿರೋದು ಅದೇನದು?
ಕೋರ್ಟ್ ನೋಟಿಸ್
ಹೋಗಿತ್ತಾ?
ಕೋರ್ಟ್ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದೀವಿ. along with process court notice ಹೋಗಿದೆ.
ಆಯ್ತು ಅಷ್ಟೇ. ತೊಗೊಳ್ಳಿ. List this matter.
14
ಇಲ್ಲಿಂದ ಹೋಗಿರೋದು ಕೆಲವು ರಿಟರ್ನ್ ಬಂದಿದೆ. ಏನ್ ನೋ ನೀಡ್. List this matter on 14/11.
please. Entry matter
ಇದೆಯಾ? Entry matter granted earlier is extended till next date of hearing. Vijay Kumar K. Furnishing of PF correct address. Notice to R1 to R5.
In this matter. Hand summons issue ಆಗಿತ್ತು ಇದರಲ್ಲಿ, but the office I could not collect the hand summons in time.
Hand summons ಮಾಡಿಲ್ಲ.
And
ನೋಟಿಸ್ ಹೋಗಿದ್ದು ಇನ್ನು ಕೊಟ್ಟೆ ಅಲ್ವಾ ನೀವು?
notice was not ordered on the last date of occasion. Last hearing notice was
ಆರ್ಡರ್ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಹಿಂಗ್ PF ಅಂತ ಹೆಂಗ್ ಕೊಡ್ತಾರ್ರಿ?
the first time ಅಂತ ತೋರಿಸಿದ್ದಾರೆ. On the last date of hearing it was ordered.
ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿಲ್ವಾ? only hand summons ಆಗಿತ್ತಾ?
ಆರ್ಡರ್ ಆಗಿತ್ತು.
ನೀವು ತಗೊಂಡಿಲ್ಲ. In spite of
one submission man.
Order to take hand summons not taken.
Inadvertently file could not reach the pending branch in time. Though the case was listed on 1/10/2024, file has reached the pending on 26/10 and the hand summons was signed on 28/10. For that reason I could not collect in time.
Hand summons
Hand summons was could not by.
ಆಯ್ತು, ಈಗ ಏನ್ ಬೇಕು? ರೀಇಶ್ಯೂ ಮಾಡ್ಬೇಕಾ? Council's request for reissue of hand summons and also directed to pay PF. If PF paid, issue notice against the R1 to 5.
Interim order mechanism.
Interim order granted earlier is extended till next date of hearing. List this matter on 22/11. Immediate ಕೊಡಿ PF. Mediation report stating this matter is not settled.
So I pay for the respondent.
Applicant filed by advocate for R1 and proposed R2.
appellant melod ಇದು ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ಸುಮ್ಮನೆ. Application
Explaining application copy ಕೊಟ್ಟಿಲ್ವಾ?
Served my lords, I'll give another copy. I had served it.
Monday
ಸರ್ವ್ ಮಾಡಿದಿರಿ?
My lords, what has happened is, my lords, the respondent is the only plaintiff, my lords. He is dead. The suit schedule property, my lords, is bequeathed, my lords, in favor of the impleading applicant under a registered will.
ಆಯ್ತ್ರಿ, ಕಾಪಿ ಕೊಡ್ರಿ ಅವರಿಗೆ.
ಕೊಟ್ಟಿದ್ದೀನಿ ಸ್ವಾಮಿ, ಕೊಡ್ತೀನಿ ಸ್ವಾಮಿ, ಇನ್ನೊಂದು ಕಾಪಿ.
ನೋಡ್ಬಿಟ್ಟು ಮಂಡೆ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ, ನೋಡ್ಬಿಟ್ಟು ಸುಮ್ಮನೆ ಮಂಡ್ಯಾಗೆ ಹಾಕೊಂಡ್ರೆ.
ನೋಡ್ರಿ ಹೋಗ್ಲಿ, ಏನಲ್ಲಿ ಸರ್ವ್ ಆಗಿದೆ ನೋಡ್ರಿ, ಕಾಪಿ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಇದೆಯಾ ನೋಡಿ ಹೋಗ್ಲಿ. ಒಬ್ರು ಕೊಟ್ಟಿದ್ದೀನಿ, ಇನ್ನೊಬ್ರು ಕೊಟ್ಟಿಲ್ಲ. ಸೈನ್ ತಗೊಂಡಿದ್ದೀರಲ್ರಿ ಇಲ್ಲಿ? ಸಾಗರ್ ಬಿಬಿ ಮೊದ್ಲಿದ್ದಾರೆ ಯಾರು ನಕಲು ಬಂದಿದೆ ಏನೋ RA ಅಡ್ವೊಕೇಟ್ ಫಾರ್ ಅಪಲೆಂಟ್ 27/2/24 ಕಾಪಿ ಸರ್ವ್ ಆಗಿದೆ ಅಲ್ರಿ ಯಾರಿಗೆ
Same date is filed.
ಮೊದ್ಲು ನರಸಿಂಹಮೂರ್ತಿ ಇದ್ರಾ ನೀವೀಗ ಒಕ್ಕಲತ್ ಹಾಕಿರಾರ
ನಾವೇ ಅಪಲೆಂಟ್ಸ್
RP ಸೋಮಶೇಖರ್
ನಮ್ಮ
NOC
senior.
ನಾಟ್ ಒಬ್ಟೈನ್ಡ್ ಅಂತಿದೆ
RP ಸೋಮಶೇಖರ್ ನಮ್ಮ ಸೀನಿಯರ್ ಇದ್ ಮಾಡಿ
ನೀವ್ ಯಾರ ಆಫೀಸ್ ಹೇಳಿ ಫಸ್ಟ್
RP ಸೋಮಶೇಖರ್ ಜೂನಿಯರ್.
ಬಟ್ ನಿಮಗೆ NOC ತಗೊಂಡೇ ಇಲ್ವಲ್ಲ ನಿಮ್ಗೆ ಹೆಂಗ್ ಸರ್ವ್ ಮಾಡ್ತಾರ ಅಲ್ಲಿ ಆಲ್ರೆಡಿ ಮೊದ್ಲಿದ್ದವ್ರಿಗೆ ಅವ್ರು ಸರ್ವ್ ಮಾಡವ್ರೆ ತಗೊಳ್ಳಿ ಅಪ್ಲೆಂಟ್ ಕೌನ್ಸಿಲ್ ಇಸ್ ಡೈರೆಕ್ಟೆಡ್ ಟು ಟೇಕ್ NOC from the earlier advocate
ಪಾಸ್ ಓವರ್ಸ್ ಯಾಕಂದ್ರೆ ಸೀನಿಯರ್
ಏನ್ ಮಾಡ್ತೀರಿ
ನೋಡ್ಬಿಟ್ಟು ಇದು ಮಾಡಿ ಪಾಸ್ ಓವರ್ಸ್
ಏನ್ ಮಾಡ್ತೀರಿ ನೋಡ್ರಿ ಪಾಸ್ ಅವರು
ಅದೇ
ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ NOC ತಗೊಳ್ಳಿ ಹಾಕಿ ಮುಂದಿನ ಸರಿ ಏರ್ ಮಾಡೋಣ ಅಷ್ಟೇ ಕಾಪಿ ನೀವ್ NOC ತಗೊಳ್ಬೇಕಾದ್ರೆ ಅರ್ಲಿಯರ್ ಅಡ್ವೊಕೇಟ್ ಕಡೆಯಿಂದ ಬ್ರೀಫ್ ಏನೇನಿದೆ ತರ್ಸ್ಕೋಬೇಕಲ್ಲ ಕಾಪಿ ವಾಸ್ ಆಲ್ರೆಡಿ ಸರ್ವ್ಡ್ ಆನ್ ಹಿಮ್
ನೋಡಿ ಇಂಟಿಮೇಷನ್ ಪಾಸ್ ಓವರ್ಸ್ ಸೀನಿಯರ್.
ಆಯ್ತು ಪಾಸ್ ಓವರ್ ನೀವೇನಿರೋ ಅವಶ್ಯಕತೆ ಇಲ್ಲ ಅದೇನ್ ಮಾಡ್ತಾರೆ ಮಾಡ್ಲಿ TN ವಿಶ್ವನಾಥ್ and TN ರಮೇಶ್ non filing of acknowledgement for having served the notice to R1A.
The Lordship,
And
I
C.
appear for R1A to C. We were appearing for R1A to C. The respondent number 1B has taken back all the
A and
records.
C.
A to C we were appearing for. R1B has taken back all the records along with NOC. On behalf of R1A and C also, we had filed the memo for retirement.
ಯಾವಾಗ ಹಾಕಿದಿರಿ
5/1/24 ಗೆ we had filed memo for retirement.
5/1/24 ತೋರ್ಸೇ ಇಲ್ಲ
Alla, what has happened is the court accepted it only for R1B, but he has taken back all the records, all of them, they are family members, your lordship.
ಅಕ್ಸೆಪ್ಟೆಡ್ ಅಂದ್ರೆ ಮೋಸ್ಟ್ಲಿ ಅಕ್ನಾಲ್ಮೆಂಟ್ ಒಬ್ರಿಗೆ ಇತ್ತು
Illa, he has signed it. He has only signed it.
ಯಾರು
R1B has signed the memo for retirement.
ಹೌದು ಅವ್ರೊಬ್ರಿಗೆ ನೀವು ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ರಿ ಅಂತ ಕೋರ್ಟ್ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡಿರ್ತಾರೆ
Our mother and
ಆನ್
sister.
ಬಿಹಾಫ್ ಆಫ್ 1 and C ಆಲ್ಸೋ ಟೇಕನ್ ದಿ ಬ್ರೀಫ್ ಅಂತ ಏನೋ ಬರ್ದವ್ರ ಅದ್ರಲ್ಲೇ ಅಕ್ನಾಲ್ಮೆಂಟ್ ಅಲ್ಲಿ ನೋಡೋಣ
That was not written, your lordship. But
The above
it's his
appeal
mother.
signed was appearing for the respondent number 1A to C.
Yes, sir.
Respondent number 1B has taken back all the records along with NOC. He has also signed this memo acknowledging the receipt of the records along with the no objection from the undersigned counsel. Hence, the undersigned counsel be permitted to retire from the above case in the interest of justice and equity.
He has signed the memo. If I'm right there,
No,
the
no
mother and
objection
sister.
from the undersigned counsel antide.
Yes,
Huh.
sir. We were appearing for all the three. It's his mother and sister, irodu R1A.
ಆಯ್ತು ಈಗ ಯಾರು
and C.
ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡ್ತಾ ಇಲ್ವಾ?
Illa.
Court already passed an order only accepting in respect of R1B ಅಷ್ಟೇ.
We don't have their details. All the records have been taken from us.
ನೀವು ಬರಿಬೇಕಾ?
His mother and
ನೀವ್ ಆಗ ಬರಿಬೇಕು ಮೇಡಮ್. He has taken the
on behalf of.
on behalf of other appellant number appellant respondent number 1A and C also ಅಂತ ಬರಿಬೇಕಿತ್ತು ನೀವು.
Actually, it's his mother and
ಹೋಗ್ಲಿ ನಿಮ್ಮ
sister.
ಅಸೈನ್ಮೆಂಟ್ ಎಲ್ಲಿದೆ ತೋರಿಸಿ ಅದ್ರಲ್ಲಿ ಏನಾರು ಇದೆಯಾ?
Illa, he has signed this memo.
ಪಾರ್ಟಿ ಸೈನ್ ಮಾಡಿರೋದು ಅಷ್ಟೇನಾ?
It's signed. He has signed the memo. for
1B
it.
only had signed. Received all the records along with no objection ಅಂತ ಇದೆ ಅಷ್ಟೇ.
It's his mother and sister only, your
ಏನ್
lordship.
ಮಾಡೋಣ ನಾವು ಪ್ರಿಸೂಮ್ ಮಾಡಕ್ಕಲ್ವಲ್ಲ ನಾಳೆ ಬಂದು ಇಲ್ಲ ಅಂದ್ರೆ ನೀವು ಅವಾಗಲೇ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡೋಗ್ಲೇ ಕೋರ್ಟ್ಗೆ ಹೇಳ್ಬೇಕಿತ್ತು.
I had made that mention. We didn't have the
ಈಗ
papers.
ಅಕ್ಸೆಪ್ಟ್ ಆಗಿರೋದು
with us.
ಓನ್ಲಿ ಫಾರ್ 1B ಅಷ್ಟೇ.
We
ಹೇಳ್ರಿ ಏನು ಈಗೇನ ನಿಮ್ದೇನ್ರಿ ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ಅಕ್ಲೈನ್ಮೆಂಟ್ R1A C ಅಕ್ಲೈನ್ಮೆಂಟ್ ಹಾಕಿಲ್ಲ ಅಂತ.
Let's see the order dated 16.
Memo treating A1 B to E as LRs of deceased A1A ನಾ ತೊಗೊಳ್ಳಿ
Let's the order dated 16/11/23.
16/11/20 ಏನಾಗಿದೆ?
R1A is still alive ಅಂತ you are required to verify.
Your lord-
16/11/23 ಏನಾಗಿದೆ?
The submission is made that R1A is still alive.
R1A still alive.
ಹಾಕಿದ್ದಾರೆ. They were required to get instructions whether R1A.
Learned counsel for the respondent submits that R1A is alive ಅಂತಲ್ರಿ. ಬದುಕಿದ್ದಂಗೆ ಹೆಂಗ್ರಿ ಬೇರೆಯವ್ರನ್ನ ಎಲ್ಲಾರು ಸುದ್ದಿ ಮಾಡ್ತೀರಿ?
Further instruction.
ಹಾ?
We place it on it.
ಲಾಸ್ಟ್ ಟೈಮ್ ತಗೊಂಡಿದ್ರಲ್ಲ ಅಪಲೆಂಟ್ ಟು ಮೇಕ್ ನೆಸೆಸರಿ ಸಬ್ಮಿಷನ್ ಇನ್ ದಿಸ್ ರಿಗಾರ್ಡ್ ಅಂತ 16/11/23 ಒಂದ್ ವರ್ಷ ಆಯ್ತು.
Senior at the inspection.
The counsel appearing for the respondent, ನೀವ್ ಯಾರಿಗೆ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್
R2.
R2 brought to notice of this court that R1A is alive. And the same is also brought to the notice of this court on 16/11/23, and in spite of direction is given to make necessary submission in this regard. Till date not verified. However, 1 week time granted to make submission with regard to the A1A is alive. List this matter, one vara bitkodi. 8/11.
Colleague uploads, it has been, paper book has been filed and paper book is ready.
ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ಪೇಪರ್ ಬುಕ್ ಹೇಳಿ ಏನಾಯ್ತು?
Paper book ready ಇದೆ. ನಮ್ಮ
ಹಾ.
colleague it has been filed ಅಂತ ಹೇಳ್ತಾರೆ. But there is no manner endorsement has been.
ಫೈಲ್ಡ್ ಅಂತ ಇಲ್ವಲ್ಲ, ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ಪೇಪರ್ ಬುಕ್ ಅಂತಿದೆ.
I will verify in the office itself within 10 days. If it is not been filed, manner within 10 days, I will file manner. Everything.
ಅಲ್ಲರಿ 4/2/15,
ಇಲ್ಲ, ಇಲ್ಲ.
10/11/16, 26/11/21.
Filed ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ, ಅದಕ್ಕೋಸ್ಕರ that is.
ಎಲ್ ಫೈಲ್ಡ್ ಅಂತಿದೆ?
ಅಲ್ಲ, ಅವರು ಕೊಟ್ಟಿದ್ದೀನಿ ಆಫೀಸ್ ನೊಳಗೆ ಅಂತ ಹೇಳ್ತಾರೆ. I will verify.
ಕೊಟ್ಟಿರೋ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಇರುತ್ತಲ್ಲ, ಶೋ ಮಿ ದಿ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್.
ತಗೊಂಡಿಲ್ಲ ಅದಕ್ಕೋಸ್ಕರ.
ತೊಗೊಳ್ಳಿ.
OC ಒಳಗೂ ಇಲ್ಲ.
In spite of order was passed on 4/2/15, 10/11/16 and 26/11/21 paper book is not filed. And again council 6 time, and hence on further on cost of rupees 1,000, another 2 weeks time granted. This matter up to 2 weeks bit kodi.
ಕಾಸ್ಟ್ ಕಟ್ಟಬಹುದು. ಕಾಸ್ಟ್ ಎಷ್ಟು ಬೇಕು?
15 cost payable at registry. Date 13/11.
Pay for appellant number 4.
Memo for retirement
Oh.
filed by advocate for proposed R9.
Yes, my lord, filed a return.
IA is already rejected.
Hmm?
IA impleading application is rejected. IA 1 of 17 is rejected on 4/12/23.
Rejected ಆದ್ಮೇಲೆ ಮತ್ತೇನ್ ರಿಟೈರ್ಮೆಂಟ್ ಬರ್ತ್ರಿ? ಅದು ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್?
Yes, my lord.
ಅದು ರಿಜೆಕ್ಷನ್ ಆದ್ಮೇಲೆ ಮತ್ತೇನು ರಿಟೈರ್ಮೆಂಟ್ ಬರುತ್ತೆ? ನಿಮ್ ವಕಾಲತ್ ಗೋಸ್ ವಿತ್ ದಿ ಅಪ್ಲಿಕೇಶನ್. ಒಂದೆಷ್ಟು ಏನಕ್ಕೆ ಪೋಸ್ಟ್ ಮಾಡಿದಾರೆ ಮೇಡಮ್ ಇದು? ಈಗ ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರು ಅಲಾಂಗ್ ವಿತ್ ವಕಾಲತ್ತು. ವೆರಿ ಅಪ್ಲಿಕೇಶನ್ ಇಟ್ ಸೆಲ್ಫ್ ಇಸ್ ರಿಜೆಕ್ಟೆಡ್. ಈ ಕೋರ್ಟ್ನವ್ರಿಗೆ ಏನ್ ಮಾಡಕ್ ಕೆಲಸ ಇಲ್ವ? ಕೆಳಗಡೆ ಕೂತ್ಕೊಂಡು 4 ಸರಿ ಕಾಫಿಗೆ ಹೋಗಿ ಬರೋದು, ಆಮೇಲೆ ಮತ್ತೆ ಈ ತರದ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕೋದು. ನಮ್ಗೇನ್ ಕೋರ್ಟಲ್ ಕೆಲಸ ಇಲ್ಲ ಜಡ್ಜ್ಗೆ ಅಂತನ? ಯಾಕೆ ಬರ್ತದ್ರಿ ಇದು? ದಿ ಅಪ್ಲಿಕೇಶನ್ ಇಟ್ ಸೆಲ್ಫ್ ಇಸ್ ರಿಜೆಕ್ಟೆಡ್ ಅಂಡ್ ಕ್ವಶನ್ ಆಫ್ ರಿಟೈರ್ಮೆಂಟ್ ಡಸಂಟ್ ಅರೈಸ್. ಕಾಮನ್ ಸೆನ್ಸ್.
Our name may be deleted. Our name may be deleted in the councils.
The registry is directed to delete the name of the council. ಏನು ರಕ್ಷಿತನಾ?
Rakshita.
Rakshita DJ. In view of rejection of application for impleading. 33. Memo for reporting death of R12.
Well as died.
Filed by advocate for R12.
I am appearing for the appellant, my lord. 16/4/24, my lord, R12 is reported to be dead.
16/4/24
was the death of.
ರಿಪೋರ್ಟ್ ಆಗಿದೆ.
ಅವ್ರು ಹಾಕಿದ್ದಾರೆ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಡ್ವೊಕೇಟ್.
ನೀವ್ ಯಾಕೆ ಸ್ಟೆಪ್ಸ್ ತಗೊಳ್ಳಿಲ್ಲ ಇಲ್ಲಿವರೆಗೂ?
ಬರ್ದಿದ್ದೀನಿ.
ಅಬೇಟ್ ಆಯ್ತಲ್ಲ ಹಾಗಾರೆ?
ಹೌದು.
ತಗೊಳ್ಳಿ. In spite of death was reported
On 27/5.
on 27/5/24 that R12 passed away on 16/4/24. Till date steps are not taken and hence appeal against R12 is abated.
Please.
34. Raghavendra V. Compliance of office objection raised on IA 1 of 24 for the calling the and recalling the order. ಏನಾದ್ರು objections? ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದಿರಿ, ಹೋಗಿ ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ರಿ. ಎಷ್ಟೇ ಸರಿ ಬಂದಿದೆ ನೋಡಿ ಮೇಡಮ್. ಕೋರ್ಟಲ್ ಮೆಮೋ ಮೂವ್ ಮಾಡಿರೋದಾರ ನೀವೇನಾ?
ನಾವೇ ಮಾಡಿ.
ಕಂಪ್ಲೇಂಟ್ಸ್ ಮಾಡ್ದಲ್ಲ ಯಾಕೆ ಮೂವ್ ಮಾಡಿದಿರಿ? ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ದಲ್ಲ ವೈ ಯು ಹ್ಯಾವ್ ಮೂವ್ಡ್ ದಿ ಮ್ಯಾಟರ್ ಬಿಫೋರ್ ದಿ ಕೋರ್ಟ್? ವಕಾಲತ್ತೆ ಹಾಕಿಲ್ಲಂತೆ?
ಇಲ್ಲ ಸರ್, ಸರ್ವ್ ಆಗಿರ್ಲಿಲ್ಲ ಯಾರು.
ತಗೊಳ್ಳಿ. In spite of office has raised the objections on IA 1 of 24. Office objections are not complied. Even on both IA number 1 of 24 and 2 of 24, however, filed the memo before the court. And hence on cost of rupees 500, 2 weeks time granted to comply with office objections on IA 1 of 24 and 2 of 24. List this matter on 1511. Cost payable at registry. ಬೆಳಗ್ಗೆ ಎದ್ದು ಬಂದ್ಬಿಟ್ಟು ಮೆಮೊ ಕೊಟ್ಬಿಡೋದು ಕೋರ್ಟ್ ಮುಂದೆ. Next hearing, interlocutory application. 1 hour ಬರೀ ಇದೆ ಕೆಲಸ.
Delay in filing of the LR's application, my lord, these 47 days. Respondent.
Notice ಹೋಗಿದೆಯಾ?
ಇಲ್ಲ ಸರ್, ಹೋಗಿಲ್ಲ ಸರ್. First
To notice on A number 1 of 24, 2 of 24, 3 of 24 against the LRs of R5. That is R5 A to E. Correct?
ಹೌದು ಸರ್.
Connected all same common order. ಮತ್ತೆ ನಾನ್ ಕಂಪ್ಲೇಂಟ್ಸ್ ಏನೋ ಅದ್ರಲ್ಲಿ ಇದೆಯಲ್ರಿ? R5 ಈಗ R5 ತಿರ್ಕೊಂಡಿದಾರಲ್ಲ ಇವ್ರು ಎಲ್ಲ ನೀವು ತರ್ತಾ ಇರೋದು R5 ಗೆ ಅಲ್ವಾ? ಮತ್ತೆ ಅವರೇ ತಿರ್ಕೊಂಡಾರಲ್ಲ, ಮತ್ತೇನು ಒಕ್ಕಲತ್ತು. ಆಯ್ತು, ನೆಕ್ಸ್ಟ್. Furnishing of PF copies to issue notice to R2 for third time ಅಂತ ನೋಡ್ರಿ.
IA number 1 of 2023 is 2 minutes, my lord. The respondent number 3 and 4 had mortgaged the property by way of registered mortgage by availing a loan of 7.8 crores from the appellant bank. Subsequent to default, the appellant has initiated surface proceedings and obtained orders under section 14 of the Surface Act. At the time of taking possession of the property, initially they filed a suit before the Supreme Court, which came to be rejected. Subsequently, another collegiate suit came to be filed in May all. That also came to be rejected. Now, for the third time, the respondent number 1 and 2 claiming being the plaintiffs filed a suit. Your lordships may kindly see one document, my lord, based on an unregistered mortgage by conditional sale. Page number 1. Stated to claiming that
ಈ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಏನು ಎಂಟ್ರಿ ಮಾಡ್ರು ಕೊಟ್ಟಿದಾರಾ?
order not to interfere well as not to auction the property. There is outstanding balance of around 12 crores payable to
ಇದೇ
the.
ಸರಿ ರೀ, ನೀವು ನೋಟಿಸ್ ಯಾಕೆ ಜಾರಿ ಮಾಡ್ತಾ ಇಲ್ಲ?
ಅಲ್ಲ, the plaintiff address in the cost title as well as we have taken.
ಆಯ್ತು, ಇಲ್ಲ ಸಬ್ಸ್ಟಿಟ್ಯೂಟೆಡ್ ಸರ್ವಿಸ್ ತಗೊಳ್ಳಿ.
And
ಸರ್ವಿಸ್ ಕಂಪ್ಲೀಟ್ ಆಗ್ಲಿ, we can consider this MFA.
I will make necessary application.
ಮತ್ತೆ
Yeah,
already there was an order to issue notice.
There is an interim order by this honorable court.
ಇದ್ರಲ್ಲಿ R2 and R3 necessary partyನಾ ಹೌದಾ ಅಲ್ವಾ?
R1 and R2 are necessary.
R1 and 2 are necessary party.
R1 is duly served.
R2 ಗೆ ಸರ್ವಿಸ್ ಆಗಿಲ್ಲ
R2
ಅಲ್ಲ?
is the plaintiff number 2 before the trial court. He is intentionally awaiting the service of notice.
ನೀವು ಸರ್ವಿಸ್ ಮಾಡಿಸ್ಬೇಕು ಅಷ್ಟೇ.
I will take substituted service. Fine, necessary.
2 ಸರಿ ಹೋಗಿ ಬಂದಿದೆ ಮೇಡಮ್, 2 ಸರಿ ಏನಂತ ಬಂದಿದೆ ನೋಡಿ ಎಂಡಾರ್ಸ್ಮೆಂಟ್.
The cost title, that is the last known address.
ನೋ ಸಚ್ ಪರ್ಸನ್ ಇನ್ ದಿ ಅಡ್ರೆಸ್ ಅಂತ ನೀವು ಅಸರ್ಟೈನ್ ಮಾಡಿ ಎಲ್ಲಿದ್ದಾನೆ ಅನ್ನೋದ್ರ ಹುಡುಕಿ ಅಡ್ರೆಸ್ ತಗೋಬೇಕು.
Cost title is the address.
ಕಾಸ್ಟ್ ಟೈಟಲ್ ಪ್ಲೇಂಟ್ ಹಾಕುವಾಗ ಇರ್ತಾನ್ರಿ, ಈಗ ಇರಲ್ಲ. ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ? ಸರ್ವಿಸ್ ಹೆಂಗ್ ಮಾಡೋದು? ಆಸ್ ಆನ್ ದ ಡೇಟ್ ಆಫ್ ಫೈಲಿಂಗ್ ಆಫ್ ದ ಸೂಟ್ ಹಿ ವಾಸ್ ಪ್ರೆಸೆಂಟ್ ಅಲ್ವಾ? ಬಟ್ ಅಟ್ ದ ಟೈಮ್ ಆಫ್ ಸರ್ವಿಸ್ ವೆನ್ ದಿ ಕೋರ್ಟ್ ವಾಸ್ ಇಶ್ಯೂಡ್ ದಿ ನೋಟಿಸ್ ಹಿ ವಾಸ್ ನಾಟ್ ದೇರ್. ದೆನ್ ಯು ಹ್ಯಾವ್ ಟು ಅಸರ್ಟೈನ್ ದಿ ಕರೆಕ್ಟ್ ಅಡ್ರೆಸ್. ಏನ್ ಬ್ಯಾಂಕ್ ನೀವು? ಬ್ಯಾಂಕ್ನವ್ರು ವೆರಿಫೈ ಮಾಡ್ಬೇಕು ಅದನ್ನ. ಲೋನ್ ಕೊಡಕ್ಕೆಲ್ಲ ಯಾವ
they are not borrowers. Respondent number 1 and 2 claiming that 3 and 4 are the borrowers, my lord.
3 and 4 are the borrowers.
ಅವರು mortgage ಮಾಡಿದ್ದಾರೆ ಅಂದ್ಬಿಟ್ಟು ಒಂದು unregistered document ಮೇಲೆ 17.5 crores loan ಕೊಟ್ಟಿದೀವಿ ಅಂತ now the court has granted the interim order. The lordships may kindly see that document. Mode of payment ಎಲ್ಲೂ ಹೇಳಿಲ್ಲ. 17.5 crores ಹೆಂಗ್ ಪೇಮೆಂಟ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ. Unregistered conditional mortgage come conditional sale ಅಂದ್ಬಿಟ್ಟು ಒಂದು ಡಾಕ್ಯುಮೆಂಟ್
ಸರ್ವಿಸ್ ಮಾಡ್ರಿ, ವಿಲ್ ಕನ್ಸಿಡರ್ ಇಟ್ ಆನ್ ಮೆರಿಟ್ಸ್. The appellant counsel is directed to furnish the correct address, ascertaining the same within 1 week, and if PF and correct address furnished, issue notice against R2.
ಆರ್ಡರ್ ಕಾಪಿ
R2
ನಮ್ಗೊಂದು ಆರ್ಡರ್ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿಲ್ಲ.
ನಿಮ್ಗೆ ನೀವು ಪಾರ್ಟಿ ಇದೀರ ಇದ್ರಲ್ಲಿ?
ಮಾಡಿದ್ವಿ ಸರ್. 6 to 10
ಎಲ್ಲ ಪೊಲೀಸ್ ಅವ್ರನ್ನೆಲ್ಲ ಪಾರ್ಟಿ ಮಾಡಿದ್ವಿ. ಪೊಲೀಸ್
ಅವ್ರು ಮಾಡಿರೋದ?
ಅವ್ರ ತಹಸೀಲ್ದಾರ್ ಪೊಲೀಸ್ ಸುಮ್ನೆ ಇದು ಮಾಡಕ್ಕೆ. This is the third round of litigation. And they have found a way to get the interim order.
ಆಯ್ತು, ಒಂದು ಕಾಪಿ ಕೊಟ್ಬಿಡಿ ಅವರಿಗೆ.
ಕೊಡ್ತೀನಿ.
ನೀವು ತಗೊಂಡಿದ್ದೀರಾ ನೋಟಿಸ್?
Necessary parties.
ಆಗಿಲ್ವಾ? AG is directed to take notice for R7 to
10.
Not even necessary parties.
6 also, na?
6 to 10.
6 to 10.
Please.
Appellant counsel is directed to serve the copy of this appeal memo on the AGA.
Obliged.
ಇವ್ರಿಗೆಲ್ಲ ನೋಟಿಸ್ ಸರ್ವ್ ಆಗಿದೆ.
Appearing for appellant.
For the Act 2, respond number 2.
PD of 8 days, heard the appellant counsel and also the counsel appearing for the respondent on IA 4 of 23, and there is a delay of 8 days in filing the appeal. And for reasons stated in the accompanying application of affidavit, delay of 8 days is condoned. Next, an appointment of guardian.
Guardian.
ಯಾರಿಗೆ?
Respondent number 4 minor. 4 and 5 minor.
4 and 5 are minors.
Yes, minor.
ಯಾರನ್ನ ಅಪಾಯಿಂಟ್ ಮಾಡ್ಬೇಕು ಗಾರ್ಡಿಯನ್ ಆಗಿ?
For mother minor.
ಮದರ್ ಯಾರು?
Geeta V, respondent number 4, Geeta V, minor, mother. And respondent number 5, Ranjita V.
ಅಂದ್ರೆ 5 is the minor, 4 is the mother. ಹೌದಾ?
4 and 5 is the minor, minor.
4 and 5 are the minors.
Yes, minor. 2
Mother,
is the,
mother ನ ಗಾರ್ಡಿಯನ್ ಆಗಿ ಅಪಾಯಿಂಟ್ ಮಾಡ್ಬೇಕು. ಮದರ್ ನೀಗ ಪಾರ್ಟಿ ಇದಾರೆ ಆಲ್ರೆಡಿ.
our father ಇದ್ದಾರೆ minor, party.
ಫಾದರ್ ಇದ್ರೆ ಫಾದರ್ ನೇ ಮಾಡಿ. ಮತ್ತಕ್ ಮದರ್ ಕೇಳ್ತೀರಿ? ವೆದರ್ ದೇ ಆರ್ ಸ್ಟೇಯಿಂಗ್ ಅಲಾಂಗ್ ವಿತ್ ಮದರ್ ಆರ್ ಫಾದರ್ ಒಟ್ಟಿಗೆ ಇದಾರ ಇಲ್ಲ?
ಜೊತೆಗೆ.
ಹಾ?
ಜೊತೆಗೆ.
ಜೊತೆಗೆ ಇದಾರೆ. ಮತ್ ಫಾದರ್ ಆಲ್ರೆಡಿ ಪಾರ್ಟಿ ಅವ್ರನ್ನೇ ಗಾರ್ಡಿಯನ್ ಮಾಡ್ಬೋದಲ್ಲ, ಇನ್ನೊಬ್ರು ಯಾಕೆ ಮದರ್ನ ಪಾರ್ಟಿ ಮಾಡ್ತಿದ್ದೀರಿ ಅಂತ ಕೇಳಿದೆ. ಇದಾರ ಏನು? ಅದೇ ಒಬ್ರು ಇದಾರಲ್ಲ ಫಾದರ್. ಹಾ, ಇಬ್ರಿದ್ದಾರೆ ಅಂದ್ರೆ 4 and 5 are, ಹಾ, ಅವ್ರಿ 2 and 3 are the father of respective minors. ಹಾ, ಯಾಕೆ ಮದರ್ ಕೇಳಿದಿರಿ? ಏನ್ರಿ ನಿಮ್ದೇನ್ ತಕರಾರು ಇದೆಯಾ?
ಏನ್ ತಕರಾರಿಲ್ಲ.
So, heard on IA number 1 of 23, wherein prayer is sought to appointment of guardian for the minors, respond number 4 and 5 of their mother as guardian. And counsel for the respondent also not disputes that they are the minors. And also the prayer is to appoint mother as guardian in respect of both the minors. And hence, for the reasons stated in the accompanying application under which IA 1 and 2 are allowed. ಅಲ್ಲ, ಅದು ಬೇರೆ ಬೇರೆ IA ಇದೆ. 1 and 2 are allowed. Next, IA 5 of 23 is not pressed and hence dismissed as not pressed.
ಅದು ಪೇ ಮಾಡಿದ್ದೀನಿ.
PF ಕೊಟ್ಟಿದ್ದೀರಾ? ಯಾವಾಗ?
ಬೆಳಗ್ಗೆ.
Council submit that he has paid the PF today and hence issue notice against R1, R3 and R4.
DPF also paid, my lord. I served 2 copies.
Compliance ಏನೋ ಒಂದು ಇದೆಯಲ್ಲ?
Yes, my lord. I paid.
And the council is also directed to comply with office objections regarding deficit PF
I already
and
paid.
copy.
Copy also served by.
And council and also council submits that copy is served on the ಯಾರಿಗೆ? Other side?
Yes, sir. R5 to R.
ಯಾವ್ದ್ರದ್ದು? ಯಾವ್ದ್ರ ಕಾಪಿ?
ಇದು appeal copy ಮಾಡಿ.
ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀರಾ PF ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಕ್ಕೆ?
Yes, yes, my lord.
PF ಕವರ್ ಏನೋ ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತ ಅವರು.
My lord, ಎಲ್ಲ ಕೊಡಿ.
ಆಯ್ತು. And council submits that regarding deficit PF and also furnishing copy are already furnished. Issue notice again. Next R5 and R6 emergent notice ಅಂತ. 38 delay of 13 days. ಇದಾರ ಇಬ್ರು? ಇಲ್ಲ, ರೆಸ್ಪಾಂಡೆಂಟ್ ಇಲ್ಲ. ಹರ್ಡ IA number 1 of 24 and there is a delay of ಇದಾರ? ಇದಾರಲ್ಲ, ಏನ್ರಿ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆಯಾ?
ಏನ್ ಬೇಡ?
Heard on IA 1 of 24, then there is a delay of 13 days in filing the appeal and for the reasons stated in the accompanying application of Probate, delay of 13 days is condoned. Next, post the matter for admission along with IA 2/24 for TI on 13/11. 747 days delay. Notice ಹೋಗಿದೆಯಾ?
ಇಲ್ಲ ಸರ್.
Issue notice on IA 1 of 24 and also against IA number 2 of 24 and also on main against the respondents. PF ಕೊಡಿ immediate ಆಗಿ. Delay 297 days. ಯಾರು other state ಆಗಿದ್ದಾರಾ?
Respondents are served through hand summons and through the process, my lord, sir, by order of this honorable court.
ಏನ್ರಿ ನಿಮ್ದೇನ್ ತಕರಾರು ಇದೆಯಾ ಐಎಗೆ?
Government land, my lord.
ಗೌರ್ಮೆಂಟ್ ಲ್ಯಾಂಡ್
ಅಲ್ಲ ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದು
ಈಗ ಡಿಲೇ ಇದೆ 297 days. ಗೌರ್ಮೆಂಟ್ ಲ್ಯಾಂಡ್ ಅದನ್ನ ಆಮೇಲೆ ಡಿಸೈಡ್ ಮಾಡೋಣ.
297.
ಅಯ್ಯ ಡಿಲೇಗೆ ಏನಿದೆ ನಿಮ್ದು?
Delay ಇದೆ.
ಹಾ?
Delay ಇದೆ.
ಡಿಲೇ ಏನು ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕ್ತೀರಾ ಏನು?
Reply file ಮಾಡ್ತೀನಿ.
ಹಾ?
ತಾವ್ ಹೇಳಿದ್ರೆ objections ಆಗ್ತದೆ.
ನಾನ್ ಹೇಳೋದಲ್ಲ, ನೀವ್ ಹೇಳ್ಬೇಕು, ನಿಮ್ ಕೆಲ್ಸ ಅದು.
Objections ಆಗ್ತದೆ.
ಹಾ? ನಾನ್ ಹೆಂಗ್ ಹೇಳಕದ್ರಿ? ನೀವು ಡಿಲೇಗೆ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕ್ತೀರಾ ಇಲ್ಲ ಅಂತ? ಹಾಕ್ತೀರಾ?
as per this honorable court's order, my lords, of the year 1993,
ಹಾ.
property belongs to Mutt ಅಂತ compromise decree ನೇ ಆಗೋಗಿದೆ.
ಹಾ.
Now, because of this respond number 5 to 8, my lords, Tahsildar passes an order stating that, my lords, the property, schedule B property belongs to the endowment, my lords. Thereafter, my lords, in your
As against the court decree.
ಹೌದು. Thereafter, my lords, in your the subsequent development, the
ಹೋಗ್ಲಿ ಕಂಟೆಸ್ಟಿಂಗ್ ಸ್ಟೇಟ್ ಬಿಟ್ರೆ ಮತ್ ಬೇರೆ ಯಾರಿದ್ದಾರೆ?
ಈ 5 to 8 ಕಂಟೆಸ್ಟ್ ಮಾಡ್ತಾ ತೊಂದರೆ ಕೊಡ್ತಾ ಇರೋದು ಈಗ ಸ್ಟೇಟ್ ಅಲ್ಲ.
5 to 8 ಯಾರು?
They are private parties, my lords. They are virtually, they are
ಅವ್ರಿಗೆ ಸರ್ವ್ ಆಗಿದೆಯಾ?
ಆಗಿದೆ. And summons ಅವರಿಗೆ ಕೊಟ್ಟಿದೆ, ಅವ್ರು ಬರ್ತಾ ಇಲ್ಲ. One of the respond number 6 is advocate, my lords. He is also not.
ಸಮನ್ಸ್ ಆಯ್ತು ಥ್ರೂ ಕೋರ್ಟ್ ಟು ಸಮನ್ಸ್ ಜಾರಿ ಆಯ್ತಾ ಅಂತ ಕೇಳಿ.
ಆಗಿದೆ.
Told. Third on IA 1/24 and there is a delay of 297 days in filing the appeal. And notice has been served on the other side and not filed any objections to IA. And for the reasons stated in the accompanying application and affidavit, delay of 297 days is condoned. List the connected idea?
Connected.
And list this matter for admission along with IA number 2 of 24.
Mainly my prayer is to repair the Mutt building.
On 14/11. ಬರ್ಲಿ ಅಡ್ಮಿಷನ್ ಬರ್ಲಿ ನೋಡ್.
Please.
For the respondent, we have made the application, my lord.
ಏನು ಡಿ ಕ್ಲಬ್ ಡಿ ಲಿಂಕ್ ಇದು?
ಅದು ಎರಡು mining is one and the same, my lord.
ಹಾ.
Here the case,
ಡಿ
my
ಲಿಂಕ್
lord,
ಆಗ್ಬೇಕಾ?
D-link ಆಗ್ಬೇಕು. We
ಬೇರೆ
are
ಬೇರೆ ಮ್ಯಾಟ್ರ್.
not filing the paper book intentionally and dragging the case, my lord. This is the,
But appeal is arising out of same judgment?
no, my lord, different judgment.
Paper book is already filed, my lord.
ಯಾವ್ದ್ರಲ್ಲಿ?
482.
778. 482 ನಲ್ಲಿ paper book ಹಾಕಿದ್ದಾರೆ.
778 ಇದೆ,
Yes.
ಎರಡು appeal ಇದೆ.
778 is concerned, my lord.
ಹಾ.
Here it is the case that in the year 1977, partition deed was taken place. That is
ಇದ್ರಲ್ಲಿ ನಾನ್ ಫೈಲ್ ಪೇಪರ್ ಬುಕ್ ಫೈಲ್ ಮಾಡಿಲ್ವಾ?
ಮಾಡಿಲ್ಲ, 4 ಡೇಟ್ ಆಗಿದೆ.
78 ಮಾಡಿಲ್ಲ.
22 ಇಂದ.
482 ಅಲ್ಲಿ ಮಾಡಿದ್ದೀವಿ.
482 ನಲ್ಲಿ ಮಾಡ್ಲಿರಿ, ಅದ್ ಬೇರೆ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲೇನ್ರಿ?
Judgment.
ಇಂಡಿಪೆಂಡೆಂಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಬೇರೆನು? ಹಾ?
ಇದು 778 ಬಂದು partition deed ನ ಡಿಕ್ಲರೇಷನ್ ಕೇಳ್ತಾರೆ, null and void ಅಂತ ಹೇಳಿ.
ಬೇರೆ ಸೂಟ್ ಬೇರೆನಾ?
ಸೂಟ್ ಬೇರೆ.
ಆಯ್ತು. The registry is directed to D-Link.
My lord, objections ಆಗ್ತೀವಿ, my lord.
Both the appeals, ಯಾವ್ದಕ್ಕೆ?
ಡಿಕ್ಲಬಿಂಗ್ ಐ ಹಾಕೊಂಡಿದ್ದಾರೆ.
ಹಾ.
ಅದಕ್ಕೆ objections ಆಗ್ತೀವಿ. which time will be granted?
ಕಾಪಿ ಯಾವಾಗ ಸರ್ವ್ ಮಾಡಿರೋದು?
ಕಾಪಿ ಸರ್ವ್ ಲಾಂಗ್ ಬ್ಯಾಕ್, my lord.
ನಿಮಗೆ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿರೋದು ಯಾವಾಗ್ರಿ? 1/24.
10-9.
ನೋಡಿ ಮೇಡಮ್, ಎಲ್ಲ ನೀವೇ ನೋಡ್ಕೊಳ್ಳಿ, ಕೋರ್ಟ್ನವರೇ ನೋಡ್ಕೊಂಡು
10-9
ನೀವೇ ಆರ್ಡರ್ ಬರೀರಿ ಅಂತ.
Which time will be granted, my lord? Objections.
Here they purposefully they are dragging the case, my lord.
ಯಾವತ್ತು ಫೈಲ್ ಮಾಡಿರೋದು ಹೇಳಿ?
10-9.
10/8 of
9 September.
10/9/24.
24.
ಆಯ್ತು ತೊಗೊಳ್ಳಿ. ಹಾ? Copy is also served on the same day.
My lord.
ತೊಗೊಳ್ಳಿ. The appellant counsel seeks 1 week time to file objections to IA number 1,
14.
IA 1/24. And hence 1 week time granted to file statement of objections. List this matter on 8/11.
Oblige.
Any time after 14.
My lord, they are purposely dragging.
ಏಕೆ?
ನಮ್ಮ senior wedding ಇದೆ.
ಎಲ್ಲಿದ್ದೀರಾ?
Wedding ಇದೆ.
Senior son's wedding ಇದೆ.
ಸೀನಿಯರ್ ಸನ್ಸ್ ತಾನೆ? ಸೀನಿಯರ್ದಲ್ಲ.
Any time.
ಆಯ್ತಾಯ್ತು, ಒಂದ್ ವಾರ ಸಾಕು.
Oblige.
ನೀವೇ ತಯಾರು ಮಾಡ್ರಿ ಅಬ್ಜೆಕ್ಷನ್ಸ್, ಅದೇನಿರ್ತದೆ ಡಿ ಕ್ಲಬ್ಗೆ? ಹಾ?
At least 11.
ಸೀನಿಯರ್ ಮದುವೆ ಮಾಡ್ಲಿ ಮಗಂದು, ನೀವ್ ಕೂತ್ಕೊಂಡು ತಯಾರು ಮಾಡಿ ಆಫೀಸಲ್ಲಿ. ಆಯ್ತು.
11th or
ಕಲ್ತ್ಕೊಳ್ಳೋದು ಯಾವಾಗ? ಅಯ್ಯಗಳಿಗೆ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ರೆಡಿ ಮಾಡೋದು. ಹಾ?
11th or
ಮದ್ವೆ ಇರೋದು ಯಾವತ್ರಿ?
8 and 9. my lord.
ಮದ್ವೆ ಇರೋದೇ 8 and 9.
They are purposely omitting false.
ಆಯ್ತು. ಮದ್ವೆ ಇಲ್ವಾ?
ಮದ್ವೆ ಇಲ್ಲ, ಇವರು 2022 ಪೇಪರ್ ಬುಕ್ ಹಾಕ್ಬೇಕು. ಅದೊಂದೇ ಗ್ರೌಂಡ್ ಪೇಪರ್ ಬುಕ್.
ಹಾ.
ಅದನ್ನ 4-5 ಡೇಟ್ ತಗೊಂಡಿದ್ದಾರೆ, ಆಗ್ತಾ ಇಲ್ಲ.
I'm not lying, my lord. It's
5th ಗೆ ಹೇಳಿ ಸ್ವಾಮಿ, 5ನೇ ತಾರೀಕು.
ಸೀನಿಯರ್ ಮಗನ ಮದ್ವೆ ಇದೆಯಾ ಇಲ್ಲ? ಯಾವಾಗದು?
8 and 9.
ಇದೆಯಾ?
ಅವ್ರ ಕಾರ್ಡ್ ಪ್ಲೇಸ್ ಅವ್ರು ಇಲ್ಲ, ಸುಳ್ಳು ಹೇಳ್ತಾ ಇದಾರೆ ಸ್ವಾಮಿ. 5ನೇ ತಾರೀಕು ಆಗಿ
I can.
ಅವ್ರ ಕಾರ್ಡ್ ತೋರಿಸ್ಲಿ ಸ್ವಾಮಿ. ನಾನು ಇಲ್ಲ, ಇದನ್ನ ಬೇಕು ಅಂತ ಪರ್ಪಸ್ಫುಲಿ ಟ್ರ್ಯಾಗಿಂಗ್ ವೆಕೇಟ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಜಾಗ. purposefully dragging rejectment case.
ಹ್ಮ್.
Yes, I appear for the respondent.
ಹ್ಮ್.
Till Monday ಒಂದು ಸ್ವಲ್ಪ ಟೈಮ್ ಕೊಟ್ಟಿದ್ರು.
ಹ್ಮ್.
Monday ವರೆಗೆ ಟೈಮ್.
ಏಕೆ?
ಸ್ವಲ್ಪ ರೆಕಾರ್ಡ್ಸ್ ಬರ್ಲಿಕ್ಕಿದೆ ಅವ್ರು. He has served a copy, my lord.
ಹ್ಮ್.
I served a copy on the other day, my lord.
Yes, he has served, my
Point for
lord.
consideration.
Till Monday, my lord.
ಹೊಸ
ಆಯ್ತು.
act ಪ್ರಕಾರ.
Counsel for respondent. ಈ ನೋಟಿಸ್ ನಾಟ್ ಆರ್ಡರ್ ಟು R2 and R3 ಅಂತಿದೆ.
ಅದು ಗವರ್ಮೆಂಟ್.
ಅವ್ರು ಯಾರು R2 and R3?
ಗವರ್ಮೆಂಟ್.
ಹಾ?
ಗವರ್ಮೆಂಟ್.
ಗವರ್ನಮೆಂಟ್ ಗವರ್ನಮೆಂಟ್ ಅವ್ರ ನೋಟಿಸ್ ತಗೊಳ್ಳಿ.
Take note. I may be permitted to.
KG is directed to take notice for R2 and R3 and counsel for the appellant is directed to serve the copy of this appeal memo forthwith.
Please.
Counsel for R1 seeks time list this matter on Monday ಆಗಲ್ಲ, ಬೇರೆ ದಿವಸ 7th 8th
ಎತ್ತಿದೆ my lord. ಸ್ವಲ್ಪ ಎಂಟರ್.
811.
ಒಂದ್ ಲಕ್ಷ ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ. 1 ಲಕ್ಷ ಕೊಟ್ಟಿದ್ದಾರೆ ರೆಫರೆನ್ಸ್ ಕೋರ್ಟ್. 1,28,800 ಕೊಟ್ಟಿದ್ದಾರೆ. ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡ್ಕೊಂಡು
ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್
ಜಾಸ್ತಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ಹಂಗಾಗಿ ಇನ್ ಆಫ್ ದಿ ನೋಟಿಫಿಕೇಶನ್
28,000 ಜಾಸ್ತಿ ಮಾಡವ್ರ ಅಷ್ಟೇ. ಆಯ್ತು, ಅವ್ರು ನೋಡೋಣ, ಹೇಳಿ, ಇಬ್ರು ಹೇಳಿ ನೋಡೋಣ. ಆಯ್ತು, 811. ನೆಕ್ಸ್ಟ್ ಅಡ್ಮಿಷನ್. ಹ್ಮ್. 1 and 3 are dismissed.
Respondent, my lord, in this matter.
ಏನಾದ್ರು ಎಂಟ್ರಿ ಮಾಡಿದೀಯಾ?
ಇಲ್ಲ, ಎಂಟ್ರಿ ಮಾಡಿಲ್ಲ.
ಸೂಟ್ ಇನ್ನು ಪೆಂಡಿಂಗ್ ಇದೆಯಾ? ಡಿಸ್ಪೋಸ್
ಪೆಂಡಿಂಗ್ ಇದೆ. Plaintiff's evidence. It's a plaintiff's appeal. The matter, this MF will become infructuous because what is under challenge, my lord, is an application, my lord, was filed.
Changing the temporary injunction against the defendant number 4, restraining him from alienating the suit shall
ಅದು ಕಾಮನ್ ಆರ್ಡರ್ 2 IAS, my lord. 39(1) and 2 ಒಂದು from alienating. ಅದು ಅದರಲ್ಲಿ MFS 7818 of 2015. That, my lord, on 16th of October they got withdrawn. MFA withdraw ಮಾಡಿದ್ದಾರೆ. ಇದು this is the MFS 7819.
ಇನ್ನೊಂದು MFA ಇದೆಯಾ?
ಇದು arising out of the common order.
7819 ಇದೆ. ಅದು 7819. ಇದು ಅಪೀಲ್.
ಇದರಲ್ಲಿ ಸ್ಟೇಟಸ್ ಕೋ ಫ್ರಮ್ ಪುಟಿಂಗ್ ಅಪ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಅಂತ ಇದೆ.
ಮೋಸ್ಟ್ಲಿ FR ಏನಾರ FR.
Two applications, my lord, common order.
ಸ್ಟೇಟಸ್ ಕೋ ಇದೆ, ನಾಟ್ ಟು ಏಲಿನೇಟ್ ಇದೆ.
Not to alienate do MFS 7818, my lord, they withdrawn.
7818.
7818 of
ನಾಟ್ ಟು ಏಲಿನೇಟ್ ಈಗಿಲ್ಲ ಕೋರ್ಟ್ ಮುಂದೆ.
ಅದಿಲ್ಲ.
ಆಯ್ತು. ಇನ್ನೊಂದು
ಇದು IA ನಂಬರ್ 3 ಮೇಲೆ ಸ್ಟೇಟಸ್ ಕೋ ಫ್ರಮ್ ಪುಟಿಂಗ್ ಅಪ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಅಂತ.
ಅದು ಡಿಸ್ಮಿಸ್ ಆಗಿದೆಯಲ್ಲ?
ಅದು
dismiss.
dismiss. Both IAs are dismissed. Both IAs are dismissed. Now construction is completed. So this IA will not survive, my lord, for consideration.
The counsel appearing for the respondent would submit that
Construction is
the order challenged in MFA 7819 is against the dismissal of IA number 3, correct?
For status quo.
To maintain status quo. And counsel submits that already construction is completed. The IA itself doesn't survive for consideration and consequently MFA also doesn't survive for consideration. The appellant counsel is absent. However, one opportunity is given to the appellant counsel. If appellant counsel doesn't appear in the next date of hearing, appeal will be dismissed for non-prosecution. This matter on 1411.
Great.
Abhinay YT. AA allowed, set aside and modified, enhanced.
Yes, my lords. Agreement is entered between the contractor and
Other side are idara Kotari Sarud. R3 Rajanna Sarud. Unrepresented alla?
Unrepresented.
Heli.
Agreement is entered between the contractor and the railways. They invoke arbitration clause. Arbitration tribunal is set up. 11 claims are put forth. Some of them are awarded. Then they file an application under section 34 of the ANC Act. ಅಲ್ಲಿ 3 claims na modify ಮಾಡ್ಬಿಟ್ಟು compensation under certain claims enhance ಮಾಡ್ತಾರೆ.
1 ಲಕ್ಷ ಇದ್ದಿದ್ 20,000 ಇದ್ದಿದ್ 1 ಲಕ್ಷ ಮಾಡಿದ್ದಾರೆ. 50,000 ಇದ್ದಿದ್ 2,59,000 ಮಾಡಿದ್ದಾರೆ. ಇನ್ನೊಂದು 4,650 ಇದ್ದಿಂದ 1,44,500 ಮಾಡಿದ್ದಾರೆ. ರೀಜನ್ ಸೇಲ್
My lords, reasons are considering. this
Records
matter.
ಇದೆಯಾ ಮೇಡಮ್ ಇದ್ರದ್ದು? ಇಲ್ವಾ?
So, my contention is that under section 34, the award can be set aside or confirmed. It cannot be modified. I will just pass one that.
ಇದೆಯಾ? ಕೊಡಿ ಅದೇನು ಸೈಟೇಷನ್ ಕೊಡ್ರಿ.
Supreme Court judgment in civil appeal number 80. Paragraph number 11 minus. Consideration and conclusion.
ಅಡ್ಮಿಟ್ ಆಗಿದೆಯಾ? ಅಡ್ಮಿಷನ್ ಆಲ್ರೆಡಿ ಆಗಿದೆ. ಪೋಸ್ಟ್ ದಿ ಮ್ಯಾಟರ್ ಫಾರ್ ಫೈನಲ್ ಹಿಯರಿಂಗ್. ಡೇಟ್ ಕೊಟ್ಬಿಡಿ ಆನ್. 14/11. Next 46 PB Raju. Raghunath.
Please.
Order 9 Rule 9 dismissed on cost of rupees 2,000 each against R2 to 7 collectively. 14. 8 respondents separately, R9 and 10 jointly. Yes, counsel, what is the ground?
Is the first plaintiff in OS 27-051 of 2011. Suit for partition and separate possession. Lord, on 2/9/2015, I would file an amendment application that is allowed. Additional written statement and rejoinder is filed. Lord, my
Amendment allowed and later on?
Pardon?
Amendment allowed?
Allowed. Then they file additional written statement. To which I file a rejoinder application seeking leave to file a rejoinder on 5/1/2016. That is dismissed. Against which I filed WP 1685 of 2016. Challenging the dismissal of the rejoinder. My lord, this court on 9th February 2016, while dismissing my writ petition, passes a direction that the suit shall be disposed of within a particular time frame. My lord, aggrieved by which I file an SLP on 8/4/2016, SLP 8205-06. My lord, in the SLP, because evidence was not yet commenced, the SLP was admitted and notice was issued. On a subsequent date, it was also made clear also in the SLP that I shall conduct the trial and in view of the direction given by this court.
This court.
My lord, then what happens when the matter is listed before the court? I file a memo and an adjournment application telling that this is the problem, that matter has been issued. Nevertheless, my counsel was present, the application was filed. I was not present, the counsel was present and the memo was filed. My lord, that order, my lord will get. At page, order sheet I produced. That is just stating that this is recorded, but nevertheless.
What happened to that memo?
Memo, on that memo, no order is passed. All that the judge says.
You filed a memo for adjournment.
I filed an application for adjournment and a memo intimating the SLP is pending.
SLP is pending.
Pending. This court, however, dismisses the thing. And
dismisses the IA?
Suit, dismisses the suit.
Suit itself?
Suit is dismissed for non-prosecution. Then, my lord, this present miscellaneous is filed. In the miscellaneous, the only reason that the court says is that despite the direction, you have not been diligent. My lord, my only humble submission is, my lord, it is not that I have not been diligent. I have been active, my lord, the sufficient cause.
Active to go to the Supreme Court also.
Pardon me?
Active to go to the Supreme Court also, but not in conducting the case.
But that is the one first date, second date, now adjournment. This is the reason. In fact, that order
ಆಯ್ತು
of-
ಆರ್ಡರ್ ಶೀಟ್ ಇದೆಯಾ? ಯಾವಾಗ ಡಿಸ್ಮಿಸ್ ಮಾಡಿರೋದು ನೋಡೋಣ. ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ದು ಯಾವಾಗ ಹೈಕೋರ್ಟ್ನವರು? ಹೈಕೋರ್ಟ್ ಡೇಟ್ ಆಫ್ ಡೈರೆಕ್ಷನ್ ಹೇಳಿ. ರಿಟ್ ಪಿಟಿಷನ್
ಹೌದು sir.
9th day of February 2016.
ಹೌದು
ಹೌದಾ?
ಹೌದು
ಏನಾರ ಟೈಮ್ ಬೌಂಡ್ ಪೀರಿಯಡ್ ಟು ಡಿಸ್ಪೋಸ್ ದಿ ಸೂಟ್ ಅಂತ?
ಹೌದು. My lord, the
ರಿಟ್ ಪಿಟಿಷನ್ಸ್ ಆರ್ ಡಿಸ್ಮಿಸ್ಡ್ ಅಂತಿದೆ.
yes. My lord, my application seeking adjournment is at page 136. My submission to my lord is, my lord, having regard to the fact that I have made an adjournment application, I have detailed the facts, the suit was nevertheless dismissed. Then, my lord, what the miscellaneous court in the miscellaneous proceeding, the reason assigned, my lord, may kindly come to page 28. Only there was a specific direction from the Honorable High Court of Karnataka dispose of the case within a specified time frame. The suit ought to have been disposed of within 30/6/2016 itself. The perusal of the order sheet in the original suit, it has seen the court while adjourning the matter on 16/6 had directed the petitioner plaintiffs to lead evidence without fail on the next date of hearing without seeking adjournment, and the case was posted on 20/6/2016. The order sheet shows that the counsel for the plaintiffs 3 and 4 submitted that he is going to file a memo for retirement. Counsel 1 and 2 paid time on the ground SLP is pending. The plaintiffs 1 and 2 were absent on said date. Therefore, the suit was dismissed. This shows that the petitioners have not complied with the directions of the Honorable High Court and also for the trial court giving specific direction to go on with the suit for evidence on next. Well, what this in the miscellaneous court, what the same reason that was assigned for dismissal of the suit, the same reason is accepted. Well, the reasons which to be considered by the miscellaneous court and the original side are different. In the miscellaneous court, I must show before the miscellaneous court my reason for non-appearance on that day. That was only one date. My counsel was present. And my counsel has said that this is the reason, it is on that reason I was not present. My counsel has nevertheless appeared and filed a memo. That memo is there.
Larry, even you filing of that adjournment also, the Supreme Court already dismissed your SLP
Well,
and directed to go ahead with the case in terms of the order passed by the High Court.
the
Then
further,
why you have filed an adjournment once again?
yeah, the further order of, my lord, kindly see the next page of the SLP order.
ಏನಾಗಿದೆ next?
The SLP says once, if this court were pleased, the miscellaneous would allow, the SLP can be revived onto it.
ಮತ್ ಮಿಸ್ಲೇನಿಯಸ್ ಅಲೋ ಆಗ್ಬೇಕಲ್ಲ, ಮಿಸ್ಲೇನಿಯಸ್ ಅಲ್ಲ ಅಲೋ ಆಗಕ್ಕೆ ಏನ್ ಗ್ರೌಂಡ್ಸ್ ನಿಮ್ದು?
My lord, the miscellaneous grounds allow abek ಅನ್ನೋದು ಒಂದೇ ಈ ಕಾರಣ. The reasons assigned by the miscourt is different, my lord. What all that the miscourt says is the same reasons assigned
Record
by.
shows that the counsel appearing for the plaintiff before the Honorable High Court of Karnataka had undertaken
Yes, my lord.
that the plaintiffs would complete their evidence within the specified time framed and had given consent for the fixing the time frame for disposal of the suit. The pendency of the miscellaneous first appeal before the High Court of Karnataka against the order rejecting the application for appointment of commissioner will not be a hurdle in the way of plaintiff proceeding with the trial of the case. Therefore, this court of the opinion that petitioners have not shown any.
My lord, it is the same reason, my lord.
Prevented by any sufficient cause from leading the evidence on 26/26/16 when the case was called for their evidence. Hence, point number 1 is answered in the negative.
It is virtually the same reason, but in the miscellaneous court, I have said the reason for non-leading evidence is these facts. That where is the appreciation insofar as those aspects are concerned?
What is the ground you have urged before the miscellaneous court for to set aside the order?
My lord, the ground urge was, my lord, I was confident that there I would get some relief in the SLP, and once the SLP, because
The SLP already dismissed on,
the SLP was
8 for
disposed of in view of the dismissal of the miscellaneous, my lord.
no.
How-
This miscellaneous ಯಾವಾಗ dismiss ಆಗಿರೋದ್ರಿ?
My lord, may kindly see, I have given,
27th day of March 2017. ಹೌದಾ? ಹಾ.
my lord, it was dismissed on 27th March 2017. My SLP is dismissed subsequently in view of the dismissal of the miscellaneous. And the Honorable Supreme Court has said, considering the submissions and the facts and circumstances of the case, we dispose of these specially with the liberty to the petitioner plaintiffs to revive the specially if the petitioners plaintiffs succeed in the revision petition before challenging the order under Rule 930. So if my lord will please to accept my reasons, my lord, probably it is a partition suit, my lord. I will.
Nine to 2016 order was passed by this court directing to lead evidence and complete the evidence within a time bound period. Then why you have not led the evidence?
3 months, my lord. I was hopeful that I would get some relief in the SLP. The SLP, and as on the date of the admission of the SLP.
Here is the High Court order, then we'll say High Court order. Look, you have given consent while passing such an order. Really, the High Court order? 9th day of February 2016,
Page 119. my lord.
119.
ಇಲ್ಲ, I did not.
Time frame ಎಲ್ಲಿದೆ? Time frame ಬಗ್ಗೆ ಮಾತ್ರ ಹೇಳಿ.
Pardon, my lord?
Time bound ಕೊಟ್ಟಿದಾರಲ್ಲ ಡೈರೆಕ್ಷನ್ ಅದೆಲ್ಲಿದೆ? He was aged about 73 years.
ಇಲ್ಲ, one defendant is aged, one of my uncles is aged 73 years.
Since there is a direction from this court in the writ proceedings giving time bound direction to dispose of the suit early on the ground that defendant number 9 is a senior citizen, age 73 years. The trial court by assigning sound reasons has rejected the application of the petitioner's plaintiff hearing. There is no illegality. Order ilwalla, ಮತ್ತೆ ಬೇರೆ ಆರ್ಡರ್ ಯಾವ್ದು ಇದೆ? ಟೈಮ್ ಬೌಂಡ್ ಡೈರೆಕ್ಷನ್ ಯಾವ್ದ್ರಲ್ಲಿದೆ? One more order ಇದೆಯಾ?
There are 3 orders, please, my lord. Exhibit R1, 20th September 2013 is the first order, please.
First order ಯಾವಾಗ ಡೈರೆಕ್ಷನ್
20th September 2013.
30th September.
20.
2013 ಅಲ್ಲಿ ಏನ್ ಟೈಮ್?
MFA 5484 of 2013.
MFA
5484 of 2013. The order is like this, my lord. In view of the matter, the trial court is directed to dispose of the suit within 6 months from today. The respondents are directed not to alienate the property. This is the first order. Second order is Exhibit R2, dated 1st October 2015. In WP 41550515. Not the order passed by this honorable court in this writ is, this is what it says, please. At page 7, para 5, having regard to the facts and circumstances of the case, and since the trial is yet to commence, no exception can be taken to the orders passed by the learned trial judge, permitting the amendment of the plaint in the manner proposed in order to decide the real questions in controversy between the parties and minimize the litigation. Similarly, no exception will be taken for permitting additional defendants to be brought on record. In view of permitting amendment of the plaint, additional issues may arise for determination. Both the sides shall file draft additional issues, if any, on 3/10/2015. The learned trial judge shall raise the additional issues on 3/10/2015, keeping in view of the pleadings of the parties as amended. The plaintiff shall adduce and complete their side of evidence on or before 8/1/2016.
8/1/2016.
This is the directions in the writ court, please, ma'am. The defendant shall adduce and complete their side of evidence within a period of 3 months from the date of plaintiff closing their side, the suit to be decided with expedition and on or before 30th June 2016. The time bound direction is issued by keeping in
The
view-
second direction.
This is the second direction.
First direction 8/1/26.
Yes, ma'am.
Second direction 36.
2016, the final judgment should be passed. The reason for this direction is
Even
Time-
in spite of these two directions.
they did not
evidence-
follow.
Evidence has not been
Yes,
commenced.
madam. And the last paragraph of the judgment is, if either party seek any unnecessary adjournment, trial judge is at liberty to refuse the same and proceed further for deciding the suit within the time period. Therefore, my lord, the learned judge has followed the directions of this honorable court. And in fact, in miscellaneous petition, my learned friend's client has led in evidence. He said, as on the date of the last date when the Supreme Court had set up them, directed them to file evidence, they had not kept their affidavit chief examination ready itself. This is their tendency, please, my lord. File a suit against father for partition, drag on the matter.
As on 4/4/2016.
And Apex Court, my lord, Apex Court on 4/4/2016 has specifically directed, my lord. This is what it says. The step in addition is permitted. It is made clear that pendency of SLP before this court shall not stand in the way of the trial court proceeding with the case as directed by the High Court.
That is exactly what I want to read, my lord. As on 4/4/2016, the Supreme Court was made aware of all these past events.
Yes.
Despite which the Supreme Court has said that it is made clear pending. So therefore, I was supposed to go ahead with the matter before the trial court. My lord, my lord, after 4/4/2000, this order, my lord, the matter was listed in June on the 13/6. It's on 13/6 and 16/6. On the first 2 dates, I made one application, my lord. My lord, having regard.
The Supreme Court order ಅದು 4/4 ಅಲ್ಲೇ.
4/4
They had to.
Even you go ahead with the evidence.
June ಅಲ್ಲಿ matter list ಆಯ್ತು. June matter list ಆಗ ಒಂದು adjournment application ಆಗ್ತದೆ. That is rejected and suit is dismissed.
Then why you have not let the evidence as directed in the earlier MFA? 6 months time was given on 29/2013. 13 till 2016. You have not let any evidence also.
Partition suit, my lord.
Partition suit ಆದ್ರೇನು? Direction ಇದ್ದ court direction ಇದ್ದಾಗ ಒಂದ್ಸರಿ ಅಲ್ಲ 2 ಸರಿ ಇದೆ. ಒಂದ್ಸರಿ MFA ನಲ್ಲಿ, second time WP ನಲ್ಲಿ.
As between the parties, my lord, I would request this court have to take a little liberal view, my lord. I will give an undertaking now, my lord, within some specified time frame, I will go ahead with the matter. After all, the dispute is within the family, my lord.
Yes, counsel, what is
Lord, the specific direction is they should have led in evidence on or before 8/1/2016.
Those aspects are.
That has given a go by them. Till 4/4/2016, no evidence has been led by them, please. Then what is the sanctity of the directions issued by this honorable court? Not once, as my lord said, thrice. One in MFA and 2 in WPs, my lord. Then directions will have no. Subsequently also, this timetable which is fixed in the first WP is confirmed in the second WP. Please, my lord.
That is
R3.
9th day of February 2016.
In the third WP also, this is what this honorable court says. At page 11.
All things.
My lords, I am appearing for R14 and R15, my lords. I'm appearing for R14 and R15. I undertake to file wakalat. I do not have any objection to allow this petition.
They are co-plaintiffs who said they are retiring from the case for want of.
My lords, my share is yet to be adjudicated, my lords. So I do not have any objection for allowing this petition.
4 plaintiffs,
The
my lord,
partition
none
suit,
of them
my lords.
enter the witness box.
My lord, all things said and done, my lord. My humble submission is, my lord, having regard to the nature of the suit and the fact that it is a dispute between the family members, my lord, a liberal view may be taken and some time bound frame will fix, my lord.
Totally. Heard the appellant counsel and also the counsel appearing for the respond number name esto?
Respondents. Kevata respondent 1, please. And also R1 to 6, please.
R1 to 6. And also the counsel appearing for
R14,
respond
15, my
number?
lords. R14, R15.
14.
14 and 15, my lords.
14 and 15. This miscellaneous appeal is filed against the rejection of miscellaneous number 25092 of 2016 with order dated 27th day of March 2017. Petition filed under order 9 rule 9 read with section 151 of CPC. Praying the court to set aside the order of dismissal passed by the trial court in OS number 27051 of 2011 dated 26/2016. And to restore the suit. The factual matters of the case is that the petitioners have filed the above suit seeking the relief of partition and separate possession of 1/10 share in the properties described in the plaint.
Clarify.
The case was also posted for the evidence of plaintiff as a last chance on 16/6/2016. The court by its order dated 26/2016 dismissed the suit for non-prosecution. The petitioners have stated that due to certain developments, the petitioners were unable to adduce their evidence. And they have filed an application to amend the plaint. And the court by order dated 2/9/2015 itself was pleased to allow the amendment application. And filed additional written statement by the respondents. And respondent in reply to the amended plaint. The respondents raised several fresh pleadings in their additional written statement. Therefore, the petitioners have to file the rejoinder to the additional written statement and the application dated. All application for rejoinder was rejected on 5/1/2016. The WP was filed before the High Court. And the same was dismissed against the said order. Special petition was filed. And the same was admitted on 8/4/2016. When the matter was pending before the Supreme Court, an application was filed for appointment of receiver under Order 41 Rule 1 of CPC. And the same was also rejected on 17/3/2016. And appeal was also filed. It is also contended that petitioners were unable to produce their evidence in view of the order passed in WP number 2776 of 2016. Though there was a direction to dispose the same within a time-bound period. And on account of admission of SLP, evidence was not commenced. Memo was also filed regarding pendence of SLP. And explaining the inability of the plaintiff for reducing the evidence. The application also filed on 13/6/2016 for adjournment and awaiting the outcome of the order of the High Court of Karnataka, and they could not adduce their evidence. And so even though sufficient cause was shown, because cause is shown for restoration of the suit. Though respondents appeared and filed statement of objections by the respondent number 4 and 7, and the same was adopted by respondent number 2, 5, 6. Respondent number 8 had filed separate objections. The respondent 14 and 15 have submitted no objections. The trial court, having taken note of the grounds urged in the petition and also the statement of objections, formulated the point whether there is a sufficient cause for their not leading evidence. The trial court, having considered the material on record, that is evidence adduced by the petitioner, and also the documents exhibit P1 to 6, and respondents have also relied upon the order passed by the Honorable High Court of Karnataka in MFA number 5484 and 5485 of 2013 as R1, and certified copy of the order passed by the Honorable High Court of Karnataka in the writ petition number 41550 and 42344 of 2015 as R2, and also the certified copy of the order passed by the Honorable High Court of Karnataka in writ petition number 1685.86 of 2016 as marked as R3. And comes to the conclusion that not made out any ground to set aside the order and restore the same. On the other hand, relies upon the R1 to R3 with regard to the direction given by this court. Being agreed by the rejection order passed by the trial court present, appeal is filed. It is contended that trial court wholly erred in not appreciating the facts. and by dismissing the suit, taken away the rights of the plaintiff. And a suit for partition has to reach finality on its merits, not on the ground of not producing evidence. The council also would vehemently contend that the order passed by the High Court was challenged before the Apex Court in SLP number 8205.06 of 2016, and the same was admitted. And Supreme Court of India to decide whether the issue of filing a rejoinder to the additional written statement would be necessary or not. In spite of it, trial court committed an error in dismissing the miscellaneous, and also counsel brought to notice of this court that the Apex Court also, while dismissing the SLP, given liberty to revive the special leave petitions if the petitioners plaintiffs succeed in the revision before the High Court, challenging the order passed under Order 9 Rule 8 of CPC. The council also vehemently contend that suit is for the relief of partition, and this court can take lenient view, and if any terms also would set aside the order, and time bound limit may be given to dispose of the suit. Per contra, the counsel appearing with respondent would vehemently contend that suit was filed in the year 2011 and the same was dismissed in 2016. The council also would submit that there was a direction in the MFA 5484 of 13 to dispose the suit within 6 months. And in spite of the specific direction, even not led any evidence. And also counsel would contend that when the writ petition is filed against the rejection of application filed before the trial court, and once again there was a direction to dispose of the matter in 36/2016. And also even in the third writ also there was a direction to dispose of the same, but even not led any evidence. The maximum period was also in the subsequent direction 36/2016. And suit was also dismissed in the month of June only, when the time was given positively to lead evidence. On that day also not led evidence, but filed an application for adjournment, and the same was rejected. And hence the appellant has not made out any ground to set aside the order. Having heard the appellant and also the counsel appearing for the respondent and admitted material are, suit is filed for the relief of partition and separate possession. And the suit was filed in 2011. It is also important to note that MFA was filed before this court. It is MFA number 5484 and 5485 of 2013. And the direction was given to dispose the suit within a period of 6 months. It is also not in dispute that subsequently an approach is made before this court by filing WP number 41550 and 42344 of 2015. And the said writ petitions are also disposed with the directions to dispose the suit on or before 8/1/2016, and time bound period also given to complete the evidence, and thereafter even defendants also given time bound time to lead evidence. It is also important to note that there were 3 directions. One is that the first instance in 2013 itself to dispose of the suit within 6 months, and even plaintiff have not led any evidence. And afterwards in 2015 also, when the writ petitions were filed, and once again direction was given to dispose of the suit on or before 8/1/2016. And that
To
time
lead
also-
evidence,
Huh?
to lead evidence on or before 8/1.
8/1?
To lead evidence on or before 8/1/2016.
To lead-
Disposal 36.
Directed to the plaintiff to lead evidence without fail on or before 8/1/2016.
16, yes.
And thereafter 3 months time was given to
For defendants.
defendants to lead evidence.
Not the question of,
Fixing the date for 36/2016. ಹೌದಾ?
Please, ma'am.
not the question of willful disobedience.
ಆಯ್ತು ಅದನ್ನ ನೋಡೋಣ ಆಯ್ತು. 36/2016 and even not led any evidence, even as per the directions given in the writ petition also. And also in terms of MFA 5484 of 13 and other connected MFA. Not, the material also discloses that the suit of the year 2011. And even not taken any steps to lead evidence as per the directions of MFAs within 6 months. And subsequently, when the applications were rejected and writ petitions also filed, specific date is given to complete the evidence on or before 8/1/2016. And appellant oblique plaintiff have not led any evidence. No doubt, SLP was filed before the apex court, challenging the dismissal of writ petition. That is 1685 of 2016 and 1686 of 2016. And also it is not in dispute that the apex court also passed an order. Go ahead with the evidence in terms of the direction given by the High Court. And in spite of it also not led the evidence. Even after such an order passed by the SLP also not led evidence, but application was filed in the month of April. April. Once again for adjournment. And the order of the apex court on 4/4/2016 is also very clear that go ahead with the matter. And in spite of it not led the evidence and filed an application for adjournment again. Even from the direction from 2013 to dispose of the matter, even not taken any steps to lead evidence within the time bound period. And hence it is clear that the appellant not made any effort to lead evidence in spite of directions given on 3 times to lead the evidence, and hence I do not find any error committed by the trial court in dismissing the petition. And trial court also, having considered the grounds which have been urged before the trial court, taking into note of the order passed by the court as well as rulings of this court and also the judgment of Kolkata, and so also the rulings of the Supreme Court observed in paragraph number 19 that it is true that liberal approach has to be adopted by the court while considering the fact as to whether petitioners have made out sufficient cause for not leading the evidence. In detail discussed in paragraph number 20, 21 and 22, taking into note of these dates, particularly dispose of the case within this specified time frame. That suit should have been disposed of on 36/2016 itself. And the plaintiff, instead of leading the evidence, filed an application for seeking adjournment. And also the case was posted on 26/2016 with a direction to lead the positive evidence. The plaintiff also not led evidence on that day also. Once again played the time only on the ground that special leave petition is pending. This court has made it clear that even this special leave petition also, the apex court directed to go ahead with the matter as per the directions of the High Court. And the same has not been complied also. In spite of 3 orders and also the order of the apex court, and there was no any stay of the further proceedings by the apex court in the SLP. And also the trial court taken note of there is an order dated 4/4/2016 passed by the Supreme Court also. wherein it was made clear that pendency of the special leave petition shall not stand in the way of the trial court in proceeding with the case as directed by the High Court of Karnataka. The same is also observed in paragraph number 21 of the order of the trial court. And having considered all these materials also, the trial court comes to the conclusion that the record shows that counsel for the plaintiff before the High Court of Karnataka had undertaken that plaintiff would complete their evidence within the specified time framed and had given consent for the fixing the date for disposal of the suit. In spite of it, not taken any steps, and also during the pendency of the miscellaneous first appeal before the High Court of Karnataka against the order rejecting the application for appointment of the commissioner, comes to the conclusion that the same will not be hurdle in the way of the plaintiff proceeding with the trial of the case. And hence comes to the conclusion that not prevented the plaintiff in leading the evidence. Having perused the material and also the contentions of the respondent as well as the grounds urged in the appeal. And when the series of directions are given, even not commence the evidence, and hence I do not find any ground to interfere with the order of the trial court. No doubt the counsel appearing for the respond number 14 and 15 would submit that he has no objection to allow the appeal and set aside the order. And mere saying of no objection by other side, other party, court cannot grant such a relief. The trial court particularly taking into note of the exhibit R123, that is direction given in MFA number 5484 of 84 and 5485 of 2013, and also the writ petition number 41550 and 42344 of 2015, and also the writ order passed in WP number 1685.86 of 2016, taken note of the aspect and also taken note of the directions given by the trial court as well as the apex court also. Apex court also made clear that the plaintiff has to proceed as per the directions of the High Court, and no such effort was made, even not commence the evidence. Hence, there is no ground even to show any lenience as contended by the appellant counsel that even terms may be imposed and set aside the order. And such circumstances is also not warranted when deliberately not let any evidence, and the very contention of the counsel that no intentional delay on the part of the appellant also cannot be accepted. And hence, no ground is made out since suit was filed in the year 2011 and the same was dismissed in 2016. And it doesn't require any interference. In view of the discussions made up by Pasipal and Goda, writ petition appeal is dismissed.
47, Manasa Bira, B. Bachchan.
Lord, this is a
This is our repetition.
suit and a counter suit. I am the plaintiff in a suit for bare injunction in OS number 9024 of 2000. I am a developer who is constructing residential apartments in my land measuring 4 acres 20 guntas in survey numbers 132/1 to 132/4 of Hudi village. My extent
132/1
to 132/4.
132/4. Total extent is
4 acres 20 guntas.
20 guntas.
To the north of my property is Whitefield ITPL main road. That means my land is to the south of the road. And to the south of my land is Giddanakere Lake. Lord, may I just point out, my Lord, Your Lordship, may just have a look at one map, my Lord, Your Lordship will get an idea. Your Lordship looks at the first sketch, your lordship will see ITPL main road, my lord. This is the building that has been put up by me. Then Giddan Kere Lake ide.
That is 132/4.
132/12 alle ಮೇಲ್ಗಡೆ ಬರ್ತಿದ್ಯಲ್ಲ Vaswani exquisite survey number 132/1, 132/2, 132/3 and 132/4.
So total 4 survey numbers.
4 survey numbers.
But you are the owner only to the 132/1, 132/4.
No, 132/1 to 132/4.
1 to 4.
1
All
to
4.
1, 2, 3, 4 sub numbers. ಒಟ್ಟಾಗಿ ಸೇರಿ 4 ಎಕರೆ 20 ಗುಂಟೆ ಆಗುತ್ತೆ. ಅದರಲ್ಲಿ ನಾರ್ತ್ ಬೈ ITPL ರೋಡ್, ಸೌತ್ ಬೈ ಲೇಕ್ ಅಂತ ಇದೆ. So my lord, your lordship will see this. So after my property, the lake buffer zone baratte.
Yes.
And thereafter it is the lake property. So my suit is for bare injunction. I was at the stage of putting up construction of these apartments at the time when the suit came to be filed by me in 2014.
Yes.
Our interfere madidru construction nalli. They claim to have the land to the south of my property. South of my property buffer zone ide. Adadmele lake property ide. There is no property to the south of my property capable of being utilized by them. Anta, that is our contention. Then, my lord, I had the benefit of an interim injunction when the suit was before the trial court. Then, my lord, in 2016, they file a suit for a declaration that they are the owners of 38 guntas.
Your suit number is OS number?
Mine is 9024 of 2014.
Permanent injunction.
Permanent injunction filed by the developer, that is Vaswani Whitefield Projects Limited.
Yes.
Then, my lord, they file a suit, OS number 2835 of 2016. With respect to 38 guntas of land to the south of my property, that is 28 guntas plus 10 guntas, Yard sale deed, to the south of my property, which they give the number as 132/4A and 132/4B.
4A and B.
4A and B. They located to the south of my property. Now, your lordship would see 3 things. First, my contention in their suit for declaration is that land is not in existence. 2, it is landlocked because there is no way to access that property. And it is really land that is sought to be located within my land. A land illa anta namdu contention. Lord, they did not have the benefit of an injunction before the trial court. The trial court considered both the suits separately, but passed separate orders on the same day. And my injunction, which I had the benefit from 2014, that came to be vacated by the impugned order on 26/2017. And for the first time, gave injunction to the plaintiff in their suit on 26/2017. 2 separate orders, but your lordship will see that lot of it is a cut and paste job.
Yes.
As soon as this order came to be passed on 20th of June 2017, Lord, on 21st, I filed this appeal. Please have a look at the order sheet. And on 21st, the very next day, I got stay. On 21/6/2017, as far as my order was concerned, my lord, I got a status quo order directing them to maintain status quo. And as far as the injunction granted in their suit, my lord, for the first time, which they did not have the benefit of, my lord, I got a stay of that order. This is where we are today. Now what has happened is, during the last, my lord, 7 years when the appeal has been pending, 3 things, important things have happened. One is, my lord, I have completed the partial construction of my property. 17 floors I have constructed, about 300 apartments. Now I have a sanction for constructing 4 more floors, that is 18 to 21. Other construction inu nadita ide. This is as far as my aspect is concerned. For ground plus 17 floors, I have already produced before your lordships the partial occupancy certificate. Your lordship will see modified after 1, 2, 3, 4, 5, modified plan was sanctioned for construction of residential building comprising 2 basement plus ground plus 17 upper floors, A, B, C, D block having 302 units and clubhouse, etc., etc.
Yes.
So, Ishtakke 17 floors ke I have got partial OC, but there is also further construction of 4 more floors. Adinu nadita ide, jari ide adu. Now, what is most important, my lord, your lordship would see that after the filing of the suit, Madam, in their suit, that is 2835 of 2016, my lord, they have understood one thing, my lord, that it is not possible. In their suit, my lord, they can't keep going on and saying that that land is there unless they identify that land. So please look at the plaint in OS 2835 of 2016. I have just given your lordships now. The amended plaint in 2835, please come to page 15 of that plaint. They have now amended it and asked for recovery of possession of that property. So, and they have also named it as Schedule C property anta ಒಂದು identify ಮಾಡ್ಬಿಟ್ಟು ನಮಗೆ defendant ಇಂದ ನಮಗೆ possession ತೆಗೆಸ್ಕೊಡಿ ಅಂತ ಅವ್ರು ಕೇಳಿದ್ದಾರೆ. So now, my lord, there are 3 things that come out of this. One is there can't be an injunction in their favor, at least in their suit, since they are not in possession of the property. No possession, no injunction. So, my lord, as far as that appeal which relates to 4903 of 2017, 4902 is from my suit, 4903 is from their suit. 4903 of 2017, in view of the subsequent events, namely plaintiff seeking the relief of recovery of possession of Schedule C property, Lord, that injunction will have to go because that property is not in existence. It will have to be determined. As far as my injunction is concerned, your lordship may consider the main ground of attack that I have taken up in 4902 is, Lord, I had already put up 7 floors on the date of the petition. Because from the date from 2014 till 2017, construction was going on because I had an injunction in my favor. Now, your lordships are aware that while considering an injunction application, my lord, those 3 ingredients have to be discussed. If your lordship looks at ink page 48 of 4902, 4902, ink page 48, internal page 22, where the points for consideration. Adralli 1 and 2 nodi, 1 is prima facie case, 2 is balance of convenience. Irreparable injury, there is no issue that is framed at all as far as that. Only on this ground it will have to go. Then secondly, your lordship would see, please look at the next page, 49, paragraph number 8. He says intends to construct high-rise apartments. Item number 8, paragraph 8. Ade tara in 2-3 kade, as though I have not yet commenced construction, since you have not yet commenced construction, no hardship will be caused to you anta aa reeti nalli hogtare. Photographs kottittu, plan kottittu, amele plan sanction agakinta munche, there are a lot of other preconditions that have to be satisfied.
Plan explore sanction agide nimge
17.
17.
2 basement, ground plus 17 upper floors. A plan sanction agittu, plan ginta munche commencement certificate, pollution control board clearance, fire force department, BWSSB, BESCOM, and environmental clearance because it was next to the lake. All those sanctions had been given. He doesn't consider all that. He says intends to construct anta heli without considering the question of irreparable loss and injury. My lord, he goes on. But I prepared a short list of dates if your lordship.
Yes, IA1 was rejected.
Pardon?
IA1 was rejected in your case.
Yes. And IA1 was allowed in their case.
Yes, counsel.
Lordships may kindly continue the hearing after post lunch. My senior is held up in court all 20. I was expecting.
Commencing the argument.
We are ready with the arguments, my lord.
And already you have sought for the relief of recovery of possession.
But so far as the possession, my lords, I concede to the position, my lords, that we have lost the possession. So far as that, my lords, I may have to submit, my lords, the appeal is infructuous. Regarding the further construction that is being put up, my lords, that is the issue that arises for consideration. Lordships may kindly have it post lunch. My senior is held up in Code Hall 20.
Pass.
My lord, your lordship has a
Pass out.
230 list, I noticed.
Hmm.
This will be taken up after the 230.
After the,
After Passover and
after the 230 list.
Okay.
Hmm.
Just so that I know I can arrange
Yes.
my affairs.
We can come at,
Please, no,
after the,
no, I'll be here, my lord.
other list.
48.
Ajesh Kumar.
Plaintiff, my lord. Plaintiff's appeal, my lord, is a rejection of the interim relief by the trial court. Suit, my lord, was for recovery of money. My lord is pleased to see.
Other
The-
side are Illandri? Yeah, other side. Chandrasekhar
Concern
Reddy.
is, my lord, that they are looking at selling the property. That's why we had moved it. They're looking at the suit schedule property. So basically, my lord, in the first instance, we had a status quo order.
That is vacated.
That was vacated. And there's no dispute with regarding to the loan, my lord. Please see their own admission. Their admission, their reply is at ink page 90. The only contention is on limitation. My lord, I had lent them 5 crores in 2012 with an interest to be paid on that. I issue them a legal notice, my lord, because they acknowledge the debt. They reply on 31/2016, admitting that the money has been borrowed by them. They only dispute
Admitting the total extent of the 5 crores?
5 crores plus interest, my lord, will come to around 70 crores. They have paid, my lord, I should say fairly.
70 crores.
70 crores, because 24% interest is what we have agreed.
Availed 5 crores.
5 crores. My lord, they have admitted the liability. Please see in page 90, my lord, annexure E.
Yes.
When I had given them a legal notice for payment of the dues, para 1, the statement made in para 3 of the notice that 5 crores has been advanced during 2012 and as stated therein is correct. It is true that my client has taken the said loan. And even please see the written statement, my lord, in the trial court, in page 107, annexure J, para 2, the averment made in para 4 of the plaint that the first defendant had agreed to pay interest at 24% is not correct, but the allegation that 5 crores has been advanced is true. So the amount is
only dispute with regard to the interest.
Then in page 118, initially, my lord, the trial court had granted a protection, which, my lord, when it was vacated, please see the order, my lord, at the reasons. My lord, the trial court frames 3 issues, 2 issues, prima facie case and balance of convenience, and nothing with reference to injury. Page 25, my lord. Internal page of the order is page 25. Page 25, bottom, whether plaintiff has made out prima facie case, whether balance of convenience lies in favor of the plaintiff. And this is answered, my lord, at ink page 46, para 12. Upon perusal of the case of the plaintiff and defendant, number 1, it is admitted fact that 5 crores loan is taken by defendant number 1 from the plaintiff. Now, my lord, please turn to page 49. From the top, my lord, the 8th sentence. The above said IA prayers are against the defendant relating to the below mentioned description of the suit schedule properties shown as item number 1 and 2, which are landed properties, and the building appears that the property values of the said mortgage deed is mentioned for 5 crores only for the purpose of obtaining loan from the plaintiff. It is crystal clear that the photocopies and CDs produced by the plaintiff
disclosed that the suit schedule property multi-story buildings are appearing. It is admitted that both the said buildings are more than 5 crores of the mortgage consideration amount. In that sense, each floor will get more than 5 crores. The said multi-story buildings may become 40 to 50 crores. That being the fact, plaintiff cannot seek relief of IA 2 and 1 and 2 against the defendant. The plaintiff cannot prevent the defendant 1 to 4 to execute any sale deed. This is lis pendens, my lord. In the nature of conveyance with somebody relating to above said multi-story building, if the same is prevented, the defendant number 1 who has constructed a building in his property by using a huge amounts from defendant now 1 to 4 will be put to hardship. Suppose even though the mortgage deed is disputing by defendant number 1, a mortgager of the said property or false are required to impound, it is open to them to establish their respective case of the plaintiff and defendant full-fledged trial. Now it is not a point for considering the mortgage deed. For the reliefs of IA 1 and 2 as stated, the plaintiff cannot prevent the defendant from making any transaction with anybody in respect to the property. That is a multi-story building which are worth more than 100 crores. Open to the plaintiff. It is to insist on the defendant for executing a security deed in respect of 5 crores, which is admitted by the defendant. Even though the defendant 1 and 4 are disputing the above recovery of 5 crores money, also on the point of limitation, it cannot be accepted by this court at present because defendant 1 and 2 have to furnish a sufficient document of security relating to the land or any constructed building above the said 5 crores loan. The plaintiff succeeded in a trial against the defendant, and if the amount is paid by the plaintiff, then the said security deed deemed to be cancelled. On the other hand, if the defendant number 1 succeeded to disprove the very case of the plaintiff, the suit of the plaintiff will be dismissed, and the very security given by defendant 1 to 4 in favor of the plaintiff also becomes as to be deemed as cancelled. The very denying the reliefs of the plaintiff is that the worth of the suit properties is multi-story building is constructed more than 5 crores. Please see the document, my lord, and thereafter rejection. The document is at ink page 91. Ink page 92 is the amount of admission at the bottom, where it has been paid by check 5 crores. And please see page 9, sorry, it's not 90, 70, 92. 72. Sorry, my lord, ink page 72, written as 90, 72. Ink page
Deed of
70.
mortgage.
Please, my lord.
Deed of
Deed of
mortgage.
mortgage. At the bottom, the mortgager in need of money has approached the mortgagee to
Yes,
provide a
yes.
loan of 5 crores.
Details of 5 crores are given.
Yes, yes. And please see, ink page 74. I have the right, my lord, clause number 6. If he refuses to pay the money, I can seek recovery of by sale of the property.
Yes.
Again, in page 76, clause number 11, 12 and 13, they cannot sell the property without my consent. My lord, I should fairly say to my lord, separately, my lord, I filed a petition also for winding up before this honorable court. There they have paid some amount of around 3 crores towards the interest amount. Because under section 62 of the Contract Act, whatever money is first paid will be adjusted towards interest.
Yes.
Then towards principal. All I'm requesting, my lord, why I moved the matter, because when I saw this, even if my lord is pleased to see the order sheet of this honorable court, we have made many attempts to compromise and settle the matter. But last minute they have backed out, used it as a delay technique. All I'm saying, my lord, let them not sell it without leave of this honorable court.
Hello, apparents. Pass over ಮಾಡಿ ನೋಡಿ.
Grateful.
49.
In this case.
I'm appearing for the respondent, my lords. So matter may be taken up any day in next week, my lords.
Matter may be taken up any day in next week, my lords, please.
Why?
Senior counsel is appearing in this matter, my lords.
Senior counsel?
Is appearing in this matter, my lords.
Senior counsel
Respondent.
appear ಆದ್ರೆ ಏನ್ ಮಾಡ್ಬೇಕು?
ಬೇರೆ ಕೋರ್ಟಲ್ಲಿ ಇದಾರೆ.
ಏನ್ ಮೇಡಮ್ ಟೈಮ್ ಕೇಳ್ತಾ ಇದಾರೆ?
Anytime next week. any
Appellant
date,
counsel, sorry, respondent counsel, respondent counsel seeks time on the ground that senior counsel is engaged in this matter and is appearing in other court. Please, and counsel for the appellant says no objection, list this matter on 15/11. Great. 50.
Sangamesh Sharbi, Mallikarjuna Swamy,
To appear for the appellant. This matter also, my lords, may I seek for a short accommodation? I have to produce some more documents in this matter. Not very long, lords, 3 or 4 days. Subject
Appellant
to what?
counsel seeks time, counsel for respondent present. Appellant counsel seeks time on the ground that he wants to produce some documents.
But let them not seek in, let them not seek in further
will not.
at
I
my
will not,
instance.
lords. Any date fixed, I'll argue, lords, the interim order may be
Respondent
explicit.
not to seek adjournment in the next state of hearing, and hence list this matter on 15/11.
Interim order may be.
No, I make submission, there's nothing for extension. My lords, not to restraining alienation order either.
Tuesday ನೇ ಆಗ್ಬೋದು.
But
Tuesday
there is
itself I am-
nothing extension ಬರೋದಿಲ್ಲ ಸ್ವಾಮಿ ಇದರಲ್ಲಿ. Because the other order is
ಅಬ್ಸಲ್ಯೂಟ್ ಇದೆ ಅಂತ ನೋಡ್ರಿ.
first.
ಅಬ್ಸಲ್ಯೂಟ್ ಇದೆ, ನೀವು ವೆಕೇಟಿಂಗ್ ಹಾಕಿದ್ರಿ ಅಪ್ಲಿಕೇಶನ್.
At the inception, my lord, first order ಇದೆ. That shall be an order of injunction restraining different from alienating or creating any third party into the suit schedule property ಅಷ್ಟೇ.
ಅದೇ ಅಬ್ಸಲ್ಯೂಟ್. ಟಿಲ್ ನೆಕ್ಸ್ಟ್ ಸ್ಟೇಟ್ ಅಂತಿಲ್ಲ.
ಏನೇನಿಲ್ಲ.
You only filed an application for vacating.
Extension ಅಂತ ಏನಿಲ್ಲ. The prayer was for extension.
Extension ಏನಿಲ್ಲ ಅದ.
ಆಗ್ಬೋದು.
Obligement.
Till 11.
Obligement. Somewhere, my lord, some 5.
Last date ಅಲ್ಲಿ extend ಆಗಿದೆ 2/11.
4th or 5th.
Next week ತುಂಬಾ ಇದೆ. ಅದಕ್ಕೆ 15/11.
10th or 11th, my lords.
10th ಎಲ್ಲ ರಜಾ ರೀ. 10th ರಜಾ ಸಂಡೇ. 11th ಇಂದ. ಆಯ್ತು 12/11.
12/11.
Obligement.
I am obliged.
ಏನಂತ ಕ್ಲಾರಿಫೈ ಮಾಡಿದ್ದಾರೆ? alienating or creating any third party interest in the suitable property. There is no injunction order against the defendant number 8 from developing the property ಅಂತಿದೆ. Not to alienate ಇದೆ ಅಷ್ಟೇ. ಅಷ್ಟೇ. ಆಯ್ತು.
My lord, I appear for the appellants, my lord. I seek to file a memo of retirement, my lord. Appellant 1 has passed away. We should notice and try communicating with the LR. We also issued legal notice as well as acknowledgement has been attached to the copy, my lord.
Memo of retirement.
My-
What happened this letter?
My lord, it's been delivered, my lord. They haven't come forward and they refused to pick up phone calls as well.
What is the name?
Shakuntala is one of the LRs who are supposed to come on record, my lord. All of them stay together. 3 LRs,
Item delivered.
3 LRs, that is the wife and
On
2 children.
28/10. 2 days,
My
2
lord?
days before.
Yes, my
It
lord.
was served on 2 days before.
Yes, my lord.
Third. The appellant counsel has filed memo for retirement along with letter addressed to the ಯಾರು ಇವರು ಅಪಲೆಂಟ್ ಎಲ್ಲಾರ?
Yes, my lord. That is the
Narayan
son
Reddy.
of Narayan Reddy, my lord, appellant 1.
ಸುಮನ್ ರೆಡ್ಡಿ.
Yes, my lord.
ಬಟ್ ನೀವು ಇಲ್ಲಿ ಕೊಟ್ಟಿರೋದು ಯಾರೋ ಶಕುಂತಲಾ ಅನ್ನೋರಿಗೆ.
My lord, that is the Suman Reddy's mother, my lord. All 3 of them stay in the same house, my lord.
According to you, mother has acknowledged the same.
Yes, my lord.
Notice is sent to the appellant. And also produce the postal track. The same having been served on the mother of the appellant. And on perusal, it is dated 28/10/24. That is 2 days.
We have filed application for vacating
Back.
stay.
And council also submits that appellant is no more,
No more, my lord, appellant number 1.
appellant is no more and LRs have not approach the appellant. Having considered only it was served on 2 days back, it is appropriate to list this matter up to 2 days, 15 days. And list this matter on 15/11. No.
My lord, we have also filed a application for vacating stay.
Vacating.
How,
At 15/11.
please?
Probate petition came to be dismissed, man,
Hmm.
on the ground that attesting witness not examined. But in fact, PW number 2 is the attesting witness. He ident-
PW2 na.
PW number 2
Hmm.
is the attesting witness. PW number 3 is the scribe of the will, man.
Hmm.
My mother executed will in my favor.
Hmm.
My lord, the trial court was pleased to, my lord, dismiss only one para judgment, page number 13, para number 10.
Hmm.
Attesting witness illa anta finding ಕೊಡ್ತಾರೆ. In fact, PW number 2 is the
Paragraph number?
10, my lord. 9 and 10, 10 is the.
Is another witness to exhibit P5, he has identified his signature. Exhibit P5, therefore, from the above oral and document evidence, it is seen that the petitioner has examined attesting witnesses to exhibit P5. But as per section 5 of Transfer of Property Act, and also section 63 of the Indian Succession Act, attestation means the witness signs the document in the presence of the executant, and executant affixes his signature in the presence of the witnesses. Therefore, it was the attesting witnesses to the will who are appropriate persons to identify the signature of the testator. To prove due execution of the will, it must be proved that signature found in exhibit P5 is that of the testator. The same has not been complied with. Therefore, it is to be held that petitioner has failed to prove the due execution of will in accordance with law. ಏನ್ ಹೇಳ್ತಿದ್ದೀರಿ ಅವ್ರ ಕಡೆ?
In the previous para, in previous para, PW number 2, my lord, which is a attesting witness. The Naveen Kumar.
Attesting witness ಆಯ್ತ್ರಿ, ಅವ್ರು ಏನ್ ಹೇಳಿದಾರ್ರಿ?
ಅವ್ರು ಹೇಳ್ತಾರೆ, ನನ್ನ presence ಅಲ್ಲಿ she has executed the signature and I have also executed the signature.
ಎಲ್ಲಿದೆ ಎವಿಡೆನ್ಸ್ ಎಲ್ಲಿದೆ?
Evidence, certified copy ಇದೆ, if I am permitted to, I will cite.
ಕೋರ್ಟಿಗೆ ಹಾಕ್ಬೇಕಲ್ಲ ಅದನ್ನ?
ಕೋರ್ಟ್ ಹಾಕಿದೀವಿ sir. Evidence
ಕೋರ್ಟಿಗೆ ಹಾಕಿದೀರಾ?
ಅಲ್ಲ, PW number 2, evidence of.
ಇರೋದು ಕೋರ್ಟಲ್ಲಿ. ಇಂಪ್ಯೂಂಟ್ ಆರ್ಡರ್ ಬಿಟ್ರೆ ಬೇರೆ ಏನಿಲ್ಲ.
Permitted, certified copy.
ಇವ್ರು PW2 ನಾ?
ಹೌದು sir. Naveen Kumar. Naveen Kumar is the sister son of the deceased Ratnam. ಅಷ್ಟು 2 lines ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ sir. ನನ್ನ ಪ್ರೆಸೆನ್ಸ್ ಅಲ್ಲಿ ಪ್ರಿಪೇರ್ ಆಗಿ ಸೈನ್ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಿ.
ಎಲ್ಲಿದ್ದಾರೆ ಇದ್ರಲ್ಲಿ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ? ನನ್ನ ಸಮಕ್ಷಮದಲ್ಲಿ ಸಹಿ ಮಾಡಿರುತ್ತಾರೆ ಅಂತ ಹೇಳಿ.
ಹೌದು ಸ್ವಾಮಿ, ಬಟ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಸ್ವಾಮಿ kindly ಪ್ಯಾರ ನಂಬರ್ 9 ಸೆಟ್ ಟು ಬಿ ಅಟೆಸ್ಟಿಂಗ್ ವಿಟ್ನೆಸ್ ಅಂತ ಹೇಳ್ತಾರೆ. ಓನ್ಲಿ ಒನ್ ಪ್ಯಾರಾ ಫೈಂಡಿಂಗ್ ಕೊಟ್ಟು ಈಸ್ ನಾಟ್ ಅಟೆಸ್ಟಿಂಗ್ ವಿಟ್ನೆಸ್ ಅನ್ನೋದಕ್ಕೂ ಫೈಂಡಿಂಗ್ ಕೊಟ್ಟಿಲ್ಲ.
PW2 ಬಗ್ಗೆ ಎಲ್ಲಿ ಬರ್ದಿದ್ದಾರೆ ಇಲ್ಲಿ? PW3 ನೀವು ಓದಿರಿ, PW2
ಪ್ರೀವಿಯಸ್ ಪ್ಯಾರಾದಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ. ಪ್ರೀವಿಯಸ್ ಪ್ಯಾರಾದಲ್ಲಿ ಫಸ್ಟ್ 2 lines.
Chandrappa in favor of petition, exhibit B has been marked through PW2, who is stated to be an asserting witness to the will. In his chief examination, PW has stated in corroboration with the petition averments.
It's against evidence, man.
You know, the execution of will. However, he has identified a signature in exhibit P5 which has been marked as P5A. You discussion ಮಾಡಲಿಲ್ವಾ?
ಹೌದು ಸ್ವಾಮಿ, against to the evidence of the PW number 2. And PW number 3 is the scribe of the will. He is also my lord.
PW3 is the scribe.
ಹೌದು ಸ್ವಾಮಿ.
Respondents ನಿಲ್ಲ.
ಇಲ್ಲ ಸ್ವಾಮಿ.
Sorry, this matter is listed for admission. I heard the appellant counsel. This appeal is filed. against the dismissal of. ಏನ್ ಕೇಳಿರೋದು ನೀವು ರಿಲೀಫ್? What is the prayer? Dismissal of the petition filed for grant of probate with respect to will dated 23/2/22, executed by his mother Ratnamma, who died on 27/2/22. The factual matters of the case of petitioner in a petition filed under section 276 of the Indian Succession Act contended that Ratnamma, being the absolute owner of the scheduled property, bequeaths the same in favor of the petitioner by the unregistered will dated 23/2/22. It is contended that Ratnamma died on 27/2. In ನಾಲ್ಕು ದಿವಸದಲ್ಲೇ ಸತ್ತೋಗ್ಬಿಟ್ರೇನ್ರಿ? 27/2/22. The petitioner, in order to prove the case, examined himself as PW1 and 2 witnesses have been examined as PW2 and 3. 5 documents are marked exhibit P1 to P5. The trial court, having considered both oral and documentary evidence, comes to the conclusion that the petitioner has not proved the execution of the will dated 23/2/22. Hence dismiss this same. The counsel appearing for the appellant would vehemently contend that trial court committed an error in coming to the conclusion that will has not been proved, and contend that will has been drafted by PW3 and for which the PW2 was the attesting witness. In response to paper publication, no person appeared before the trial court. The oral and documentary evidence led on behalf of the appellant clearly goes to show that mother of the appellant executed the will in favor of the appellant, but trial court committed an error in dismissing the petition on the ground of technicalities. The counsel also vehemently contend that the trial court only relied upon the evidence of PW3, who is the scribe, but not relied upon the evidence of PW2 and not considered both oral and documentary evidence while passing in such an order, and record and evidence on record clearly establishes the execution of will by the testator and even met the requirements of section 63 also and committed an error. This appeal is filed against the order of the trial court, and no respondents have been arraigned, and also record discloses that citation was taken before the trial court and none appears and contested the matter. Having perused the material on record, the exhibit P5 is the certified copy of the will, and so also produced the genealogical tree as per exhibit P1, and exhibit P2 and P3 are RTCs in respect of the subject matter of the will, and also exhibit P4 is the certified copy of the sale deed. The will is marked as exhibit P5. Having perused the evidence of PW1, he reiterates with regard to the very execution of the will in his favor. In order to substantiate his contention, also examined the PW2. And PW2 categorically stated that on 23/2/2022, the very executant took him to Hosadurga and obtained his signature, and he is aware of the contents of the will. It is also his evidence that the will was prepared by PW3, and he also signed the said document, and also witnesses have signed the same, and he also signed the same as a witness, and also categorically says that the executant, who is the mother of the petitioner, also signed the same, and he also identified the signature. Having perused this evidence, it is very clear with regard to the very execution of the will, and also his signature is marked, and also signature of the executant is also marked, and also the other witness Ananta Brahma and witness Ramesh have also signed. And specifically spoken that PW3 only describe and the Ratnamma executed the will in favor of the petitioner. The petitioner also relied upon the evidence of PW3, who also speaks with regard to preparing of the will by himself. And also witnesses have signed in his present as well as the executant also signed the document. Having perused the reasoning given by the trial court, and trial court only discussed the evidence of PW3. That is the scribe of the exhibit B5. The court comes to the conclusion that to prove the due execution of will, it must be proved that the signature found in exhibit P5 is that of the testator. The same has not been complied with, and the said observation is erroneous, and PW2 categorically stated that he is a attesting witness, and also he had signed the same, and in his presence also the executant had signed the will. And the very conclusion arrived by the trial court that section 63 of the Indian Succession Act has not been complied is against the material available on record. The trial court though referred the evidence of PW2 attesting witness and speaks about in corroboration with the petition averments and execution of the will. And he has identified the signature in exhibit P5, which has been marked as exhibit P5A, but not discussed anything about the evidence of PW2. And he is an eyewitness, and he categorically deposed before the court that the very testator called him to Hosadurga and prepared the will through the PW3. And he had also spoken with regard to the very execution and attestation and identifying the signature of the testator. And in spite of it, trial court not discussed anything about the evidence available on record, particularly taking into the note of evidence of PW 1 to 3 as well as documentary evidence, and hence trial court committed an error in dismissing the petition, and it requires interference of this court in view of non-application of mind as well as non-consideration of evidence, particularly the evidence of PW2, and order requires to be set aside. In view of the discussions made up, I pass the following order. Appeal is allowed, impugned order is set aside, and consequently the probate is granted as sought.
B.B. Shivkumar, N.S. Seshadri.
Respondent number 2 and 3. Or respondent number 2 and 3.
But they were impleaded on an application filed by them to seek impleadment because they have purchased the property after the order of attachment.
After the
order of attachment by this court.
My vendor has purchased the property in the year 1990. There were defendant is the second purchaser of the same property, in the year 2006. There was a litigation between my vendor and the defendant, and wherein the Honorable High Court of Karnataka has rectified the mistakes, my lordships, and entered my vendor's name in the revenue records. Thereafter, my lordships, I have purchased the property. We had no notice of the cases pending before the money recovery suit or attachment, my lordships. And my vendor is not a party, and he is the absolute owner of the property.
Yes, reasoning.
But the application was filed under 38 Rule 5, seeking attachment of
Attachment.
the amount
Hmm.
for recovery. But the learned judge at
Suit is
page
for recovery
70,
of money,
1 crore 50 lakhs
recovery of money.
money.
Hmm.
This respondent is a government official.
Hmm.
He is assistant executive engineer, and also he has been doing business
Hmm.
as a government servant. I don't know what is his capacity.
Hmm.
But in page 17,
Hmm.
the learned judge gives reasoning at para 6 of
Hmm.
the order. After he comes to the conclusion,
Hmm.
in the background of the above case, plaintiff has filed the above application by seeking order for attachment.
Hmm.
The application scheduled property before judgment, but nowhere in the application plaintiff alleged that defendant with intent to delay or make the decree ineffective had the plan to sell the property situated within jurisdiction of this court. In fact, if contention of both the sides were considered, defendant is also a businessman who has a sound financial capacity, who in fact claiming the counterclaim by paying court fee. The dispute requires the detailed trial, but anyway, plaintiff made out the grounds that he has apprehension that plaintiff with intent to defeat decree, if any, passed by this court, had the intention to sell away the properties, moving out of jurisdiction of this court. In the absence of said material, pleadings in plaintiff application cannot be considered. This is a short reasoning that the learned judge gives. The contention as on that date was, there is no apprehension that he would sell away the property. That's his opinion that is expressed by him. Then when this rejection was there, my lord, I approached this court. This honorable court granted an order of attachment, attaching the very same property. But the application now filed by the impleading applicant, what he contends may have to be looked into by this court. But while filing application before this court, the impleading applicant contends that a deed of confirmation is executed in his favor. But that my lords would get at para 7 of his affidavit. His affidavit before the court.
Impleading applicant already, application was allowed?
It was allowed.
His application is allowed by this court.
Yes, yes.
Appeal papers and impinged order was not served upon me, my lords. Appeal copy and impinged order was not
So
served
you have
upon.
been impleaded, memo, appeal memo was not served on you?
No, my lords. Only cost title was sent
the-
through post.
So, counsel for the respondent number 2 and 3 submits that appeal memo is not served on him. And hence appellant counsel is directed to furnish the copy of the appeal memo on the counsel forthwith.
I may be permitted to file my statement of objection.
Huh?
I will file my statement of objections.
Yes, statement of objection.
Disclosing the true facts that they are not the owners of the property and we are the owners of the.
Is this matter on 11/11? ಹಾಕೊಂಗಿದ್ರೆ ಹಾಕ್ಬೋದು.
Please, madam.
P4, Kamaleshwara Pujari, Nagaraj S. Jain.
Hearing for the respondent, I kindly before pass over my law.
My lord, this matter may be called along with the
Yeah,
MFA
go
number
to engage this matter, my
2997
kindly
bar
pass over my law.
2024.
That's
99?
2997 bar 2024. Connected amendment.
299.
ಹೌದು 2997 ಬಾರ್ 2024.
2024.
7th my lord, 7th may kindly.
construction has, building has been already constructed and the coordinate bench has passed an order in the month of December last year, my lord. They have permitted to construct a building, my lord. Kindly pray for pass over, my lord.
ಅಲ್ಲ ರೀ, ಈಗ ಅವ್ರೇನು ಒನ್ಲಿ ಇನ್ನೊಂದು ಮ್ಯಾಟರ್ ನ ಲಿಸ್ಟ್ ಮಾಡಿ ಒಟ್ಟಿಗೆ ತಗೊಳ್ಳಿ ಅಂತ ಹೇಳ್ತವ್ರೆ. ವಾಟ್ ಇಸ್ ದಿ ಅರ್ಜೆನ್ಸಿ ಫಾರ್ ಯು?
Urgency for me. ಏನಿಲ್ಲ.
The appellant counsel submits that another MFA 2997 of 24 is also pending and the same also may be listed along with this.
Along with MFA number
Bill.
8388.
That is 8388 of 23. And hence
7
list both on
711.
1111. 7 ಎಲ್ಲ ಜಾಸ್ತಿ ಇದಾಗಲ್ಲ.
11 ಇನ್ನೊಂದು ಕನೆಕ್ಟರ್ ಮಾಡಿ ನಾನು
11 ಇದ್ರೇನು ಅವತ್ತೇ ಇರ್ಬೋದು, ಎರಡನ್ನು ನೋಡಿ.
ಒಂದಿನ ಹಿಂದೆ ಮದುವೆ ಮಾಡಿ ಕೊಡಿ. 11 ಬೇಡ, 11 ಬೇಡ.
12th ಆಗ್ಬೋದಾ?
10 or 9.
10 Sunday.
9 mind, I'm sorry.
9 second Saturday.
12 may kindly give me. 12.
ಆಯ್ತು, 12/11.
Please.
Five, Shankar Reddy, Venkatrami Reddy. To the respondent, madam.
Respondent number.
ರೆಡಿ ಅಲ್ಲ ಇಬ್ರು?
I undertake to produce the documents. It is from Calcutta. I undertake to produce original document, death certificate from concerned office in Calcutta. Because of cyclone, I could not get it. Kindly grant me 2 weeks time.
This ಏನ್ ಬೇಕು ನಿಮ್ಗೆ ಏನು
Death certificate.
ಡೆತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಯಾರ್ದು?
Produce ಮಾಡಕ್ boss.
Lord, it is a case where not they take up a contention before the court that the person who had executed the general power of attorney. I have purchased the property through the general power of attorney. They want to take up a contention that general power of attorney holder was already dead. Therefore, I have fabricated a registered general power of attorney. That contention was not taken in the written statement. For the first time, my lord, they filed a copy of the death certificate before the court. Thereafter, my lord, I took time before this court, my lord, to verify from the Kolkata Municipal Corporation whether the copy that has been furnished to the court is a genuine one or not. I have got an endorsement indicating that they have produced a fake document before the court. That endorsement has been produced before the court issued by the Kolkata Municipal Corporation. Now they want to cross-check my my lord, endorsement. On that ground, my lord, 2 adjournments have already been taken by them.
ಏನ್ರಿ
2 weeks time.
ಇನ್ನೇನು ಟೈಮ್ ತಗೊಂಡಿದ್ದೀರಂತಲ್ಲ ಕ್ಲಾಸ್ ವೆರಿಫೈ ಮಾಡಕ್ಕೆ
2 ಸರಿ ತಗೊಂಡು
ಅವರ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಗೆ stating that the death certificate of so and so base that is being attached with the request do not matches with the original and no record are there in their file.
ಹೌದು ಆತರ ಯಾವ್ದು ಇಲ್ಲ ಅಲ್ಲಿ ಸತ್ತೋಗಿರೋದನ್ನೇ ಇಲ್ಲ ಅದೇ ಡಾಕ್ಯುಮೆಂಟ್ ನ ಫೋರ್ಜ್ ಮಾಡ್ಕೊಂಡ್ ಬಂದು ಕೋರ್ಟ್ಗೆ ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ.
Counsel for the respondent again seeks time. ನಾನೇ ಟೈಮ್ ಕೊಟ್ಟಿದ್ದೀನಲ್ರಿ?
ಹೌದು,
15 days.
Last time quoted this only because of cyclone, I could not get documents. Kindly grant.
The respondent counsel again seeks time to cross verify with regard to the endorsement produced by the appellant. And record disclosures in the earlier occasion also took time. And finally granted
2
time,
weeks time.
list
15.
this matter on 12/11.
15. Like over the.
15/11.
56. Anand.
I'm for the appellant in this case.
I am for the respondent.
And before this honorable court, my lord, I've entrusted the construction work to a respondent, my lord. I was searching for a contractor to construct the house of in my property, ground plus 2 floor, my lord. In that aspects, I was searching for the contractor.
Ground plus
I
first
found-
floor, not 2 floor, 1 floor.
I found
3 plus 1,
3+1.
1.
Ground and first floor.
Lord, G plus 2 floor, my lord.
G+2.
Yes, my lord. As per
According to you, G+2, according to him, G+1.
Construction agreement
as
is
per the
very,
construction
very clear.
agreement, details is there, my lord. Construction agreement details is there, my lord. My lord, when I was searching for a contractor, I found this respondent. Through the respondent, there is a negotiation on this construction work, and the quotation has been given by the respondent. As per the quotation, the agreement has been drafted by the respondent, my lord. As per the agreement, he's supposed to give a good quality of the construction in my property while constructing the property. As per the construction agreement, I have paid the, instead of 18 lakhs, I paid the 20 lakhs as an advance to him for the construction of the foundation work, my lord. When the construction work is carrying out in between, the respondent started using the poor quality of standard of quality of work in the construction on the foundation itself, my lord. In this aspect, many communication has been happened, but even the respondent has not corrected on the construction work to provide a good quality on the amount has been paid by me. On this, in this aspect, the termination, I've made a termination agreement, terminate the agreement on 11/10/2023, my lord. And after that, there is no construction work activities has been going on. In 18/12, I have been approached to the expert opinion to get the tested by the construction work on 18/12/2023. As per the construction agreement, there's one report. I've been come to the conclusion that the construction work which has been carried out by the respondent is not adequate to the carry out the construction work on the ground plus 2 floor, my lord. As per that. And in this aspects, when I started to get the test of the report of that, immediately respondent approached to the civil court and stating that they have approached for the permanent injunction restraining the defendant. It is my property, my lord. I have given an amount to the respondent to make the inserted the respondent to carry out the construction work. There, when the
What is
test
the order
report
you
is
had obtained?
When the test report is come to the conclusion, then what? They immediately approach to the civil court and they're taken restraining the defendant from the interfering the peaceful possession of the property of the plaintiff, my lord. Though I'm not given any possession to him. I'm now only entrusted the work which have been given amount to them in that aspects, my lord. And page number 86 of my petition, my lord, the expert opinion from the Bureau of this standard expert opinion report, my lord. Indian standard code is to be practiced in this report, my lord. Page number 86, it is conclusion remark. It is clearly says that inadequate to carry out the construction work on the ground plus 2 upper floor labs, 3 labs, including the terrace floor. In this aspect, in this aspect, even I have filed a consumer petition is also before this principal district consumer forum, my lord. The petition is still pending, my lord. And my lord, I pray this honorable court here to expedite the proceedings in the OS proceedings, my lord. The intention of the respondent is nothing but to drag on the proceedings and make a harassment to my lord, my lord. In this aspect, they have approached the civil court and they have taken a interim order restraining me to interfering my peaceful possession of the property. After getting the interim order, my lord, they have 3 times they come towards the construction area. They have taken all the jelly, steel, sand, everything and all, my lord. And after that, they're making allegation on me that I have stolen the all these things, my lord. There is a telephonic conversation is also available in my aspects, my lord. That's saying that nanellu helilla nimge katkondu hogta idira anta. Nanu ella en material nan tagondu hogta idini like that. The contractor will speak like that. In my absence, such kind of activities is going on, my lord. So I pray this honorable court kindly set aside the order of the stay and also expedite the proceedings within the 2 months to carry out this. Here, my lord, the respondent is not seeking for the additional amount what he is incurred as per his claim, my lord. He has filed only a permanent injunction restraining me from the peaceful possession of the property. And if really he having any loss on his construction, definitely he would have went for the approach for the money recovery suit, my lord. Here, the legal notice issued by him, then I issued the termination letter on 11/10/2023. And after the same is also sent through the email to him on 13/3/2023. The acknowledgement is also produced before this honorable court, my lord. This clearly shows that the intention of the respondent is only to drag on the proceedings and make the harassment loss to me, my lord. Nothing else, my lord. The amount which have been incurred in the property, my lord, he has used only half of the amount to construct on the property. And the test report is clearly says not only it is inadequate to construct the floor in the future, it is a future is the durability of the building is a lack of the durability. I'll be residing in with my family, my lord. With the intention of the good intention, I have been initiated the respondent to carry out the building work, but the respondent has cheated me with giving a poor quality materials, my lord.
Yes, counsel, next.
Please, my lord. The petitioner has approached me. I am basically a civil contractor in profession, having put up many projects. After verifying my projects, inspecting my sites and all that, he approached me for a putting up of the construction of the house G+1. And agreed sale construction amount was 1 crore 2 lakhs. 1 crore 2 lakhs, out of which 20 lakhs was paid. Upon the execution of an agreement of construction on 15 June 2023.
Agreement is dated
15/6/2023, my lord. And in that construction agreement, every clauses, when he has to pay the slab-wise payment, everything is mentioned, my lord. Now, upon the payment of 20 lakhs, my lord, I have put up the construction. It is, maybe if your lordship permits me to produce the, lordship kindly see the site. Idu a retaining wall, my lord. Retaining wall, my lord. I have invested 18 lakhs for construction of a retaining wall. Adu Halladallittu Swami site. So nanu a pillar wise ground floor vargu kattidini Swami. Nanu produce the photograph for present for lordship. Now, thereafter, after putting up the retaining wall, construction, base till footing, my lord, basement and everything. The petitioner was there on the site. He was inspecting the materials. The A1 quality materials, he agreed, accepted, everything he was happy, my lord. Now, when, as per the agreement of construction, when I started demanding second payment, now we started, sir, nan loan ಬರ್ತಾ ಇದೆ, loan I apply ಮಾಡಿದ್ದೀನಿ, construction loan, ಬರುತ್ತೆ, ನೀವು ಸ್ವಲ್ಪ invest ಮಾಡಿ, because this is not the only construction site, my lord. In Bangalore, commercial and as well residential, so many construction projects is ongoing projects. ನಾನು sites ಇಂದ ತಗೊಂಡ್ಬಂದು ನಾನು believing that you will release the second payment. I have invested further 18 lakhs, my lord, on this site. Now, when I demanded the second payment, he started this one coming with rowdies. ನೀವು ಇದು ಮಾಡಿ, ನೀವು ಸ್ಟಾಪ್ ಮಾಡಿ, ನೀವು ಹೋಗಿ, ನೀವು ನಾವು ಕೊಡೋದಿಲ್ಲ ಅಂತ. Then when rowdies and all the
What is the status of construction?
My lord, here, I have to have a photograph before this on-board court.
my lord, I have to put up the first slab, my lord.
Agreement ಪ್ರಕಾರ ಸೆಕೆಂಡ್ ಪೇಮೆಂಟ್ ಯಾವಾಗ ಕೊಡ್ಬೇಕು? ರಿಟೈನಿಂಗ್ ವಾಲ್ಗೆ ಅಂತಾನೆ ಒಂದು 10 ಲಕ್ಷ ಇದೆ ಅಗ್ರಿಮೆಂಟ್ ಪ್ರಕಾರ.
ಹೌದು ಸ್ವಾಮಿ, ರಿಟೈನಿಂಗ್ ವಾಲ್ ಆಗಿ
ಇನಿಷಿಯಲ್ ಅಡ್ವಾನ್ಸ್ 18 ಲ್ಯಾಕ್ ಅಂತಿದೆ.
ಹೌದು ಸ್ವಾಮಿ,
ಹೌದಾ?
ಹೌದು.
ಆಫ್ಟರ್ ಫಸ್ಟ್ ಲ್ಯಾಬ್ ಮತ್ತೆ 20 ಲ್ಯಾಕ್ಸ್ ಕೊಡ್ಬೇಕು ಅಂತಿದೆ. ನೀವು ಫಸ್ಟ್ ಲ್ಯಾಬ್ ಬಂದೇ ಇಲ್ವಲ್ಲ, ಮತ್ತೆ ಹೆಂಗ್ ಸೆಕೆಂಡ್ ಪೇಮೆಂಟ್ ಮಾಡ್ತಾರೆ? ಹೋಗಿ ನಿಮ್ಮ 35 ಪೇಜ್ ನಂಬರ್ 35 ಹೋಗಿ 35.
Some photographs is before me also.
I'm sorry, my lord.
According to you, only you put up the retaining wall and also the columns. Nim
Basement,
photographs.
House.
How you can seek a relief of permanent injunction against him? Not
No,
to interfere.
no, the roadies and the.
ಏನೇ ಇದ್ರೂನು ನೀವು
I
contract
have lodged the complaint, my lord.
ಪ್ರಕಾರ you can recover the amount, that's all. ಅಲ್ವಾ?
ಅಲ್ಲ, ನಾನು I am ready. I am with the construction, Swami. He has not terminated my agreement of construction.
ಮಾಡಿದಾರಲ್ಲ cancellation.
ಇಲ್ಲ ಸ್ವಾಮಿ, that has not been served on me. Before that, I have caused a legal notice on him for release of the further payment. He has not replied. Then I lodged the complaint when the police and the rowdies.
For 70 million.
ನಿಮ್ಮ ಫೋಟೋಗ್ರಾಫ್ ಪ್ರಕಾರ ರಿಟೈನಿಂಗ್ ವಾಲ್ ಹಾಕಿದ್ ಬಿಟ್ರೆ, ಕಾಲಮ್ಸ್ ಹಾಕಿರೋದ್ ಬಿಟ್ರೆ ಬೇರೆ ಏನ್ ಹಾಕಿದಿರಿ? ನಿಮಗೆ ಮತ್ತೆ ರಿಲೀಸ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ದುಡ್ಡು ಓನ್ಲಿ ಆಫ್ಟರ್ ದಿ ಫಸ್ಟ್ ಸ್ಲ್ಯಾಬ್ ಅಂತಿದೆ, ಅದು 18 ಲ್ಯಾಕ್. ಈ ಫಸ್ಟ್ ರಿಟೈನಿಂಗ್ ವಾಲ್ 10 ಲಕ್ಷ
ಇಲ್ಲ, ರಿಟೈನಿಂಗ್ ವಾಲ್ ಅನ್ಬಿಟ್ಟು ಏನು ಇಲ್ಲ, my lord. For the foundation itself is started charging for the
agreement.
Yes, my lord. As per the agreement itself, my lord.
ನೀವು ಹಾಕಿರೋ ಡಾಕ್ಯುಮೆಂಟ್.
Yes, my lord. Retaining wall ನ ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಆಡ್ ಆನ್ ಮಾಡಿರೋದು ಇದನ್ನ, ಅದನ್ನ ಫಸ್ಟ್ ಅಲ್ಲಿ ತೋರಿಸಿದ್ದಾರೆ. But at the time of construction work, I have paid him 20 lakhs, my lord, in the good intention of the construction work to be carried out. When
ನಿಮ್ಮ ಡಾಕ್ಯುಮೆಂಟ್ ಪ್ರಕಾರ
yes, my lord.
ಶೆಡ್ಯೂಲ್ ಇದೆ ನೋಡಿ,
Yes,
ಪೇಮೆಂಟ್
my lord.
ಶೆಡ್ಯೂಲ್.
Yes, my lord. Yes, my
You
lord.
also a part of-
Initial payment 18 lakhs. Adal 20 lakhs rupees payment ಮಾಡಿದೀನಿ. ಅವ್ರು ರಿಟೈನಿಂಗ್ ವ್ಯಾಲ್ಯೂನು ಕಂಪ್ಲೀಟ್ ಮಾಡಿಲ್ಲ. ರಿಟೈನಿಂಗ್ ವಾಲ್ಗೆ ಇನ್ನೂ ಮುಂದೆ ಬರುತ್ತೆ. ಇದು ಫೌಂಡೇಶನ್ ಸ್ಟೇಜ್ ಅಲ್ಲೇ ಇದೆ. Let me look into my photographs, my lord. A foundation work itself carried out in an inadequate way and also in a poor standard of work.
Hammer test.
My lord, that test is not an Indian standard test, my lord. Not the test which has been produced by me before this on-board court with the Bureau of
First
Investigation.
quality ಅಂತಾನೆ ನನ್ನ ರಿಪೋರ್ಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
Clearly shows that when all the tests should be done by the Indian standard test, my lord. The same, whenever this test column will be there is the test report definitions ಬೇರೆ ಇರ್ತದೆ, my lord. ಇದಲ್ಲ, as per that. And when the point of termination of agreement comes, my lord, here, page number 70, please look into the annexure G, my lord. The termination of contract have sent to him a email also. When I went to personally given to him.
No, where he has mentioned sub-quality ಅಂತ ಎಲ್ಲೂ mention ಮಾಡಿಲ್ಲ.
He rejected me and he has given a threat to me, my lord.
Termination notice ಎಲ್ಲಿದೆ?
It is in the page number 68, my lord.
68.
Yes, my lord. And same is sent through email to him also on the page number 70, my lord. And when I've given a personally went to him his office and given a termination letter, And that time he has not accepted and he has given a dhamki, my lord, in that time. And that time later on, I have sent him through the email, my lord. That has been accepted by you. That is the email acknowledgement before this honorable court I produced, my lord. It is clearly says that one, my lord, in September itself, the construction work was stopped.
No bona fide reason he has mentioned any
And
word, single word, my lord,
Amount
it is
which
a
has
termination
been
letter.
incurred, what
After
the amount
causing
which
my
has been given
notice,
to
he
him,
has-
my lord. Not more than that, my lord. If really he having a intention of the recovery, he would have given for a recovery of the amount, my lord, not on the permanent injunction. It is only to intention of the harassment. It is nothing but the abuse process of law, my lord.
Where is your termination notice, Re?
Notice illa sir.
Well, a termination letter by the, directly by the party itself.
In
my lord.
accordance
It
with law,
is
he
the
has not
68,
terminated.
ಇದೆಲ್ಲಿದೆ?
My lord,
ನೀವು ಕಳಿಸಿದ್ದೆಲ್ಲಿದೆ ಅಂದ್ರೆ?
annexed, yes, my
Termination
lord.
of contract work for our residence.
Yes, my lord.
Site number 455. In settlement on my investment which I have paid to you, rupees 20 lakh.
ಅದ್ರಲ್ಲಿ 15 ಲಕ್ಷ ಖರ್ಚು ಮಾಡಿದೀರಾ, ಇನ್ನು 5 ಲಕ್ಷ ವಾಪಸ್ ಕೊಡಿ, ಟರ್ಮಿನೇಟ್ ಮಾಡೋಣ ಕಾಂಟ್ರಾಕ್ಟ್ ನ ಅನ್ಬಿಟ್ಟು I've signed on the 11/10/2023 itself.
It is not a
And
statutory.
same is also sent by the email also on page number 70, annexure Gmail, or the copy of the computer extracted copy is before this on page number 70, annexure Gmail.
Not been served, my
When the
lord.
contract itself terminated, my lord, when I've started to get the test report from the site area for the suitable authority, on that time, the respondent rushed towards the city civil court, restraining me from the interfering the peaceful possession of the property. Later on, all the jelly, sand and steel and everything is taken by him, my lord. But false complaint before me, it's been filed before the jurisdiction police station. And on the day itself, even I have filed a complaint against him. And later on, when he started, once again, he came before the site area and taken all.
ಆಯ್ತ್ರಿ ನಿಮ್ ರಿಲೀಫ್ ಏನ್ರಿ? ಆಯ್ತು. You are preventing him to put up the construction. What you would get? He is the owner of the site.
I have no
Work
dispute.
is interested.
I have
to
no
do.
dispute, my lord.
Ah.
As per the contracts, he agreed 15 lakhs, 5 lakhs ಕೊಟ್ಬಿಡಿ. My agreement has not been conveyed. Nan purpose, I am the civil engineer. I have invested. I have put up a lot.
ಆಯ್ತು, ನಿಮ್ಮ ಅಗ್ರಿಮೆಂಟ್ ಪ್ರಕಾರನೇ ನಿಮಗೆ ಕೊಡ್ಬೇಕಾದ್ರೆ ದುಡ್ಡು ಆಫ್ಟರ್ ಫಸ್ಟ್ ಸ್ಲ್ಯಾಬ್ ಅಂತ ಇದೆ. ಸೆಕೆಂಡ್ ಪೇಮೆಂಟ್ ಮಸ್ಟ್ ಬಿ ಆಫ್ಟರ್ ಸೆಕೆಂಡ್ ಸ್ಲ್ಯಾಬ್ ಅಂತ ಇದೆ. ನೀವು ಸ್ಲ್ಯಾಬೇ ಹಾಕಿಲ್ಲ, ಸ್ಲ್ಯಾಬ್ ಹೋಗಿ ಇನ್ನು ಯಾವ ಕಾಲಮ್ಸ್ ಕೂಡ ಎತ್ತಿಲ್ಲ, ಏನ್ ಮಾಡ್ಬೇಕು?
Hello, retaining wall ಮತ್ತೆ ಇದು footing, basement ಇದೆಲ್ಲ
Let the be.
Any commissioner may
to evaluate the same and.
ಅಷ್ಟೇ ಸಮಯ ಒಬ್ಬ ಕಮಿಷನರ್ ಅಪಾಯಿಂಟ್ ಮಾಡಿ ಹೌ ಮಚ್ ಐ ಇನ್ವೆಸ್ಟೆಡ್, ನಾನು ಐ ಆಮ್ ಸೀಕಿಂಗ್ 18 lakhs ಕೊಡಿ ಅಂದ್ರೆ ಅವ್ರು ಇಲ್ಲ 5 ಲಕ್ಷ ಕೊಡ್ತೀನಿ ಅಂತಾರೆ. That is ನಾನು ಐ ಆಮ್ ಎ ಸಿವಿಲ್ ಇಂಜಿನಿಯರ್. ನಾನು ಲಾಸ್ಟ್
According to you, how much you have spent already?
ಸ್ವಾಮಿ ನಾನು ಇನ್ಫಾರ್ಮ್ ಸ್ವಾಮಿ ನೋಟಿಸ್ ಅಲ್ಲಿ ಹೇಳಿದ್ದೀನಿ 18 lakhs ನಾನು ಅಪಾರ್ಟ್ ಫ್ರಮ್ 20 lakhs.
ನೀವು ಆಯ್ತ್ರಿ 20 ಲಕ್ಷ ತಗೊಂಡಿದ್ದೀರಿ
ಹೌದು ಸ್ವಾಮಿ
ಅಲ್ವಾ?
ಅದು ಅಪಾರ್ಟ್ ಫ್ರಮ್
ಎಷ್ಟು ಬರ್ಬೇಕು ನಿಮ್ ಪ್ರಕಾರ?
ನನ್ನ ಪ್ರಕಾರ ಒಂದು 16,50,000 ಅಂತೇನೋ ಇದೆ ಸರ್.
35 ಲಕ್ಷಕ್ಕೆ ನಿಮ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಕೆಲಸ ಏನ್ ತೋರ್ಸಿ? You cannot claim blindly. You see your own photographs.
My lordship,
Except retaining wall and columns. What you have done? Why you are claiming out of 1 crore 2 lakhs ಅಲ್ಲಿ ನೀವು 35 ಲಕ್ಷ ಈಗಲೇ ಕೇಳಿದ್ರೆ ಕೆಲಸ ಮಾಡಿರೋದು ಇಷ್ಟು.
My humble request to your lordship is to appoint a commissioner, my lord. ಅವ್ರು ಏನ್ ರಿಪೋರ್ಟ್ ಕೊಡ್ತಾರೆ I accept, my lord.
ಆಯ್ತು ನೋಡ್ರಿ, ಇಬ್ರು ವ್ಯಾಲ್ಯೂರ್ ಕಳ್ಸೋಣ.
My lord.
ನಾನು mediation ಮಾಡಿದೆ ಸರ್.
ಅವ್ರು ಬರೀ
If they are recovering the amount, my lord.
15 ಲಕ್ಷ ಖರ್ಚು ಮಾಡಿದ್ದಾರೆ ಅಂತ
My lord, if they are recovering the amount, they would have filed a suit for the recovery suit, my lord. This suit is for the permanent.
ನಾನು ರಿಕವರಿ ಮಾಡಕ್ಕೆ ನಾನು ಐ ಆಮ್ ಎ ಸಿವಿಲ್ ಇಂಜಿನಿಯರ್, my lord.
My lord.
As per the contract, I have put up the construction. ನಾನು ರಿಕವರಿಗೆ ಯಾಕೆ?
ನಿಮ್ಮ ಅಗ್ರಿಮೆಂಟ್ ಪ್ರಕಾರ ಏನಿದೆ ಕ್ಲಾಸ್ ಹೇಳಿ? ಅಗ್ರಿಮೆಂಟ್ ಫಾರ್ ಹೌಸ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಅಲ್ಲಿ ಏನಾದ್ರು ಕ್ಲಾಸ್ ಇದೆಯಾ ಅದ್ರ ಬಗ್ಗೆ?
And my lord, moreover, in the agreement of construction, he has to use a M25 grade of cement, my lord.
ಆಯ್ತು, ಅದೆಲ್ಲ ನೋಡೋಣ, ಅದು ಆಮೇಲೆ ನೋಡೋಣ, ಅವ್ರು ಮಾಡ್ಲಿ. ಸ್ಟೀಲ್ ವರ್ಕ್, ಮೇಸನ್ರಿ, ಎನಿ ಕಂಡೀಷನ್ ಅಷ್ಟೇ. Owner should provide the power for construction purpose and monthly electrical bills should be paid. Any increase in power capacity whenever required shall be done and owner shall bear its charges. Pescom deposit and charges, road cutting charges, owner shall bear its charges. Fitting and labor charges will be borne by, electrical fittings and labor charges will be borne by owner.
Avella have been bared, my lord.
Point in false ceiling.
Apart
where
from the payment of
extra
him.
cost.
Apart from the payment of him and other things, charges and all are bared by myself only, my.
He says one-
Electricity, water and everything and all, my lord.
ಅಲ್ಲ, he says
ಅಲ್ಲೂ
second floor ಅಂತ
ಬಂದ್ಬಿಟ್ಟು
ಹೇಳ್ತಾರೆ
ಆ
sir, first
motor
second. It is mentioned ground plus
electricity
ಇಲ್ಲ ಬಿಡಿ,
ಮಾಡ್ತಾರೆ.
ಒಂದೇ ಸೆಕೆಂಡ್ ಫ್ಲೋರ್ ಏನಿಲ್ಲ ಅವ್ರು ಹೇಳೋ ಪ್ರಕಾರ
ಹೌದು.
ಇರೋದೇ ಆಫ್ಟರ್ ಫಸ್ಟ್ ಲ್ಯಾಬ್ ಒಂದ್ ಪೇಮೆಂಟ್,
ಅದೇ ground first ಅಂತಾನೆ
ಸ್ಲ್ಯಾಬ್ ಒಂದ್ ಪೇಮೆಂಟ್,
Second slab ಆದ್ಮೇಲೆ ಇನ್ನೊಂದು payment
ಆಫ್ಟರ್
ಇದೆ.
ಕಂಪ್ಲೀಷನ್.
ವೆರಿ ಕ್ಲಿಯರ್ಲಿ ಮೆನ್ಷನ್ ಸೊಮ್ಮೆ at ground plus first floor ಅಷ್ಟೇ. One floor, 2 lakhs.
But first slab and second slab.
But footing ಮತ್ತೆ slab
I
ಸಿಕ್ಕಾಪಟ್ಟೆ.
pray this on,
I will-
their
I will
intention
dic-
only to
will
drag on
dictate-
the
I will
proceedings,
dictate
my
at
lord.
2:30.
I pray this on to kindly expedite the proceedings for within 2 months, my lord. Because
2 months.
yes, my lord, because my property ನೋಡಿ, my lord, it is already ruined. ತುಂಬಾ ಏನೇನೋ ಬೆಳ್ಕೊಂಡು ಹೋಗ್ತದೆ.
ಎವಿಡೆನ್ಸ್ ಕಮೆಂಟ್ಸ್ ಆಗಿದೆಯಾ?
ಈಗ ಮೇಡಮ್, it is in the,
ಎವಿಡೆನ್ಸ್ ಕಮೆಂಟ್ಸ್
my
ಆಗಿದೆಯಾ?
lord, it is
ಇಲ್ಲ, ಇಲ್ಲ,
already-
sir.
it is
Issues-
supposed to be comments for the evidence.
ಹಾ.
Issues ಗಿತ್ತು
ಟ್ರಯಲ್ ಜಡ್ಜ್
preliminary
ಮ್ಯಾಜಿಕ್
issues ಗೆ 3 and 4 ಗೆ clarification
ಡಿಸ್ಪೋಸ್
ಕೇಳಿದ್ರು.
ಮಾಡಕ್ ಟ್ರಯಲ್ ಜಡ್ಜ್ ಮ್ಯಾಜಿಕ್ ಮಾಡ್ಬೇಕತ್ರಿ.
My lord, one submission, my lord.
ಹಾ.
Issue number,
ಯಾವ
preliminary
ಊರ್ನಲ್ಲಿ-
issue number 3 and
ಯಾವ
4 ಗೆ
ಊರ್ನಲ್ಲಿ ಆಗೋದ್ರಿ
clarification
ಇದು?
ಕೇಳಿದ್ರೆ
ಬೆಂಗಳೂರೇನೆ ಇನ್
Yes, my lord.
ಜಡ್ಜ್ ಬೆಂಗಳೂರು.
RR ನಗರ sir.
plaintiff is
He would have-
intentionally drag on the proceedings.
The petitioner
not
would have
presenting
accept-
and time, taking a time in
No,
the trial.
petitioner would have-
I will dictate at 2:30.
Petitioner would have cooperated, my lord. I would have finished the construction by time.
with,
So
with a poor quality work, my lord.
ಅಲ್ಲ ರೀ, ನೀವು ಬರೀ ಫೌಂಡೇಶನ್ ಗೆನೆ ಇನ್ನು 35 ಲಕ್ಷ ಕೇಳ್ತೀರಿ, ಅವ್ನ ಏನಾಗ್ಬೇಕು ಹೇಳಿ?
ಅದು
as per ನಾನು contracts ಅಲ್ಲೇ ನಾನು ಕೇಳ್ತಾ ಇದ್ದೀನಿ sir. Yes, sir.
I have a report before.
ಅಲ್ಲ, 5 ಲಕ್ಷ
construction report
ಕೊಡ್ತೀನಿ
also
ಅಂತಾರೆ.
before the
ನಾನು I
court
spent
report.
16.5.
ಆಯ್ತು ನೋಡೋಣ. Whether you are entitled for relief of injunction against the owner,
An interim order.
not to
will extend.
interfere with your construction.
Construction activities ಅಂತ.
ಮತ್ತೆ
ಅಷ್ಟು ತೊಂದರೆ ಕೊಟ್ಟರು some rowdyism
My lord,
ಆಯ್ತು.
the trial-
ಆ time ನಲ್ಲಿ.
my-
Otherwise, I wouldn't have approached the civil court, mala. And the court wouldn't have entertained.
Number 3 and 4 says 41H prakara, specific relief prakara, whether you are entitled ಅಂದ್ಬಿಟ್ಟು preliminary issues ನ clarify ಮಾಡಿ ಅಂತ hearing ಇದ್ರೆ, they will come before this court and they take adjournment before the court, my lord.
ಆಯ್ತು.
And their intention only to protract the proceedings and made the appellant to run behind the court when the construction work is still on the under construction.
ಆಯ್ತು, ನೆಕ್ಸ್ಟ್ ಹೇಳ್ರಿ, ಏನಾರು ಇದೆಯಾ ಸಬ್ಮಿಷನ್ಸ್ ಯಾರ್ದಾದ್ರು?
Serial number 71, my lords.
ಹಾ?
Serial number 71, my lords.
21 ಇರಿ ಸ್ವಲ್ಪ.
My lord.
ಈಗ ನಾವ್ ಎಲ್ಲಿದ್ದೀವ್ರಿ? 56 56 ಇಂದ 60 ವರ್ಗ ಏನಾದ್ರು ಸಬ್ಮಿಷನ್ ಇದೆಯಾ?
61
61 ಹೇಳಿ ಏನಾಗ್ಬೇಕು? ಆರ್ ಪಿ
ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ಅಕ್ನಾಲಜ್ಮೆಂಟ್ ಅಂತ ಇದೆ. ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದೀವಿ lordship.
ಯಾವಾಗ
ನೆನ್ನೆ ಮಾಡಿದ್ವಿ.
ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದ್ರೆ ಅಕ್ನಾಲಜ್ಮೆಂಟ್ ಹಾಕಿದೀರಾ?
ಹಾಕ್ತೀವಿ ಇವತ್ತು.
ಆಯ್ತು.
ಮತ್ತೆ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಸೇಮ್ ಕೌನ್ಸಿಲ್
ಹಾ.
97 ಅಲ್ಲಿ ಆಲ್ರೆಡಿ ವಕಾಲತ್ ಹಾಕಿದ್ದಾರೆ. ಆರ್ಡರ್ ಮಾಡಿದ್ರೆ ಅದನ್ನು ಸರ್ವ್ ಮಾಡ್ಬಿಟ್ಟು
ಯಾರು ಅವ್ರ ಕೌನ್ಸಿಲ್?
ಕೌನ್ಸಿಲ್ ಲordship
ಯಾರಿಗೆ ಅಂತ ಹೇಳಿ.
ದೇವರಾಜ ಅಂಡ್ ಮಂಜುನಾಥ.
ಆಯ್ತು, ಮಧ್ಯಾಹ್ನ ನೋಡೋಣ. ಅದೆಲ್ಲ ಈಗ ನೋಡಕ್ಕಲ್ಲ, ಈಗೆಲ್ಲ ಆರ್ಡರ್ ಶೀಟ್ ನೋಟ್ ಮಾಡ್ಬೇಕು. ನೆಕ್ಸ್ಟ್ ಏನಾದ್ರು ಮೆನ್ಷನಿಂಗ್ ಇದೆಯಾ?
62, my lords. 62.
62 ಹೇಳಬೇಕು. ಹೇಳಿ ಎಲ್ ರಾಜಣ್ಣ ಅಂಡ್ ಲೋಕೇಶ್ ಕೇಸ್ ಇದ್ಯಾವ್ದೋ ಕಮಿಷನರ್ ಹೋಗಿ ಏನೋ ರಿಪೋರ್ಟ್ ಬಂತಲ್ಲ ಅದ? ಹೇಳಿ ಏನಾಗ್ಬೇಕು?
From my side, there is, we are.
ಫರ್ದರ್ ಹಿಯರಿಂಗ್.
Could it be on 13th?
From our side, my lord, appellant side,
ಹಾ.
there is no submission. We are.
I am
Already.
requesting for an adjournment. I am requesting.
Third, appellant counsel submits that there is no further argument and counsel for respondent seeks time. ಯಾವಾಗ ಬೇಕು?
My request on 13th, my lord.
13th ಅಷ್ಟು ದಿವಸ ಹಾಕ್ಬೇಕ್ರಿ?
That's next
It
week.
already matter was heard.
ಅಲ್ಲ, next
And
week
this court felt that point number 1 has to be considered first and later on other substantive question.
I'll not seek for adjournment on 13th. Next week ಸ್ವಲ್ಪ busy.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಹೇಳಿ.
Next week ಸ್ವಲ್ಪ problem.
ಮತ್ತೆ ರಜಾ ಬಂದ್ಬಿಡುತ್ತೆ, ನಾವ್ ಆಮೇಲೆ ಜಡ್ಜ್ಮೆಂಟ್ ಬರೀಬೇಕಲ್ಲ.
If it is not inconvenient.
ಫೈನಲಿ ಅಪ್ಡೇಟ್ ಕೊಡೋದಿಲ್ಲ.
ಇಲ್ಲ, ಬೇಡ.
13-11 ಆಯ್ತು.
My lord, serial number 71, my lords.
ಇರ್ರಿ 62 to 66 ಯಾರು ಇಲ್ಲದ್ರಿ?
My lord, 67, my lord.
ಹೇಳಿ ಏನ್?
My lord, senior ಅಮೆರಿಕದಲ್ಲಿ ಇದ್ದಾರೆ ಸ್ವಾಮಿ.
ಅಮೆರಿಕಕ್ಕೆ ಹೋಗಿದಾರ?
ಹೌದು ಸ್ವಾಮಿ.
ನೀವು
8ನೇ ತಾರೀಕು ಬರ್ತಾರೆ ಸ್ವಾಮಿ.
ಜೊತೆ ಹೋಗ್ಬೇಕಿತ್ತು.
11ನೇ ತಾರೀಕು ಕೊಟ್ರೆ ಒಂದೇ ಒಂದು ಹಂಡ್ರೆಡ್.
ಏನಕ್ಕಿದೆ? 2006
ಹ್ಮ್.
ನೀವ್ ಯಾರಿಗೆ?
ಅಪಲೆಂಟ್ my lord.
ಅಪಲೆಂಟ್ ಅದರ್ ಸೈಡ್ ಇದಾರ ಕೌನ್ಸಿಲ್?
ಇಲ್ಲ my lord, ಇನ್ಫಾರ್ಮ್ ಮಾಡ್ತೀನಿ my lord.
ಟಿ ವಿ ಸುಧೀಂದ್ರ ಅವ್ರಿಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದಿರಾ?
ಮಾಡ್ತೀನಿ my lord.
ಮಾಡ್ಬಿಟ್ಟು ಮಧ್ಯಾಹ್ನ ಹೇಳಿ 2:30.
Yes my lord.
ನೆಕ್ಸ್ಟ್ 69 ಆಯ್ತು ಏನ್ರಿ 71
71, my lords.
ಹೇಳಿ ಮೇಡಮ್.
My lords, RFA 595 by 2008, it may be connected with RFA 423 by 2018. my lord.
RFA
423 by 2018, my lords.
2018
Yes, my lord.
18 ಹೆಂಗ್ 2008 ಜೊತೆ ಕನೆಕ್ಟ್ ಆಗುತ್ತೆ ಮೇಡಮ್?
I will clarify the year. my lords.
10 ವರ್ಷದ ಮೇಲೆ
423 by 2000.
ನೋಡಿ ಅದು ಮಧ್ಯಾಹ್ನ ಚೆಕ್ ಮಾಡ್ಕೊಂಡು ಹೇಳಿ.
Serial number 17, my lord.
Number?
Serial number 72.
72
Filed a
ಹೇಳಿ.
debt reporting memo of respondent number 15, 16, 17.
ಹಾ.
I am for the respondent 12, 13, 14, 15, 16, 17.
ಯಾರು ತೀರ್ಕೊಂಡಿದಾರ?
Respondent 15, 16, 17.
ಮೆಮೊ ಹಾಕಿದಿರಾ?
Memo, I filed a memo. Memo ಹಾಕಿದ್ದೀನಿ sir.
ಯಾವಾಗ?
ನಿನ್ನೆ ಹಾಕಿದ್ದೀನಿ.
ಕೋರ್ಟ್ ಇನ್ನು ಬಂದಿಲ್ಲ.
ಇನ್ನು ಬಂದು.
ಅಪಲೆಂಟ್ ಕೌನ್ಸಿಲ್ ಯಾರು ಇದರಲ್ಲಿ? ಹರೀಶ್ ಕುಮಾರ್ MS ಇದಾರ? ಇಲ್ಲ. ನಿಮ್ ಪ್ರಕಾರ ಯಾರು ಸತ್ತೋಗಿರೋದು?
15, 16, 17.
ಹಾ
I filed.
ಬರ್ಲಿ ಅವ್ರು ಮಧ್ಯಾಹ್ನ ಬರ್ಲಿ ಅವ್ರಿಗೆ ಹೇಳೋಣ.
So far as this concerned, I am appearing for the respondent number 1B, my lord.
ಹಾ
My lord, in this matter, what happened, my lord, please. I have started to put up construction in a portion of my property. So now they have filed an application restraining me from putting up construction, my lord. So that order is operating. I made an application for
vacating.
So this honorable court, when it has come up for consideration before you, my lords, this is an order to consider along with the main. My lord, to decide that aspects regarding the rights of the appellants, if any, absolutely I know that. My construction is stopped in the Midland. I have raised 45 lakhs amount already investment is there. So at least I may be permitted to complete the construction subject to result of the appeal. I am ready to go down to any of the terms imposed on.
ಆಯ್ತು ಬರ್ಲಿ ಅದರ್ ಸೈಡ್ ಬರ್ಲಿ. ಈಗ
That is the problem. Kindly take
ಬರ್ಲಿ
up
ಬರ್ಲಿ
on
ನಾನೇ
it,
ಡೇಟ್
yeah.
ಕೊಟ್ಟಿಲ್ಲ.
And that.
ಡೇಟ್ ಕೊಟ್ಟಿಲ್ಲ. ಅವ್ರು ಹೇಳಿದ್ರು ಕೆಲವ್ರು ಸತ್ತೋಗಿದ್ದಾರೆ ಅಂತ. ಬಟ್ ಅವ್ರ ಗಮನಕ್ಕೆ ಅಪಲೆಂಟ್ ಗಮನಕ್ಕೆ ತರ್ಬೇಕಲ್ಲ. ಆಯ್ತು ಮಧ್ಯಾಹ್ನ.
That is the my urgency.
ಆಯ್ತು.
68.
ಹಾ
68.
68 ಏನಾಗ್ಬೇಕು ಹೇಳಿ. ಹಾ ನೀವ್ ಯಾರಿಗ್ರಿ? ಅದರ್ ಸೈಡ್ ಹೇಳಿದಿರಾ? ಯಾರು ಆನ್ಲೈನ್ ಅಲ್ಲಿ ಇದ್ದಾರೆ? ಪ್ರಮಿಳಾ ಸರ್ಗೆ ಬರೀ ಫೋಟೋ ಹಾಕಿ ಹೋಗವ್ರೆ. ನೀವ್ ಬೆಳಗಿಂದಲೂ ನಮ್ ಫೋಟೋ ನೋಡ್ಕೊಂಡಿರಿ ಅಂತ ಅವ್ರಿಗೆ ಹೇಳ್ರಿ. ಹೇಳಿ ಅದು ದಿನ ಅದೇ ಆಗ್ತಾ ಇದೆ ಅವ್ರದ್ದು. ಹೇಳಿ ಯು ಇಂಟಿಮೇಟ್ ನಾಟ್ ಟು ಪೋಸ್ಟ್ ದಟ್ ಸಚ್ ಫೋಟೋಸ್. ಹಾ ಅವ್ರು ಇಲ್ರಿ ಅಲ್ಲಿ ಫೋಟೋ ಮಾತ್ರ ಇದೆ. ಹಾ ಬರೀ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿ ಆಮೇಲೆ ನೋಡೋಣ.
My lords, serial number 71, my lords.
71, I appear for
71,
second
my lord.
respondent.
ಹಾ ಹೇಳಿ ಏನೋ.
It may be RFA 595 by 2008 may be connected with RFA 423 by 2018, my lord.
18 ಹೇಗ್ರಿ ಆಗುತ್ತೆ? 8ಗೂ 18
ಸೆಕೆಂಡ್ ಪ್ಲೇಂಟಿಫ್ ಏನ್ ಹಾಕಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ.
ಈಗ 18 ಅಲ್ಲಿ. ಹಾ
ಇವಾಗ
ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ ಅದ್ ನೋಡ್ಬೇಕು. ನೀವ್ ಹೇಳ್ಬೇಕು ಕರೆಕ್ಟ್ ಆಗಿ. ಹಾ
ಎಲ್ಲ ಸೇರಿ ಬೇಕಿಲ್ಲ ಅಂತ ಲಾಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ ಆಗಿದೆ.
VB ಶಿವಕುಮಾರ್ ಇದ್ರಲ್ಲಿ ಏನೋ ಇದೆ ನೋಡಿ. ಮತ್ತೆ ಬ್ರಿಂಗಿಂಗ್ LRs ಆಫ್ ಡಿಸೀಸ್ಡ್ R1 ಅದೆಲ್ಲ ಸ್ಟೆಪ್ಸ್ ತಗೊಳ್ಳೋದೆಲ್ಲ ಇದೆ. ಮಧ್ಯಾಹ್ನ ನೋಡೋಣ. ನೋಟಿಸೇ ಹೋಗಿಲ್ವ ಇನ್ನು?
ನೋಟಿಸ್ ಏನು ಬೇಕಿಲ್ಲ, ಪವರ್ ಆಫ್ ಅಟಾರ್ನಿ ಆರ್ಡರ್ ತೀರ್ಕೊಂಡಿರೋದು ಅಂತ ಹೇಳಿ ಲಾಸ್ಟ್ ಟೈಮ್
ಆಯ್ತು ರೀಚ್ ಆದಾಗ ನೋಡೋಣ. ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಇರೋದು ಈಗ. ಸ್ಟೆಪ್ಸ್ ತಗೊಳ್ಳೋದೆಲ್ಲ ಈಗ ನೋಡಕ್ಕಾಗಲ್ಲ.
ಮೇಡಮ್ ನಂದೆಲ್ಲ ಬರಿತಾ ಇದ್ದಾರೆ. ಗೋಪಾಲ್ ಕೃಷ್ಣ ಸ್ಟುಡಿಯೋ ಅಂತ. ಮತ್ತೆ ಮೇಡಮ್
ರೀಚ್ ಆಗಲ್ಲ.
Court officer? Court officer? Madam Girija Hiremat, HCGP Dharwad.
Hello,
Madam,
court.
Audible from Gulbarga?
Hello,
Heli.
Gulbarga bench audible idea, madam.
Huh?
Gulbarga bench and audible video.
Gulbarga in the?
Gulbarga in the madam. ಕೇಳಿಸ್ತಾ ಇದೆಯಲ್ಲ madam audio.
ಕೇಳಿಸ್ತಾ ಇಲ್ಲ sir.
Hello, madam.
Sir, ಗುಲ್ಬರ್ಗಾ ಇಂದ
Gulbarga in the.
ನೀವು ಏನ್ HCGP ನಾ ಸರ್?
Hello, madam.
ಸರ್ ಕೇಳಿಸ್ತಾ ಇಲ್ಲ. ಇಲ್ಲ ಫಸ್ಟ್ ಪ್ರೊನೌನ್ಸ್ಮೆಂಟ್ ಆಮೇಲೆ 230 ಮ್ಯಾಟ್ರ್ ಆಮೇಲೆ ಪಾಸ್ ಓವರ್ ಆಮೇಲೆ ರೆಗ್ಯುಲರ್.
Hello, madam.
ಸಂತೋಷ್ ಅಣ್ಣಪ್ಪ ಒಂದೊಂದು ಅಷ್ಟೇ.
Hello, madam. Hello.
ಪ್ರೊನೌನ್ಸ್ಮೆಂಟ್ ಹೇಳಿದ್ದೀರಾ ಅಲ್ಲಿಗೆ ಅನೌನ್ಸ್ಮೆಂಟ್ ಇದೀರಾ ಸರ್? ನೀವು ಎಷ್ಟು ಮಾಡಿದ್ದೀರಾ? ಎಷ್ಟು ಮಾಡಿದ್ದೀರಾ? ಎಲ್ಲ ಮಾಡಿ 3 ಇತ್ತಲ್ವಾ? ಇಲ್ಲ ಫಸ್ಟು ಪ್ರೊನೌನ್ಸ್ಮೆಂಟ್ ಆಮೇಲೆ ಧಾರವಾಡ ಗುಲ್ಬರ್ಗ ಆಮೇಲೆ 230 ಆಮೇಲೆ ಪಾಸ್. ಹೌದು
Hello, court officer. ಕೇಳಿಸ್ತಾ ಇದೆಯಾ ಗುಲ್ಬರ್ಗ bench ಇಂದ?
ಆಮೇಲೆ ಇವ್ರೇನು ಅವ್ರು ಯಾರು ಅಂತ ಗೊತ್ತಿಲ್ಲ, ಕೇಳಿಸ್ತಾನೆ ಇಲ್ಲ. HCGP ಇದು ಸಂತೋಷ್ ಅಣ್ಣಪ್ಪ ಜಮಾದಾರ್ ಅಂತ, ಇವ್ರೇನು ಅಂತ ಕೇಳಿಸ್ತಾ ಇಲ್ಲ. HCGP ನ ಅಣ್ಣಪ್ಪ ಜಮಾದಾರ್. ಧಾರವಾಡ ಯಾವ್ದು ಕೇಳಿದ್ರೆ ಹೇಳಕ್ ಗೊತ್ತಾಗುತ್ತೆ.
Lord.
This one pronounce Pronouncement.
Mil- two,
Here for them.
75.
Here for them. Respondent in.
Complaint.
76. Ajitesh. Respondent manner. $77.
Here for the respondent.
Matter pertains to Dharwad bench. She has Nilopan.
I appear for the petitioner. Lord, I'm not hearing the court.
Yes, counsel.
Please, my lord. My lord, last occasion, Lordship has heard this matter. The matter pertains to, my lord, the offence under section 420 of IPC, my lord. My lord, in the charge sheet, my lord, section 3 and 7 of Essential Commodities Act have been removed. Only section 420 of IPC is remained, my lord. The allegation, my lord, in the complaint is that the present petitioner is accused number 3, my lord. Accused number 1 and 2 have purchased, my lord, milk packets of 200 kgs. Which ought to have been supplied to the schools. They wanted to sell the same to the general public, my lord, is the allegation. Accused number 3 has no role, my lord, in the entire complaint itself. It is the only allegation that accused number 1 and 2 have purchased the packets from accused number 3, my lord. And I have produced the document to show that, my lord, totally 9,000 kgs, my lord, packets were supplied, my lord. Out of that, my lord, petitioner has supplied 8,989 kgs to the beneficiaries, my lord. And 11 kgs he has already surrendered to the District Cooperative Milk Federation. So, my lord, in view of the same, my lord, the criminal proceedings as against the present petitioner, my lord, does not survive. Lord, have produced the letter.
Then counsel, if it is surrendered to the particular department, how these accused number 1 and 2 got the same?
Yes, that is my submission, Lord. There are allegations against accused number 1 and 2, but the fact that whether it is purchased from accused number 3, my lord, is not clear from the complaint. Your lordship may kindly see the annexure F.
According to no material.
Yes, my lord. And I have produced the entire, my lord, the receipts for having supplied, my lord, E-series documents. And annexure F, your lordship may kindly see.
Whether any document is collected by the IO during the course of investigation, surrendering the remaining 11 kgs.
Lord, he has not required, but I have produced in the petition.
You have produced.
Yes, my lord. Annexure F, my lord.
Annexure F.
Page 126, my lord.
Page 120.
6, my lord.
6.
Yes.
Is it an authenticated document for having?
Yes, my lord. They have received them, my lord. They have put the original seal on the document.
Whether any statement is recorded of the department employee for having surrendered the same?
That is not forthcoming.
That is not forthcoming.
Yes.
Where is
And
the document?
Annexure F, my lord, 126.
Annexure F.
A typed copy I have produced
ನನ್ನ
original.
ಹತ್ತಿರ ಬಳಿ ಇದ್ದು ಸದರಿ ನನ್ನ ಮೇಲೆ ಅಂಕಲಿ ಠಾಣೆಯಲ್ಲಿ ಫಿರ್ಯಾದಿದಾರರು ಇದ್ದು ಕಾರಣ ಬಾಕಿ ಉಳಿದ 11 kg ಪ್ಯಾಕೆಟ್ಗಳ ತಮ್ಮ ವರ್ಗ
ಉಗ್ರಾಣಕ್ಕೆ ಈ ದಿನ ಅಂದ್ರೆ 18/2 ವಾಪಸ್ ಮಾಡಿದ್ದೇನೆ.
That is after registration of the case, sir.
Yes, my lord.
Huh?
Totally 9,000 kgs, my lord.
ಆಯ್ತ್ರಿ, after the registration of the case, sir.
Yes, my lord.
You have delivered, surrendered the same. What you have
11
received
kg.
earlier, what you have received earlier?
I have stated 9,000 I had received, my lord.
Why you have surrendered after the registration of the case?
Lord, because I had left with only 11 kgs of my lord the packets.
Why you have surrendered the same after the registration of the case and whether the same material or different material? Which you have received earlier?
Lord, I have for having supplied 8,989.
Yes,
I have produced
counsel, no dispute is only with regard to the 11 kg according to you.
Yes,
that you have already surrendered. Why you have surrendered material or other material you have supplied after the registration of the case?
It is supplied on 18/2/2019, my lord. Complaint is on.
Counsel, you are not answering to my question. My
Yes,
question
yes.
is, ನಿಮ್ಮ ಹತ್ರ ಸರ್ಪ್ಲಸ್ ಇತ್ತು.
Yes, my lord.
ಸರ್ಪ್ಲಸ್ ಅದೇ ನಿಮಗೇನ್ ಸಪ್ಲೈ ಮಾಡಿದ್ರು ಅದೇನೆ ಈಗ ಅಕ್ಯೂಸ್ ನಂಬರ್ 1 and 2 ಕಡೆಯಿಂದ ಸಿಕ್ಕಿದೆ ಅಂತ ಅವ್ರ ಕೇಸ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಕೇಸ್ ಹೌದಾ?
Please.
ಇಲ್ವಾ? Then why you have been arraigned as accused number 3?
The complaint is at annexure B, my lord.
ಆಯ್ತ್ರಿ, ಬಟ್ ನೀವು ಈಗ ಯು ಆರ್ ರಿಲೈಂಗ್ ಅಪಾನ್ ಡಾಕ್ಯುಮೆಂಟ್ ಅನೆಕ್ಷರ್ 126.
Yes, yes.
ಇದು ಯಾವಾಗ ನೀವು ಸಪ್ಲೈ ಮಾಡಿರೋದು ವಾಪಸ್ ಸರೆಂಡರ್ ಮಾಡಿರೋದು?
18/2/2019.
ಕೇಸ್ ರಿಜಿಸ್ಟರ್ ಆಗಿದ್ದು ಯಾವಾಗ?
12/2/2019.
That's what I am asking you.
Yes.
After registration of FIR, after 6 days, you have surrendered this.
Yes, my lord.
Now the dispute is whether the very same article which you have received earlier,
Yes,
or the surrendered, what you
Are
have surrendered.
New packets.
New pockets. That is the
Yes,
issue.
Yes.
That you have created this document after the registration of the case
Illa.
against you.
Lord, that is not the
Yes.
intention.
Who appears for the state?
Your Lordship, myself, Girija, head of HCGP, Your Lordship. Your
Yes,
Lordship.
madam. Yes.
Your Lordship, after completion of investigation, Your Lordship, charge sheet has been filed wherein he was specifically stated it was, Your Lordship, ಆರೋಪಿ ನಂಬರ್ 3 ಇವನು ತನಗೆ ಶಾಲೆಗಳಿಗೆ ವಿತರಣೆ ಮಾಡಲು ಕೊಟ್ಟಿದ್ದ
I have read the column number 17, madam. Then what is the material?
ಈಗ
Because he relies upon annexure F. Whether any statement of witnesses is recorded to that effect, annexure F.
Annexure F ಉಳಿದ 11 ಪ್ಯಾಕೆಟ್ಗಳನ್ನು ತಮ್ಮ ಉಗ್ರಾಣಕ್ಕೆ ಈ ದಿನ ಅಂದರೆ ಅದರಲ್ಲಿನೇ ಉಳಿದಿದ್ದು ಕೊಟ್ಟಿದ್ದಾನೆ ಅಂತ that is the case, Your Lordship. And the same is to be after trial.
Was there any earlier order for rejection of this quashing petition?
Yes, my lord. Yes, my lord. Liberty was granted after to prepare a petition after filing the charge sheet.
After filing of the charge sheet. Now the liberty is given. What is the material you are arguing for quashing? Except annexure F. Is there any other material?
My lord, my second submission is, my lord, there is no grievance either by the Milk Federation or by the school authorities, that is the beneficiaries. That they have not supplied the packets. There is no complaint by the authorities or by the, my lord, beneficiaries.
No. Prosecution case is whatever the material given to you.
Yes.
Only supplied portion and remaining what with your custody that has been seized from the accused number 3. Accused number 1 and 2. Accused number 1 and 2.
Please.
That material was given to you for supply the same to the schools.
Yes.
Howda?
Yes.
That is their case.
Yes.
Except annexure F, you have not produced any document.
I have not produced it. I have produced the E-series document.
ಆಯ್ತು, ಡೇಟ್ ಆಫ್ ಸಪ್ಲೈ ಯಾವಾಗ ನಿಮಗೆ ಕೊಟ್ಟಿರೋದು?
Work order, my lord, is
Work
on.
order. ವರ್ಕ್ ಆರ್ಡರ್ ನಿಮಗೆ ಸಪ್ಲೈ ಮಾಡಿ ಈ 8,899 kg ಯಾವಾಗ ಕೊಟ್ಟಿದ್ದು ನಿಮಗೆ?
29/1/2019.
29/2018.
19, my lord. 29/1/2019.
29.
Yes, my lord.
ಕರೆಕ್ಟ್ ಡೇಟ್ ಹೇಳಿ ಕರೆಕ್ಟ್ ಆಗಿ.
29 January 2019.
ಜನವರಿನಾ 2018?
Yes.
These articles are seized from accused number 1 and 2 on what date?
My lord, on 12/2/2019.
12/2/2019.
Yes.
Yes. ಯಾವ ಮಂತ್ ಕೊಟ್ಟಿದ್ದು ನಿಮಗೆ ಸಪ್ಲೈ ಮಾಡಕ್ಕೆ ಅದನ್ನ ಸ್ಕೂಲ್ಗಳಿಗೆಲ್ಲ?
January, my lord.
January 2018.
19, my lord.
Sorry.
2019, my lord. 29 January 2000.
21/2018 19?
29 January 2019, my lord.
ಹೌದ್ರಿ, ನೀವು ಯಾವಾಗ ರಿಟರ್ನ್ ಸರೆಂಡರ್ ಮಾಡಿದ್ದೆ ಅವಾಗ?
18/2/2019.
ಅದೇ ಆಫ್ಟರ್ ದಿ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಆಫ್ ದಿ ಕೇಸ್.
Yes.
ಹೌದಾ? That's all. Heard,
Yes,
resolved. ಕಲಬುರ್ಗಿ ಬೆಂಚ್ ಕೂಡ ಇದೆಯಾ?
Matter pertains to Kalburgi bench. Non-compliance.
Obliged.
Serial number 1. Nadgavga.
ಎಷ್ಟು ಟೈಮ್ ಬಂದಿದೆ ನೋಡಿ ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ಗೆ? ಕಲಬುರ್ಗಿ.
Appear for petitioner on behalf of Arvind Algoda, my lord. 2 weeks
yes,
time may be granted, my lord. Last time date ಕೊಟ್ಟಿದ್ರೆ ಬಟ್ ಫೈಲ್ ಬಂದಿರಲಿಲ್ಲ my lord, ಅದಕ್ಕೆ ಒಂದು 2 weeks. ಕಲಬುರ್ಗಿ ಬೆಂಚ್
Petitioner counsel seeks 2 weeks time granted as sought. Next. Mantesh Patil, ಹೇಳಿ. First time orders. HCGP is directed to take notice. ಕಲಬುರ್ಗಿ ಅವರು ಇದಾರಾ?
Please, my lord.
Take notice. List this matter on next witness. ಆಗುತ್ತಾ? ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಏನಾರು ಇದ್ರೆ ಹಾಕ್ಬೋದು. ಯಾವಾಗ? 6/11.
Serial number 3.
Directed to take notice, file objections if any. Next. 482. Jamadar Sabuddin. Extension of 3 months time for disposal of CC. Kodri mostly letter received from officer irbek. Good. Having perused the letter of PO dated 25/9/24, there was a delay of communication of the order for about 2 months. And also SLP was filed before the Supreme Court and the same was also disposed of on 31/5/24. And hence the officer was unable to record the evidence and thereafter started the evidence, recorded the evidence. And also letter discloses that matter was heard and posted for judgment, and at this juncture officer was deputed to the judicial training till 9/9/24 and hence 24 and also the complainant report WP. And in the said matter granted stay and unable to pass the judgment. Hence seeks another 3 months time. And having already recorded the evidence, case was posted for judgment. No need to grant 3 months time and 2 months time granted from the date of receipt of the order of this court. The registry is directed to communicate this order to the PO forthwith. 213 ತಗೋಬೇಕು ಈಗ ಇರೋದೇ 213 ಮೆನ್ಷನ್ ಮಾಡಿದ್ವಿ. ಫಸ್ಟ್ ಇದು ಮುಗಿಸಿ ಆಮೇಲೆ.
This one. 78. First time non-compliance.
Dahin Banu, Ilva, petitioner counsel absent 2 weeks time granted to comply with the office objections. List the matter after compliance.
Orders first time 79. Latif B.
HCGP is directed to take notice and file objections if any. List this matter on 6/11.
80. Mohan Kumar D.
Mohan Kumar D. Huh? Process, yarig notice ಹೋಗಬೇಕಾ? The counsel submits that he has paid the PF today and hence issue notice against R2. And also additional SPP is Ilva is directed to serve the notice against the respond number 2 through IO.
81.
81.
I'm the petitioner in this case, my lord. I am not received any copy from the government, my lord.
In letter for extension of time.
Last time my lordship has granted
the matter in SC number.
Dismiss the bail petition and liberty was given to me, my lord. So within the 2 months, they are not disposed about its petition. They are not, liberty was given to me, my lord, to approach the appropriate forum, my lord, to grant bail, my lord. 439. We are filing the bail application, my lord, in the criminal petition number FR number W111878 of.
Now we have filed fresh petition.
Yes, my lord.
Third, HCGP is directed, additional SPP is directed to take notice and file objections if any.
It may be connected together, my lord. 11878 of 2024. Criminal petition FR number, my lord.
Why it has to be connected? One more petition you have filed?
Yes, ma'am. Please, my lord. We filed the fresh bail petition, my lord.
Oh, this is the other petition 7042 already disposed of.
Please, my lord. Already disposed of. Then
here only the consideration for
extension of time.
Letter for extension of time.
Please, my lord.
You have filed separate petition.
Yes, my lord. Please, my lord.
No, that is not put up, Allah.
Both might have clubbed together, my lord.
Yes, additional SPP, have you read the copy of the letter? You have not received the copy?
No.
For extension of time?
No, your lordships. Your lordships, the petition copy itself not served, your lordships. Petition copy is served by the lordships.
Petition copy, fresh petition ಬಂದಿಲ್ಲ ಕೋರ್ಟ್ ಮುಂದೆ ಬಂದಿಲ್ಲ ಅದು ಬರ್ಲಿ ಆಮೇಲೆ ನೋಡೋಣ.
It may be connected, my lord.
Oh, it will be a connected counsel. This is disposed of matter.
Please,
you move the matter for fresh consideration if any fresh petition is filed.
Please, my lord.
CDR and certificate on section 65B of the Evidence Act 65 so also examined so also probably further examined in chief. Prosecution agency did not secure the presence of CW 43 who had conducted post-mortem examination and who is a material witness to the case of the prosecution. Hence, rigorous process of witness warrant was issued and now it is brought to the notice of the court that investigating officer shall secure the presence of this witness on 26/10/24. I further submit that investigate here into the crime by so-and-so is working as circle inspector of the police Nagpur. Recent communal riots which had taken place at Nang, he could not appear before the court as he was engaged in maintaining law and order. Hence, this court was in a position to record, is not in a position to record. Ultimately appeared before the court, and his examination in chief was conducted in part which runs up to 90 pages. His further evidence has to be conducted in addition to it. The court has to examine CW 43 who had conducted postmortem examination. In addition to this, counsel for the accused number 2 had filed application under section 311 of CRPC to recall PW 17, and application was allowed. I will submit that in case the voluminous documentary or secular evidence is involved, though the court has made sincere endeavors to dispose of the matter in due compliance, could not sound so order to conclude that in trial it requires at least 3 months time in the given circumstances of the case, and for the reasons stated herein above, in such an event the dispose of the matter on merits. It requires 4 months time. Having perused the letter dated 22/10/24, the presiding officer has stated that prosecution agency did not secure the presence of CW 43, conducted the post-mortem examination, and who is a material witness. Apart from that, the investigating officer who conducted the investigation was examined, and it runs 90 pages of the deposition. His further evidence has to be conducted. And also, letter discloses that accused number 2 had filed application under section 311 of CRPC to recall PW 27, and the application was allowed. And in view of voluminous documentary and ocular evidence is involved, request for 4 months time for disposal of the same. Having perused the reasons assigned, and also all material witnesses have been examined, only CW 43 has to be examined, who conducted for post-mortem examination, and also the IO who conducted the investigation was partly examined. It is appropriate to grant further time of 2 months instead of 4 months as sought. And hence 2 months time is granted to dispose of the same. The registry is directed to communicate this order forthwith to the PO. Forthwith. ಆಯ್ತು, ನಿಮ್ ಪಿಟಿಷನ್ ಏನಾದ್ರು ಇದ್ರೆ ಫ್ರೆಶ್ ಆಗಿ ಮೂವ್ ಮಾಡ್ಕೋಬಹುದು.
My lord, I will file the petition, my lord.
You have already filed?
Please, madam, I'll already filed.
Yes, you move the matter, that's all.
Please, madam.
82, Vikram Raj.
Lordship had sought antecedents report in this matter. Producing the antecedent.
ಏನ್ ಅಫೆನ್ಸ್ ಏನು? 394 and 397. ಲಾಸ್ಟ್ ಟೈಮ್ ಏನೋ ಆಂಟಿಸಿಡೆಂಟ್ಸ್ ಏನಾರು ಇದೆಯಾ ಅಂತ ಕೇಳಿದ್ವಿ.
Please. There are 8 cases, your lordship.
ಎಷ್ಟು?
Third page. 8 cases.
8 cases.
Please.
307. ಏನಾಗಿದೆ 8 cases ಸ್ಟೇಜಸ್ ಏನು? ರಿಸಲ್ಟ್
394, 302.
ಎಲ್ಲ ಸಿಮಿಲರಾ? First case is 41A.
Please, your lordship.
109. Second case 302. Third case 153A, 143, 144, 147, 148, 341, 324, 354, 307, 506. Other case is 302. 307. NDPS Act.
324, then next matter is 394.
Purva Police. 394, 397. Entry.
I may have a look on the report, your lordship. It's, because some of the cases, as per the instructions given to me, your lordship, some of them he is acquitted.
Acquitted ಯಾವ್ದು ಕೊಡಿ ಲಾಸ್ಟ್ ಟೈಮ್ ನಿಮ್ಗೆ ಹೇಳಿದೆ. You give a details of acquittal ಅಂತ ಕೇಳಿದ್ದೆ ನಾವು ಲಾಸ್ಟ್ ಟೈಮ್ ಸಬ್ಮಿಷನ್ ಮಾಡಿದಾಗ. ಹೌದಾ?
Yes, your lordship. ಅವರಿಗೆ ಫ್ಯಾಮಿಲಿ ಅವರ ಹತ್ರ ಅಪ್ರೋಚ್ ಆಗಿದ್ದಕ್ಕೆ ಅವರ ಹತ್ರ ಸ್ಟೇಟಸ್ ಇರಲಿಲ್ಲ, your lordship. One date may give him, I'll look into the status and get back here.
Additional SPP filed. The details of antecedents and copies also served on the petitioner counsel, and petitioner counsel seeks time to submit regarding status of the cases pending against the petitioner and hence list this matter ಯಾವಾಗ ಬೇಕು ಹೇಳಿ
Next Thursday, your lordship.
6/11
Grateful.
ಲತೀಫ್ ಬಿ
Lord, this
ಲಾಸ್ಟ್ ಟೈಮ್ ಈ ಮ್ಯಾಟರ್ ಹಿಯರ್ ಮಾಡಿದ್ವಿ ಅನ್ಸುತ್ತಲ್ಲ
On merit, Lord, I made a submission that long incarceration is also one of the ground for seeking bail.
Made a submission that.
ಏನೋ ಸೈಟೇಷನ್ಸ್ ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರಿ ಹಾ ನಿಮ್ ಕೇಸಲ್ಲಿ ಅವ್ನು 21 ಇಂದ ಇದಾನಲ್ಲ
ಹೌದು.
ಅಫೆನ್ಸ್ 302
ಹೌದು.
ಹಾ ಹೇಳಿ
Lord, here in the present case, Lord, the petitioner is the
ಕೇಸ್ ಸಿನ್ಸ್ ಲಾಸ್ಟ್ 8 years ಹೌದಾ
Lord, first case last 4 years.
ಹಾ 4 year
4 years. Paragraph,
ಪೇಜ್ ನಂಬರ್ 6 ಹೋಗಿ 7 ಹೋಗಿ
paragraph number 21.
14 ಅಲ್ಲಿ ಜೈಲ್ ಸಿನ್ಸ್ ದಿ ಲಾಸ್ಟ್ 8 years ಅಂತೇನಾ ಓನ್ಲಿ 2 witnesses had been examined recorded ಅಂತೇನೋ ಇದೆ ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 14 ಅಲ್ಲಿ
ಇಲ್ಲ ಇದರಲ್ಲಿ
So the appellant is in jail since the last 8 years and evidence of the only 2 witnesses had been recorded ಅಂತ ಇದೆ ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 14 ಅಲ್ಲಿ
ಇಲ್ಲ paragraph number 21.
21 ಅಲ್ಲಿ ಏನಂತಿದೆ 7 years
ಹೌದು. ಇಲ್ಲ punishment is up to 7 years.
ಹಾ
And he is in custody from last 4 years.
ಆಯ್ತು ಅಲ್ಲಿಗೆ 50% ಇದಾನೆ ಅಂತ ನಿಮ್
Last,
ಕೇಸಲ್ಲಿ
paragraph.
ಕೇಸಲ್ಲಿ ಲೈಫ್ ಆಯ್ತು ಇದೇ ಅಪ್ಲೈ ಆಗುತ್ತೆ
ಇದರಲ್ಲೂ ಲೈಫ್ ಸರ್.
ಹಾ?
ಇದರಲ್ಲಿ ಲೈಫ್.
ಯಾವ್ದ್ರಲ್ಲಿ
Paragraph number 21.
10 years 21 ಅಲ್ಲಿ ಏನೋ ಇದೆ
ಇಲ್ಲ ಇಲ್ಲ. There is
UAP Act
Section 16 of UAP Act
ಹಾ.
carries the maximum sentence
life
is life
imprisonment.
imprisonment if he convicted.
On the other hand, the maximum sentence under section 489 ಮಾತ್ರ 7 years ಅಂತ ಹೇಳ್ತಾರೆ.
ಹೌದು.
ಹಾ.
ಇದರಲ್ಲಿ UAP ಇದೆ.
ಹಾ.
Then Lord, the period undergone, Lord, 4 years at page number 23 ಅಲ್ಲಿ bottom ಅಲ್ಲಿ ಇದೆ. 23. Bottom last line. He is in custody from under trial prisoner from last more than 4 years. Got it? No? Last line.
Para 23 na?
ಹೌದು.
23 point?
23, exact 23. Last line.
However, stringent penal law may be ಅಂತಿದೆ.
ಅಲ್ಲ
23.1 ಅಲ್ಲಿ 23 ನಲ್ಲ
23.
prisoner for more than 4 years.
ಹೌದು. Now, Lord, the second judgment. Lord.
Offense is 489.
And UAPA, section 16 of UAPA.
Your case is a 302, taking of a life of a person. Next.
The second judgment, Lord, he is in judicial custody from 5 years. And the paragraph number, Lord, 3 and 4. The appellant has been custody from 2011 for over 5 years. A trial has not yet commenced as much as a state council has submitted that on 9/5/16, the first date was fixed for
The
trial.
5 years ಅಲ್ಲಿ trial fix ಆಗಿಲ್ಲ.
Yes.
ಹೌದಾ?
ಹೌದು.
Next.
The third judgment, Lord, at paragraph number 3, Lord. Charges against the accused are upon undoubtedly serious. However, it observed that earlier order dated so and so, such changes have been balanced with the certain other facts like period of custody suffered and likely period within the trial can be expected to be completed in our previous order so in 16 passed by the passed.
4 years ಇಂದ ಇದನ್ನ.
ಹೌದು. 4 years.
147 witnesses ಇದಾರೆ ಅಂತ ಅದರಲ್ಲಿ.
ಹೌದು. The next judgments, Lord. This page number 42, my Lord. 2020 SCC online, SCC 2068. There, my Lord, the custody only for 1 year, 7 months. During the course.
Offense ಏನು?
NDPS.
NDPS.
The NDPS Act, there is a rigor of section 37 also.
ಆಮೇಲೆ ಆಯ್ತು. ಹಾ 21 C ಅದರಲ್ಲಿ ಅಫೆನ್ಸ್.
ಹೌದು.
ಹೌದು.
And the rigor of 37 will come in the way of
37 ಇರ್ಬೋದು, but what is the punishment for 21C?
20 years,
Maybe a rigorous presumption,
20 years.
ಎಷ್ಟಿದೆ ಅದು?
Commercial quantity,
Quantum ಏನ್ರಿ?
commercial quantity.
ಆಯ್ತು,
That was 1 year, 7 months blood. As on 9/6/2020 trial preliminary stage, only one witness has been examined. Next judgment blood. Paragraph number 3 blood. Instance arising in the applicant prepared by so and so 439 seeking bail under so and so.
This is also 21C.
Yes.
NDPS.
Yes, NDPS. There, the out of 10 witnesses cited and examined, only one witness appears. 4 witness has been already been examined out of 10 witnesses.
Right, next.
And coordinate bench plot, paragraph plot is 7. Criminal petition, paragraph number 7. They have been spent for 2 years, 7 months custody.
Accused number 4 doesn't have any criminal antecedents.
Yes.
Offense ಏನು?
NDPS.
ಇದು NDPS.
ಹೌದು.
ಎಲ್ಲ you are relying upon NDPS ಆರ್ಡರ್ಗಳು.
ಹೌದು.
I also given bail in several cases, NDPS cases. 302 ಹೇಳಿದ್ರೆ ನೀವು ಯಾವ್ದಾದ್ರು ತರ್ತೀರಾ. Next.
Next case also lots of NDPS. Paragraph number 4. As regards the twin condition
He
contains
spent more than 3.5 years in custody.
more. Please, Section
Prolonged
37 of the Council for the
incarceration.
State is heard. The conditions stand complied.
ಇದು NDPS.
Howd.
ಎಲ್ಲ NDPS ಹಿಡ್ಕೊಂಡ್ ಬಂದಿದ್ದೀರಿ. Next.
The last judgment plot. That is paragraph number 7 and 8. There is UAPA case plot.
UAPA.
They having heard the counsel for appearing for the parties have gone through the material on record. We are inclined to exercise our jurisdiction in favor of keeping mind of following aspect. Appellant is in jail under trial prison from past 4 years. Until date, the trial has not been able to even proceeded to frame the charge. As pointed out on Council of State as well as NIA, prosecutor intend to examine not less than 80 witnesses. Ultimately, my lord, the paragraph number 19 and 20, considering the article 21 of the Constitution, my lord, the granted bail.
General theory, article 21. ನಿಮ್ ಕೇಸಲ್ಲಿ ಏನ್ ಹೇಳಿ? Eyewitnesses ಇದಾರಾ?
Lord, in my case,
Witnesses ಇದಾರಾ?
there is no eyewitness for the, Lord, the allegation is assault is against accused number 1, Lord. The only the circumstance relying by the prosecution is we sitting, the deceased and accused number 1 and 2 are sitting together and consuming alcohol. That was noticed.
Accused number ಎಷ್ಟು?
2, my lord.
2.
One had a illicit, having any ill will against the deceased, saying that, my lord, deceased's wife and A1 having a illicit relation. In order to eliminate the husband, they conspired together A1 and 2 and the deceased. And when the complainant and her and his son going to the farmland, they were noticed. All 3 are sitting together and consuming alcohol. That is the one of the strong circumstances relied by the prosecution. And the body was buried, and which was from at the instance of accused number 1, it was exhumed, and it is the property of the accused number 1. And the allegation of against me is that I was not assaulted. I helped to bury the body. That is the charge sheet allegation. And motive is against A1. A2 allegations, not kindly, I'll read that. Paragraph, page number 50 ಅಲ್ಲಿ ಇದೆ. Last paragraph. Assault ಎಲ್ಲ ಮಾಡಿರೋದು A1.
Paragraph?
Page number 50 of the charge sheet. ದಿನಾಂಕ 27/11.
ಎಷ್ಟನೇ ಪಿಟಿಷನ್ ಇದು? 4ನೇದು.
ಹೌದು. On merits plot it was.
ಎಲ್ಲ ಮೆರಿಟ್ ಮೇಲೆ ಡಿಸೈಡ್ ಆಗಿರೋದು.
ಹೌದು.
All. Now what is the change circumstance?
Plot, the material witness already been examined. The,
Whether they have supported or
they
not.
supported the case.
All of them have supported.
Please,
Whether this court can sit and appreciate the evidence by usurping the jurisdiction of the.
Lord,
trial
I am
court.
not saying that to appreciate the evidence.
Once they have supported.
Yes,
Ah,
my submission is the custodial trial is not required here, Lord, from the last 2 years.
Hmm.
He is in custody.
Hmm.
Material witness already been examined.
Hmm.
And question of tampering the witness does not arise at this stage.
Hmm.
Therefore, Lord, further custody, and he is already undergone 2 years. Allegations of assault is against A1. Only the case rests on circumstantial evidence. And the allegation in the charge sheet is that he had helped him to bury the body.
Hmm. Body is recovered at the instance of you only having the knowledge about where the body was
A1,
buried.
A1.
A2 only,
No,
two only. I read the earlier order. Dead body has been recovered at the instance of accused number 2, and the same is discovery under section 27 of the Evidence Act. That is the observation in the earlier order in paragraph number 6 of the earlier order. While rejecting it. That is the reasoning given earlier.
here, Lord, one observation at paragraph number 4 of the same order.
Hmm.
He is contended he is not at the instance
That
of
is contention, but reasoning given by this court. In paragraph number 6.
yes. Hence, it is clear the discovery at the instance of accused number 1 and A1 and 2, and not only at the instance of accused number as well contend by the senior counsel for the petitioner, joint recovery.
Right, ಇನ್ನೆಷ್ಟು witnesses ಇದ್ದಾರೆ madam examine ಮಾಡ್ಲಿಕ್ಕೆ?
Lordships, I'll have to get that information.
Huh?
I'll have to get that information.
Last time also matter was heard and he
52.
only took time to
Lordships.
produce the citations. Why you are again seeking time?
Lordships,
Would have-
citations, your Lordships, but regarding the status, there was.
How many witnesses have been examined?
Lord, I have
ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ ಇನ್ನು ಎಷ್ಟು ಜನ ವಿಟ್ನೆಸ್ ಆಗ್ಬೇಕು?
52 witness ಇದ್ದಾರೆ.
52.
ಹೌದು.
ಆಲ್ರೆಡಿ ಎಷ್ಟು ಜನ ಎಕ್ಸಾಮಿನ್ ಆಗಿದೆ?
Already seven ತನಕ examine.
7 ವರೆಗೆ ಮಾತ್ರ ಆಗಿದೆ.
ಹೌದು.
ಆಯ್ತು ನೋಡಿ. Anything to say, madam?
Please.
Heard the petitioner counsel and also the counsel appearing for the respondent. This is fourth successive bail petition filed by this petitioner who has been arraigned as accused number 2. This court earlier rejected the applications, petitions on merits. Now the very contention of the counsel before this court is that he was arrested in the year 2021. Howda?
ಹೌದು.
And trial has been commenced and 7 witnesses have been examined and prosecution has cited 52 witnesses and yet to examine other witnesses and it takes time. The counsel also would vehemently contend that no need of custodial trial once the investigation has been completed and question of tampering the prosecution witnesses doesn't arise. The counsel also in support of his argument relied upon the judgment of the apex court as well as this court in granting the bail, taking into note of Article 21 of the Constitution and in the judgment of Sheikh Javed Iqbal case, wherein the apex court exercised the discretion in section 121A, 489 and 489C, taken note of 4 years from 4 years he is in custody. And hence prayed this court to exercise the discretion in the case on hand also. The counsel also relied upon the judgment of the apex court in Angela Harris Sontek and brought to notice of this court paragraph number 3, wherein an observation is made that he is in custody from 2011 from 5 years trial yet to commence. The other judgment is Sagar Tayaram Gorke and another reported in 2021, 3 Supreme Court cases 725 and also brought to notice of this court observation made in paragraph number 3, wherein there were 147 witnesses and he was in custody from 4 years. The council also relied upon the judgment of Union of India versus K. Nazib. ಅದ್ ನೀವ್ ಹೇಳಿಲ್ಲ ಅನ್ಸುತ್ತಲ್ಲ?
ಇಲ್ಲ.
The council relied upon the order passed by the Apex Court in 2022 SEC online SC 2068 in a case of NDPS for the offense punishment section 21C and 37 of NDPS Act. One year, 7 months he was in custody. Case was in preliminary stage. And so also the order passed in 2020 SEC online SC 1536. Chitta Biswas alias Subhas, wherein also offense is invoked 21C and already 4 witnesses have been examined out of 10 witnesses. The council also relied upon the coordinate bench order passed in criminal petition number 10343 of 2023 in a case of NDPS, and he is in custody from 2021. The other order also 2023 live law SC 533 with regard to the NDPS offences. And he has spent more than 3.5 years in custody. The council also relied upon the judgment of Apex Court 2024 SEC online SC 1693 and brought to notice of this court paragraph number 7 and 8 and also paragraph number 19, wherein also discussed with regard to the fundamental right of an accused to have a speedy trial as enshrined under Article 21 of the Constitution. And the council relying upon this judgment would contend that when he is in custody from 2021, the petitioner may be enlarged on bail. For counter, the council appearing for the state additional SPP would submit that this court already considered the matter on merits, and this is a 4th petition. And he is in custody from 2021 is not the ground, since the offense alleged against the petitioner is 302 of IPC, and also even case is rest upon the circumstantial evidence. Body was recovered at the instance of this petitioner who had the knowledge of committing the murder as well as disposing of the body. And the witnesses who have been examined before the trial court have supported the case of the prosecution. This court cannot usurp the jurisdiction of the trial court and appreciate the evidence. Having heard the petitioner counsel and also the counsel appearing for the respondent, it is not in dispute that this is a 4th successive bail petition. It is also a settled law that while considering the successive bail petition, court has to take note of the changed circumstances in granting the bail and exercising the discretion. No doubt the counsel appearing for the petitioner has relied upon more judgments before this court, and particularly all of them are with regard to the NDPS cases. And so, and no doubt the first judgment in Sheikh Javed Iqbal case, wherein also the Apex Court, while exercising the discretion, taken note of he was in custody for 4 years, and the same is an offense under section 489 B IPC and 489 C of IPC. And in the other case, no trial was fixed, even though accused is in custody from 2011 for a period of almost 5 years. In a case of Angela Hari Sontekke. And the factual aspects of the case on hand is also different. And in the case on hand, though he was taken to custody in 2021, already trial has been fixed and 7 witnesses have been examined, and all of the witnesses have supported the case of the prosecution, and the same has not been disputed by the petitioner counsel. When such being the case, this court cannot usurp the jurisdiction of the trial court to appreciate the evidence and only to see whether there is a prima facie case. And this court already comes to a conclusion that there is a prima facie case against the petitioner herein. And only on the ground of delay in trial cannot be exercise discretion. In the case on hand, there is no such delay also, even though case was registered in 2021 And already trial has been commenced and 7 witnesses have been examined and only remaining witnesses have to be examined. And when such being the case, the principles laid down in the judgments referred supra by the counsel appearing to petitioner will not come to the aid of the petitioner, and else I do not find any ground to enlarge the petitioner on bail exercising the discretion in successive bail petition. In view of the discussions made above, I pass the following order. Petition is dismissed.
84, Ganesh K.
SPP, they have to face.
Your Lordships, ED matter, Your Lordships. Directorate of Enforcement, Your Lordships, Special PP Prasanna Kumar will be.
Special PP Prasanna Kumara, ನಿಮ್ಗಲ್ವಾ?
On health.
ಅವ್ರಿಗೆ ಯಾಕೆ ಸರ್ವ್ ಮಾಡಿದ್ರಿ ನೀವು?
Yes, I have. Already they have taken notice. Already they have taken
notice. Notice ತಗೊಳ್ತೀರಾ?
On health ground, I have.
The special PP Prasanna Kumar takes notice for respondent.
Yes.
ಕಾಪಿ ಅವ್ರಿಗೆ ಸರ್ವ್ ಮಾಡಿದೀರಾ?
ಮಾಡಿದ್ದೀವಿ.
ಮಾಡಿದೀರಾ?
Already, sir, yes.
ಯಾವಾಗ?
Yes. Already, sir.
ಇಲ್ಲೇನ ಹೆಸರು ನೋಡಿ ಅಡಿಷನಲ್ SPP ತೋರಿಸ್ತಾ ಇದ್ದೀರಿ.
Yes. Sir.
ನೀವು ಸರ್ವ್ ಮಾಡಿರೋದು ಯಾರಿಗೆ? ಇಲ್ವಲ್ಲ ಇಲ್ಲೇನು ಸರ್ವಿಸ್ ಏನು ಇಲ್ವೇ ಇಲ್ಲ. And hence counsel for the petitioner is directed to serve the copy of this petition on the special PP and list this matter on
health ground, actually, we are moving the matter.
health ground ಅಲ್ಲಿ ಆಮೇಲೆ ಮಾಡೋಣ, ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿ ಆಮೇಲೆ
Yes, yes.
health ground ಕೊಡೋಣ.
We serve it on Monday.
List this matter on 6/11. Serve the copy 4th week. Last day ಕೊಟ್ಬಿಟ್ಟು ಆಮೇಲೆ ನಾಳೆ ನಿಂತ್ಕೋಬೇಡಿ ಬಂದು.
85, Vikyat. Petition.
Yes, counsel. ಏನ್ ಅಫೆನ್ಸ್ ಏನ್ರಿ?
Successive bail petition.
302, successive bail petition.
Yes, my lord.
And what is the changes? Circumstances.
Lordship,
Earlier it was considered on merits.
yes, my lord. My lordship, while disposing the bail petition, my lordship has given liberty to this petitioner.
Petitioner to approach this court after the receipt of FSL report.
FSL.
ಆಯ್ತು, FSL
My
report
lordship.
ಎಲ್ಲಿದೆ FSL report?
I have given some kind of documents, my lordship. Page number 8, my lordship.
8.
8, my lordship. On perusal of this
ಇವನ್
FSL
ಕಡೆಯಿಂದ
report.
ರಿಕವರಿ ಏನು?
Sorry?
ಇವನ್ ಕಡೆಯಿಂದ ರಿಕವರಿ ಏನು ಅಂದೆ?
Recovery only mobile phone ಅಷ್ಟೇ sir.
ಮೊಬೈಲ್ ಫೋನ್.
Mobile phone ಅಷ್ಟೇ.
ಹಾ.
Lordship, but page number
ಅದಕ್ಕೇನ್ FSL report ಬೇಕಾಗ್ತದ್ರಿ?
ಗೊತ್ತಿಲ್ಲ.
ಮೊಬೈಲ್ ಫೋನ್ಗೆ?
ಇಲ್ಲ sir.
You go to the earlier order. What is his name?
ಲೋಕೇಶ್.
Location. This is Naveen. ನೀವ್ ಯಾವ್ದೋ ಕಾಪಿ ಕೊಟ್ಟಿರೋದು ಯಾವ್ದೋ ನವೀನ್ ಇದೆ?
ಇಲ್ಲ sir. Page number 2 ನಲ್ಲಿದೆ. 3774 of 2021. 3774 of
ಮೋಸ್ಟ್ಲಿ ಬೇರೆ ಅಕ್ಯೂಸ್ಡ್ ಇದಾಗಿರ್ಬೇಕಂತ. ಇವನು ಇದಾನ ಲೋಕೇಶ್?
ಇದಾರೆ sir. ಇದಾರೆ. My lordship, page number 12, I have given some documents, my lordship. It could be seen from the document.
ಫಸ್ಟ್ ಅರ್ಲಿಯರ್ ಆರ್ಡರ್ ತೋರ್ಸ್ರಿ, ಏನಾಗಿದೆ ನೋಡೋಣ. ರೀಸನ್ ಏನು ರಿಜೆಕ್ಷನ್ಗೆ?
My lordship, reason is that
ಅಕ್ಯೂಸ್ ನಂಬರ್ ಎಷ್ಟು ಹೇಳಿ?
accused number 5.
5.
Yes. Observation made, my lordship, by this honorable court.
ಎಲ್ಲಿದೆ?
Page number 6, Your Lordships.
Page number 6.
6 ಅಲ್ಲಿ ಇದೆಯಾ? Having heard the respective counsel.
Yes, my lordship.
When there is a direct evidence against the petitioners here in CW 2 to 5 who are the eyewitnesses and the statement of eyewitnesses was also recorded on 9/7/2020. Immediately after the alleged incident on 8/7/20, no doubt learned counsel for the petitioner brought to the notice of this court that names of these petitioners were revealed on 11/7/2020 after their arrest. FSL report is awaited when there is direct evidence as well as seizure at the instance of the petitioners blood-stained cloths antide.
Cloths. ಇಲ್ಲ ಸ್ವಾಮಿ,
It
seizure.
is not appropriate to enlarge the petitioners on bail at this juncture. ಹೇಳಿ.
There is no cloths seized at the instance of this petitioner, my lordship.
ಲೋಕೇಶ್ ಸಂಬಂಧಪಟ್ಟಿದ್ದ ಶರ್ಟ್ ಮಂಜೇಶ್, ಶ್ರೀನಿವಾಸ್, ಮಂಜು, ರಾಘವ್, ಆರಿಫ್, ನವೀನ್.
Yes, my lordship.
Sword, Vinod Kumar, 1 shirt, pant. ಏನ್ madam, what is the recovery at the instance of this petitioner?
Your Lordships, there is bike, that joint recovery of bike, Your
ಏನೋ
Lordships.
bike?
3 bikes that have been recovered.
3 bikes.
3 bikes that have been
ಆಯ್ತು.
recovered. The instance of 3, 4, 5, 6, 7, 8, 10, 11 and 13. Bike has been recovered.
Bike, joint recovery.
Joint recovery.
ಅಷ್ಟು
3
ಜನ
bikes.
ಕಡೆಯಿಂದ 1 bike recoveryನಾ?
4 bike.
3 bike.
3 bikes.
Bike belongs to whom?
That RC not standing in the name of this petitioner, my lord.
Go to column number 17.
Yes,
Email ಏನಿದೆ charges? What is the role played by you? Accused number 5 ಅಲ್ಲ?
Yes, my lord. Please, your lordship. Third line, your lordships.
ಆರೋಪಿನ A5 ಆರೋಪಿ ಕ್ರಿಕೆಟ್ ಬ್ಯಾಟ್ ಅನ್ನು ಲಾಂಗು ಗಂಗಡ ಒಳಗಾದ ಜೀವನ್ ಬಾಲಕನ ಕತ್ತಿಯನ್ನು ತೆಗೆದುಕೊಂಡು ವಿನೋದ್ ಕುಮಾರ್ ಕಾರಿನ ಮೇಲೆ ದಾಳಿ ಮಾಡಿ A1, A5, A7 ರವರು ಗಾಜಿನ ಗ್ಲಾಸ್ಗಳನ್ನು ಹೊಡೆದು ಹಾಕಿ ನಂತರ A1 ಆರೋಪಿಯು ಕಾರಿನ ಡೋರ್ ತೆಗೆದು ಇಲ್ಲಿದ್ದ ವಿನೋದ್ ಕುಮಾರ್ನನ್ನು ಬಲವಂತವಾಗಿ ಹೊರಗೆ ಎಳೆದುಕೊಂಡು ನನ್ನನ್ನೇ ಎತ್ತುತ್ತೀಯಾ ಎಂದು ಸುಳ್ಳ ಮಗನೇ ಎಂದು ತನ್ನ ಕೈಯಲ್ಲಿ ಇದ್ದ ತಲವಾರದಿಂದ ವಿನೋದ್ ಕುಮಾರ್ ತಲೆಗೆ ಬಿಸಿದಾಗ ಅದನ್ನು ಕೆಳಗೆ ಬಿದ್ದಾಗ A1 ಆರೋಪಿ ತಲವಾರದಿಂದ ವಿನೋದ್ ಕುಮಾರ್ ತಲೆಗೆ ಹೊಡೆದು ಕೆಳಗೆ ಬೀಳಿಸಿ ತಲವಾರದಿಂದ ತಲೆ ಹೊಡೆದು A2 ಆರೋಪಿ ಲಾಂಗಿನಿಂದ A4 ಆರೋಪಿಯನ್ನು A5 ಆರೋಪಿಯು ಕ್ರಿಕೆಟ್ ಬ್ಯಾಟಿನಿಂದ ಸಂಘರ್ಷಕ್ಕೆ ಒಳಗಾದ ಜೀವನ ಕೈಯಲ್ಲಿ ಕತ್ತಿದರದ ಆಯುಧದಿಂದ ವಿನೋದ್ ಕುಮಾರ್ ಮೇಲೆ ತಲೆ ಹಿಡಿದು ಆಯ್ತು. ಐ ವಿಟ್ನೆಸಸ್ ವಿಚಾರಣೆ ಆಗಿದೆಯಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಇನ್ನ ಟ್ರಯಲ್ ಕಮೆನ್ಸ್ ಆಗಿಲ್ಲ.
ಮತ್ತೆ?
ಚಾರ್ಜ್ ಫ್ರೇಮಿಂಗ್. ಪೇಜ್ ನಂಬರ್ 23.
He assaulted with cricket bat ಅಂತ.
Cricket bat.
PM report.
Perusal of inquest and PM.
report.
There is no wounds caused by
PM report ಎಲ್ಲಿದೆ ರೀ?
PM report.
ಹಾಕಿದಿರಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ.
ಮತ್ತೆ ಹಾಕ್ಬೇಕಲ್ಲ PM ರಿಪೋರ್ಟ್.
Death
ನೀವು
is due
ಬೇಕಾಯ್ತು
to-
ಮಾತ್ರ ಹಾಕೊಳ್ಳೋದ ಪಿಟಿಷನ್ ಅಲ್ಲಿ?
Death is due to shock and hemorrhage as a result of injury.
ಆಯ್ತು, ಎಲ್ಲಿದೆ ರೀ PM ರಿಪೋರ್ಟ್?
They have not filed.
Why you have not produced all the materials of charge sheet?
I'll produce.
ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ ಮುಂದಿನ ಸರಿ ನೋಡೋಣ, ಎಲ್ಲ ಕೊಡಿ. ಅದೇನಿದೆ PM ರಿಪೋರ್ಟ್, ಸ್ಟೇಟ್ಮೆಂಟ್ಸ್ ಅವೆಲ್ಲ ಕೊಡಿ. FSL ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ ಇವಂದೇನಿಲ್ಲ. ಇವಂದು
ಏನು?
ಓನ್ಲಿ
Mobile phone is
recovery of the
Bikes.
bike.
Please.
That is joint recovery.
Giant.
PM
mobile-
report ಅಲ್ಲಿ ನೋಡೋಣ ಏನಿದೆ injuries. According to the prosecution allegation, he assaulted with cricket bat ಅಂತ.
Bat.
Cricket bat ಇಲ್ಲಿ ಹೊಡೆದಂತ injuries ಏನಾರು ಇದೆಯಾ ಅಂತ ನೋಡಿ.
Only he caused chop wounds.
Only chop wounds.
Chop wounds.
ಕೊಡಿ ಹೋಗ್ಲಿ, ನಿಮ್ಮ ಚಾರ್ಜ್ ಶೀಟ್ ನಾರು ಕೊಡ್ರಿ. ಅಲ್ಲ, ಚಾರ್ಜ್ ಶೀಟ್ ಜೊತೆ ಏನಾರು ಇದ್ರೆ PM ರಿಪೋರ್ಟ್ ಕೊಡಿ. ಐ ವಿಟ್ನೆಸ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಯಾರು ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಹೇಳಿದಾರಾ?
ಏನು ಹೇಳಿಲ್ಲ sir.
ಇವನ್ ರೋಲ್
ಇಲ್ಲ
There is
sir.
no specific allegation.
ಚಾಪ್ ಇಂಜುರಿ
Even the 164 statements have been recorded for CW 2 to 5.
ಅದೇ 2 to 5 ನಲ್ಲಿ ನೋಡಿ ಸ್ಪೆಸಿಫಿಕ್ ಏನಾರು ಓವರ್ ಟ್ಯಾಕ್ಸ್ ಅಲಿಗೇಷನ್ ಇವನ್ ಮೇಲೆ
No,
ಏನಾದ್ರು
no
ಇದೆಯಾ?
overtact is attributed against this petitioner.
ಇಲ್ವಾ?
ಇಲ್ಲ sir.
ಮತ್ತೆ ಯಾರು ಹೇಳಿದ್ದು ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಹೇಳಿದಾರಲ್ಲ A5 ಅಸಾಲ್ಟೆಡ್ ವಿತ್ ಕ್ರಿಕೆಟ್ ಬ್ಯಾಟ್ ಅಂತ?
ಹೌದು sir.
ಅದನ್ನ ಯಾರು ಹೇಳಿದ್ರಿ ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಹೇಳ್ಬೇಕಾದ್ರೆ?
CW
ಕಾಲಂ
2 to
ನಂಬರ್
5.
17 ಅಲ್ಲಿ
CW 2 to 5 is ಅವರು ಹೇಳಿದ್ದಾರೆ.
ಅವ್ರು ಹೇಳಿದಾರಾ ಅಂತ ಕೇಳಿದೆ.
ಹೇಳಿದ್ದಾರೆ sir.
ಹೇಳಿದಾರೆ.
ಹೇಳಿದ್ದಾರೆ.
ಅದೇನೆ ಕೇಳ್ತಾ ಇರೋದು.
But in the 164 statement, it is very different from 161 statement. my lordship. There is a contradiction between 161 statement and 164 statement.
ಎಲ್ಲ ಇಂಜುರೀಸ್ ಎಲ್ಲ ಚಾಪ್
Chop wounds ಇದೆ.
ಎಲ್ಲ ಇದೆಯಲ್ಲ ಮೇಡಮ್?
Please. There is only one.
ಕ್ರಿಕೆಟ್
abrasion.
ಬ್ಯಾಟ್ ನಿಂದ ಹೊಡೆದಾಗ ಆಗೋಂತ ಇಂಜುರೀಸ್ ಏನಾರು ಇದೆಯಾ ನೋಡಿ ಹೇಳಿ ನೆಕ್ಸ್ಟ್ ಟೈಮ್.
There's only third injury which says abrasion measuring, your lordships.
ಅಬ್ರೇಷನ್ ಮಾತ್ರನಾ?
Abrasion measuring 6 into 2 centimeters.
Heard. Heard the petitioner counsel and also the counsel appearing for the state. This court earlier rejected the bail petition in criminal petition number. ಎಲ್ಲಿದ್ದಾರೆ ಅದು ಕಾಪಿ ಆಫ್ ದಿ ಆರ್ಡರ್?
Page number 1. ಈ ಕೊಟ್ಟಿರೋ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಎಲ್ಲಿದೆ sir?
Page number 6, your lordship.
In criminal petition number 1918/2022 connected with criminal petition number 3774 of 2021, with order dated 23rd day of May 2022. This court also, while rejecting the bail petition of this petitioner, who is the petitioner number 1 in criminal petition number 3774 of 2021, who has been arraigned as accused number 5, comes to the conclusion that there are eyewitnesses to the incident, that is CW 2 to 5, and their statement have been recorded. And also recovery is made at the instance of the petitioners, and FSL report is awaited. And so also bloodstained cloths of the petitioners were also seized and hence rejected the application. However, given liberty to approach the petitioners to after the receipt of FSL report regarding seizure of bloodstained cloths. In the case on hand, the counsel appearing for the petitioner would contend that there is no any recovery. And the FSL report is produced before the court and the recovery of the stained cloths belongs to the different accused and not in respect of this accused. The allegation made in the charge sheet in column number 17 is that he had assaulted with the cricket bat. The counsel also brought to notice of this court that PM report doesn't disclose such injuries. And the injuries are mainly on the chop wounds and stab wound. ಇದೆಯಲ್ರಿ ಒಂದ್ ಕ್ರಿಕೆಟ್ ಬ್ಯಾಟ್ ಏನೋ ಇದೆ ಅದ್ರಲ್ಲಿ ಏನಾರು ಇದೆಯಾ?
Spot also is
Of examination, presence of blood stains were detected in items number 1-3. 3 ಅಂದ್ರೆ cricket bat.
Yes, my lordship. That is seized in the spot, my lordship, not from this accused.
ಹೌದಾ?
ಹೌದು sir.
ಏನಾಯ್ತು ಮೇಡಮ್? Stab injuries. And though the eyewitnesses spoken about the role of this petitioner under section 161, there is no any prima facie material against the petitioner herein. The counsel also would submit that no doubt the one cricket bat was seized at the spot and not at the instance of this petitioner, though allegation is made against this petitioner that he had assaulted with cricket bat. And hence he is entitled for bail. For contra, the counsel appearing for the respondent state would submit that cricket bat is serial number 3. ನೋಡಿ ಮೇಡಮ್ ಅದೆಲ್ಲಿ ಸೀಸ್ ಯಾರ ಕಡೆಯಿಂದ ಆಗಿರೋದು ಅಂತ ಏನಾರು ಇದೆಯಾ ನೋಡಿ ಸ್ಪಾಟ್ ಅಲ್ಲ ಎಲ್ಲಿದೆ ಸ್ಪಾಟ್ ಅಲ್ಲಿ ಸೀಸ್ ಆಗಿರೋದು ಅದು ಅಂತ and the FSL report discloses the same is stained with blood. ಮಾಜರ್ಲಿ ಇದೆಯಾ?
ಇದೆ sir.
ಏನಂತ ಸ್ಥಳದಲ್ಲಿ
Spot measure also sir. On 9/7/2020.
ಸುಜುಕಿ ಕಾರು ರಕ್ತ
Under PF number 82 of 2020.
ಸುಮಾರು 3 ಅಡಿ ಉದ್ದದ ಮರದ ಒಂದು ಕ್ರಿಕೆಟ್ ಬ್ಯಾಟ್ ಹೌದಾ?
ಹೌದು sir.
ಅದು ಎಲ್ಲಿದಾಗಂತ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇದೆ ಸ್ಪಾಟ್ ಅಲ್ಲಿ ಎಲ್ಲಿದೆ ಸ್ಪಾಟ್ ಮಾಜರ್?
ಅದ್ರ ಬ್ಯಾಕ್ ಸೈಡ್ ಇದೆ
ಸ್ಥಳ ಕೃತ್ಯ ಸ್ಥಳ ಪಂಚನಾಮೆನಾ?
ಹೌದು sir.
ಎಲ್ಲಿದೆ ಅದ್ರ ಹೇಳಿ ಯಾವ ಲೈನ್? ನಾನೇ ಓದ್ಕೋಬೇಕಾ ನೀವ್ ಹೇಳ್ತೀರಾ ಅಸಿಸ್ಟ್ ಮಾಡ್ತೀರಾ?
ಅದರಲ್ಲಿ ಇದೆ sir.
ಎಲ್ಲಿದೆ ಹೇಳ್ರಿ ಯಾವ ಲೈನು? ಮರದ ಬ್ಯಾಟ್ ಆಗಿರುತ್ತದೆ, ಹರಿತವಾದ ಬೆಂಡಾಗಿರುತ್ತೆ, ಸುಮಾರು ಅದರಲ್ಲೂ 1/2 ಇಂಚು ಹಿಡಿಕೆ ಇರುತ್ತೆ. ನಂತರ ಸುಮಾರು 3 ಅಡಿ ಉದ್ದದ ಒಂದು ಮರದ ಬ್ಯಾಟ್ ಆಗಿದ್ದು ಮತ್ತೊಂದು ತುಂಡಾಗಿದ್ದು 2.5 ಅಡಿ ಉದ್ದದ ಮರದ ಬ್ಯಾಟ್ ಆಗಿರುತ್ತೆ. 2 ಬ್ಯಾಟ್ಗಳು ಮತ್ತು ಲಾಂಗು ಕತ್ತಲೆ ರಕ್ತ ಕಲೆಯಾಗಿರುತ್ತವೆ. ಸದರಿ ಮಾಸ್ತ್ರಗಳನ್ನು ಪ್ರತ್ಯೇಕವಾದ ಬಿಳಿ ಕೃತ್ಯ ಸ್ಥಳದಲ್ಲಿದ್ದ counsel appearing for the state would submit that there are eyewitnesses CW 2 to 5 and also they have given the statement regarding involvement of this petitioner. And though injuries are found in PM report, injury number 3 is an abrasion. And evidence commence ಆಗಿದೆಯಾ?
ಇಲ್ಲ ಸಮಿಟ್
Evidence
ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿಲ್ಲ.
Evidence is not yet commenced and evidence is yet to be recorded. And
He is in the judicial custody since 4 years. He has no bad antecedents. This is the only case filed against him, this petitioner.
And the offences alleged against the petitioner is heinous offence, and all of them have shared the common object in eliminating the victim. ಎಷ್ಟು injuries ಇದೆ ಅವನಿಗೆ?
16 injuries.
And there are 16 injuries. And at this stage, the court cannot segregate the role of each of the accused. And when he was very much present at the time of the incident. Having heard, and in reply to the arguments, the counsel appearing for the petition would submit that he is in custody from
10/7/2020.
10/7/2020.
House.
And the charge has not been framed and yet to fix the trial. ಯಾವ ಊರಿನಲ್ಲಿ ಇರೋದು?
ಬಳ್ಳಾರಿ.
ಹರವಳ್ಳಿ. ಅಂದ್ರೆ ಕನಕಪುರನ?
ಇಲ್ಲ sir.
ಮತ್ತೆ?
Kanakpura village, but he was staying in Bangalore.
Offense ಎಲ್ಲಿ ಆಗಿರೋದ್ರಿ? ಬೆಂಗಳೂರಾ ಎಲ್ಲಿ?
Kaglipura. Bengaluru. Bengaluru.
ಬೆಂಗಳೂರೇ ಬರುತ್ತೆ.
Bengaluru.
Having heard the petitioner counsel and also the counsel appearing for the respondent state, and this court earlier rejected the bail application with a liberty to approach the court after the receipt of FSL report. No doubt, serial number 3 of the FSL report, the same is a cricket bat and it also contains the blood stains, but no recovery at the instance of this petitioner, and the bat is also recovered at the spot. The witnesses have spoken about the assault made by this petitioner with cricket bat, and also counsel appearing for the petitioner brought to notice of this court nature of injuries sustained, which have been mentioned in the PM report, and also on perusal of PM report, almost all injuries are chop wound and stab injuries, except the injury number 3, that there is an abrasion. And having taken note of the said fact into consideration, and also the very specific overt act allegation against this petitioner, which doesn't disclose us the nature of injury in the PM report, assaulting this victim with the cricket bat, and also having taken note of the material against this petitioner, FSL report. In the absence of any recovery at this petitioner, the petitioner has made out a prima facie case for enlarging the petitioner with conditions, since the incident was taken place in 2020 and also trial has not been commenced. Under the counsel submission is that even charge has not been framed. And when such being the case, taking into note of the Article 21 of the Constitution and the presence of this petitioner in the custody for trial, need not necessary, having considered the material on record, and hence the petition is allowed with conditions. Conditions with 2 lakh with conditions, other conditions. Okay.
86, Mohan Kumar D.
Successive bail application, my lord. Accusing custody on 20/12/2017.
2017.
17, my lord.
Pencil.
My lord, 302. My lord, my lord, the PW 1 to
Trial commence ಆಗಿದೆ ಇಲ್ಲ?
comments, my lord, PW 1 to 4 examine.
1 to 4.
The case of the prosecution, CW 2 and 4 eyewitness. My lord, CW 4 is turned hostile. My lord, PW 1 is hearsay witness, and 3 also hearsay witness.
What about CW 2 eyewitness?
2, my lord, chief examination completed. Last 2 occasion is absent. ಅಂದ್ರೆ ಕ್ರಾಸಿಗೆ ಬಂದಿಲ್ಲ. ನೆನ್ನೆ ಇತ್ತು, ನೆನ್ನೆ PW 1 ಕಂಪ್ಲೀಟ್ ಮಾಡಿದೆ ಕ್ರಾಸ್, ನೆನ್ನೆನೂ ಬಂದ.
CW 2 ಏನಾದ್ರು ಸಪೋರ್ಟ್ ಮಾಡಿದಾನ ಇಲ್ಲ ಚೀಫ್ ಅಲ್ಲಿ?
ಚೀಫ್ ಅಲ್ಲಿ ಇಬ್ಬರು ವ್ಯಕ್ತಿಗಳು ಅವನಿಗೆ ಹೊಡಿತಿದ್ರು ಅಂತ ಹೇಳ್ತಾರೆ. ಆ ಸ್ಟೇಷನ್ ಅಲ್ಲಿ ತೋರಿಸ್ತಾರೆ ಇಬ್ರು ಇವ್ರೇನ ಅಂದಾಗ 1 and 2 ನ ಈ ಐಡೆಂಟಿಫೈ ಇನ್ ದಿ ಸ್ಟೇಷನ್. My lord, in this background of the case, my lord, I before this court and also, my lord, accused number 1 died during the judicial custody.
A1 died.
Died. ಅಣ್ಣ ತಮ್ಮ, ಇಬ್ರು ಅಣ್ಣ ತಮ್ಮ.
ಇವನ್ ಪಿಟಿಷನರ್ A2 ನಾ?
A2, my lord.
A2.
ನಿನ್ನೆ ಟ್ರಯಲ್ ಇತ್ತು, ಕ್ರಾಸ್ ಆಯ್ತು.
Earlier main petition merits men dismiss ಆಗಿಲ್ಲ?
ಆಗಿದೆ.
ಆಗಿದೆಯಾ?
ಆಗಿದೆ.
ಎಲ್ಲಿದೆ ಆರ್ಡರ್?
My lord, in page number, my lord, 38.
38.
38. ಎರಡ್ ಸಲ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಆಗಿದೆ.
ಓ, ಮೊದ್ಲೊಂದ್ಸರಿ ಆಗಿದೆ.
ಹೌದು.
38.
38 my lord.
Very same judge dismissed twice. 2019, 2020, even Harisha.
Harish.
Twice it was dismissed.
Yes, my lord.
2021. Now what is the ground?
My lordship, only my limited 1 month may be granted. Mother, limited period of 1 month. ತಾಯಿ ನೋಡ್ಲಿಕ್ಕೆ ಅಷ್ಟೇ ಇನ್ನೇನಿಲ್ಲ.
ಈಗ ನೀವು ಕೇಳ್ತಾ ಇರೋದು ಏನು ಆ ಗ್ರೌಂಡ್ ಮೇಲೆ?
ಅದೊಂದೇ ಸ್ವಾಮಿ, ಇನ್ನೇನಿಲ್ಲ.
ಏನಾಗಿದೆ ತಾಯಿಗೆ ನೋಡಕ್ಕೆ?
ಅಂದ್ರೆ ಏಜ್
ಓಲ್ಡ್.
ಏಜ್ ಓಲ್ಡ್ ಅಷ್ಟೇ, ಬೇರೆ ಏನಿಲ್ಲ.
ಎಷ್ಟು ಏಜ್?
65.
65. ಈಗೆಲ್ಲ 85 ಮಿನಿಮಮ್.
ಅಲ್ಲ, ಮೊದಲನೇ ಮಗ ತೀರೋದ ಜೈಲಲ್ಲೇ. ವಿತ್ ಪೊಲೀಸ್ ಕಸ್ಟಡಿ ಆಲ್ಸೋ.
ಏನಾದ್ರು ಹೆಲ್ತ್ ಇಶ್ಯೂಸ್ ಇದೆಯಾ ಮದರ್ಗೆ?
ಅದೇ ಬ್ಯಾಕ್ ಪೈನ್, ಅದೊಂದು ಬ್ಯಾಕ್ ಪೈನ್ ಅಷ್ಟೇ, ಡಯಾಬಿಟಿಕ್
ಪೇನ್ ಮಾತ್ರನೇನ್ರಿ?
ಅಷ್ಟೇ.
ಆಯ್ತಾ, ಅಮ್ಮನೆ ಬಂದು ನೋಡ್ಕೊಂಡು ಹೋಗ್ಬೋದು ಮಗನ.
ಅಲ್ಲ, ವಿತ್ ಪೊಲೀಸ್ ಕಸ್ಟಡಿ ಆದ್ರೂ ಸರಿ ಸ್ವಾಮಿ. ಅಲ್ಲಿ
ಏನ್ ಪೊಲೀಸ್ ಕಸ್ಟಡಿ?
ಅಲ್ಲ, ಎಸ್ಕಾರ್ಟ್ ಸಮೇತ ನಾನು ನೋಡ್ಲಿ ಅಂತ ಅಷ್ಟೇ.
ಅಲ್ಲ ರೀ, ಅಮ್ಮಂಗೆ ಇನ್ನು ಏಜ್ 61.
ಅಲ್ಲ,
65 ಅಂತೀರಿ.
ಇಲ್ಲ 65.
61 ನಿಮ್ ಸರ್ಟಿಫಿಕೇಟ್ ಅಲ್ಲಿ ಇದೆ ನೋಡಿ, ಪೇಜ್ ನಂಬರ್ 9. ಸಂಜೀವಮ್ಮ.
ಎಸ್ ಮೈ ಲಾರ್ಡ್. ಕರೆಕ್ಟ್. ಇಲ್ಲಿ ಇಲ್ಲ, ಎರಡ್ ಕಡೆ 61, 65.
ನಮ್ ಕಣ್ಣಿಗೆ ತಪ್ಸಕ್ಕಾಗಲ್ಲ.
ಅಲ್ಲ 61, 65 ಎರಡು ಹಾಕಿದ್ದಾರೆ ಗವರ್ಮೆಂಟ್ ಹಾಸ್ಪಿಟಲ್.
61 years ಅಂತ ಇದೆಯಲ್ರಿ, ಸೀನಿಯರ್ ಸ್ಪೆಷಲಿಸ್ಟ್ ಜನರಲ್ ಹಾಸ್ಪಿಟಲ್. ಅದರಲ್ಲಿ ಬ್ಯಾಕ್ ಇರೋದು ಅಷ್ಟೇನೆ, ಏನಿಲ್ಲ. ಅಮ್ಮನ್ಗೆ ಹೋಗಿ ನೋಡ್ಕೊಬರ ಕೇಳೋದಷ್ಟೇ. ಓ, ಏನೋ ಫೋಟೋ ತಗ್ಸ್ಕೊ ಬಂದಿದ್ದೀರಿ, ಹಾಸಿಗೆ ಮೇಲೆ ಮಲಗಿಸಿ ಅಮ್ಮನ್ನ.
ಅಲ್ಲ, ಓನ್ಲಿ ಅದೊಂದೇ ಗ್ರೌಂಡ್ ಅಷ್ಟೇ, ತಾಯಿ ನೋಡ್ಲಿ ಅಂತ ಅಷ್ಟೇ, ಬೇರೆ.
ಒಂದೇ ಗ್ರೌಂಡಾ?
ಅದು ಒಂದೇ ಗ್ರೌಂಡ್
ನೋಡಿ, ಆರಾಮಾಗಿ ಚೇರಲ್ಲಿ ಕೂತ್ಕೊಂಡವ್ರ. ಒಂದ್ ಮಲಗಿಸಿದಿರಿ, ಒಂದ್ ಕೂರ್ಸಿದಿರಿ.
ಅಲ್ಲ, ಒಬ್ಬ ಸತ್ತೋದ, ಇನ್ನು ಒಬ್ಬನೇ ಇರೋದು, ಅದು ಒಂದು ಗ್ರೌಂಡ್ಗೋಸ್ಕರ.
ಏನ್ ಅಫೆನ್ಸ್ ಏನ್ 302 ಅಲಿಗೇಷನ್ ಏನು?
The accused number 1 and 2 for property dispute between the deceased and accused number 1 and 2 family. My lord, A1 and 2.
Nature of injuries ಏನ್ರಿ? ಹೊಡೆದಿರೋದು ಎಂತ?
41 injuries, my lord.
41 injuries.
41.
ಹೊಡೆದಿರೋದು ಎಂತದ್ರು?
ಅದು ನೈಫ್ ಅಲ್ಲಿ accused number 1 stab injury.
Not a case for granting bail. Bloodthirsty. It is nothing but bloodthirsty. 41 injuries. Third. Heard the petitioner counsel, maybe ಜಮೀನ್ ಡಿಸ್ಪ್ಯೂಟ್ ಇರ್ತದ್ರಿ, ಕೋರ್ಟ್ ಕಚೇರಿ ಇರೋದು, ಅದಕ್ಕೇನೆ ಡಿಸೈಡ್ ಮಾಡಕ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಜೀವ ತೆಗಿಯಕ್ಕಲ್ಲ.
After examination of CW2.
CW?
2 liberty may be given.
Heard the petitioner counsel and also the counsel appearing to the state. This is a successive bail petition and this court earlier rejected the bail petition of this petitioner in criminal petition number 7273 of 2018. ನಾಲ್ಕನೇದ್ರಿ ಇದು? ಆರನೇದ? ಓ, 6th petition. ನಾವೇ ನೋಡಿದ್ಮೇಲೆ 3ನೇದು ಅಂದ್ಮೇಲೆ ನೀವು 6ನೇದು ಅಂತ ಬಾಯ್ ಬಿಡ್ತೀರಾ?
ಇಲ್ಲ, ಅದು 3 ಸಲ ವಿಡ್ರಾ ಮಾಡಿದ್ದು.
ಆಯ್ತು, 6th bail petition. And now only the relief is sought based on the medical records pertaining to the mother who is aged about 61 and suffering from backache. Having perused the medical records, also there is no any serious illness of the mother of the petitioner. And mother is also aged about 61 years. And when such being the case, even on medical ground of the mother, the petitioner cannot be enlarged on bail and serious offense of taking of life of a person, that too causing injury of 41 injuries. It is nothing but bloodthirsty and question of exercising discretion in a case on hand when already court rejected 5 times the bail petition. And hence I do not find any change circumstances to enlarge the petitioner on bail.
CW2 ಆದ್ಮೇಲೆ liberty.
The counsel also submits that some of the witnesses have been examined. Only CW2 and 4 are the eyewitnesses. 2 and 4 are the eyewitnesses, and CW4 has been examined as with PW Stone.
4 hostile.
4 and he has turned hostile. And CW2 other eyewitness has been examined in chief and not subjected for cross examination. And the counsel also submits that petitioner may be given liberty to approach this court after the examination of CW2. Having considered the material on record, ಅವರು ಇಬ್ರೇ ಮಾತ್ರ ಐ ವಿಟ್ನೆಸಸ್, ರಿಕವರಿ ಇಲ್ವಾ?
ರಿಕವರಿ ಇದೆ.
ಮತ್ತೆ ರಿಕವರಿ ವಿಟ್ನೆಸಸ್ ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಲ್ಲ.
A1 ಕಡೆ ಅಂದ್ರೆ.
Having considered the factual aspects and also the recovery at the instance of the petitioner only on the ground of examination of CW2 cannot be a ground to give liberty to approach the court and other witnesses also to be examined in the matter, and also court has to take note of the gravity of the offense also and nature of the nature and manner of the alleged murder has been committed, and hence no ground is made out. In view of the discussions made up, I pass the following order. Bail petition is rejected. 87 Prasanna Kumar P.
Appear for the respondent, Your Lordship. Objection is ready. Kindly permit me to file.
ಏನ್ objections? ಫೈಲ್ ಮಾಡಿದೀರಾ?
ಇಲ್ಲ ಮಾಡ್ಬೇಕಿದೆ, objection ready ಇದೆ. Register ಅಲ್ಲಿ file ಮಾಡ್ತೀವಿ.
ಇವತ್ತು ಫೈಲ್ ಮಾಡ್ತೀರಾ?
ಇವತ್ತು file ಮಾಡ್ತೀವಿ.
Respondent counsel submits that he is going to file a statement of objections and also directed to furnish the copy of the statement of objections.
Received a copy.
ಮಾಡಿದೀರಾ?
Receive ಮಾಡಿ.
And copy of the statement of objections is also furnished to the other side. List this matter on 6/11.
One request, my lord.
Huh?
They have sent the papers for prosecution sanction. Let there be an order not to file charge sheet till then, please.
Huh?
They have sent papers for prosecution sanction.
Huh.
ಅಲ್ಲಿವರೆಗೂ may be protected, please.
Already heard in part ಅಂತಿದೆ. ಮ್ಯಾಟರ್ ಎಂಟ್ರಿ ಮಾಡಿದೀಯಾ earlier?
It's pending, IA is pending.
ಪೆಂಡಿಂಗ್.
Pending.
ಆಯ್ತು 6/11 ಕೊಟ್ಟಿದ್ದೀನಿ. ಏರ್ ಮಾಡೋಣ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಅವತ್ತು.
Not file charge sheet till then, ಅದಕ್ಕೋಸ್ಕರ.
No such order.
Serial number 90, Your Lordship, same.
ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಮಾಡಬೇಡಿ, ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡಬೇಡಿ ಅಂತೆಲ್ಲ ಆರ್ಡರ್ ಕೊಡಲ್ಲ ಈ ಕೋರ್ಟ್ ಅಲ್ಲಿ. ಆಯ್ತಾ? ಸಾಕು 7,000 ಪೆಂಡಿಂಗ್ ಇರೋದು ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮ್ಯಾಟರ್ಸ್. ವಿಕ್ಟಿಮ್ಸ್ ಎಲ್ಲ ಸತ್ರು. ವಿಕ್ಟಿಮ್ ಫ್ಯಾಮಿಲಿ ಎಲ್ಲ ಸತ್ರು.
Serial number 90, 91, 92 are all connected to that.
Same.
ಯಾವುದು?
90, 91, 92
ಅದು ಕನೆಕ್ಟೆಡಾ?
connected.
ಪೋಸ್ತಿ ಅದನ್ನು ಕೂಡ ಅವತ್ತೇ ಹಾಕ್ಬಿಡಿ. 90, 91, 92 ಎಲ್ಲ ಮ್ಯಾಟರ್ಸ್.
May I request one more matter, my lord? Criminal petition 6/222 is also connected to the same. 6/222 of 24.
ಇದು ಇನ್ನೊಂದಿದೆಯಾ?
ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ, ಅದನ್ನು ಇದಕ್ಕೆ connected.
Council also submits that the criminal petition number
6/222
of
24
also may be listed, and the same is also arising out of the very same crime.
Incident,
ಹೌದಾ?
not
Very
crime.
same incident, and hence the registry is directed to put up the same and list all matters on 6/11.
Obliged.
88.
Bring for the petition. Give us.
Lordship, today only we have received the papers, Lordship, and wakalat. I may be permitted to file the wakalat, Lordship.
ಏನ್ papers ರೀ?
ಇವತ್ತು ಬಂದಿದೆ ವಕಾಲತ್ತು papers.
ನಿಮ್ಗ?
Yes,
Council ಶ್ರೀ?
H&M Prasad, Manjunath Prasad HN.
Manjunath Prasad HN submits that he is going to file wakalat for respond number 2 na?
2, Lord, please.
Respond number 2.
Please.
And 6 time, and hence list this matter on ಯಾವಾಗ?
Monday, Manoj.
Monday.
Matter has been compromised in the trial court.
ಆಯ್ತು.
ಅಲ್ಲಿ they have undertaken. to
ಯಾವತ್ತು
withdraw the plea.
ನೀವ್ ಯಾವಾಗ ರೆಡಿ ಆಗ್ತೀರಿ ಹೇಳ್ರಿ ಬೇಗ?
Monday or Tuesday.
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 ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಇದೆ ನೋಡ್ರಿ ಮೇಡಮ್. Tuesday weekend ಅಲ್ಲಿ ನೋಡಿ.
Meantime, I may be.
ಅಲ್ಲ ನೆಕ್ಸ್ಟ್ ಬುಧವಾರಕ್ಕೆ ಹಾಕ್ಬಿಡಿ 6/11. Criminal matters ಎಲ್ಲ 6/11.
Place the documents on record last week.
ನೋಡಿ petitioner counsel has filed memo along with documents. ಆ copies ಅವ್ರಿಗೆ ಸರ್ವ್ ಮಾಡಿದ್ರ? And copies are also served on the R2 counsel. ಸರ್ಕಾರಕ್ಕೆ ಕೊಟ್ರ?
Only
ಅಲ್ಲಿ
petition.
ನಾವೇ ಕೇಳ್ಬೇಕಲ್ರಿ ಎಲ್ಲರಿಗೂ ಕೊಟ್ರ ಅಂತ. And copy is also served on the SPP.
Much less.
89.
ಕರುಣಾಕರ.
ಏನಾಯ್ತು ಮೇಡಮ್ ಇದ್ರಲ್ಲಿ ಪೇಪರ್ಸ್ ಬಂತಾ? ಲಾಸ್ಟ್ ಟೈಮ್ ಏನೋ ಇವ ಕಡೆಯಿಂದ ಪೇಪರ್ಸ್ ತರ್ಸ್ಕೊಳ್ತೀನಿ ಅಂತಂದ್ರಿ.
Your Lordships, I have not yet received, Your Lordships.
ಅಲ್ಲ ಮೇಡಮ್, ಬಿಫೋರ್ ಧಾರವಾಡ ಬೆಂಚಿಗೆ ಹೋಗೋಕ್ಕಿಂತ ಮುಂಚೆನೆ ಯು ಟುಕ್ ಟೈಮ್ ಟು ಸೆಕ್ಯೂರ್ ದಿ ರೆಕಾರ್ಡ್ಸ್. ಲಾಸ್ಟ್ ವೀಕ್ ಆಲ್ಸೋ ಯು ಟುಕ್ ಟೈಮ್. ಹೇಳಿ, ಈ ರೆಕಾರ್ಡ್ಸ್ ಇಲ್ವಾ?
Records in.
ಅದು ಮಿಸ್ಸಿಂಗಾ ಅಥವಾ ಏನು? ಮತ್ತೊಂದು ಮಿಸ್ಸಿಂಗ್ ಕೇಸ್ ರಿಜಿಸ್ಟರ್ ಮಾಡ್ಬೇಕಾ ಏನು?
Your Lordships, last one more date may be given, Your Lordships.
ತಗೊಳ್ಳಿ. The council additional SPP again seeks time, and in spite of sufficient time is granted, not secure the records, and hence directed to secure the IO and keep the IO present before the court. ಆಗ್ಲೇ ಬುದ್ಧಿ ಬರೋದು, ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. This matter on 6/11.
Interim order. Interim order.
Interim order ಇದೆಯಾ? Interim order granted earlier is extended till next date of hearing. Keep him present before the court, madam. Why he is not furnishing the documents?
90 to 92, Arjun, 93.
93. GS Prasanna Kumar.
Respondent number 3.
Ah,
Respondent number 2, my lord.
Sir,
Or
Madam
two.
Usharil.
Ah,
He is not well, sir.
Huh?
He is under treatment, sir. UTI.
who is under treatment?
ಇಲ್ಲ ನಮಿಗೂ ಹೇಳಿದ್ರು ಅವ್ರ ಪೆಟಿಷನರ್ ಕೌನ್ಸಿಲ್ ಅವ್ರು ಏನೋ ಸ್ವಲ್ಪ ಸೀರಿಯಸ್ ವೈರಲ್ ಫೀವರ್ ಇದೆ ಅಂತೆ ಬರಕ್ ಆಗ್ತಾ ಇಲ್ಲ ನಮ್ಗೆ.
Senior counsel ಇದಾರಲ್ಲೇನ್ರಿ? ಇದು ಯಾವ್ದು ಮ್ಯಾಟ್ರ್ ಹೇಳಿ? ಇದನ್ನು ಕೂಡ ಮಿಸ್ಸಿಂಗ್ ಆಫ್ ರೆಕಾರ್ಡ್ಸ್.
ಕರೆಕ್ಟ್.
ಬೇಲೂರಿನಲ್ಲಿ ರೆಕಾರ್ಡ್ಸ್ ಮಿಸ್ಸಿಂಗ್ ಆಗಿ ಕೇಸ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಿ.
ಅದೇ ಕೇಸ್.
Number 3 is before the court, your lordships.
ಅಕ್ಯೂಸ್ ನಂಬರ್ 3.
Accused number 3.
ಇದೇನಾ?
ಇದೇ ಕೇಸ್ ಮೈ ಲಾರ್ಡ್.
ಹೌದಲ್ಲ?
ಹೌದು.
ವೇರಿ ಚೌಟಾ, ವೇರಿ ಸಂದೇಶ್ ಚೌಟಾ. ಲಾಸ್ಟ್ ಟೈಮ್ ಏನೋ ನಿಮ್ ಕೊಲಿಗ್ ಏನೋ ಹುಷಾರಿಲ್ಲ ಅಂತ ಏನೋ VC ನಲ್ಲಿ ಕೇಳಿದ್ರು, ಟೈಮು ಕೊಟ್ಟಿದ್ದೆ. ಹೇಳಿ ಇವತ್ತೇನಾಯ್ತು? ವೆರ್ ಇಸ್ ಹಿ ನೌ? ಏನ? ನೀವ್ ಹೇಳದ್ ನಂಗೆ
ಇಲ್ಲ ನಮಿಗೂ ಫೋನ್ ಮಾಡಿ ಹೇಳಿದ್ರು ಅವ್ರಿಗೆ ಏನೋ ವೈರಲ್ ಫೀವರ್ ಆಗಿದೆ.
ಅವ್ರಿಗ್ರಿ ಲೇಡಿ ಅಡ್ವೊಕೇಟ್ ಹುಷಾರಿಲ್ಲ, ನನಗೂ ಗೊತ್ತು. ಲಾಸ್ಟ್ ಟೈಮ್ ಐ ಆಲ್ಸೋ ವಿಟ್ನೆಸ್ ಥ್ರೂ VC ಅಲ್ಲೇನ್ರಿ? ಮಧ್ಯಾಹ್ನ ಅಲ್ಲೆಲ್ಲ ಇದ್ರು ನೋಡ್ದೆ. ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಇಲ್ರಿ, ಫಾರಿನ್ಗೆ ಹೋಗಿದಾರ. ಚೋಟಂಗ್ ಫಾರಿನಿಗೆ ಕಳ್ಸಿದ್ರೇನ್ರಿ? ವಾಪಸ್ ಬಂದಾಯ್ತಾ? ಮತ್ತೆ ಎಲ್ಲಿ ಟ್ರಾವೆಲಿಂಗ್ ಅಂತನ? ಯಾರು ಇವತ್ತು ಹೇಳಿದಿರಾ ಅಥವಾ ಲಾಸ್ಟ್ ವೀಕ್? ಇವತ್ತೇನಾಯ್ತು? ಏನ್ರಿ ಏನಾಯ್ತು ಪ್ರೋಗ್ರೆಸ್ ಅಲ್ಲಿ ಗೌರ್ಮೆಂಟ್ ಅಲ್ಲಿ? ಯಾರು ಗೌರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಯಾರು ಅಪಿಯರ್ ಆಗೋದು? DPR ನ ಲಾಸ್ಟ್ ಟೈಮ್ ಏನೋ ಎನ್ಕ್ವೈರಿ ಮಾಡ್ತಾ ಇದೀವಿ ಏನೋ ಅಂತ ಹೇಳಿದ್ರು, ಮಿಸ್ಸಿಂಗ್ ಆಫ್ ರೆಕಾರ್ಡ್ಸ್ ಮೇಲೆ.
Additional AG is coming.
ಏನಾಯ್ತು? ಎನಿ ಪ್ರೋಗ್ರೆಸ್?
Progress is there. your
Enquiry.
lordships, and report is also ready. It's with the additional AG. your lordships.
ಆಯ್ತು, ಒಂದು ಡೇಟ್ ಕೊಡಿ ನೋಡೋಣ. ಪಿಟಿಷನರ್ ಕೌನ್ಸಿಲ್ 6 ಟೈಮ್.
ಸರ್ ಅಷ್ಟೇ ಮಾಡು.
ಆಯ್ತು, 6-11 ಬರ್ತಾರಾ? ಎಲ್ಲಿದ್ದಾರೆ? ಆಫೀಸಲ್ಲಿ ಇದಾರಾ? ಆಯ್ತು, ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 6-11. ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಡೇಟ್ ಕೊಡೋದಿಲ್ಲ, ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಬೇಕು. ನಾನು ಲಾಸ್ಟ್ ಅಕೇಶನ್ ಇಟ್ ಸೆಲ್ಫ್ ಐ ಮೇಡ್ ಇಟ್ ಕ್ಲಿಯರ್, ಆರ್ಗ್ಯೂ ಆನ್ ಮೆರಿಟ್ಸ್ ಅಂತ. ವಾಟ್ ಎವರ್ ಮೇ ಬಿ ದಿ ಡೈರೆಕ್ಷನ್ ಗಿವನ್ ಟು ದಿ ಗವರ್ಮೆಂಟ್, ಲೆಟ್ ದೆಮ್ ಫೈಲ್ ದಿ ರಿಪೋರ್ಟ್ ರಿಗಾರ್ಡಿಂಗ್ ಎನ್ಕ್ವೈರಿ ಇಸ್ ಕನ್ಸರ್ನ್.
ಅವ್ರದ್ದು ಇಂಟ್ರಿ ಮಾಡಿದೆ, ಇಂಟ್ರಿ ಮಾಡ್ರು ಮೇ ಬಿ ಎಕ್ಸ್ಟೆಂಡೆಡ್ ಮೇಲೆ.
ಇದ್ರ ಇಂಟ್ರಿ ಮಾಡಿದ್ಯಾ?
ಆಯ್ತು.
ಇಂಟ್ರಿ ಮಾಡ್ರಿ ಇಸ್ ಎಕ್ಸ್ಟೆಂಡೆಡ್ ಟಿಲ್ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್.
ಪ್ಲೀಸ್.
ನೀವ್ ಯಾರಿಗೆ ರೆಸ್ಪಾಂಡೆಂಟ್ ಪಿಟಿಷನರ್?
ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 2ಗೆ ಅಂದ್ರೆ ಅವ್ರು ಹೊಸದಾಗಿ ಬಂದಿದಾರಂತ ಅವರಿಗೆ ಸಬ್ಮಿಷನ್ ಮಾಡಕ್ಕಿದಲ್ಲ, ಹಂಗಾಗಿ
ಆಯ್ತು,
ಪ್ಲೀಸ್.
ಕಾಫಿ ಕೊಡ್ಸಿ ಅವ್ರಿಗೆ ಕರ್ಕೋಗಿ. ನಿಮ್ ಪರವಾಗಿ ಅವ್ರ ಪ್ರೇಯರ್ ಕೇಳಿದಾರೆ. ಆಯ್ತು. ಏನ್ರಿ? ಏನಾಯ್ತು? ಏನಾಯ್ತು? ಕೋರ್ಟ್ ಮುಂದೆ ಬಂತಾ ಇಲ್ಲ?
ಕೋರ್ಟ್ ಮುಂದೆ ಇನ್ನೂ ಬಂದಿಲ್ಲ.
ಈಗ ಬರಲ್ಲ ಬಿಡಿ, ಅದು ನೀವೇನ ಮಾಡ್ಕೊಳ್ಳಿ. ಆಯ್ತು, ಹೇಳಿ. ಏನು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಹಾಕಿದಾರೆ ಲಾಸ್ಟ್ ಟೈಮ್, ಅದೇನೋ ಅಡಿಷನಲ್ ಹೇಳಿ.
ಜಜ್ಮೆಂಟ್ಸ್
ಇಲ್ಲ ರೀ, ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ಜೊತೆಗೆ ಸುಮಾರು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಹಾಕಿದಾರೆ. ನಾನು ಧಾರವಾಡ ಬೆಂಚ್ ಅಲ್ಲಿ ಇದ್ದಾಗ ನಾನು ರಿಸರ್ವ್ ದಿಸ್ ಮ್ಯಾಟರ್, ಬಟ್ ಇನ್ ವ್ಯೂ ಆಫ್ ಫೈಲಿಂಗ್
ಇದೊಂದು
ದೀಸ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇದೆ ಅಲ್ವಾ?
ಇನ್ನೊಂದು ಕೊಟ್ಟಿದೆ.
ಇದ್ಯಾವ್ದು?
ED ರೇಡ್ ಆಗಿತ್ತು, ಅದು ಕ್ರಾಸ್ ಆಯ್ತು. ED ರೇಡ್ ಆಗಿತ್ತು, ಅದು ಕ್ರಾಸ್
ಅದಾಯ್ತು. ಲಾಸ್ಟ್ ಟೈಮ್ ಏನೋ ನೀವು ರಿಸರ್ವ್ ಮಾಡ್ಕೊಂಡ್ಮೇಲೆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೊಡ್ತೀನಿ ಅಂದ್ರೆ ಇಷ್ಟು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೊಟ್ಟಿದ್ದೀರಿ, ಅದಕ್ಕೋಸ್ಕರ ಟು ಹಿಯರ್ ದಿ ಮ್ಯಾಟರ್ ಅಂತ ಹಾಕಿದ್ದೆ. ಈ ಕಾಪೀಸ್ ನಿಮಗೆ ಕೊಟ್ಟಿಲ್ಲೇನ್ರಿ?
ಕೊಟ್ಟಿದೆ.
ಇದೆ ಅಲ್ಲ, ಕಾಪಿ ರಿಸೀವ್ಡ್ ಅಡ್ವೊಕೇಟ್ ಫಾರ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಂತ ಇದೆ. ಯಾರು ಅಂತ ಗೊತ್ತಿಲ್ಲ.
ಇವರೇ
19/9/24 ನೋಡಿ, ಆಲ್ಮೋಸ್ಟ್ 194 ಪೇಜ್ ಏನೋ ಇದೆ ನೋಡಿ. 275 ಪೇಜ್ ಇದೆ. ಅವ್ರು ಹಾಕಿರೋದು ಅಡಿಷನಲ್ ಪೇಪರ್ಸ್.
ಹೌದು,
ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ಹಾಕಿದ್ದಾರೆ, ಜೊತೆಗೆ ಮೆಟೀರಿಯಲ್ ಹಾಕಿದ್ದಾರೆ. ಆ ಚಾರ್ಜ್ ಶೀಟ್ ಏನೇನು ಫಸ್ಟ್ ಅವ್ರಿಗೆ ಇದು ಅಡಿಷನಲ್ ಆಮೇಲೆ ಹಾಕಿರೋದು ಮೇಡಮ್. ಅದ್ ನೋಟ್ಸ್ ಬಿಡಿ, ಅಲ್ಲಿ ನಾನು ಹಿಯರ್ ಮಾಡಿದ್ದು. ಇದು ಅಡಿಷನಲ್ ಆಮೇಲೆ ಹಾಕಿದಾರೆ ನೋಡಿ. 19/9/24 ಇದಲ್ವಾ? ಇನ್ನೊಂದು ಹಾಕಿದಾರ? ಇಲ್ಲ, ಇಷ್ಟೇ ಹಾಕಿದ್ದು. ಲಿಸ್ಟ್ ಆಫ್ ಸೈಟೇಷನ್ಸ್ ರಿಸೀವ್ಡ್
ಹೌದು.
ಕ್ರಿಮಿನಲ್ ಬ್ರಾಂಚ್ ಧಾರವಾಡ ಅಂತ ಏನೋ ಹಾಕಿದಾರಲ್ಲ ಇಲ್ಲಿ. ಇದು ಅಡಿಷನಲ್. ಆಯ್ತಾ?
ಅದ್ರಲ್ಲಿ ಇಡಿ ಅವ್ರದ್ದು ಕ್ರಾಸ್ ಆಗಿದೆ ಅಂತ ಹೇಳಿದ್ರೆ ಸರ್ಟಿಫಿಕೇಟ್ ಕಾಪೀಸ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಸರ್.
ಹಾ,
I have filed some,
ಇಡಿ ರೇಡೆಡ್
ಈಗ ಏನ್ ಹಾಕಿದ್ರಿ ನೀವು?
ಅದು ಕ್ರಾಸ್ ಆಗಿದೆ.
but I have filed a list of citations on 29.
ನೀವು ಹಾಕಿದ್ದೀರಾ?
ನಾನು ಹಾಕಿದ್ದೆ.
ಯಾವಾಗ?
29 January.
19 ಇದೆ, ಅಲ್ಲಿದೆಯಾ ನೋಡಿ ಮೇಡಮ್. ನೈನ್ಟೀನ್ 4 ಅಲ್ಲ ಮೇಡಮ್, ಈಗೇನ ಅವ್ರೇನೋ ಹಾಕಿದೀನಿ ಅಂತಾರ ಅವರು. 19 ಯಾವಾಗ ಡೇಟ್ ಅಲ್ಲಿ, ಯಾವ ಡೇಟ್ ಅಲ್ಲಿ ಹಾಕಿದ್ರಿ ನೀವು ಸಿಟೇಷನ್ಸ್?
29.
ಈ 29th
ಹೌದು.
ನಿನ್ನೆ.
ಹೌದು.
ಇನ್ನು ಪುಟಪ್ ಆಗಿಲ್ಲ ಅನ್ಸುತ್ತೆ. ನೋಡಿ, ಕಾಪಿನ ಅದರ್ ಸೈಡ್ ಸರ್ವಿಸ್ ಮಾಡ್ಬೇಕಲ್ಲ ನೀವು. Counsel for respondent submits that he has filed the citations in the registry yesterday, and hence the registry is directed to put up the same. The counsel also filed the copy of the SLP na ಏನದು ಹಾಕಿದ್ ನೀವು?
ಇದು
ಏನ್ ಹಾಕಿದ್ರಿ?
diary.
Copy of the diary for having filed the SLP before the diary number, for having filed the SLP before the
Supreme Court.
Supreme Court as against the order of ಏನು
In
quashing
quashing of accused number 1 is
in order passed in WP 44/16 of 22. Quashing of the same.
please.
The same is taken on record.
ನಾವೊಂದು ಮೆಮೊ ಹಾಕಿದ್ದೀವಿ ಸರ್.
ನೀವೇನ್ ಹಾಕಿದ್ರಿ?
WP ಇನ್ನೊಂದು ಇಡಿ ರೇಡ್ ಮಾಡಿದ್ದನ್ನ ಕ್ರಾಸ್ ಮಾಡಿದ್ದು ಅದನ್ನ ಡೀಟೇಲ್ ಕೊಟ್ಟಿದ್ದೆ. ಕಾಪಿ ಬಂತು, ಈಗ ಅದನ್ನು ಈಗ ಕೊಟ್ಟೆ.
ಈಗ ಕೊಟ್ರಾ?
ಹೌದು.
ಯಾವ್ದದು? The
Memo
counsel for the petitioner also filed memo along with copy of the order passed by the coordinate bench in writ petition number 16081 of 2024. ಹೌದಲ್ಲ?
ಹೌದು.
ಇದ್ರ ಕಾಪಿ ಅವ್ರಿಗೆ ಕೊಟ್ರ ನೀವು?
ಕೊಟ್ರಿ.
The
ಕೊಟ್ಟಿದ್ದಾರೆ.
counsel for the state is also received the copy of the same. List this matter on 6/11.
ಎಂಟ್ರಿ ಮಾಡಿ ಕೊಡ್ಬೋದು.
Entry order granted earlier is extended till next date of hearing. Entry order ಇದೆಯಾ ಇದ್ರಲ್ಲಿ?
ಎಂಟ್ರಿ ತಾವು ಕೊಟ್ಟು ಅದನ್ನ ವೆಕೆಟ್ ಮಾಡಿದಿರಿ. ಎಂಟ್ರಿ ಮಾಡಿ ಕೊಟ್ಟು ಅದನ್ನ
ವೆಕೇಟ್ ಆಗಿದೆಯಾ?
ಎಂಟ್ರಿ ಕೊಟ್ಟ ಆದ್ಮೇಲೆ ವೆಕೆಟ್ ಆಗಿತ್ತು. ಬಿಕಾಸ್ ಸರ್ಟನ್ ಡೀಟೇಲ್ಸ್ ಆರ್ ನಾಟ್ ಫರ್ನಿಶ್ ಅಂತ ಹೇಳಿ ಈಗ ಎಲ್ಲಾ ಡೀಟೇಲ್ಸ್ ಕೊಟ್ಟಿದ್ದೇನೆ. ಮತ್ತೆ ಈ ಪರಿಸ್ಥಿತಿಯಲ್ಲಿ ಇದೆ ಸರ್. ಯಾಕಂದ್ರೆ ಎಕ್ಸೆಪ್ಟ್ 2% ರಿಮೈನ್.
ಈಗ ಆಲ್ರೆಡಿ ಪಾರ್ಟೆಡ್ ಮ್ಯಾಟ್ರು ನೀವು ಅಡಿಷನಲ್ ಮೆಟೀರಿಯಲ್ಸ್ ಹಾಕಿದಿರಿ.
ಹೌದು ಸರ್.
ಅವರು ಸೈಟೇಷನ್ಸ್ ಹಾಕಿದ್ದಾರೆ.
ಹೌದು.
ನೆಕ್ಸ್ಟ್ ಟೈಮ್ 6ನೇ ತಾರೀಕು ಆ ಸೈಟೇಷನ್ಸ್ ಏನಿದೆ ಹೇಳಿ, ವಿಲ್ ಪಾಸ್ ಆರ್ಡರ್ಸ್.
ಮತ್ತೆ ಪುನಃ
ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇನ್ನೊಂದು ವಾರಕ್ಕೆ. ಏಕೆ ಇದ್ ಮ್ಯಾಟ್ರು ಇಟ್ ವಾಸ್ ಹರ್ಡ್ ಲಾಂಗ್ ಬ್ಯಾಕ್. ಮೋಸ್ಟ್ಲಿ ನಾನೇ ನೀವೇನೋ ಕೊಡ್ತೀರಿ ಅಂತ ಹೇಳೋದಕ್ಕೆ ಅವ್ರು ಕೊಡ್ಲಿಲ್ಲ ಅಂತ 3 ವಾರ ಕಾಯ್ತಿದ್ದೀನಿ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಕ್ಕೆ ಅಂತ, ಧಾರವಾಡ ಬೆಂಚಲ್ಲಿ ಇದ್ದಾಗ. ಆಮೇಲೆ ಕೊನೆಗೆ ಇನ್ನೊಂದ್ 3 ದಿವಸ ಇದ್ದಾಗ ಕೊಟ್ರು ಅವರು. ಆವಾಗ ಮೆಟೀರಿಯಲ್ 275 ಪೇಜ್ ಇಂದ ಈ ಕೋರ್ಟ್ಗೆ ಹಾಕೊಂಡ್ವಿ. ಆಯ್ತಲ್ಲ?
ಕೊಟ್ಟಿದ್ವಿ. ಇಲ್ಲಿಂದ ಪೇಪರ್ಸ್ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿದೆ.
ನಮಗ್ ಬಂದಾಗ 3 ದಿವಸ ಇತ್ತು.
ಹೌದು.
Finally, second week of May.
ಅಲ್ಲಿ ಆದ್ರೆ ಎಂಟ್ರಿ ಮಾಡಿ ರಿಲೀಸ್ ಮಾಡಿ ಸುಮ್ಮನೆ ಅಲ್ಲಿ ನಮ್ಗೆ ಅಲ್ಲಿ ಹರಾಸ್ ಮಾಡ್ತಿದ್ದಾರೆ ಅಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ.
6/11 ನೋಡೋಣ. ಯಾಕೆ ನಿಮ್ಗೇನ್ 6th
Difficulty to get it posted before the Supreme Court.
ಮಾಡ್ಕೊಳ್ಳಿ. ಪೋಸ್ಟಿಂಗ್ ಇನ್ನೂ ಮಾಡ್ಕೊಂಡಲ್ಲ ನೀವು. ಇವಾಗ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ರಜಾ ಇತ್ತಾನೆ ಈ ವಾರ. ಆಯ್ತು. ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಅಂತ
ಅದಕ್ಕಾಗಿ ಎಂಟ್ರಿ ಮಾಡ್ತಾರೆ.
ಮತ್ತೆ ಡೇಟ್ ಕೊಡೋದಿಲ್ಲ.
ಅಲ್ಲ ಹಾಗಾಗಿ
ಪಾರ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಕೌನ್ಸಿಲ್ ಇನ್ನೇನ್ ಮತ್ತೆ ಎಂಟ್ರಿ ಮಾಡ್ರಿ. ಹೇಳಿ ಮೇಡಮ್, ಪಾಸ್ ಓವರ್ ಆಗಿದೆಯಾ?
ಡೇಟ್ ಮೇಡಮ್.
With your lordship, that item number 93. Where it is urgent to 6th.
Urgent to 6th.
We will file the reports, my lord. Good progress is made and I will be able to.
Progress ಆಯ್ತು. ಏನ್ ಎನ್ಕ್ವೈರಿ ಮಾಡಿದ್ರಾ?
There only DPR has to issue the orders. Every department has given all particulars. Only DPR has to formally, my lord, issue order relating to prosecution.
ಏನ್ ಆರ್ಡರ್ ಮಾಡ್ಬೇಕು?
Or DPR permitting them to.
ಇನ್ನು ಎನ್ಕ್ವೈರಿನೇ ಮಾಡಿಲ್ವಾ?
ಮಾಡಿದ್ದಾರೆ. I will place all the reports before the lordship. 6th I will give the appointments.
ಅಲ್ಲ ಏನ್ ಎನ್ಕ್ವೈರಿ ಆಯ್ತಾ?
I was there. I was held up some. 6th I will.
ಆಯ್ತು. 6th ಆಲ್ರೆಡಿ ಹಾಕಿದೆ. ಕೊಡಿ ಅದೇನ್ ರಿಪೋರ್ಟ್ ನೋಡೋಣ. ವಿಲ್ ಸಿ. 2:30 ಅದು ತಗೋಬಿಡಿ, ಅದು ಮುಗಿಸ್ಬಿಡೋಣ. ಅಡ್ಮಿಷನ್ ಏನೋ ಅರ್ಜೆನ್ಸಿ ಅಂತಿದ್ರಲ್ಲ, ಏನದು?
Last date, by oversight to have been submitted execution.
Non-compliance of office objection for fourth time ಏನ್ರಿ ಅದು?
ಅಲ್ಲ, ಅದು amount ಎಲ್ಲ pay ಮಾಡೋದಕ್ಕೆ there was a direction by the Honorable Court as per that.
ಅದ್ ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ ಅಲ್ಲ, ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ fourth
ಅದನ್ನ
time ಏನು?
ಮಾಡ್ತಾ ಇದ್ದೀವಿ. Will comply it in the course of ಅದು date fix ಮಾಡಿದ್ರೆ.
Entry ಮಾಡ್ರ ತಗೊಳ್ತೀರಿ, ಯಾಕೆ
ಅಲ್ಲ,
ಕಂಪ್ಲೈ ಮಾಡೋದಿಲ್ಲ?
entry ಮಾಡೋದ್ರಲ್ಲಿ there was some mistake, my lord. ಅದು
Copy of this appeal memo along with its annexures on the counsel who appears for the decree holder in the execution petition. Copy serve ಮಾಡಿದ್ರ?
the trial court advocate.
ಹಾ.
Today we have moved it before this court because in the last date we.
ಅಲ್ಲ, ಈಗ ಸರ್ವ್ ಮಾಡಿದ್ರ ಇಲ್ಲ?
Trial court serve ಮಾಡಿದ್ದೀವಿ.
ಮಾಡಿದಿರಾ? ಆಯ್ತು. This matter on 11/11 ಅಂತ ಡೇಟ್ ಕೊಟ್ಟಿದ್ವಿ.
ಹಾ ಸರ್.
ನೀವು ಅರ್ಜೆನ್ಸಿ ಇದೆ ಅಂತ ಮಾಡಿದ್ರಾ?
ಇಲ್ಲ ಸರ್, ಅದ್ರಲ್ಲಿ
ನೀವು ಬಟ್ ಅವ್ರಿಗೆ ಡೇಟ್ ಯಾವ್ದು ಹೇಳಿದಿರಿ?
ಇವತ್ತು ಡೇಟ್ಗೆ.
ಈ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದ್ರಲ್ರಿ, ಕೋರ್ಟ್ಗೆ ಹೈಕೋರ್ಟ್ ನವ್ರು ಯಾವಾಗ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಅದರ್ ಸೈಡ್ ಕೌನ್ಸಿಲ್ ಹೇಳಿದಿರಿ.
Intimated them that the matter is posted on 11 along with the copy of this court order we have given them, your lord.
ಹಾ.
To the court also we have.
ಇವತ್ ಮೂವ್ ಮಾಡಿದ ಬಗ್ಗೆ ನೀವು ತಿಳಿಸಿದಿರಾ ಇಲ್ಲ ಅವ್ರಿಗೆ?
ಇವತ್ತು ಮೂವ್ ಮಾಡಿದ ಬಗ್ಗೆ we have intimated to the court itself, your lordship, saying that the court.
ಆಯ್ತು, ಈ ಕೋರ್ಟ್ ನವ್ರು ಏನ್ ಡೇಟ್ ಕೊಟ್ಟಿದಾರಾ ಅಥವಾ?
The matter is still kept, your lordship. They have set it down for final arguments and for consideration of application on attachment, your lordship.
The council ಮೊದ್ಲಿನ ಹಾಕಿದ ಅಟ್ಯಾಚ್ಮೆಂಟ್ ಏನಾಯ್ತದು? ಆರ್ಡರ್ ಆಗಿತ್ತಲ್ವಾ?
ಅದು recall ಮಾಡಿದ್ದಾರೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್.
ಅಟ್ಯಾಚ್ಮೆಂಟ್ ಆರ್ಡರ್ ಮಾಡಿದ್ದೇನೆ ರಿಕಾಲ್ ಮಾಡಿದ್ದಾರೆ.
ಹೌದು.
ಯಾವಾಗ ರಿಕಾಲ್ ಮಾಡಿದ್ದು? ಈ ಕೋರ್ಟ್ ಆರ್ಡರ್ ನ ಸ್ಟೇ ಮಾಡಿತ್ತಲ್ವಾ?
But
The order passed by the trial court in execution petition number 916 of 23 dated 16/10. 24 is still in a state of hearing ಅಂತಿದೆ.
lordship oversight, we had not had the knowledge, it was previously only recalled ante Swami. Upon that they have again moved an application.
ಈಗ ಸತ್ಯ ಬಾಯಿ ಬಿಡ್ತೀರಿ ನೋಡಿ. ಮತ್ತೆ once it has been already been recalled, why you got an order of stay of that order?
There was a miscommunication from
Huh?
the trial, from the.
No, you are not entitled for any relief. Let the matter come on 11th.
Just only further.
No, counsel, you made false submission before the court and obtained an interim order, staying of the order. Then why you made the submission that attachment order was passed on 16/10/24 anta?
It was previously made, your lordship, then.
Previous ಇಂದ ಯಾವಾಗ ಮಾಡಿರೋದು ಅದು?
16/10ಕ್ಕೆ ಮಾಡಿರೋ ಆರ್ಡರ್ ನ they have got it recalled ante.
ಯಾವಾಗ ರೀಕಾಲ್ ಆಯ್ತು? ನಾ ಅದನ್ನೇ ಕೇಳ್ತಾ ಇರೋದು. ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿದ್ಮೇಲೆ ರೀಕಾಲ್ ಮಾಡಿದಾರಾ?
ಹೌದು, ಆಗಿದೆ.
ಯಾವಾಗ?
Please, your lordship. Before that. Correct, good.
ನಮ್ಮ ಹತ್ರ ನೀವು ಆರ್ಡರ್ ತಗೊಂಡ್ರು 28/10 ಅಲ್ಲಿ. Sorry, the counsel appearing for the appellant would submit that in terms of the order dated 28/10/24, ಯಾವಾಗ recall ಆಗಿರೋದು ಹೇಳ್ರಿ. Copy is served on the counsel for the respondent who appears in the execution petition.
20.
The counsel also would submit that the order passed by the trial court attaching the property of the appellant was recalled and now they have filed the fresh application for attachment. And also the trial court is insisting for final arguments on final arguments and listed today. And in view of the appellant made the submission before the court that he is going to deposit the entire amount within a week from today. The further proceedings of the trial court is stayed till a state of hearing. The appellant counsel also directed to comply with order passed by this court, depositing the entire amount within a week from the date of order 28/10/24. ಆಯ್ತಲ್ಲ, further stay ಆಯ್ತು. ಆಮೇಲೆ ನೋಡೋಣ, this matter on 11/11. ಅಷ್ಟೊಳಗೆ ಬರ್ಲಿ ನೋಡೋಣ, ಅವ್ರೇನ್ ರೆಕಾರ್ಡಿಗೆ ಬರ್ತಾರಲ್ಲ. Before getting an order from this court, first you have to verify the records of the trial court. And when there is no such order is in existence, how you made submission before the court and obtain an interim order?
Next one, pastoral matter, serial number 3. RFP.
In this case, I'm filing a memo for withdrawal, my lord. It has to be filed before the session judge, my lord. I filed MFA, it has to be MA.
So the appellant counsel has filed memo seeking permission to withdraw the appeal, Allah?
Yes, my lord.
And hence permitted to withdraw.
To file before the appropriate court.
You already filed or you are going to file?
I'll file, my lord.
Already filed.
It's filed, my lord.
In view of filing of the, ಮತ್ತೆ liberty ಯಾಕೆ ಕೇಳ್ತೀರಿ?
I apologize, my lord. I filed, my lord.
In view of filing of the appeal before the district court.
Yes, my lord.
ಮತ್ತೆ ಇದನ್ನ ಕರೆಕ್ಟ್ ಮಾಡಿ ಮೆಮೋನಲ್ಲಿ ಏನೇನೋ ಬರೀತೀರಾ ನೀವು ಏನೇನೋ ಕೇಳ್ತೀರಾ ಆಯ್ತು. ಹಾ.
Field number 8.
8.
Needful has been done.
ಏನಾಯ್ತ್ರಿ ಡಿಸ್ಮಿಸಲ್ ಆಫ್ ಅಪೀಲ್ ಏನಾಯ್ತು?
Needful has been done.
ಎಲ್ಲಾನು ಕಂಪ್ಲೈ ಮಾಡಿದಲ್ಲ. The apparent counsel submits that he has paid the cost and also complied all the office objections. The office is directed to verify and put up and list this matter for admission on 11/11.
50.
ಏನ್ರಿ?
Court fees ಒಂದು ಕಟ್ಟೋಕೆ.
Dismissal of the cost ಕಟ್ಟಿದ್ರಾ?
Cost ಕಟ್ಟಿದ್ವಿ.
ಎಷ್ಟಿತ್ತು? ಹಾ.
Court fees
ಮಾಡಿದ್ರೆ ಇನ್ನು 3 ಇದೆ. The counsel submits that he has paid the cost and also complied some of the office objections and remaining office objections he is going to comply within
1 week ಮೇಲೆ.
1 week. And hence list this matter after 1 week.
Much obliged.
ಹಾ? ಅವ್ರು ಹೇಳ್ಬೇಕು. ಆಯ್ತು 12/11. after 1 week and ಬೇಡ 12/11 ಅಂತ ಹಾಕಿ.
29.
ಏನ್ರಿ ವಿತೌಟ್ NOC?
ಅದ್ರಲ್ಲಿ ಮುಂಚೆ ಅವ್ರು ಪ್ಯಾನಲ್ ಅಡ್ವೊಕೇಟ್ ಇದ್ರು, ಪ್ಯಾನಲ್ ಇಂದ ಹೋದ್ಮೇಲೆ ನಮಗೆ ವಕಾಲತ್ ಕೊಟ್ರು, ಹಂಗಾಗಿ ನಾನು ವಕಾಲತ್.
ಪ್ಯಾನಲ್ ಅಡ್ವೊಕೇಟ್ ಅವರು.
ಹೌದು, ಇದು KVIC ಆದಿ ವಿಲೇಜ್ ಇಂಡಸ್ಟ್ರಿ.
The counsel submits that. ಆಯ್ತು ಅವ್ರ ಹತ್ರ NOC ತಗೊಳ್ಳೋದು ಬೇಡವಾ ನೀವು?
ಇಲ್ಲ, ಪ್ಯಾನಲ್ ಇಂದ ತೆಗೆದ್ಮೇಲೆ.
ಹೌದಾ? So the counsel submits that earlier advocate was in the panel and now he has been removed from the panel and hence he filed the fresh wakalat. And hence, obtaining of NOC doesn't arise. But ಬೇರೆ ಏನಿದೆ? Mediation report.
ಬೇರೆ ಅದು ಹಾಕಿದ್ದಾರೆ ಅವರು. I have no objection to allow the application.
ಅವ್ರೇನೋ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿಲ್ಲ ಅಂದ್ರಲ್ಲ impleading application.
ಸರ್ವ್ ಮಾಡಿಲ್ಲ, ಈಗ ಕೊಟ್ಟರು, ಕಾಪಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಕೊಟ್ಟಿದ್ದೀರಾ?
ಈಗ
The
ಕೊಟ್ಟಿದ್ದಾರೆ.
counsel submit that he has furnished the copy of IA number 1/24 on the counsel for R1 and R2. ಸರಿನಾ?
ಅವರೇ ಹಾಕಿದ್ದಾರೆ.
ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿರೋದು
ಅವರೇ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ.
ಅವ್ರ ಕಾಪಿ ಈಗ ನಿಮಗೆ
ನಮಗೆ
ಕೊಟ್ಟಿದ್ದಾರೆ.
ಕೊಟ್ಟಿದ್ದಾರೆ. ಹೌದು.
ನೋಡಿ, counsel for R1 and R2 furnished the copy of IA to the appellant counsel and hence list this matter on 12/11.
47.
ಅದರ್ ಸೈಡ್ ಇರ್ಲಿಲ್ಲ ಹೇಳಿ.
I'm sorry, my lord, I was held up in the other court.
ಈಗ ಆಲ್ರೆಡಿ you have sought for an amendment for delivery of possession.
Correct.
And as a result, one the IA.
The two IAs, my lord, one is.
IASL one already it becomes alwa.
The one.
To grant the relief in their favor, if you succeed in the matter, then you are entitled for possession, that's all. Alwa?
My lord, the construction, my lord,
Hmm.
should be done at, without seeking equity tomorrow, my lord. They are doing the construction during the course of the pendency of the suit.
17 floors are completed.
17 floors are
And
constructions.
also the some of the persons have occupied the premises also. Completion certificate is also given. Occupation certificate is also given.
That is not placed on record, my lord. I am not aware.
I've given it to
my friend.
Copy ಕೊಟ್ಟಿದ್ದಾರೆ ನೋಡಿ.
I'll obtain instructions on that, my lord. But the possession of the property, my lord, was taken during the pendency of the suit. That's the reason I amended the plaint. No, my lord, when I filed an application, the application was not to put up further construction. So construction started at the time of filing of the suit. It's being done during the course of the pendency of the suit. And no, my lord, even if they want to say.
Well, they have filed the suit in 2014.
That is a bare injunction suit, my lord.
Temporary injunction ittu.
Really, temporary injunction was
They
not.
have started construction and also they have taken the temporary injunction. It was vacated in 2017 after 3 years. ಹೌದಾ? 14 ಅಲ್ಲಿ interim order ಆಯ್ತು.
That was an ex parte interim order granted.
So that was vacated in 2017 only.
My comprehensive suit was filed in 2016, my lord.
ಆಯ್ತ್ರಿ, ನೀವು ಡಿಕ್ಲರೇಷನ್ ಕೇಳಿದ್ರಿ 38 ಗುಂಟಾಸಿಗೆ ಕೇಳಿದಿರಿ.
ಹೌದು.
ಹೌದಾ? ಸೌತಿಗೆ ನಿಮ್ ಲ್ಯಾಂಡ್ ಇದೆ ಅಂತ.
ಹೌದು,
The property of them.
Please.
Not disputing that they are having the property. but your property is located on the south of the property of
Correct.
the appellant.
Correct,
ಹೌದಾ?
correct.
Now you also sought for the relief of the
Possession.
possession
Please, my
on
lord.
the ground that now you are not in possession.
Possession was taken
Then-
from it, please.
Huh.
No, but they'll have to still say, my lord, how they're entitled to put up construction because it's suit for declaration, my lord.
So let them complete it if you succeed in a suit for declaration to the extent of 38 guntas is concerned. Let them not claim any equity, that's all.
I'll once examine the OC and the CC, my lord. I just received it today. I was not even aware of it. I'm sorry. Once at the other note, but I'll make,
Permit them to put up the construction.
please,
If you succeed in declaratory suit,
please,
let them not claim the equity, that's all.
please.
Get right.
If your lordship kindly looks at
Next,
the list of dates I have given your lordships.
ಆಯ್ತು ಡೇಟ್ಸ್ ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದೀರಿ.
ಅಲ್ಲ,
But now they
ಅಲ್ಲ, ತಾವ್ ಕೇಳಿದ್ರಿ ಯಾವಾಗ ಶುರು ಮಾಡಿದ್ವು ಅಂತ. My plan is in 2014 itself.
ಆಯ್ತು 14 ಆದ್ಮೇಲೆ ನೀವು ಕನ್ಸ್ಟ್ರಕ್ಷನ್
14 ಆದ್ಮೇಲೆ
started construction, interim order was granted, vacated in 2017. By
and
that time
re-granted by this
by
court.
that time already 7 floors
Yes.
ಇಲ್ಲ, ಇಲ್ಲ,
constructed.
yes,
ಹೌದಾ?
Yes,
ಈಗ
yes,
now you have completed
yes,
and occupied the
Yes.
almost 17, 18 floors.
yes.
ಹೌದಲ್ಲ?
302
Ah,
apartments are.
In case if you have constructed the building,
Hmm.
if the land belongs to them,
Hmm.
then you cannot claim equity. Then we will say,
No, that they will have to ask for, I mean, they have not asked for that relief against,
ಯಾವ relief?
but not to claim equities.
ಅವ್ರು ಕೇಳಿಲ್ಲ.
ಅವ್ರು ಕೇಳಿಲ್ಲ.
But if you have constructed,
Somebody, your lordship,
ಅಲ್ಲ,
see,
if you have
I have,
constructed
my lord, I
on
have,
the property of them,
that is yes,
that's what I
on
am
their
telling.
property. Because,
That's what I am telling.
yeah, because
If they succeed in their suit for declaration, if any construction is made by you
on their land,
on the property of their land,
Yes.
you cannot claim equity.
that is always there, that is always.
We can dispose it of both the.
I'll just obtain instructions, my lord. I just received the,
Heard the appellant counsel and counsel for the respondent 6 time. List this matter on Tuesday.
please, my lord.
Heard. ಆಯ್ತು.
Obliged.
Tuesday ಎಷ್ಟು ಹೇಳಿ 511 ಅಲ್ಲ? ಆಯ್ತು ನೆಕ್ಸ್ಟ್. ಇದು ಒಂದು ಪಾಸ್ವರ್ಡ್ ಆಯ್ತಲ್ಲ 48. ಅದರ್ ಸೈಡ್ ಬರ್ಲಿಲ್ವಾ?
No man.
Heard the appellant counsel and counsel for the respondent is absent. If respondent counsel doesn't appear in the next date of hearing, matter will be disposed of in his absence. List this matter on. ಯಾವಾಗ?
Anytime
next week, huh?
Next week.
Next week ಯಾವ್ದಾರ ಒಂದು ಡೇಟ್ ಕೊಡಿ ಮೇಡಮ್. 8/11 ಹಾಕಿರ್ ನೋಡ್ರಿ.
My lord, interim order, my lord.
ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇದೆಯಾ?
No,
ಇಲ್ಲ ಅಂದ್ರೆ ಈಗೇನು 2018
because my lord, just one submission, my lord. I won't,
ಕೌನ್ಸಿಲ್ 2018
till now there was no question of sale.
ಇಲ್ಲಿವರೆಗೂ ಎಂಟ್ರಿ ಮಾಡ್ರಿಲ್ಲ.
No question of sale, my lord.
ಆಯ್ತು ಈಗೇನ್ ಅಗ್ರಿಮೆಂಟ್ ಮಾಡ್ಕೊಂಡವ್ರ ಏನ್ ಮಾಡಿದಾರೆ ಹೇಳಿ?
Yes, my lord, I
What is
produced a press document.
ಏನ್ ಡಾಕ್ಯುಮೆಂಟ್ ಅದು?
Trial court, my lord, has said that they should give security. Trial court has said clearly that if they sell the property, they have to give security. I produced, I produced a press article where they have notified the public that we are buying the property,
There?
that we are going to sell the property. That is why I have come before my lord. That's why I moved it.
ಎಲ್ಲಿದೆ ಆ ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್?
Yes, my lord. Please see Nexus selects trust to acquire Vega City Mall for 877 crores.
ಎಲ್ಲಿದೆ ಯಾವಾಗ ಕೊಟ್ಟಿದ್ದೀರಿ ನೀವು?
This morning I gave, my lord. Morning.
This is only a status of the case ಅಷ್ಟೇನೆ ಕೊಟ್ಟಿರೋದು. ಬೇರೆ ಏನೇನು ಕೊಟ್ಟಿದ್ದಾರೆ ಮೇಡಮ್ ನೋಡಿ?
My lord, the trial court has said that if they are going to sell the property, they have to give security. They have not approached the trial court. Here they have been going on saying that I am going to compromise. Now, please see, my lord, this is a press article.
Then you have to make an application.
No, my lord, please to see.
Based on this material.
No, this is going for registration now, my lord. My difficulty is I'll be without a remedy. Admitted liability. Till now, my lord, there was no circumstance. I should not trouble my lord when there is.
Sari re, when you have received the material, you would have.
Only now, my lord.
You have filed an IA.
No, my lord, I got it
Without
October,
IA, how can court
October
pass an
21st.
order?
My IA is here, my lord. It's still pending.
IA ನಲ್ಲಿ ಏನಿದೆ? Relief.
Yes, not to sell. Please
Not
see
to
ink
sell.
page 154. Ink page 154.
TIA.
Yes, not to sell the property. All I'm saying is, my lord, let them not execute any sale deed.
Creating any third party.
Yes,
interest.
that's all I'm saying.
But trial court ಅಲ್ಲಿ ಏನಾಯ್ತು? ಮತ್ತೆ status quo ಕೊಟ್ಟು vacate
It was originally status quo. Then trial court said that if they are.
the heard on IA number 1/18, wherein also prayer is sought. Restrain the defendants from mortgaging the social property by creating any third party interest, by executing any lease agreement, sale agreement, or mortgage, etc., in any manner whatsoever, pending disposal of the suit. And counsel would submit that now the appellant came to know that a publication
Yes, my lord. Article in the newspaper, October 21st.
found a article in the newspaper dated
October 21st, 2024.
21st of October 2024. Yenanta,
And please see that they are going to sell the property.
and they are going to the suit schedule property.
Yes, yes,
Suit schedule property.
yes. Please see ink page 8, my lord. That is the suit schedule property. Ink page 8. The property consists of a fully functional mall having so and so square feet, Blue Horizon Hotels. Mall is constructed, presently owned by Muniswamy HUF. Total purchase consideration of
Owned by so and so.
Yes.
Purchase of consideration and going to sell the same.
Yes,
Rupees 8,700, million.
million. It comes to 877 crores.
877 crores. And if it is sold, it leads to the multiplicity of proceedings. And having taken note of this document placed before the court and also the relief sought earlier. And earlier also the trial court granted status quo and thereafter vacated the same, and hence it is appropriate to grant the interim order of status quo till the next date of hearing.
Grateful. My lord, may I request hand delivery of the order, my lord?
Togoli.
Grateful.
Kodi, memo kodi.
I'll file it right.
56.
For the appellant,
I am for the response.
right, for the expeditiary proceedings, my lord, in the trial court, within a 2 months. Everything like.
Modern.
Much of it.
Heard the appellant counsel and also the counsel appearing for the respondent. This miscellaneous appeal is filed against the order dated 15th day of April 2024, rejecting the granting the
interim order
in favor of the plaintiff, restraining by an order of temporary injunction from interfering with the plaintiff's possession over the scheduled property in any manner.
not to disturb the construction activities of this.
In prayer ಕೇಳಿದ್ರೆ ಇಲ್ಲಿ ಆರ್ಡರ್ ಬರಿತಾ ಇದ್ದೀನಿ, ನಾನು ಆರ್ಡರ್ ನೋಡ್ಕೊಂಡು ಬರಿತಾ ಇದ್ದೀನಿ, ಆಯ್ತಾ? Interfering with the plaintiff's possession over the scheduled property in any manner pending disposal of the suit. ಆಯ್ತಾ? The above order is also, however, subject to cancellation, variation, or modification if necessary during the course of the proceeding. The IA filed under Order 39 Rule 4 of CPC is rejected. IA 2 filed by the applicant dependent under Order 39 Rule 4 of is rejected. Being agreed by the order, the defendant have filed the present appeal, wherein mainly contended that the court below has committed an error in granting the relief and fails to take note of the fact that plaintiff appellant defendant is in actual physical possession of the suitable property and the same belongs to him, and also contend that there was an agreement for the construction of the building and only right was given to the respondent to put up the construction in terms of the agreement. The trial court fails to take note of the said fact into consideration, and question of granting the relief of not to interfere with possession in favor of the plaintiff doesn't arise. The counsel also would submit that the appellant has already paid excess amount of rupees 20 lakh and also initial construction is only retaining wall and also only put the
Only foundation work, my lord.
columns and foundation. Howda?
Only foundation. That foundation itself,
Payment
still
ought
it is
to have been-
incomplete.
Payment ought to have been made after the first slab, and dispute was arisen between them. And the respondent plaintiff also insisting for payment, and he doesn't have any right to interfere with he doesn't have the right to get an order of injunction. The trial court committed a serious error by concluding by conclusion that the plaintiff has made out a prima facie case and balance of convenience, and it is only an agreement for the agreement between the parties for the construction of the building. If any dispute between with regard to the payment of the amount spent by the respondent, he has to file a suit for recovery, not for the restraining the owner in interfering with possession, and no such exclusive possession is given to the respondent, and only he was permitted to put up the construction in terms of the agreement.
That's what I am doing, Mullah. I am putting up the constructions and he is distracting and disturbing my.
Council appearing.
Payment has to be paid by me to make a construction, my lord. When it is already terminated, the contract
The
is not
council
arise.
also would submit that already terminated. The agreement on Yavaga?
11/10/2023, my lord.
That is not the proper way of.
10/23, whether it was served on him?
Yes, my lord, it is
No,
through
my-
the email, it is served, my lord. Page number
email.
73.
Same is sent through
No, Mullah, I have not.
Page number,
email,
mail, my lord.
Mail.
It is through the email.
Yavaga? Illiದೆ 73 na?
After causing my statutory notice for further payments and.
ನೀವ್ ಹೇಳಿರಂತ್ರಿ, ನಾನ್ ನಿಮ್ದು ಬರ್ಕೊಳ್ತೀನಿ.
Page number 70, my lord.
ಅವ್ರದ್ದು ಬರ್ಕೊಳ್ತೀನಿ, ನಿಮ್ದು ಬರ್ಕೊಳ್ತೀನಿ, ಆಮೇಲೆ ನಾನು ಡಿಸಿಷನ್ ಕೊಡ್ತೀನಿ, ಆಯ್ತು.
Page number 70, my lord.
17 na?
70, annexure G, my lord. 70.
As per annexure G. That is on 15th October 2023.
Yes, my lord. Email ಮಾಡಿದೀನಿ. That letter is 11/10/2023.
ಯಾವಾಗ ನಿಮಗೆ ಲೆಟರ್ ಕೊಟ್ಟಿರೋದು?
No, I have given a termination letter, my lord. Personally, I have given to them in the office, but they denied, they make me to go out of the house. This one from the office. Later on, the same thing I have sent by the email.
ಆಯ್ತು, ಸೆಂಟರ್ ಇಮೇಲ್ ಆಯ್ತು, ಅವ್ರೇನೋ ಒಂದು ಲೆಟರ್ ಕೊಟ್ಟಾರ ಅಂತಲ್ಲ, ಅದೇ
But they have not sent any legal notice to me. At the time of filing a suit, I come to know about there is a legal notice. That is unserved. It is there in the record, my lord.
ಸರ್ವ್ ಆಗಿಲ್ಲ.
Yes, served ಆಗಿಲ್ಲ. It is unserved. It is there in the record, my lord.
ಆಯ್ತು, ತಗೊಳ್ಳಿ. The
ಸರ್ವಾಗಿದ್ದಕ್ಕೆ.
council also would submit that when the
He
notice
has refused in receiving the.
when the notice was given terminating the contract work, question of granting the interim relief in favor of the respondent doesn't arise. For contra, the council appearing for the respondent filed. ಈಗ ಇಲ್ಲಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹಾಕಿರೋದ? ಫೈಲ್ಡ್ ದಿ ಡಾಕ್ಯುಮೆಂಟ್ಸ್. ಏನೋ ಕಂಪ್ಲೇಂಟ್ ಅಂತ ಹಾಕಿದ್ರಿ? ಡಾಕ್ಯುಮೆಂಟ್ಸ್
ಅದು
ಕಂಪ್ಲೇಂಟ್
My lord, even this
filed before
consumer forum ಅಲ್ಲಿ
Consumer
petition
forum
file
ಅಲ್ಲಿ-
ಮಾಡಿದ್ದೀನಿ, my lord.
commissioner at Bangalore.
He has approached the redressal
Plus-
forum also.
Who approached?
I
have
when the
approached
interim
the
order is pending,
but
he has approached there
I have
and.
approached, my lord, here because of the in deficiency of service or maltreat practice.
The respondent counsel has had filed the documents along with statement of objections filed by him before the district consumer disputes redressal.
For recovery of the amount, my lord. there.
Commissioner at Bangalore.
That is an entirely different suit, my lord.
Council also produced the copy of the agreement. The council also would submit that notice was given to make the payment, ನೀವೇನ್ notice
Allow me to proceed the construction. ಅಂತ so. He has made
to
obstructed for further construction.
appellant not to interfere with his construction work and allow him to put up the construction and to make the payment.
And to
in
make
terms of the
further.
contract. The council also produced the copy of the plaint and other documents, list of documents and also photographs for having he has undertaken the construction work.
Produce any copy. They are not served with me any copy, my lord. What is produced?
ಈ
before
copies
this?
ಕೊಟ್ಟಿಲ್ಲ ಅವ್ರು
ಏನು
ನಿಮ್ಗೆ?
copies ಕೊಟ್ಟಿಲ್ಲ, my lord.
ಕೊಟ್ಟಿಲ್ಲೇನ್ರಿ? ಯಾರಿಗೆ ಕೊಟ್ರಿ ಅವ್ರಿಗೆ
ಹಾ.
ಅದನ್ನ?
ನಾನು ಇಲ್ಲಿ ನನಗೆ ಅವಕಾಶ ಕೊಡ್ಲಿಲ್ಲ, ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇಲ್ಲಿ ಹಾಕ್ಲಿಲ್ಲ ಸ್ವಾಮಿ. ಅದು ರಿಡ್ರೆಸಲ್ ಫಾರ್.
ಹಾಕಿಲ್ಲ, ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಹಾಕಿದಿರಲ್ವ ಇಲ್ಲಿ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದು.
My lord, this is the submission, my lord, in the trial court also.
ಯಾರು ಹಾಕಿರೋದು ಇದು? ಅಪೋಸಿಟ್ ಪಾರ್ಟಿ ಅಂತಿದೆ.
My lord, like this only they got the interim order. my lord.
ಈ ಕೋರ್ಟ್ ಮುಂದೆ ಹಾಕಿದಿರಲ್ವ ಈ document? ಇದೇನ್ ಮತ್ತೆ ಇದು ಈ ಕೋರ್ಟ್ ಮುಂದೆ ಕೊಟ್ಟಿರೋದು?
ರಿಡ್ರೆಸಲ್ ಹಾಕಿದ್ದು ಫೋಟೋಸ್
ಬರೀ ಇಲ್ಲಿ ನೀವು ಹಾಗೆ ಅಲ್ಲಿ ಹಾಕಿದೀನಿ ಅಂತ ಇಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀರಾ?
My lord, the interim order, they got the interim order like this only, my lord.
Objections along with the documents.
ಅಲ್ಲ ರೀ, ಇದಕ್ಕೇನು ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಬರಲ್ಲ. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಸರಿ ಇದೆಯೋ ಇಲ್ಲ ಅಂತ ನಾವು ನೋಡ್ಬೇಕಷ್ಟೇನೆ. ನೀವು ಇಲ್ಲಿ
But he has
ಮತ್ತೆ
produced
ಟ್ರಯಲ್
some-
ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ನೀವು ಇಲ್ಲಿ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕೋದು ಆ ಪದ್ಧತಿ ಇಲ್ಲ, ಆಯ್ತಾ? ಹಾ, ತಗೊಳ್ಳಿ. The council, documents filed on bada madam. The council submits that the appellant also filed a petition before the Consumer Redressal Forum
For the deficiency of service or maltrate practice on the ground of that matter.
and for the deficiency of service, and the same is opposed by the respondent by filing statement of objections. And council also submits that the appellant not disputes the fact that work was entrusted to the respondent for construction of the work
As per the construction agreement dated.
for the agreement.
And according to me, the
Trial court also taking into note of document of agreement of construction.
and the quality of construction, my lord, given by the competent
Undertaken the construction.
authority.
I have produced the.
And quality
report of
also, it's
good quality construction which has been carried out by the
After-
respondent.
ನೀವು ಇಬ್ರು ಹೇಳಿದಿರಿ ಕೇಳಿದೀನ್ರಿ
Much
ಮತ್ತೆ
obliged.
ನಂಗೆ ಅಲೋ ಮಾಡಿ ಡಿಕ್ಟೇಟ್ ಮಾಡ್ಲಿಕ್ಕೆ.
Much obliged.
ಹಾ ಮತ್ತೆ when I started dictation, you have to shut your mouth. Before that I heard till 1:30, ಹೌದಾ?
Much obliged.
And trial court also taking into note of the material on record rightly comes to the conclusion that appellant respondent made out a prima facie case. And granted the relief and it doesn't require any interference. Having heard the appellant and also the counsel appearing with the respondent, it is not in dispute that there was an agreement for house construction dated 15th day of June 2023. It is also important to note that in terms of the agreement, the construction cost is rupees 1 crore
2 lakh.
2 lakh, howda?
House.
And in the payment schedule also is specifically mentioned
House.
on what date payment has to be made.
House.
Also in and also description of work is also shown in the agreement itself. It is also not in dispute that the respondent also taken up the construction work and also submits that he had already constructed retaining wall and also
footage,
put up
pillar construction.
foundation and also columns also raised.
My lord, can
And only the appellant has made the payment of rupees 20 lakh. The council also contend that the report produced by the appellant contend that even work was not done for having made the payment to the extent of 20 lakhs.
Yes, my lord.
And counsel for the respondent would contend that more than 35 lakhs of work was done.
Please. As per the report given by the survey.
As per the report given by the surveyor.
My lord, no such document before the.
No, I produced, it is there, sir. I produced in the lower courts.
Lower court ಅಲ್ಲಿ ಹಾಕಿದ್ದೀರಾ?
How's some,
My lord,
how's
that is a false document. my lord.
No, false hangge. Competent authority is given.
Counsel for the appellant also relies upon the report for having taken the report from the valuer for the extent of construction and value of the construction. ನೀವು ಒಂದು ತಗೊಂಡಿದ್ದೀರಲ್ವಾ?
My lord.
ತಗೊಂಡಿದ್ದಾರೆ sir.
My lord, ಇದು
ತಗೊಂಡಿದ್ದೀರಾ?
construction.
ತಗೊಂಡಿದ್ದಾರೆ
ನಾನು
sir.
ತಗೊಂಡಿದ್ದೀನಿ, but I will.
He always
at the
denies
time
my-
of that. Here, my lord, he is not a disputing.
Also counsel for the respondent also submits that he has also taken the report. And now the dispute is with regard to the payment is concerned.
House.
And when such being the case, when if the relief is.
And I am ready to proceed with the construction, my lord. My materials are pending in the
if
site,
is
my lord.
relief
And
is
men
to
and
be-
material are there in this.
Relief is to be granted. In respect, in terms of money, the question of granting the discretionary relief of restraining the appellant interfering with possession doesn't arise. It is not in dispute that property belongs to the appellant and work is entrusted for construction. And if any dispute between the plaintiff and also the respondent regarding payment is concerned, and there is a bar under section 41H of specific relief act, to grant the relief of temporary injunction. The claim made by the plaintiff is that he had invested more money for the construction of the building other than the amount what he has received. And on the other hand, it is the contention of the appellant defendant that he did the work lesser the amount what he has received, and the work of the respondent is also not the quality work, and hence dispute was arise between them. And when such being the case, the trial court ought not to have granted the relief of temporary injunction against the owner not to interfere with the same. If any such dispute with regard to the difference of amount in respect of the work carried out by the respondent as well as the work obtained from the appellant, and that has to be sorted out, and even the respondent can file a suit against the appellant for recovery of the amount if any excess amount he had spent for the construction of the same, and there cannot be interim order of injunction restraining the owner, and the no exclusive possession was given to the construction for the respondent plaintiff, and he was only permitted to put up the construction in terms of the
Without giving exclusive position, my lord, I cannot
contract.
enter into position and put up the construction with men and material, my lord.
Contract
My lord.
entered between the parties, and hence the trial court has committed an error in granting such an interim order by exercising the discretion. And also, no doubt, the trial court while passing an order of injunction restraining the defendant also made it clear that the said order also subject to the variation, cancellation or modification if necessary. And hence it is clear that the trial court also comes to the conclusion that the order can be modified. This court already comes to a conclusion that there is a bar under section 41H granting of relief of discretionary relief if the same is payable in terms of monetary relief. And when such being the case, I have already discussed with regard to if any loss incurred by the plaintiff, he has to recover the same if any violation in terms of the contract between the parties, and hence the order requires to be set aside. In view of the discussions made above, I pass the following order. The appeal is allowed. Interim order granted by the trial court is set aside. Set aside.
Also expeditious proceedings, my lord, within 2 months. The proceedings has to be carried out within 2 months. Their
No,
intention
my
only
lord.
to drag on, my lord. Al bartare, time ತಗೊಂತಾರೆ ಹೋಗ್ತಾರೆ. ನನ್ನ property already ruin ಆಗೋಗಿದೆ, my lord. In the photo, it clearly shows that, my lord. It's a false submission, my lord. It's a false submission.
ಅಲ್ಲ ನನ್ನ construction materials ಇದೆ. Then
My lord.
that's how I approach the court, my lord. Otherwise,
ಬೆಳ್ಕೊಂಬಿಟ್ಟಿದೆ, my lord. It's already ruined.
otherwise, I invested my hard earned money.
ನೋಡ್ರಿ ನಿಮಗೆ
Believing having trust
ಆಯ್ತು,
over-
ನಿಮಗೆ ಏನ್ ರೆಮಿಡಿ ಅಂತ ನಾನು ಆಲ್ರೆಡಿ ಹೇಳಿದ್ದೇನೆ. You recover it ಅಷ್ಟೇನೆ. How you can prevent the owner in putting up construction if you have
ಅಲ್ಲ,
spent the more-
when the still
if you
construction.
have spent the amount more, you can recover it.
ನನ್ನ construction activities, ನನ್ನ construction agreement still.
ಸರಿ ರೀ, ನಿಮ್ದು ಕ್ಯಾನ್ಸಲ್ ಆಗಿದೆ.
ಇಲ್ಲ, he has not communicated as
Lord,
per law, my lord.
Property.
Statutory notice he would have.
If you have spent the more, you can recover it. That's all. Sorry. The trial court is directed to dispose of the suit within a time bound period of 9 months from today, and both the
My
appellant
lord, at
counsel
least
and
6
also
months
the
may be granted.
appellant counsel and also the counsel for the respondent directed to assist the trial court in disposal of the suit within a time bound period of 9 months. ಏನ್ 2 ತಿಂಗಳಲ್ಲಿ ಏನ್ ಮ್ಯಾಜಿಕ್ ಮಾಡಕ್
ಇಲ್ಲ ಮೇಡಮ್, 6 months ಮೇಲೆ.
ಕೆಳಗಡೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕುತ್ಕೊಂಡು
ಇಲ್ಲ ಮೇಡಮ್, at least 6 months, my lord.
ಅಲ್ಲ,
ಯಾಕಂದ್ರೆ
ಎವಿಡೆನ್ಸ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್
ಸುಮ್ಮನೆ ಏನೇನೋ ಬೆಳ್ಕೊಂಡ್ಬಿಟ್ಟಿದೆ, my lord. Property.
9 months ಕೊಟ್ಟಿದ್ದೀನಿ, ಮಾಡಿ ಏನ್ ಬೆಳ್ಕೊಂಡ್ರು ತೆಗಿಬಹುದು ಅದನ್ನ.
Much obliged.
ಆಯ್ತಾ?
Much obliged.
ಫಸ್ಟ್ ಏನ್ ಕೆಲಸ ಮಾಡ್ಸಿದ್ರಿ ಅವ್ರಿಗೆ ಅಷ್ಟು ದುಡ್ಡು ಕೊಡಿ. ಮಾಡಿದಾರಲ್ಲ ಅವ್ರು.
My lordship already paid lot of the excess of them, my
ಆಯ್ತು,
lord.
ಎಕ್ಸೆಸ್ ನಿಮ್ ಪ್ರಕಾರ ಎಕ್ಸೆಸ್, ಅವ್ರ ಪ್ರಕಾರ
The
ಕಡಿಮೆ.
quality report itself, it is there in my hand, my lord. Then only they come to the trial court.
ಆಯ್ತು, ನೀವು
Exempt ಆಗೋದಿಕ್, my lord. ಅದನ್ನ.
both of you allow me to proceed in other matters. ಆಯ್ತು.
Much obliged.
ಹೈಲೋ.
ಎಂ ನಟರಾಜ್.
ಯಾವ್ದ್ರಿ ಸೀರಿಯಲ್ ನಂಬರ್ ಎಷ್ಟು ಮೇಡಮ್? 57. ಹೇಳಿ.
Monday or Tuesday, I have engaged a senior counsel. ಬಂದು ಹೋದ್ರು, ಅಲ್ಲಿ ಹೆಲ್ಡ್ ಅಪ್ ಆಗಿದೆ.
From currently IA number 1. Not to create any third party interest ಅಂತ ಆಗಿದೆ.
ಅದರಲ್ಲಿ ಸೀರಿಯಸ್ ಫ್ರಾಡ್ ಆಗಿದೆ.
Appellant counsel 6 time ನೀವೇ ಕೋರ್ಟ್ ಹಾಲ್ ಮೂವ್ ಮಾಡಿರೋದು ಹೌದಾ? ಮೆಮೋ ಮಾಡಿದ್ಮೇಲೆ ಮತ್ತೆ
ಸೀನಿಯರ್
adjournment
ಸೀನಿಯರ್
ಕೇಳ್ತೀರಿ?
ಬೆಳಗಿಂದ ಬಂದು ಹೋದ್ರು.
ಮೆಮೋ ಮೂವ್ ಮಾಡಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಕಾಸ್ಟ್. ಏನ್ ಹೇಳಿ?
ಅಲ್ಲ ಮಂಡೇ ತೆಗೆದು.
ಮತ್ತೆ
ಮಂಡೇ ಆರ್ ಟ್ಯೂಸ್ಡೇ.
ತಗೊಳ್ಳಿ. Appellant counsel seeks time and record discloses that they only moved the matter before this court by filing memo. And hence, adjourned and cost of ₹500 payable at registry, this matter on 11/11.
58 urgent, 59.
Sushant Sharma.
So petitioner's appeal,
Yes,
my lord.
ಇದು dismissed.
Please.
Dismissed on the ground?
The sole ground on the ground of maintainability land. The will, it is a probate petition, my lord. In the probate petition, at the time of filing itself, office has raised an objection saying that the executor, at the time of filing the probate petition, the office has raised an objection, saying that there is no executor mentioned in the will. Hence, a petition under 276 is not maintainable under 222, my lord. On the basis of office objection, the Honorable Trial Court at page 18 has passed the order. It's a 3-page order. Reasoning is
Not
that
maintainable antala?
not maintainable anta ashte ಮಾಡಿರೋದು ಸ್ವಾಮಿ.
So, heard the appellant counsel and in this appeal challenge is made that the trial court committed an error in dismissing the petition on the ground that petition is not maintainable, on the ground that if the will doesn't contain appointment of the executor under the will, question of granting the probate doesn't arise. ಅವೆರಡು ಆರ್ಡರ್ ಇದೆಯಲ್ಲ ನಾವು
Please, your
ಮಾಡಿರೋ
lordship's order is only there.
The council also relied upon the order passed by this court in division bench.
Petition bench and my lords only have passed an order as well.
Reported in 2019 SEC online Karnataka 3175, wherein also this court in detail discussed section 222 as well as section 231, 234, and comes to the conclusion that even in the absence of the executor, probate can be granted. This court also
Page 12, my lord's order.
in a miscellaneous first appeal number 5120 of 23. And also in the miscellaneous first appeal number 4399 of 23.
Paragraph number 13 to 15.
Considered the similar question involved in the matter and granted the relief. And hence the trial court ought not to have passed such an order of maintainability. And hence it requires interference. Having heard the appellant counsel and also on perusal of the order passed by this court in division bench and also in MFA number 5120 of 23 and MFA number 4399 of 23. The very finding given by the trial court that petition is not maintainable is erroneous and order requires to be set aside and matter has to be considered afresh by the trial court in accordance with law. In view of the discussions made above, I pass the following order. Appeal is allowed, impugned order is set aside. The matter is remitted back to the trial court to consider the petition in accordance with law.
Obligement.
60.
Manjunath H.
Status of tenants here.
Hmm.
The defendants are the subsequent purchasers from the lessor of this appellant number 1 and 2. We are running the juice shop in the suitable property, my lord. And it is our specific case before the honorable trial court that our landlord has obtained the loan from this defendant number 1 and 2, that is 3 crore rupees. And he executed the sale deed in the month of January 2022, 18/1/2022. And we are continued in the possession and without taking the steps according to due process of law, these defendant number 1 and 2, firstly, they have surrendered the electricity facility of the building. And thereafterwards, my lord, they have filed the 2 FIR against the landlord and also the plaintiff number 2 regarding that we have segregated certain documents. And in this regard, the tenants have filed the 2 FIR and the subsequent purchaser defendant number 1 and 2 filed 2 FIR and all the 4 FIRs pending before the Rajajinagar police station. And my specific case before the trial court is that, my lord, the defendant number 1 and 2, irrespective of whether they have granted the loan or they have really purchased the property, the adjournment of tenancy law will taken into place. and they have to dispose me with due process of law. Here, my finding recorded by the Honorable Trial Court is that it is unregistered agreement for 11 months and it is not subsisting as on the date of the filing of the suit. And moreover, the tenant cannot question the validity of the sale deed in between the lessor and the defendant number 1 and 2. And further, it recorded the finding that without electricity, how can I run my business? Where we are having the diesel generator, and not only me, there are other 5 tenants who have also filed the suits and obtained the ad interim temporary injunction. And one more point is, Your Honor, in the year 2023, they have filed the K-8 petition. This defendant number 1 and 2, even against me, and that is expired. Here, my learned friend has argued before the trial court saying that in the subsistency of the K-8 petition, we suppressed the material of K-8 petition and obtained the temporary injunction without considering any of the documents placed by the plaintiffs and also the defendant. The trial court has recorded the finding that we did not make out any prima facie case. In this regard, my lord, I am relying upon the 2 judgments of the dishonorable court on the point that prima facie case cannot be confused with the prima facie title of the parties to the litigation. And further, this honorable court, my lord, may kindly peruse the para number 22 of this honorable court judgment. I have served the copy, my lord. Petitionally para 22, my lord. May I read, my lord?
Yes.
While considering an application for grant of temporary injunction, prima facie case cannot be confused with prima facie title, and court must see whether not granting an order of temporary injunction would result in irreparable loss and injury to the party seeking such relief, and whether balance of convenience is in favor of granting an order of temporary injunction. Here, my case is very simple. I am carrying the business in the suitable property. I must be disposed with due process of law, and they have to issue the termination notice, irrespective of the fact that he has for that defendant number 1 and 2 have filed the separate suit 1050 of 2024 in the year 8/2/2024. And 9/2/2024, my landlord has filed the case against the defendant number 1 and 2, challenging the sale deed as a nominal sale deed, and it is for the loan security. Under these 2 suits are pending in between the my lessor and defendant number 1 and 2, and lesser defendant number 1 and 2, and my lessor and myself, and 4 FIRs are pending before the Rajajinagar police station, and none of the documents which I placed before the trial court were considered in the impugned order, my lord.
You are a tenant.
Tenant.
What is the document you have placed before?
What is the
court
tenant
that you are-
rent document?
Okay.
Rent to the trial court document. Madam.
Other side copies ಕೊಟ್ಟಿದ್ದೀರಾ? Huh?
Received, my lord, now.
In this regard, my lord, my specific case before the honorable trial court that I am tenant. And they also filed the FIR, and it is also case that they filed the K-8. And all these things, the filing of cases and FIR is undisputed fact of the case. The honorable trial court did not understand the urgency expressed by the tenants, saying that there are criminal cases already in between the parties, and it is a commercial building. It is not a vacant site which is involved in the present dispute. My simple case is that I have to be disposed with due process of law. Without taking action under the civil forum, they have approached the criminal forum saying that to take the forcible possession, that is evident on the material on record. And moreover, my landlord is disputing the sale deed. It is none of my business, my lord. This is between the my landlord and the defendant number 1 and 2. And defendant number 1 and 2 here in the financiers who have lent the amount of rupees 3 crores on one property and 2.6 crore on another property which is standing in the name of my wife.
Here a tenant under whom?
Tenant under one first Marappa Naidu. Marappa Naidu executed.
Marappa Naidu.
Yes. Marappa Naidu executed the gift deed in favor of his son MS Venkatesh.
Gift deed in favor of his son.
His son 10/12/2021.
ಆಯ್ತು.
ಸಿನಾಪ್ಸಿಸ್ ಅಲ್ಲಿ ಹೇಳಿದೀನಿ ಸ್ವಾಮಿ.
ಆಮೇಲೆ
ಇಂದ 18/1/2022 ಗೆ ಅವ್ರು ಸೇಲ್ ಡೀಡ್ ಮಾಡ್ಕೊಟ್ಟು 3 ಕೋಟಿ ರೂಪಾಯಿ ಲೋನ್ ತಗೊಂಡು.
ಯಾರು ಸೇಲ್ ಡೀಡ್ ಮಾಡ್ಕೊಟ್ಟು?
MS Venkatesh defendant number 1 and 2 ಗೆ.
Based on the gift.
Yes, based on the gift.
Executed
sale deed
in favor of whom?
Defendant number 1 and 2.
Defendant number 1 and 2.
Yes, madam.
ಆಯ್ತು.
ಆ ಡಿಫೆಂಡೆಂಟ್ ನಂಬರ್ 1 and 2 ಮತ್ತು ಪೊಸಿಷನ್ ನಮ್ಮ ಹತ್ರನೇ ಇತ್ತು. ಪೊಸಿಷನ್ ನಮ್ಮ ಓನರ್ ಹತ್ರನೇ ಇತ್ತು. ಇವತ್ತಿಗೂ ಕೂಡ ಪೊಸಿಷನ್ ನಲ್ಲಿ ನಾವೇ ಇದ್ದೀವಿ. ಜನರೇಟರ್ ನಲ್ಲಿ 7-8 ಶಾಪ್ ನಡೀತಾ ಇದೆ. ಅಲ್ಲಿ ಜಿಮ್ ಕೂಡ ಇದೆ. ಇದೆಲ್ಲ 7-8 ಕೇಸ್ ಪೆಂಡಿಂಗ್ ಇದೆ. ಈ 2 ಕೇಸ್ ನಲ್ಲಿ ಇಂಟ್ರಿ ಆರ್ಡರ್ ವೇಕೇಟ್ ಮಾಡಿದ್ರು. ಇಂಟ್ರಿ ಆರ್ಡರ್ ಬೇರೆ ಕೇಸ್ ನಲ್ಲೂ ಕೂಡ ಇದೆ. ಇವತ್ತವರೆಗೂ ಯಾವ್ದು ಕೇಸ್ ನಲ್ಲಿ ಅಡ್ವಾನ್ಸ್ ಮಾಡಿ ಅದನ್ನ ವೇಕೇಟ್.
ಟೆನೆಂಟ್ ಆಗಿದ್ದಾಗ how you can disturb?
My lord, the suit, my lord, is a subject matter with regard to the premises only. Schedule B property may kindly look at, my lord, in the suit. A schedule property is the whole property. B schedule property is a part and parcel of A schedule property which they are claiming under the tenant rights in respect of a shop premises, my lord, is measuring, they have given B schedule property, my lord, 7 by 9 feet. My lord, the para number 4 of the plaint, page 29, may kindly look at, my lord.
Yes,
Page 29, para number 4.
29 of the appeal.
Appeal memo, my lord. It is their specific plaintiff contention before the court in the pleadings as well as portion of the A schedule property let out to this plaintiff by the landlord, and said portion is more fully described in the schedule B property in the name and style of Chaya Barmashri Juice and Charts.
Right.
The Juice and Charts Center, for running that, they have they have taken a property from the original landlord. That is their entire case, and they are in possession of the property. We are trying to interfere with property without due process of law. The defendant shall
be evicted.
evicted anta. Your lordship may kindly see that in order to substantiate their claim before the trial court, they relied upon the one rent agreement. My lord, may kindly look at that rent agreement. That rent agreement is pertaining to a property number juice center. My lord, in a person want to run a juice, still according to their case, till this day they are running the juice center. But to run a juice center, a simple logic question, my lord, is that a power is very much necessary. Without power, it is impossible to run a day and night and day out to run the juice center.
So now there is a dispute with regard to the very property itself.
That is set up. My vendors as contending that there is a dispute with regard to the sale deed executed in my favor. They are disputing that for cancellation of sale deed, they filed a suit now. This tenant filed that landlord, my lord, is original landlord, instigating these tenants and filed this suit saying that because the property, my lord, when I paid when I purchased the property, my lord, is a lesser price due to the corona situation. Now the property increased. Now, my lord, these tenants have instigated by them and filed all the suits. But rightly or wrongly, there is a sale deed. They are not in possession. In order to show that possession, tenant, my lord, is that except a single piece of document, nothing has been produced before the court. A tenant agreement was.
Rent agreement now they are claiming from the earlier one.
My previous predecessors in title. My lord, we are the purchasers. We delivered the property possession under the as per the sale deed in 2020. Thereafter, my lord, in order to demolish the building, my lord, we have vacated them and they vacated. Thereafter, my lord, we surrendered the power connection to BESCOM. BESCOM authorities, my lord, has received the meter electric power connection in respect to
their building current illa.
The property which is each portion on black one meter irutte. Your property illa. The property, my lord, is now he is not at all residing. It is a vacant property. We are in possession of.
According to him, it is a commercial premises.
Commercial premises running a juice center till this date is the case. My lord, we are saying that till this day appoint any commissioner. There is no such a type of running a juice center in the B schedule property as alleged by them. Number one. Number two, my lord, trial court has rightly para number 10 and 11 of the impugned order may kindly look at, my lord. The findings given by there is no illegal and perverse order. Please kindly look at para 10 findings, my lord. It is an admitted fact that defendants may read, my lord.
Purchase the property.
Purchases the scheduled property through a register sale deed, so and so. In my considered view, tenants do not have any right challenge or object the register sale deed executed by landlord unless there are exceptional circumstances which has not been shown herein. Therefore, the burden is on the plaintiff to prove that he continued to be in possession of B scheduled property based on the rent agreement relied on by them. The plaintiff has produced the rent agreement dated 29/2018, which shows that the agreement was executed by one Marappa Naidu. However, it is pertaining to note that Marappa Naidu is neither the owner of the scheduled property nor a proper party to the sale deed. Further, the description of the property in the rent agreement pertains to property number 74, while identity of the suit scheduled property is house number 17, new municipal number 17/4. This discrepancy raises serious doubts about the very identity of the property in dispute. Moreover, as per the terms of the rental agreement, it was agreed that property would be leased for period of 11 months. The plaintiff has failed to produce any document or material evidence to show that after expiry of the lease, they continued to occupancy of the scheduled property as a tenant. There is no documentary proof or other material placed on the records to substantiate their alleged continued possession. The plaintiff has also submitted the electricity bills, but these bills pertaining to property number 705 situated at 10th Main, 3rd Block, Rajaj Nagar, which is unrelated to suit scheduled property. Additionally, the photographs produced by the plaintiff show that the suit A schedule property is an abandoned and inhabitation condition, which further weakness of the plaintiff's claims the possession. On the other hand, defendants have produced substantial documentary evidence to support their position, including the registered sale deed acknowledgement issued by the Broad Bangalore Mahanagarapalika regarding the payment of taxes. Defendants have also submitted the acknowledgement from BESCOM dated 38/2023, confirming the surrender of electric connection for the suit property with the application same number as filed on 7/8/2023. It is important to note that present suit was instituted by plaintiff on 3/5/2024, a considerable period, nearly 9 months after surrender of electricity connection. This delay further raises a question about the plaintiff's claim of uninterrupted possession and occupation of the scheduled property. The learned counsel for defendants have argued vehemently, plaintiff being aware of the caveat petition filed by defendant deliberately filed the present suit before the vacation court to avoid the obligations to issuing notice to caveators. The ex parte interim order obtained under the circumstances is now being used allegedly in collusion with the previous owner to gain the possession of B scheduled property. In a suit for bare injunction, particularly when they seek an interim relief, the plaintiff must not only demonstrate a prima facie case, but also to show the balance of convenience and hardship lies in their favor. In the present case, plaintiff has failed to establish the prima facie case of possession. The unregistered expired rent agreement does not conclusively prove the possession of the plaintiff, especially given the agreement pertains to different property and the plaintiff has not provided any further documents to substantiate their claim. Apart from that, balance of convenience and hardship also in favor of the defendant. The sale deed produced by the defendant clearly shows that consideration of 3 crores was paid to the landlord through a registered sale deed, granting the defendant's lawful possession over the property. Defendants have also taken steps to surrender the electricity connection, indicating their intention to demolish the existing structures and commence new construction on the scheduled property. In contrast, plaintiff has not placed any sufficient material before the court to demonstrate that they would suffer irreparable injury if an injunction were not granted. Therefore, plaintiff failed to establish the necessary. So, in the light of that, by reading this, the court order passed by the trial court is based on the evidence, documentary evidence produced before the court to consider the prima facie case and pass the order by looking into all the aspects. Therefore, there is no illegal and perverse order passed by the court is.
Yes, counsel.
My lord, the number 74 is concerned. Page number 95 of the sale deed may kindly be corresponded. The documents which I have produced before honorable.
Page number
95.
ಯಾವಾಗ ಈಗ ಹಾಕಿದ್ದೀರಾ?
ಈಗ ಹಾಕಿರೋದ್ರಲ್ಲಿ.
ಕೊಡ್ರಿ ಮೇಡಮ್.
Document
95.
ಅದರಲ್ಲಿ ನ್ಯೂ ಮುನ್ಸಿಪಲ್ ನಂಬರ್ 17/74 ಮುಂಚಿನ ನಂಬರು ಮುನ್ಸಿಪಲ್ ನಂಬರ್ 74 ಇತ್ತು ಅನ್ನೋದ್ರ ಬಗ್ಗೆ ಉಲ್ಲೇಖ ಇದೆ. ತಿರ್ಗಾ PAD ನಂಬರ್ ಅಲ್ಲಿ ಕೂಡ 74 ಇದೆ. ಅವ್ರು ರೆಂಟ್ ಅಗ್ರಿಮೆಂಟ್ ಮಾಡ್ಕೊಡ್ಬೇಕಾದ್ರೆ ಮಾರಪ್ಪ ನಾಯ್ಡು 74 ಅಂತ ಮೆನ್ಷನ್ ಮಾಡಿದಾಗ ಅದನ್ನ ಇಲ್ಲ ಇದೇ ಬೇರೆ ಪ್ರಾಪರ್ಟಿ ಅದೇ ಬೇರೆ ಪ್ರಾಪರ್ಟಿ ಅಂತ ಇವರು ಇಲ್ಲಿ ಫೈಂಡಿಂಗ್ ರೆಕಾರ್ಡ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಹೇಳ್ತಾರೆ. ಮೈ ಲರ್ನ್ಡ್ ಫ್ರೆಂಡ್ read over the impugned order, my lord, where the honorable trial court has held that Mr. Marappa Naidu is neither the owner of the suit property nor a party to the sale deed. Your Honor, it is clear that Marappa Naidu once owner of the property. That is undisputed fact of the case. And he has executed the gift deed. That is also undisputed in the sale deed contents. And I am a tenant under the Marappa Naidu. I am automatically becoming the tenant of defendant number 1 and 2. If at all they have given me termination notice, claiming the rent, I would have deposited the rent before the trial court. Without making such attempt, they are using the police. Your Honor, may kindly peruse the FIR copies, where also they are not disputing that we are the occupant of the property and we registered the FIR against my name. If at all I am not in the occupation of the property, this is the way they want to get the possession through the police. That is evident on the material on record and it is specifically argued before the trial court.
ಸೇಲ್ ಡೇಟ್ ಯಾವಾಗ ಆಗಿರೋದು?
18/1/2022.
22.
Yes, January 18.
Yes. ರೆಂಟ್ ಎಲ್ಲಿವರೆಗೆ ಕೊಟ್ಟಿದ್ದೀರಿ? ಯಾರಿಗೆ ಕೊಟ್ಟಿದ್ದೀರಿ?
ಈಗ ಕೂಡ ನಾವು ವೆಂಕಟೇಶ್ ಅವ್ರಿಗೆ ಕೊಡ್ತಾ ಇದ್ದೀವಿ. ಅದ್ರ
How can Miller?
ಫಸ್ಟ್ ಫ್ರಂಟ್
This is the collision.
ಫ್ರಂಟ್ ಪೇಜ್ ಅಲ್ಲಿ ಫಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲೇ ಕೊಟ್ಟಿದ್ದೀವಿ.
ಈಗ ಹೆಂಗ್ರಿ ಕೊಡ್ತೀರಿ ಸೇಲ್ ಡೀಡ್?
ಅಷ್ಟೇ.
ಸೇಲ್ ಡೀಡ್ ಅಂತಂದ್ರೆ ಸ್ವಾಮಿ ಇದು ಲೋನ್ಗೆ ಅಂತೇಳಿ ಬಾಫ್ನಾ ಅವರು ಫೈನಾನ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
That is
we will deposit.
ನೀವ್ ಹೆಂಗ್ ಅದು ಲೋನ್ ಅಗ್ರಿಮೆಂಟ್ ಅಥವಾ ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲ ನೀವ್ ಹೆಂಗ್ರಿ ಕಂಟೆನ್ಷನ್ ತಗೋತೀರಿ?
ನಾನು ಹೇಳ್ತಾ ಇರೋದಿಲ್ಲಿ ನಮ್ಗೆ ಇವರು ಇಲ್ಲಿವರೆಗೂ ನಾನು ತಗೊಂಡಿದ್ದೀನಿ ನನಗೆ ರೆಂಟ್ ಕೊಡಿ ಅಂತ ಇವ್ರು ಕೇಳಿಲ್ಲ. ಅವ್ರು ನಾನ್ ನೋಡಪ್ಪ ಲೋನ್ ತಗೊಂಡಿದ್ದೀನಿ, ನೀವು ನನಗೆ ಬಾಡಿಗೆ ಕೊಡಿ ಅಂತ ಕೇಳ್ತಾ ಇದಾರೆ, ಕೊಡ್ತಾ ಇದ್ದೀನಿ. ಪಕ್ಕದ ಅಂಗಡಿಯವ್ರದ್ದು ಅಫಿಡವಿಟ್ ಕೂಡ ನನಗೆ ಅಫಿಡವಿಟ್ MF ನಲ್ಲಿ ಹಾಕಿದ್ದೀನಿ. ಇವ್ರ ಪಕ್ಕದಲ್ಲಿಯೇ ಇದಾರೆ, ನಮ್ ಇದರಲ್ಲಿ ನೈಬರ್ ಅಂತ ಹೇಳಿ ಕೂಡ ಅಫಿಡವಿಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀನಿ.
Application ಹಾಕಿ ನೋಡೋಣ, we'll appoint a commissioner
Yes, sir.
and then we'll see who
Yes,
is
sir.
in possession of
Yes.
this property. ಯಾವಾಗ
ಒಂದು
ಆಗ್ತದೆ?
ಡೇಟ್ ಕೊಡಿ, ಸ್ಟಾರ್ಟ್ ಡೇಟ್.
Third in part. The counsel appearing for the appellant would submit that he is going to file an application for appointment of commissioner to inspect the property. And hence list this matter on ಯಾವಾಗ ಬೇಕು?
ಏನೇ ಡೇಟ್ 5th
6/11 ನೋಡೋಣ.
ಅದು ಇನ್ನೊಂದು ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಬಂದಿಲ್ಲ ಸ್ವಾಮಿ.
ಇನ್ನೊಂದು ಇದೆಯಾ?
MFA 6562 of 2024 ಅದು ಇನ್ನೊಬ್ರು ಟೆನೆಂಟ್ ಹಾಕಿರೋದು.
ಇದೆಯಾ ಅದು?
ಅದು ಇದೆ. ಇದು ಇವರೇ ಲಾಯರ್.
ಅದು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ.
ಕ್ಲಿಯರ್ ಮಾಡಿದ್ದೀವಿ.
ಮಾಡಿದ್ದೀರಾ?
ಕ್ಲಿಯರ್ ಮಾಡಿ ಇವತ್ತು ಕಾಪಿ ಸರ್ ಮಾಡಿದ್ವಿ.
ತಗೊಳ್ಳಿ.
ಇವ್ರಿಗೆ ಆಫೀಸ್
The
ಕಾಪಿ
appellant counsel submit that other MFA number
6562
6562
of
is
2024
also of 24
may be tagged with the.
also may be listed along with this petition and hence list the same.
Milord, apart from that, Milord, one submission.
Ah.
The rent receipt they have produced before the court, 15/3/24, 15/5/24, 15/10/24. ವೆಂಕಟೇಶನ್ ಅವರಿಗೆ ರೆಂಟ್ ಕೊಡ್ತಾ ಇದೀವಿ ಅಂತಾರೆ. ಓನರ್ಶಿಪ್ ಯಾರ ಹತ್ರ ಇದೆ? ಓನರ್ ಯಾರು? ವಿನಯ್ ಬಾಫ್ನಾ ಇಸ್ ದ ಡಿಫೆಂಡೆಂಟ್ ನಂಬರ್ 1. ಅವ್ರಿಗೂ ರೆಂಟ್ ಕೊಟ್ಕೊಂಡು ದಿಸ್ ಇಸ್ ಎ ಕ್ಲಿಯರ್ ಕಟ್. ಹೌ ಕ್ಯಾನ್ ಮಿಲಾಡ್ ಎರ್ಲಿಯರ್ ಪ್ರೀವಿಯಸ್ ಓನರ್ ಇವ್ರು ರೆಂಟ್ ಕೊಟ್ಕೊಂಡು ನಾನು ಸೇಲ್ ಡೀಡ್ ಇದ್ರೆ ಇಟ್ ಇಸ್ ನಥಿಂಗ್ ಬಟ್ ಎ ಕೊಲ್ಯೂಸಿವ್ ಸೂಟ್ ಬಿಟ್ವೀನ್ ದ ಟೆನೆಂಟ್ ಅಂಡ್ ಎರ್ಲಿಯರ್ ಓನರ್ ಟು ಡಿಫೀಟ್ ದಿ ರೈಟ್ಸ್ ಆಫ್ ದಿ ಪರ್ಚೇಸರ್. ಅಲ್ಲ ಇಷ್ಟೇ ಸಾಕು. ದಿಸ್ ಇಟ್ ಸೆಲ್ಫ್ ಫ್ರೇಮ್ ಆಫ್ ಐಸ್ ಶೋಸ್ 2024 ಅಲ್ಲಿ ನಾನು 22 ಆದ್ರೆ ಅಲ್ಲಿಂದ ಕಂಟಿನ್ಯೂ ಅದೇ ಒಂದೇ ಸಲ ರಿಸಿಪ್ಟ್ ಗಳೆಲ್ಲಾನು
ನಾವ್ ಇಲ್ವೇ ಇಲ್ಲ ಅಂತ ನಮ್ಮೇಲೆ FIR ಗಳು ಹಾಕ್ಸ್ಕೊಂಡು ಇಲ್ಲಿವರೆಗೂ ಇವ್ರ ಬಾಡಿಗೆ
ರೈಟ್ ಇವ್ರ ರೈಟ್ 22 ನಲ್ಲಿ ಟ್ರಾನ್ಸ್ಫರ್ ಆದ್ಮೇಲೆ ನನ್ನ ಹತ್ರ ರೆಂಟ್ ಅಗ್ರಿಮೆಂಟ್ ಮಾಡ್ಕೊಂಡು ಇವ್ರ ಟೆನೆನ್ಸಿ ಇದ್ದಿದ್ರೆ ಇವ್ರು ಟೆನೆಂಟ್ ಆಗ್ತಾ ಇದ್ರು. ಅದಿಲ್ಲ, ಬಿಟ್ಬಿಟ್ಟು 24 ಈಗ ಕೊಟ್ಟಿದ್ದಾರೆ ಮೊನ್ನೆ.
ಪರ್ಚೇಸ್ ಮಾಡಿದ್ಮೇಲೆ ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಕೊಟ್ರಾ?
ನೋಟಿಸ್ ನಮ್ಗೆ ಪೊಸಿಷನ್ ಸಮೇತ ಕೊಟ್ಬಿಟ್ಟಿದ್ರು, ಅವ್ರು ಇರ್ಲಿಲ್ಲ, ಖಾಲಿ ಮಾಡ್ಕೊಂಡು ಹೋಗಿದ್ರು ಕರೋನಾ ಪೀರಿಯಡ್ ಬಂದ್ಮೇಲೆ ನಂತರ.
ಅಪಾಯಿಂಟ್ ಮಾಡ್ತಾ ಇದೀವಿ, ನೋಡೋಣ ಯಾರ ಹತ್ರ ಪೊಸಿಷನ್ ಇದೆ ಅಂತ. ಫಸ್ಟ್ ವಿಲ್ ಸಿ.
ಅಲ್ಲ ಇಂಜಂಕ್ಷನ್ ಸೂಟ್ ಮಿಲಾಡ್, ಐ ಹ್ಯಾವ್ ನೋ ಅಬ್ಜೆಕ್ಷನ್ ಫಾರ್ ದಟ್, ಬಟ್ ದೇರ್ ಇಸ್ ಎ ಸ್ಕೋಪ್ ಆಫ್ ಇಂಜಂಕ್ಷನ್ ಸೂಟ್ ಇಸ್ ವೆರಿ ಲಿಮಿಟೆಡ್ ಮಿಲಾಡ್.
ಮಾಡ್ಬೋದು ಅಂತಾನೆ
ಪೊಸಿಷನ್ ಯಾರಿಗಿದೆಯೋ ಅವರಿಗೆ ಕೊಡಬೇಕು.
ಟು ಅಸರ್ಟೈನ್ ದಿ ಪೊಸಿಷನ್ ಈಸ್
ಪ್ರೊಟೆಕ್ಷನ್ ಕೊಡಬೇಕು.
ಇಂಜಂಕ್ಷನ್ ಸೂಟ್
according to you, you are in possession.
yes milord, there is no dispute. I am showing that prima facie case showing that milord.
ನೀವು ಹೇಗೆ ಒಂದು ಮಾತ್ರ ಆ ಬಿಲ್ಡಿಂಗ್ ಕೊಂಡ್ಕೊಂಡ ಮೇಲೆ ಪರ್ಟಿಕ್ಯುಲರ್ ಶಾಪಿಗೆ ಮಾತ್ರ ಮೀಟರ್ ಸರೆಂಡರ್ ಮಾಡಿ?
ಇಲ್ಲ ಸುಮಾರು ಇದೆ, ಇನ್ನು ನನ್ನ ಹತ್ರ ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದೀವಿ. ಈ ಕೇಸ್ ಸಂಬಂಧಪಟ್ಟಿದ್ದು ನಾನು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ದು ಓನ್ಲಿ ವಿತ್ ರಿಗಾರ್ಡ್ ಟು ದಿಸ್ ಕೇಸ್.
ಆಯ್ತು. 6/11
yes
6562 and 24 list the matter along with this appeal. Next 61 ಏನೋ ಇದೇನೋ ಬೆಳಿಗ್ಗೆ ಏನೋ ಕೇಳಿದ್ರಲ್ರಿ ಯಾರ? ವಕಾಲತ್ತು
ಸರ್ವ್ ಮಾಡಿದೀವಿ.
ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಫೈಲಿಂಗ್ ಸರ್ವ್ಡ್ ಕಾಪಿ ರಿವಿಷನ್ ಪಿಟಿಷನ್ ಟು ದಿ ಕೌನ್ಸಿಲ್
ಸರ್ವ್ ಮಾಡಿದೀವಿ.
acknowledgement
ಫೈಲ್ ಮಾಡಿಲ್ಲ, ಕಂಟ್ರೋಲ್ ಮಾಡ್ತೀನಿ, ರೆಡಿ ಇದೆ.
appellant counsel petitioner counsel submits that copy is served on the counsel Sri Devaraja and Manjunatha B. ಹೌದಾ?
ಹೌದು ಸ್ವಾಮಿ.
Who appears for R4 and R4. If such acknowledgement is produced, put up the same. ಇನ್ನೇನ ನಾನು ವಕಾಲ ಫೈಲಿಂಗ್ ಆಫ್
ಫೈಲ್ ಮಾಡಿದ್ದೇನೆ ಸ್ವಾಮಿ.
ಮೊಹಮ್ಮದ್
I filed it today.
ತಗೊಳ್ಳಿ. The counsel Mohammad Usman Sheikh submits that he has filed the wakalat for R3. ಹೌದಾ?
Milord, one submission. Connected matter ಅಲ್ಲಿ ಸೇಮ್ R4 97 of 21 review petition ಅಲ್ಲಿ ದೇವರಾಜ್ ಮಂಜುನಾಥನ್ ಅವರು ವಕಾಲತ್ ಹಾಕಿದ್ದಾರೆ.
ಯಾರು ದೇವರಾಜ್?
ಮಂಜುನಾಥನ್ ಅವರು.
ಅವರಿಗೆ ಶುರು ಮಾಡಿ. ಮಾಡಿದಿರಿ ಈಗ? ಅದನ್ನು ಮಾಡಿದೀವಿ ಸ್ವಾಮಿ. ಮಾಡಿದೀವಿ ಆಲ್ರೆಡಿ. ಆಯ್ತು. The counsel for the review petitioner also would submit that in RP 96 of 21 also served the copy on the counsel Devaraja and Manjunatha B, who appears for R4. And if such acknowledgement is filed before the registry, put up the same and show the name of ಅಲ್ಲ ಅವ್ರು ಬರ್ದವ್ರು ಏನ್ ಮಾಡೋಣ? ಕಾಪಿ ಶುರು ಮಾಡಿ ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನೋಟಿಸೇ ಮಾಡ್ಬೇಕ. ಮೊದ್ಲಿಂದ್ರಲ್ಲಿ ಹೆಂಗೆ ಇವ್ರು ಹೆಸರು ತೋರಿಸಿದಾರೆ ಮೇಡಮ್? ದೇವರಾಜ್ ಅಂಡ್ ಮಂಜುನಾಥ B for R4 ಹಾಕಿದಾರ
ಆಲ್ರೆಡಿ ವಕಾಲತ್ ಫೈಲ್ಡ್ ಮಲೋಡ್ 97.
ಆಯ್ತು ಅದ್ ಬರ್ಲಿ ನೋಡೋಣ. ಪುಟ್ ಅಪ್ ದಿ ಸೇಮ್ ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 12/11.
ಮಚ್ ಗ್ರೇಟ್ಫುಲ್.
ಇಲ್ಲ ಯಾವಾಗ ಬೇಕ್ರಿ? ಒನ್ ಟಾಪ್ ಟೈಮ್ ಯಾವತ್? ಟೈಮ್ ಆಲ್ರೆಡಿ 5 o'clock.
I said argument already ಆಗಿದೆ.
ನಮ್ ಸೈಡ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗಿದೆ ಸ್ವಾಮಿ.
ಅವ್ರು ಮಾಡ್ಬೇಕಾ?
ಅವ್ರು ಮಾಡ್ಬೇಕು, ಅವ್ರ ಟೈಪ್ ತಗೊಂಡಿದ್ದಾರೆ.
ರೆಸ್ಪಾಂಡೆಂಟ್ ಕೌನ್ಸಿಲ್ ಇಲ್ವಾ?
ಹಾ.
ಲಾಸ್ಟ್ ಟೈಮ್ ಏನೋ ಕಾಪೀಸ್ ತಗೊಳ್ತೀವಿ ಅಂತ ಏನೋ ಅಂದ್ರಲ್ರಿ ಅವರು, ತಗೊಳ್ಳಿ. ರೆಸ್ಪಾಂಡೆಂಟ್ ಕೌನ್ಸಿಲ್ ಇಸ್ ಆಬ್ಸೆಂಟ್, ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ.
ಡಿಕ್ಟೇಷನ್ ಮಾಡ್ತೀವಿ ಅಂತ ಹೊರಟ್ರಿ ಸ್ವಾಮಿ, ಅವಾಗ ಆರ್ಗ್ಯುಮೆಂಟಿಗೆ ಟೈಮ್ ತಗೊಂಡ್ರು.
ಅವರೇನೋ ಪೇಪರ್ಸ್ ಕಲೆಕ್ಟ್ ಮಾಡ್ಕೋತೀವಿ ಏನೋ ಮಾಡ್ತಿದ್ರಲ್ಲ ಅದ ಅವ್ರು ಇವ್ರದ್ದಾಯ್ತು ಅಷ್ಟೇ. ದಿಸ್ ಮ್ಯಾಟರ್ ಯಾವಾಗ್ಲೂ ಒಂದ್ಸರಿ ಟೈಮ್ ಏನೋ ಪೇಪರ್ಸ್ ರಿಲೀವ್ ಮಾಡಿಲ್ಲ ಅಂತ. Respondent counsel for respondent seeks time. Third, the respondent counsel is absent and on 15/10/24, the counsel for respondent took time. And on 22/10/24, for want of time, matter was urgent. And today no representation and hence taken as no arguments of respondent. Reserved, post the matter for, taken as no arguments, reserved. Huh? ಏನು ಈ ಶಾಂತಭೂಷಣ್ ಏನು ಬರೀ ತಗೊಳ್ತೀವಿ ಅಂತ ಮಾತ್ರ ಹೇಳೋರ? ಆಮೇಲೆ ಏನಾಯ್ತು, ಹಾಕಿದಾರ ಇಲ್ಲ? ಆಯ್ತು. ಈಗ ಬಟ್ ಯಾರು ಹಾಕಿರೋದು? ಆಮೇಲೆ ಹಾಕಿದಾರಲ್ಲ ಇಲ್ಲ, ಎಮ್ಮೆ ಹಾಕಿದಾರ ಇಲ್ಲ ಅವರು? ಬಟ್ ಡೆಪ್ಯೂಟಿ ಇವ್ರದ್ದು ಹೆಸರಂಗ್ರಿ ತೋರಿಸಿದ್ರು. ಏನಕ್ಕೆ ಅಂತ ಮಾಡಿದ್ದಾರೆ. ಬಟ್ ಅವ್ರು ನಮ್ ಅವ್ರಿಗೆ ಇರ್ಬೇಕು, ASG ಅವರೇ ಇರ್ಬೇಕಲ್ಲ. ಆಯ್ತು, ಕೌನ್ಸಿಲ್ ಆಬ್ಸೆಂಟ್, ಪೋಸ್ಟ್ ದಿ ಮ್ಯಾಟರ್ ಫಾರ್ ಇದು ರಿಸರ್ವ್ಡ್ ಅಂತ ಹಾಕೋಬಿಡಿ ಅಷ್ಟೇ. ನೆಕ್ಸ್ಟ್ ಫೈನಲ್ ಇಯರಿಂಗ್ ಎಲ್ಲ ಡೇಟ್ ಕೊಟ್ಬಿಡಿ. ಹಿರೇಮಠದ್ದು 12/11, ತನ್ವೀರ್ ಪಾಷಾ ಇದು 12/11, 66 ಚಂದ್ರಚೂಡ್ ಆಲ್ರೆಡಿ ಅರ್ಜೆಂಡಾ 66. ಹಾ,
ಸೀನಿಯರ್ ಅಬ್ರಾಡ್ ಅಲ್ಲಿ ಇದ್ದಾರೆ ಮೈಲಾಡ, ಬೆಳಗ್ಗೆ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ದೆ. ಕೈಂಡ್ಲಿ ಆವೇಶ 15th ಮೈಲಾಡ್,
ಯಾವಾಗ
15th ಮೈಲಾಡ್.
ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 15/11.
ಮತ್ಸಬಲ
68 ಸೌಜನ್ಯ
ಫಾರ್ ಅಪಲೆಂಟ್ ಕೇಸ್.
ನೀವೇನು ಅಪಲೆಂಟ್ಗಾ? ಫಾರ್ ವಾಂಟ್ ಆಫ್ ಟೈಮ್ ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 14/11.
T9 Bhargav ji,
ಸೇಮ್ 14/11.
70
I am for the respond number
14/11. ಇದೇ ನೀವೇನೋ ಹೇಳಿದ್ರ ಅದ?
ಇಲ್ಲ ಸರ್, ಅದು ಇನ್ನೊಂದು ನೆಕ್ಸ್ಟ್ 72 ಸರ್.
70 RBS
Petitioners, my lords.
14/11.
My lords, RFA, serial number 71, my lords. RFA 595/2000
ಏನಾಯ್ತದು?
may be connected with RFA 423/18, my lords.
RFA
595/2008 may be connected with RFA 423/2018, my lords.
425
423/2018, my lords.
18.
Yes, my
How
lords.
it is connected ಅಂದ್ರೆ ನಿಮಗೆ ಕರೆಕ್ಟ್ ಅದು?
Yes, my lords.
ಅರೈಸಿಂಗ್ ಔಟ್ ಆಫ್ ಸೇಮ್ ಜಡ್ಜ್ಮೆಂಟಾ?
Madam, ಇದು 2008-18.
ಅರೈಸಿಂಗ್ ಔಟ್ ಆಫ್ ಸೇಮ್ ಜಡ್ಜ್ಮೆಂಟ್ ಏನ್ರಿ?
Yes, my lords, both are connected, my lords.
ಮಾಡಕ್ ಬರಲ್ಲ. ಕನೆಕ್ಟೆಡ್ ಅಂತ ಹೇಗೆ ಹೇಳ್ತೀರಿ? ಅದಕ್ಕೆ ಕೇಳಿದ್ ನಾನು 2008ರದ RFA 2018 RFA ಅದ್ರ ಜೊತೆ ಮಾಡಿ ಅಂತಂದ್ರೆ ಹೇಗೆ ಮಾಡಕ್ಕಾಗುತ್ತೆ? ನೀವು ಫಸ್ಟ್ ವೆರಿಫೈ ಮಾಡಿ. ಅರೈಸಿಂಗ್ ಔಟ್ ಆಫ್ ಸೇಮ್ ಜಡ್ಜ್ಮೆಂಟ್ ಬೆಳಗಿಂದ ಅದೇ ಮಾಡ್ತಾ ಇದ್ರಿ, ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ? ಯಾಕೆ ವೈ ಹ್ಯಾವ್ ನಾಟ್ ವೆರಿಫೈಡ್?
Yes, my lords, it's from the same court.
ಆಯ್ತು, ಏನ್ ಮಾಡಕ್ಕಲ್ಲ. ಫಾರ್ ವಾಂಟ್ ಆಫ್ ಟೈಮ್ ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 14/11. ಒಂದ್ಸರಿ ನೋಡ್ಕೊ ಬನ್ನಿ, ಯಾವತ್ತೇನಾರು ಇದ್ರೆ ಕ್ಲಬ್ ಮಾಡೋಣ. 72 ನಲ್ಲಿ ಏನೋ 17 ಸತ್ತೋಗವ್ರ ಅಂದ್ರೆ
R1B ಮೈಲಾಡ್.
ಹರೀಶ್ ಕುಮಾರ್ ಇದಾರ? ಇದ್ರಲ್ಲಿ ಏನೋ ಸತ್ತೋಗವ್ರಂತ್ರಿ? ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 15, 16, 17. ರೆಸ್ಪಾಂಡೆಂಟ್ ಕೌನ್ಸಿಲ್
My humble submission, my lord.
ಹೇಳ್ತೀನಿ, ನಿಮ್ ಬರ್ಕೊಳ್ತೀನಿ.
Please.
Counsel appearing for R 15, 16, 17 submits that they are no more, and hence appellant counsel is directed to bring the LRs of the R 15, 16, 17. ಆಮೇಲೆ ಹೇಳಿ ಈಗ ಏನು?
So what consent to R1B, my lords, please. In the portion of survey number 64/1, item number 7 of the suit schedule property, I have started to put up construction on obtaining, loan from the bank. My lord, in meantime, they have come up with an application before this honorable court to restrain me from putting up construction. This honorable court is pleased to pass an order as objections were not filed, as could be seen from the order. I came later on. Then an application is filed for vacating the interim order. Some of the suit for partition, my lords, please. And on the record, on the face of record, documents are also there. 1930 itself, my great grandfather has already executed a settled deed. Our property ಅವ್ರಿಗೆ ಹೋಗಿದೆ. Merits and our success ಆದ್ರು 13 acres of land is belong to our family, which is subject matter of the appeal, my lord. They are claiming 1/5 share. My lord, in a portion of the property out of 1 acre, 4 guntas of this survey number item notice. I am putting up, I may be allowed to put up construction. Let them, I say, I undertake to obey any terms, my lord. Otherwise, my lord, ಈಗ ಫೋಟೋಸ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಸ್ವಾಮಿ, ಮಳೆಗೆಲ್ಲ ಹೋಗ್ಬಿಡ್ತಾ ಇದೆ.
Kindly have it at 250, 5th minute, 2:30 minute.
ಯಾವಾಗ?
5th minute, 4th or 5th minute.
5th 2:30
ಆಗ್ಲಿ.
ನೀವೇ ಫಿಕ್ಸ್ ಮಾಡ್ತೀರಾ ಕೋರ್ಟ್
Sorry minute. Senior argued.
ಟೈಮ್?
Let's say urgency minute.
ಸೀನಿಯರ್ ಬಂದಾಗ ನಾನು ತಗೋಬೇಕಾ?
No, sorry minute, sorry minute.
ಡೋಂಟ್ ಫಿಕ್ಸ್ ದಿ ಟೈಮ್ ಟು ದಿ
Sorry,
ಕೋರ್ಟ್.
extend sorry minute.
ಇಂಥ ದಿವಸ ಅಂತ ಕೇಳಿ ಕೊಡ್ತೀನಿ.
5th minute.
ಮತ್ ನೀವು ಬಂದಾಗ ನಿಮ್ ಸೀನಿಯರ್
sorry madam, any-
ಕೂತಿಲ್ಲ.
4th or 5th, any date, ma'am.
ಅದೇನ್ರಿ ಅದು?
Monday or 15th.
4th acts.
ಹಾ.
If time permits to, my lord, on 4th itself.
ಕೋರ್ಟ್ ತುಂಬಾ ಇದೆ.
ಆಚ್ 5th.
ಅದ್ ಯಾವ್ದೊಂದ್ ನಿನ್ನೆ ಒಂದ್ 2 ಗಂಟೆ ಹಿಯರ್ ಮಾಡಿದ್ದು ಒಂದು ಹಾಕಿ
ಗೊತ್ತಾಯ್ತು.
ಅದೇನ್ರಿ?
5th ಆಗ್ಲಿ ಸ್ವಾಮಿ.
ಆಯ್ತು. ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 5/11.
ಸರಿ, ಸ್ಪೆಸಿಫಿಕ್ಲಿ ಫಾರ್ ರಿಗಾರ್ಡಿಂಗ್ ಐ ಅಂತಾನೆ ಬರ್ಲಿ ಬೇಕಾದ್ರೆ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಅಲಾಂಗ್ ವಿತ್ ಐ ಅಂತ ಬರ್ಲಿ.
ಏನೇ ಇರುತ್ತಾನೆ?
ಅಲಾಂಗ್ ವಿತ್ ಐ.
23
My lord,
ಲೋಕ್ರೆ.
my lord, here for the appellant,
ಹಾ.
I would request you to give me a short date on 7/11 if possible.
11/11.
Thank you, my lord.
11 ಕೇಳಿದ್ರು. 11/11 ಹಾಕಿದ್ವಿ.
Respondent number 1.
Rita 74 SN Bhatt, Rita Castellano. ಅದೇನ ಅವ್ರೇನಿದು? ಅಂಡ್ MS ದೇವರಾಜ್ ಅಂತ ಇದಾರಲ್ಲ. Registry is directed to show the name of MS Devraj, deleting the name of SN Bhatt since it is learned from the bar that he is no more. Correct? List this matter on 12/11. Correct ba?
ಮೇಡಮ್, ನಮ್ದು ಸೀರಿಯಲ್ ನಂಬರ್ 6 ಇಂಟ್ರಿ ಆರ್ಡರ್ ಆಗಿದೆ, ಅದು ಆನ್ಲೈನ್ ಅದು ಅಪ್ಲೋಡ್ ಬರೀ ಅರ್ಜೆಂಟ್ ಅಂತ ತೋರಿಸ್ತಾ ಇದೆ. ಅದು ಸಿವಿಲ್ ಕೋಡ್ ಅಲ್ಲಿ ಮಂಡೇ ಇದೆ.